Okay, people. I don't know when they'll come. Let us at least start. I think you are able to see. Yeah, okay. My screen is blank here. Fair enough. So let us start the marathon part. Before we dive in, the most important thing that most of you guys will have a question is that, sir, which is the, now say for example, if I'm starting now, can I even cover all the topics now? Is it possible? Can I still write the September attempt? Is it possible? So first thing is, people remember, this is your weightage. I'll be giving you your marks weightage, and you need to study in this order only if you want to cover it. As well as, people, if you're a person, if you're starting very late, I have not done any past work, sir, for the last 5-6 months, I'm a college going student or anything. Sir, should I give an attempt or should I skip it? Always remember, people, attempt is more valuable. Never skip any attempt. Whenever, no matter when you're starting, it's still fine. You can still cover it. At least do whatever is the best you can. And remember, there is never something called as a best attempt. You have to give an attempt. So accordingly, your preparations will also align. So this is your weightage. Remember, people, you need to be a master in this chapter. That is only your LLP. You have to be a master here. The reason is, people, 5 to 10 marks. Let us assume an average of people 7 marks. I'm telling you, this is going to be a cakewalk. Yeah, LLP, what is there? You can even study letter by letter. So whenever I'm telling you, you have to study letter by letter, don't even leave a single paragraph from your book. So that should be your level of preparation when you are approaching LLP chapter. Not even one letter you are going to skip. Are you getting the point? Next one, sir. Indian regulatory framework. Consistently, they have been asking for people 5 marks. Every attempt. Hardly, people. There are some 15 topics in this entire chapter. How long does it take? So it is not something which we cannot predict. So again, I'm telling you, Indian regulatory framework is again a topic where you guys should not skip. Make sure that every letter by letter is covered from the book. That is the second scenario. Third thing is, people, we are going to Indian partnership. I'll tell you the logic why we have taken Indian partnership. The reason is, people, relatable, easy to understand. You will not get confused like you get confused in Sale of Goods Act and Indian Contract Act. It is easy to answer. There is no really difficult topics except in Unit 2. So the weightage of Indian partnership will be 15 to 20 marks. That will be your third preference when you guys are studying. I'm telling you, this is, imagine tomorrow is your day of your exam. This is the order you are going to revise in. Hello? The fourth one, sir, it goes to Negotiable Instruments Act. Again, single act, very few concepts, easy to cover. Weightage has been from the previous 2-3 attempts, though, it is anywhere coming between 12 to 15 marks. Easily, there are 3 questions being asked from Negotiable Instruments Act, and it is as direct as possible. So I'm telling you, this is something which you should always encash on. The third one, the next one is called, people, Companies Act. If at all given a choice, I will put Companies Act somewhere here. But still, students say no, sir, Companies Act difficult, too many concepts and all. That's the reason I'm keeping it here. Companies Act is something, a go-to chapter. You will not at all feel confused. Direct questions. And remember, the key topic in Companies Act is definitions are very, very, very important. What are definitions? All your private company, small company, OPC, government company, all those things are very, very important in Companies Act. The next one is, people, Sale of Goods Act. And the last one I would tell you, people, is Indian Contract Act. Yes, you would have seen any other priorities also. I know people who say Indian Contract Act should be given the most priority is because of the marks. That we understand. 20 to 30 marks is the weightage. That we totally get it. But what is happening, people? To get this 20 to 30 marks, it is always a little uncertain. Meaning, if you ask me, there is one chapter where the students are struggling to answer the conceptual knowledge. That is people Indian Contract Act. So weightage is there, but remember the students are finding this particular thing difficult. I'll tell you why also. What are the things that, okay, let us do it this way. Weightage is clear. Any doubt here? Clear? If you want, you can take whatever picture, screenshot. This is going to be your weightage. And remember, this is going to be a revision order when you guys are revising before your exam. Is this clear? Yes? Okay. Now the next thing, sir, what are the things that we have to keep in mind? Why are students failing in law? What is the main reason? Why are students failing in law? The reason is people. If I have to note down a few reasons why the students are failing in law, the first most important thing, people, is confusing between topics. Confusing between topics. What do I mean by that? You will feel, array, this topic, this question, it might belong to that topic also. It might belong to this topic also. Are you getting the point? I might feel question number 1, it might belong to say section 6 as well as section 12. You will find it little confusing. Should I answer it as per this section or as per this section? Are you getting the point? As we are going to solve many questions, I'll tell you how to tackle this particular difficulty. Can we tackle it? Answer is absolutely yes. We can tackle it. Are you getting the point? Okay. Second one, the most difficult thing, if you ask me, people, that I have seen with students is, it is almost difficult. If you want, I can even write the word called impossible to attain 100 marks. The most difficult thing. If people have given an attempt, you can go and ask them, what is the number of marks you were able to write? Can I ask? What is the number of marks you were able to complete in the exam? How many? How much you guys were able to write? 80? 69? 60? 70? People, 80 people. Hand will stop. 3 hours will be done. That means what? See, are you getting why law is becoming difficult? You are getting 40, not on 100. 20, array, you didn't attend at all. Then you're getting 40 not on 100. You're getting 40 on 80. Why? Unfortunately, this is the only paper where it is writing. The entire 100 marks you are supposed to write. So constant, that's the second difficult topic is people, difficulty in covering 100 marks. Now, how do we improve it, people? You need to have the knack of moving on. That is, if I take up a question, how much I know, I will write that much. Don't overwrite, don't underwrite. There might be some topics where you guys know more. It's okay. What is required, you need to write. Don't overwrite. You are going to fall short of time. To tackle that second thing, people, is a third thing. Remember, our pen gets stuck in the exam. For this, as one of our students said, that's where I say you need writing practice. From today on, make it a habit in your life. At least write practicing, people. Start practicing 2 questions every day. Irrespective, you might be doing economics, you might be doing QA, you might be doing accounts. But writing 2 questions in a day in your life should not stop. Now, how do I get these 2 questions? Take up, people, RTPs, take up MTPs, take up the previous year question papers, take up the mock papers, take up something, but you are supposed to constantly write at least 2 questions. So students are failing. One of the biggest reason is this. And remember, people, the fourth one, again the most important thing before you go for an exam. Remember the 3-hour exam that you are going to take it up. It should not be directly in the exam hall. The 3 hours paper, you should have taken it prior. That means what, people? They conduct something called as mock exams. If no one is conducting mock exams, today you can find it 100 over the internet. Yeah. So even at Arivu we have, what are these mock exams? Before you take up an exam, people, remember, you have to first write that 3 hours sitting in your home, sitting in some exam hall. First you write it. You should have a practice of sitting that 3 hours, and that particular practice should have happened prior. It should not directly go and happen in the exam hall. Are you getting the point? So you should know, how do I face that 3 hours? You will learn a lot in this particular practice. You will know my mind is not able to put down the thoughts that I have. Time management. If here you are able to touch anywhere above 85, that's a very good exercise that you have done. Remember, fifth one, if people say that the paper is difficult, you generally say, right? Oh, this time the law has become very difficult paper. The questions has been very difficult. They say that it can be for whichever subject, people. Remember, the approach is same. What is that? If the paper is difficult, then remember, that is the paper in which your effort has to be the maximum. Don't quit in the exam or during the exam. Don't give away the hopes. Remember, if the paper is difficult for you, it is difficult for the entire country. The way your mind is telling to quit, it will tell the entire country to quit. You guys have to utilize that. Spend more time in the exam hall. Even if you are writing one question, write it with utmost accuracy. How much ever you know, spend more time. So this is very, very important. Don't quit. And remember, if your one paper did not go good, do not stop going to the exam the next day. It is your duty. You waited for 6 months, 8 months, whatever is the duration, to take up the paper. Your duty is to write all the 4 papers. Don't quit in between. Next one, people, sixth one, very important thing that the people do. One more thing is that is, what do you say, when you guys are revising, if one subject is starting, we will completely leave the other subject. Don't do that. Now let us imagine your law is done. Now your QA is done. Now when you go to economics, you're not supposed to leave the other subject. So remember, try to tag one theory subject, one practical subject. The best pair that can happen is, people, law, QA, economics, accounts. For those people, sir, we can't read the same subject from morning to night, sir. This is the best exercise you can do. Do 2 papers in a day. Hello. Next one, sir. Remember, as I've already told you, writing practice, it is your duty to see, study, prepare, and solve as much as possible all the RTPs, MTPs that is there in the internet. Make use of it. You guys have to cover all the RTPs and MTPs, mandatory. And remember, people, the more questions you solve, the better will be the results. This is, I'm telling you, a proven theory. The more questions you solve, the better will be the results. And remember, your first question should be always the most confident question. Never play around in the first question. The first impression is the best impression. It sticks on even after generations. If at all you're not able to make an impact in the first question itself, you're setting a tone to the examiner. That means what? Let us imagine if you have written your first question really good. If you're getting 4 on 5. Your second question, if you're getting 4 on 5 again. The third question, if you deserve 3 on 5, there are high chances that you will get 3.5 or 4 on 5 only in the third question. Because you have set a tone. Now I will see, as a person, anyone, they will be confused. Should I give a mark for this or not? If your first 3-4 questions has gone really good, I will say, when I'm confused whether should I give it or not, rather than not giving, I will give preference to giving the mark. So instead of deducting, there are high chances of giving the mark in that particular confused mindset. It plays a huge role. And ninth one, probably after this I'll also tell you how to present your answers instead of telling on the last day. Yeah, remember, underlining is Very, very important. Don't let the examiner search for the answer. Underline whatever you guys are writing. Very, very important. Are you getting this point? Hello, all of you. Yes. So see, these are a few things that students has to keep in mind. Are you getting the point? Yes. So try to do the changes. Start practicing from today. At least 2 questions every day. If you guys are able to do more than that. Now, for example, if law is more difficult for me, you spend more time. You do 4 questions instead of 2. So this is something which you guys have to do. Clear? Hello? Are we there? Okay. Okay. Yes, people, the first chapter, Indian Regulatory Framework. So in this, what is that we are going to study? We study that the government of India has something called as 3 organs. That is how the government of India functions. What are the 3 organs? The 3 organs are called as legislature, executive and judiciary. What is legislature? Legislature is nothing but the people who make law. What do you mean by executive? Executive are the people who make sure that they implement the law. Now we have law. What is the use if no one is implementing it? So these people will help us to implement the law. Example of executive, if I have to give you people, the best example is police. Police comes under executive. Yes. And what else? Your insolvency and bankruptcy, all your ministries. We have a lot of executive in our Ministry of Finance, your RBI. All these things will come under executive only. The next one is called as people judiciary. What do you mean by judiciary? Whenever there is a conflict, the people, the independent party who come and resolve the conflict is called as people judiciary. So in this particular chapter, we are only going to cover about these 3 people. So let us start with the first one, that is only called as law. In that people, what is the process of making law? It has been the most, people, one more thing that I am going to give you is, after every unit is done, I will try to give you what are the most important topics of that particular unit. So as and when a particular unit is done, I will tell you these are the most important topics, at least for those people who are sitting at the nth moment, it might help you. Okay, important, remember and go. Process of making law. How do we make a law? Generally what happens is, people, when we want to make a law, first what we do is we come up with a committee. That is, some specialized people in that field will be appointed. For example, when we wanted to bring Companies Act 2013, when we wanted to make, what did the government do? The government appointed some industry people who are experts. You will not believe who are appointed. People like Narayana Murthy, founder of Infosys, JJ Irani, ex-director of Tata. Such people were put in the committee. Why? They know day in and day out what are the advantages, what are the disadvantages in today's system. They know better. Now what were they done? They were put in a committee and they were asked, see that today we have Companies Act 1956. We are trying to upgrade. Can you please give us your suggestions? Now what will this committee do? The committee will refer to various countries' laws and they will prepare one draft. The committee. That draft, we call it as a bill. The draft bill will be first submitted by that committee to the Lok Sabha, the lower house. We will give it to the Lok Sabha. So in Lok Sabha, people, once we get an approval, it will now go to Rajya Sabha. In Rajya Sabha also you get an approval, people. Now what happens? You need to take the approval from the President of India. Once the President of India also puts the signature, they give their consent. Now what will happen? Now you will publish this particular law officially to the people. We need to know that the law is published. That's why they publish it in one book. That book is called as, people, Official Gazette of India. Official Gazette of India. This is how the law is made. And I hope you guys know who should make law. Is it center? Is it state? Who should make law? What type of country is India? Federal, We are generally called as people, we are federal with certain unitary features. What do you mean by this federal? Federal means nothing but people, law can be made by. If it is central law, central will make laws. If it is state, state governments will make law. There are some lists called as people, center and state. So, depending upon where that subject matter comes, the concerned government will make laws. So, where do we know, how do we know that who can make law? Is it parliament or is it state legislature? How do we know who can make law? To avoid the conflicts, people, what has the constitution done? The constitution only has given the power. I will prepare one list. In this list, I will tell what and all can center make laws. On those topics, only center can make law. State government cannot poke their nose. In the same way, I will prepare a list. I will only put the power here only on state government. Now here, central government cannot poke their nose. The third list that the constitution prepared is called as concurrent list. What is concurrent? Both state and center, both can make laws together. You also have a right, I also have a right. Example, people, center, all your military, army, air force, what else? Atomic energy. Have you ever seen army for Karnataka? Let us have army for our own states. Not possible. Who said? Constitution. In a list called as union list. If anything has to be made for army, navy and all, only the power is with center. State cannot poke their nose, whether you like it or not. You have to be silent only. The second list is called as state. The best example I can give you is agriculture, police. Now these things, center cannot come and make a law. My state government, my rules. Your state, your rules. That's why now you guys can be coming from different states. The land laws are different in your state. The land laws are different in other state. Every states have their own laws. The third list is called as people concurrent list. Concurrent means together, combined. Best example, people. How many of you have studied in state syllabus? School. Central syllabus? We have both. How? That is a best example of people concurrent. State has decided. Center has decided. Don't you think there is a one topic where both of them have made laws? Hello? That is the best example for concurrent list. Any doubts? Hello? I hope this is clear. Federal with certain unitary features. Federal means what, people? Every state has the power to make law. That's the meaning of federal. Hello? Understanding? Yes? Okay. Next one is called as people types of law. What are the different types of law? One is called as criminal law. What do I mean by criminal law? Criminal law is generally, people, nothing but there are so many public wrongs that will happen. So whenever a public wrong takes place, people, we call such particular thing as a criminal offense. Now what do I mean by criminal offense? Remember, people, in criminal offense, what we want is punishment. If someone does a criminal offense, we expect a punishment to be given to that person. Example, when a person gets murdered, what is the revenge we want? What do we need alternative? Money? Imagine A kills B. B's family need money from A. Will that suffice? Will that cause your, will it bring your heart at peace? Answer is no. Then what do we need? Remember, people, in criminal law, we want punishment. That means we are asking, sir, please go and give, death sentence to A or put him in jail forever. That is what we need in return. That is only called as what, people? Criminal offense. And the laws that deal with that is called as, people, criminal laws. Understanding? The second type of law is called as, people, civil law. What is the difference between criminal and civil law? Civil, people, simple. I don't want punishment, people. All I need is, people, compensation. That means A agreed to sell something to B. A did not sell that to B. What does B want in return? Do I want A to go and sit in jail? Or A should be hanged? What will it give me? All I want in return is people, sir, I need compensation. I have given him money. Please tell him to give it back along with some interest. That's all. That is what I want. Now that is why we call this law as a civil law. In civil law, we are not punishing people, but we are asking people to compensate. I hope you are getting the difference. Yes? Okay, now see the words they have used. Law relating to matters dispute between individuals or organization, it focuses on dispute resolution rather than punishment. And which law takes care of administration of civil law? It is always governed by CPC. Criminal law people, we can write it as BNS and BNSS. That's IPC and CRPC are now replaced by BNS and BNSS. Remember, from exam point of view, we are supposed to know this only. There is no IPC and CRPC now. It has been replaced by BNS, BNSS. Yes, the next one, people, common law. What do I mean by common law? Common law, people, is nothing but whatever we are going to study in all our chapters is nothing but we have something called as what? Case laws. Oh, what do you mean by case laws, people? Yeah, what is the whole significance of case law? Now, for example, people, let us imagine, okay, now I'll give some assignment to a student. The student does not write it. Now, what I will tell, I will give one punishment to the student. Now, why am I giving this punishment to the student? Because of two reasons. One, so that the student does not repeat it. Second thing, I am telling the entire class, remember, if anyone is doing this, even tomorrow, you will also face the same concerns. You will also have to undergo the same particular punishment. Now, people, that is only the meaning of people, common law. What do I mean by common law? Already in the past, one case has happened. Something has happened in the court. People have come for days, for months. We have, exchanged facts. And finally, the judge will give a judgment. Again, after 3 years, similar case happens, people. Do you really think we will again spend the same 1 year, 2 years again on this case? Answer is no. Something is already decided. We just apply the cut, copy, paste decision. Whatever was done in that case, we will cut, copy, paste same decision even in this case also. Are you getting the point? That becomes a law. That is what is called as, people, common law. Common law, it stands on one principle. The principle is called as, people, stare decisis. What do I mean by stare decisis? Means, people, nothing but to stand by what is already decided. Yes, so in the court, if there is already one punishment, already one judgment has been given. In the second case, if something similar comes, we will copy paste the judgment. We will not waste the same time. Understanding? All of you? Sir, exam point of view, should we remember these things? Stare decisis and all? Yes. Clear? Yes, it will have weightage. Remember, from exam point of view. And next one, sir, remember, as per Article 141 of Constitution of India, whatever has been decided in the Supreme Court automatically will bind on all the inferior courts. That means on all the high courts, on all the district courts, whatever is decided in the Supreme Court, the high court will have to follow it, the district courts have to follow it. That is the meaning of stare decisis. Article 141, you are supposed to write it in your exam. Remember and go. So, according to Article 141 of Constitution of India, whatever has been decided by the Supreme Court, it will always have a same importance even in the inferior courts. That is, in your high courts, in your district courts, same will get again repeated. Clear? Last one, sir. Principles of natural justice. It also stands on one principle called as audi alterum partem. What do you mean by audi alterum partem? Means nothing but, people, you should be given an opportunity of being heard. I have to, before punishing any person, I have to listen his version of the story. That's the simple meaning of opportunity of being heard. These are the 4 different types of laws. Any doubt here? Clear? Okay, done. The next one, sir, the structure of Indian judicial system. What is the function of Indian judiciary? The first one is people, regulation of interpretation of acts and codes. That is, whenever if there is any difficulty in understanding any topic, some laws are very confusing. The judges will give you a clarity. Remember, you should not read the law like this. You need to read the law like this. For example, Indian Contract Act, in which year it was made? 1872. People, is the lawmaker still alive? Is the committee alive? People, that time we didn't even have parliament, people. Now you tell me, if I have any doubts in Indian Contract Act, whom should I ask? Whom will we ask? The lawmaker is no more. The person, the people who gave the bill is no more. The committees are no more. Whom will we ask if we have any doubts? She is like, sir, ask me. Huh? Whom will we ask? Remember, the judges will take a call. The judges will tell you how to read a particular topic. Now, whatever they tell will become the new meaning. That's the meaning of interpretation. They will help you. That's their whole function. Remember, once they have asked, what are the functions of Indian judicial system? But it's been 4 attempts. Important for your attempt. Remember and go. Second one, sir, dispute resolution. Simple. Dispute means fight. Resolution means resolve. That's the function of the judiciary. The third one is people, promotion of fairness amongst the citizens. So no one should be treated unequally. We will make sure everyone's interests are protected. Okay. The next one is people, types of judiciary. In our India, people, we have 4 types of judiciary. So this is nothing but what people, remember people, if you have any problem, in your school days, college days, you will not directly go and tell everything to your principal, right? You will first tell it to your class leader or your class teacher, and then HM, and then vice principal, and then if something does not get resolved, you used to go to principal. Same thing happens in the court. If you guys have any problem, you will first go and tell it in the lowest court. If it is not getting resolved, you will go to the next high court. If there also it is not getting resolved, you will go next to the higher court. For example, if you guys are watching IPL, people, when a person gets out, the on-field umpire says it's out. But the batsman knows that I have not edged the ball, but the umpire gave me out. What is the immediate thing the batsman will do? The batsman will say something like this. What's the meaning of it? Sir, the lower court has not seen everything properly. As a high court, can you see with more evidences? Can you please re-look into it? And whatever you did DRS in your, cricket, sir, cut, copy, paste concept here, people, we call it as appeal. When a lower court is deciding a case, and if you are not happy with it, out is given, you are not happy with it, you can say appeal. So district court passes a judgment, you are not happy with it, it can go to the high court. You are not happy with it, it can go to the Supreme Court. You are not happy with it, die. Hey, you can't go ever, somewhere you have to put one full stop, correct? So the maximum possible court, that's why we call Supreme Court as a apex body. Apex means people, APEX. It's the utmost highest authority in judiciary. Nothing above that. Hello. Clear? Yes, sir? Okay. So there are 4 types of courts. Technically we have only 3, but some cities, we call them metropolitan, because the population is so high that wherever the city's population, if it touches, all these were made way too long back. That's why we have 10 lakh and all. But today what? One Kormangla has 10 lakh people. Yeah. So, but yes, back then what it says, if any cities, metropolitan cities, if you have a population of 10 lakh or more, that means the population is more. Having one court will not be sufficient. That's why what it say, For the metropolitan cities, let us have an extra court. So that's the whole concept. That's why we got this scenario called as metropolitan courts. Just because population is more, cases will be more. Let us have more courts. Today, in today's India, in every gully we need one court. That is the number of people we have, number of pending cases also we have. Clear? Okay, see, the lowest court that can happen in a city is people called as metropolitan court. Which city will have metropolitan court? Metropolitan cities where the population is 10 lakh or more will have metropolitan courts. They are established in metropolitan cities. Who will approve it? High Court will approve it. Understanding? Yes. Okay. The next court that we will get is people called as district court. District court can be of two things. One is called as district court. Next one we call it as sessions court, also called as court of session. So there are two things: district court, sessions court. What does district court do? What does sessions court do? Now sir, you say that there is some case. Directly you are telling me don't come to the principal or vice principal. You are telling me to go to the class teacher. Now in class teacher also you said there are two different types of laws. One is called as civil law, one is called as criminal law. So if it is civil matter, you will go to district court. If it is criminal matter, you will go to court of session or sessions court. That's the first court that you will see in every district. This is metropolitan alone. But if at all we are coming from a district which is not a metropolitan, then what is the first court we will come across? This is the first court. So one is called as district court. Next one is called as sessions court. I hope this is clear. See, under pecuniary jurisdiction, a civil judge can try suits not more than 2 crores in value. And here also there is a second limit. What is that? Sir, in district court, I am going to a civil case. Correct? Huh? Hello? What do you mean by civil case, people? Civil case, breach of contract. ArivuPro takes money. We do not do the classes. Where will you go? You will go to district court. Why? What is the value? So we paid a fees of 50,000 rupees. 50,000. Correct? Huh? The value of the case is less than 2 crore. Huh? We will first to go to district court. So imagine, sir, we went to a university. We paid fees, but something did not go right. Now there is a dispute between me and the college. What is the fees? Sir, 3 crores. My God, it is going beyond 2 crores. Hello? It is going beyond 2 crores. Now can I go to district court? Unfortunately, the judge does not have so much power. The case is getting serious. So what do I have to do? You have to automatically come to the vice principal. I understanding, because here I can maximum try with the case if the value is not more than 2 crore. Up to 2 I can do it. Beyond 2, I'm sorry, I don't have the power. Hello? Understanding? Pakka? And the third one, sir, court of session deals with criminal matters. So any criminal matters directly come here. Okay, sir. Sir, now there also, I might have not got justice. Imagine district court might have said A versus B. A won the case. B is not happy with it. Now what will B do? B will say, sir, I am not happy with the judgment passed by the district court. Mr. High Court, can you please look into it? Now we will go to High Court, people. High Court can also re-look into the matter. Remember, people, High Court has 3 types of power. One is called as, people, original power. Next one is called as appellate power. Third one is called as supervisory power. One is called as original. What do I mean by original? People, if the value of the case is more than 2 crore, you cannot go to district court. You should directly come to High Court only. Correct? Huh? That's original. So direct cases that will come to me, that is called as original power. The next type of cases that come to High Court is appellate, DRS, third umpire. So if some cases where the parties were not happy with the district court's judgment, that case will come to me as an appeal. That is called as appellant jurisdiction. Jurisdiction means nothing but power. Hello? The third one is called as people supervisory. Supervisory means what? Now there is High Court of Karnataka. High Court of Karnataka supervises all the district courts in Karnataka. Under me you all will work. Whatever I tell, you guys are supposed to listen. That is only called as what people? Supervisory power. I will tell who should be the judge. I will tell this case should not go to that court. Take it up from Mysore. Put it in say Dharwad. I can decide it as a high court of the state. That is the meaning of supervisory. So, a high court has three powers. Very, very important. One is called as original. Next one is called as appellant. Third one is called as supervisory. And remember, the high court of the state is the highest court of the state. For a state, that is the highest court. Sir, can we go to high court directly, sir? Is it possible? Can you go to high court directly? Yes, people, possible. You have fundamental rights. Hello? Jantar Mantar? Strike is happening. If someone is now detained, for example, there is a person called as Sonam Wangchuk. He was sitting on a stage doing his own peaceful strike. The police came and arrested him. Was it with his consent? Did he cause any mess? He was doing a peaceful strike. Was he taken away with his consent? No. This is against your fundamental rights, your right to movement. No one can detain you without your permission. Sonam Wangchuk can file a case directly in High Court saying that they have detained me without my consent under Article 226. I need not have to go to Metropolitan District. I can directly go to High Court. Whenever your fundamental rights are affected. Understood? Hello? Sir, High Court only. Can't I directly go to Supreme Court? If your fundamental rights are affected, you can either go to High Court, allowed, or you can go to Supreme Court, allowed. Hello? Are you understanding? Yes. So remember, under Article 32 of Constitution of India, you can go to either Supreme Court if your fundamental rights are affected, or under Article 226, you can go to High Court. It is your choice. If going to High Court is convenient to you, go to High Court. If going to Supreme Court is convenient to you, go to Supreme Court. Hello? Understood? And remember, Supreme Court is the highest authority of the judiciary. Whatever is decided by the Supreme Court, Article 141 of Constitution of India, it will always bind all the lower courts. Other courts are lower courts. Is this clear, all of you? Pakka. It is the apex body established. Chief Justice is the highest authority appointed under Article 126. An individual can seek relief under Article 32 of Constitution of India. So that means what? If it is fundamental rights, I need not have to go to district, state, and then Supreme. You can directly go to Supreme. Sonam Wangchuk can directly go to Supreme Court under this article. Hello? Are you understanding? Pakka. This is your judiciary. And the last part, that is your executives. Remember, people, every executive is important. One or the other executive can be picked up. They can ask you as a 4 to 5 mark question. Hello? Yes? Okay. So let us look at the executives only, whatever we have. One is called as Ministry of Finance. What does the Ministry of Finance do? Under Ministry of Finance only other things also will come. SEBI, RBI, all these people will come under Ministry of Finance only. What else Ministry of Finance will do? They also give you an annual budget once in a year in February. Everything will come under whom? It will come under Ministry of Finance only. Who is Finance Minister? Nirmala Sitharaman, that is her ministry, everything will come there. And what else Ministry of Finance will decide? Taxation of the country. All that people will become the role of Ministry of Finance in our country. Executive, correct? So they have given you various examples of executives. Any of these things can be asked. Remember and go. Yeah. Hello. Vitta Mantralaya, also called as the Ministry of Finance, is also called as Vitta Mantralaya, serving as the Treasury of India. Once in a year, the most important thing that they present is Union Budget. It is the controlling authority of Central Civil Services. What is that? Indian Revenue Service, Indian Audit and Account Service. What is this? This is one who takes care of your Comptroller and Audit General of India. Government companies and all should be audited, no? You guys are becoming auditors. You will audit all private companies. Who will audit government? Government shouldn't be audited. Should government be audited? RBI, don't you think they should also have accounts? RBI accounts has to be audited. ICAI, shouldn't it be audited? How much fees you guys are paying? Are they receiving funds? No? Then who? It all comes under Indian Audit and Account Service. So there is someone called as CAG and all. You'll be studying in your CA Inter. They will audit. So the entire thing will come under Ministry of Finance under this particular wing. Understood? Next one, Indian Economic Service. Everything with regards to money. Indian Civil Account Service again. Also the apex controlling authority of one of the central commerce services, namely Indian Cost and Management Accounts Service, CMA. Understood? Okay. Departments under Ministry of Finance, Department of Economic Affairs, Department of Expenditure. What are all of this? Macha, it is just like your bank account. Ministry of Finance is a bank account of the nation. In that, one department only thinks of expenses of the country. One department only thinks of revenue of the country. Department of Financial Services, Investment and Public Asset Management. Take it together. This department thinks of savings of the country. We have to invest, no? Gold or silver or tomorrow if something happens, so free reserves. So something we should have, no? That department thinks. It is also part of Ministry of Finance. The last one is Department of Public Enterprises. Something which deals with your, public undertakings. So they take this, all these bodies come under Ministry of Finance. Remember, any particular ministry can be picked up and they can ask you a question. Very, very important. Exam point of view. Very, very rarely I will tell, but a few people are blessed with by-hearting skills. Your by-hearting skills, please put it to use in ministries or, I am telling in general, executive power. Please try to by-heart every word here. I will probably, until the nth chapter, I will not use the word by heart again. This is the only place where I will tell. Macha, birthday gift to you. Yes, sir. Okay, next one is Ministry of Corporate Affairs. Under Ministry of Corporate Affairs, people, there are majorly 3 laws that are there. What are the 3 major laws? One is Companies Act, one is LLP, both are there in our syllabus only. Next one is called as Insolvency and Bankruptcy Code. What is Insolvency and Bankruptcy Code? In short, I'll tell you, see here, Insolvency and Bankruptcy Code is nothing but long back, people, if a company wants to wind up or if a person wants to become an insolvent, it used to take years. India has a record of winding up matters. 15 years was the average time it used to take. That means what? Today I want to shut down a company. If I start the application today, it used to take 15 years. I will not take the name of the states and all. It has taken 22 years and all. That means what? The person who started winding up has passed away. Case is going on. The insolvency is going on. They wanted to put an end to it. They introduced one act to fasten this process. They called that act as people Insolvency Bankruptcy Code. Now, Banking Regulation Act we have. When did Banking Regulation Act become, more and more powerful? When they nominated one person to take care of it. Who was that? RBI. Same principle they applied here. What did they do? They nominated a person to take care of it. That person only was called as IBBI. Stands for Insolvency Bankruptcy Board of India. This is the first pillar of IBC. Hello? Second pillar, sir, regulator is there. Who works? For example, we wanted to make sure, audit is properly taken care in the country. So what did we do? We formed one law, Chartered Accountants Act. We passed it. To take care of it, we have nominated ICAI. But will ICAI come and do all the audits of all the companies in India? Who are doing it? Chartered accountants. Now in the same way, I am telling you have to speeden the process. So we understood, hey, chartered accountant is doing the audit. That's why audits are happening on time. That's why it is happening so quickly. Why don't we have similar person here also? We call that person as a insolvency professional. What do we call him as? Insolvency professional. Now these people started saying that, sir, CA is a CA because they have a regulator, ICAI. Yeah, they have one body. They will conduct exams for you. If you have any problem, you will take, helpline with them. You will apply membership with them. They will conduct seminars. All that they are doing. Then who will do it for us? Insolvency professional agencies. Are you understanding? Same people, cut, copy, paste. This is how the entire system was developed. So now what happened? We have something called as an act. That act is called as Insolvency Bankruptcy Code. And we have something called as IBBI. Who is IBBI? The authority, the regulator who takes care of the entire IBC functioning. Hello? Yes? And Insolvency Bankruptcy Board of India. Next we have appointed someone called as insolvency professionals. Who are they? The people like CAs. And next we have something called as insolvency professional agencies. What are they doing? They are conducting your exams to become insolvency professionals. Hello? Today we have 3 insolvency professional agencies. 3. Who are they? ICAI, ICSI, your CMA. These 3 people only are the insolvency professional agencies also. That means what? Our bodies only went and registered under IBC as insolvency professional agencies. Your board came and said, sir, I anyways have experience in managing my exams. I will manage yours also. Same thing happened with CS. Same thing happened with CMA as well. Understood? Are you understanding? Yes, that's how this entire system is conducted. You guys are understanding something? Hello? Yes. So today if someone wants to become an insolvent, so Kingfisher, if you want to wind up, how will all of this happen? Earlier, why it used to take 15-20 years? Because if you want to wind up, you have to file an application with the court, High Court. Already matters are going on. For years the matters are going on. They are only fighting. Where will your matter be taken up? That's why to even get your hearing date, it used to take months and years. Now what did they do? Let us not go to High Court. They sent all the matters to a specified, specialized body. That body was called as NCLT. NCLT. What does NCLT stands for? National Company Law Tribunal. So remember, there are 2 bodies. One is called as NCLT. So today, let us not go to courts. Courts will take their own time. For our matter, let us create special courts. The special court created for the companies winding up is called NCLT. So all the matters will be taken up by NCLT. For companies, LLPs, all the insolvency, who will handle it? NCLT will handle it. So you said company NCLT. What about an individual? Vijay Mallya wants to become insolvent. Can I go to NCLT? He is not a company. He is a human. Okay, for him, I will create one more court. So if you are a company, go to NCLT. If you are an individual, go to DRT, Debt Recovery Tribunal. Hello? Hello? So today, IBC covers whom and all? IBC covers in total 4 people today. Who are they? Company, LLP, partnership, individuals. Company, LLP, partnership, individuals. Company, LLP will go to NCLT. Partnership, individuals will go to DRT. Any doubts? We did IBC, we did IBBI also. Important exam point of view, remember and go. Clear? I hope you understood something there. Okay. Next, what else is there? MCA we did. Next one is Ministry of Home Affairs, Griha Mantralaya. Who is Griha Mantralaya? Amit Shah ji. Ministry of Home Affairs, Moha. Yes, so what do they do? What does Ministry of Home Affairs do? Again, we are going back to Jantar Mantar. It comes under Moha. Why, sir? Remember, anything that comes to the, it is a department which mainly responsible for. So now who will say? Amit Shah will say, sir, we have to maintain the law and order. Call, I don't know whom and all you'll call. CRPF, Black Commandos, call everyone. So they are calling everyone. Why? Matter of internal security. Whose department? Department of Home Affairs. Understood? See one incident, how many examples we have. Next one is Department of? Again what? That's why people remember. हम घुस के मारेंगे. I hope you have seen Uri movie. Illa? Uri movie da? No? Okay. Border management. Hey, Dhurandhar? Ye Naye India? No? Okay. Forget. Law? Law? Law. Yeah? So all these are movie dialogues, no? Also your PM said it in all your, your press conferences. Hum guske marenge. Guske marenge means what? Till our previous thing, we said if you attack, we will show one more Gandhi principle. This person came and said, this is a new India. We will take beatings, we will beat back. Guske marenge, we will also get inside and will hit you. And that is what they did. If possible, watch. Nice movie, Uri. Real life scenarios. Not now, da? Macha is writing down. Macha, after exam. Department of Jammu, Kashmir and Ladakh Affairs. Department of Home, Department of Official Language. Official language? What is official? He's like, what official? What official, sir? We don't have official, we don't have national language. We have official language. Hindi hai hamara official language, ji. That's why any central level thing will have in 2 languages. One in English. In your exam is also conducted in 2 languages because of this department. Any government publication will come in 2 languages, even official gazette also. The first part will be Hindi, next part will be English. Remember. Yes. Next one is Department of States. Okay. Next one is people, Ministry of Law and Justice. They basically take care of 3 things. Legislative department, that means what? Making laws. This is the ministry. Who identifies the committee? Ministry of Law and Justice. Narayan Murthy ji, please, we need Companies Act. They will form a committee. because we need law. Department of Legal Affairs and Department of Justice respectively. Okay, next Department of Justice is nothing but what? They will fight all our legal cases. Hey macha, today you go and file a case on government. Today again take Jantar Mantar. Hey, learning da. Now from that side, what is that? Cockroach Janata Party is fighting. This side, who will fight? They will fight. You have to fight. On behalf of government, who do you think will fight? There should be representatives. Those lawyers that represent the government in legal cases are called as Department of. Hello? I mean, see, there are in-depth. Now, this department will also take care of hiring of judges. So, there is a lot in these two things. Clear? Hello? Next one is SEBI people. What do they do? They come under Ministry of Finance. They take care of regulation of stock market, protection of investors and all of that in India. RBI people, don't leave like that. Read and go. What does RBI do? Responsible for regulation of Indian banking system. Again see, SEBI and RBI both come under Ministry of Finance. Important points from exam point of view. It is responsible for control, issue and maintaining supply of Indian rupee. And also they only print, no. I hope you guys know. Bharatiya Reserve Bank Note Mudran. Through that only people, they print. Two of its currency printing presses located in Nashik and Dewas. Basically, our printing of currencies happen there. RBI established the National Payments Corporation of India as one of its specialized division to regulate the payment and settlement systems in India. What is NPCI? Nothing but people, this is what paid role for your UPI. Yes, Next one is people, Deposit Insurance and Credit Guarantee Corporation. What is the Deposit Insurance and Credit Guarantee Corporation? What do they do? Tomorrow, if I have done an FD in a bank, if that particular bank fails, what will happen to my money? Remember, all the banks have to take insurance on the FDs, RDs, your savings banks you would have kept money, no? Your bank has to take insurance on it with them. With whom? With a company called Deposit Insurance Credit Guarantee Corporation. What do? They make sure your deposits are having a security. What if something happens? Who will give you money? They will come and give you money. Just for our information, as a tip I am telling you, remember, if you have more money, don't keep it in one bank. Split and keep it, because the maximum insurance that is covered is 5 lakhs. There are multiple debates going on for 10 lakhs also, but let us take 5 lakhs. So up to 5 lakhs it is covered. That means if I have kept it 15 lakhs, maximum you will get back is 5. What if I keep it in 3 different banks? That's what you need to do. Understood? So keep it 5, 5, 5. It is per bank 5 lakhs. Hello? Thank you. That's your first chapter. Any doubts? Hello? Okay. So all your textbook questions, this is only your textbook questions. Let us try to complete by the end of our marathon. We'll be covering all the textbook questions inside the class. Okay. A child accountant should be aware of the law because he has to be an expert in law. He has to advise management and clients on legal matters at a basic or threshold level. Is MCQs therefore are important? No. Only it will help us conceptually. Okay, next one. Which of the following is not a main source of law? Legal textbooks, parliament, state assemblies, constitution. Legal textbooks. So my book will become source of law now. Third one, in India, we follow the federal system of government. This means all the power is with president. Powers are distributed between. This is what we saw. Yes or no? Union list, state list, concurrent. Next one, the Constitution of India was adopted in 1950. The law concerned with violation of the rule of law and punishment of the same is called Correct? Compensation, civil. Which of the following is not an example of civil law? Breach of contract, non-delivery, traffic offences, non-payment of dues. Traffic offences. When a law is proposed in parliament, it is called. Which of the following is not a department of the Ministry of Finance? Department of Economic Affairs, Department of Expenditure, Department of States, Department of Revenue. Tell me, Department of States come where? Home Affairs. Very good. What is this? Courts get territorial limits based on the local limits within which the parties resides, the local limits within which the property and a dispute is located, either A or B, none of the above. A or B? A or B? Yes or no? You guys have done textbook questions, Ada? No? You leave it and go? Remember, try to cover the textbook questions. I'll tell you the reason also. Textbook questions will have certain topics which might not be there in the main content. It might not be there in the main content. But if it is there in the textbook questions, they can ask you a question. Are you understanding what I'm saying? Now this topic is there. It might not be there in your main content. But if it is there in the questions here, they can ask you a question in the exam. Remember, in CA Inter, there is one topic, a very deadly topic. It is there in one of the question in the behind the textbook. They have cut copy pasted the topic. Machas and machis have come back saying Namaskara. Next attempt will be Paklam. Pakka happens because if it is there behind the textbook, it is there in our syllabus. Remember, that is very, very important. Are you understanding? Answer is, people, remember, it can be A or B. What do you mean by this? Answer is C. What do you mean by A or B? The territorial jurisdiction means what, people? I am telling you, you have to go to district court. Let us imagine there is a case between me and you. Now, where are you from? Tamil Nadu, some place. Now, I am from Karnataka, some place. There is a conflict between we both. Which court we should go? Is a question. That court or this court? How will you know? So, the matter can, there are two types of powers. One is the local limits within which the party resides. Or, one more way, the local limits within which the property under dispute is located. That means, if we are fighting over a property or for some company, we will the jurisdiction will be wherever the property is located. Hello? That is the meaning of it. So it can be decided even based on where the people reside or based on property resides. That's the meaning of it. Okay. Next one, what is the significance of Supreme Court and High Court in the Indian judiciary? What do they do? Whatever we have just seen, people, Supreme Court is the highest court of the country. High Court is the highest court of the state. Whatever is the power, Supreme Court has Article 141. It was established in the year 1950. The Chief Justice of the Supreme Court, the Chief Justice of India is the highest body that can be appointed. And Article 141, whatever is passed by Supreme Court binds all the inferior courts. Next one is, you can directly go to Supreme Court on the violation of fundamental rights, Article 32 of Constitution of India. Next one is High Court, highest court of the state. It has in total 3 powers. One is original, appellate, supervisory. 226, you can go to High Court on fundamental rights, again directly to possible. Correct? That is what we had seen. Remember that and go. Next one, people, what do you understand by law? Also elaborate the procedure for making a law. What do you mean by a law? Yes, what is the process of making law? Basically, the steps we saw. A committee will be formed, a committee will frame a bill, the bill will be submitted in Lok Sabha, Rajya Sabha, President of India, official gazette, notification. Yes, sir. That's the questions of, okay, Indian regulatory framework. Nature of contracts. Okay, let us start with Indian Contract Act only, people. Let us go in the same order. The first chapter is nature of contract. So let us start with unit 1. What does unit 1 say? Unit 1, people, majorly has certain things. What is that? The first one starts with, what do you mean by a contract? What do you mean by a contract? There is a definition. What is the definition? An agreement which is enforceable by law is called as a contract. An agreement enforceable by law becomes a contract. When does an agreement become enforceable by law? When does it become enforceable? When it satisfies certain conditions. If you satisfy certain conditions, that means you are enforceable by law. What are those conditions? The conditions are two types. One is given in the Indian Contract Act. One is not given in the Indian Contract Act, but still it is important. So one is given in Indian Contract Act, you have to satisfy all those conditions. One is not given in Indian Contract Act, you have to satisfy all those conditions as well. So an agreement which satisfies all these conditions becomes enforceable by law, and hence we can call it as a contract. What do I mean by enforceable by law? That means when you guys enter into an agreement, if any of the parties does not perform that agreement, can I go to court? Will the court come to my help? Will they help? If the answer is yes, it is called as enforceable by law. If the answer is no, if courts will not help, we will call it as unenforceable by law. When will the court help? When you make sure you have satisfied all the essential elements. If you have not satisfied the essential elements, court will not come to your rescue. What are the essential elements? There are two. As I told, one is which is not given in Indian Contract Act, but it is still important. It is not given in Indian Contract Act, but still it is important. Now what do you mean by that, sir? That is only called as, first one, for a contract to exist, there should be two parties. With one person, of course, there cannot be any contract. Next one is, people, there should always be an intention to create legal obligation. What do you mean by intention to create legal obligation? Nothing but, people, remember, social agreements and domestic agreements. Social and domestic agreements, people, cannot be considered as a valid contract. Can you guys tell me any case law here? Social and domestic? Balfour versus Balfour. Any agreements entered with your close people, it can be your friends, it can be your family, we cannot consider it, people, as to be serious. Correct? That is the meaning of intention to create legal obligation. Intention to create legal obligation. Okay. The case law here is, people, Balfour versus Balfour. Now, one more thing what we will do is, I'll be telling you the case law names, but with regards to the cases discussion, I'll make one complete video of all the case laws. Towards the end, please refer that particular video where all the case laws alone are discussed. Rather than taking up the complete story now, I'll tell you which case law is where. If it is something which we need to discuss, let us discuss it inside the class also. But with regards to the complete case laws, we will take it up as one particular video. Clear? Okay. Balfour versus Balfour. Next one, people, other formalities to be complied. What do I mean by other formalities to be complied? Other formalities means when I am entering into a contract, not only Indian Contract Act, some other laws can also apply. So if some other law says something, I need to comply that law also. I need to comply Indian Contract Act as well. For example, according to Indian Contract Act, people, remember, the contracts can be oral or written. But remember, if I want to sell my land today, if I want to sell a property today, I can't sell it orally. Macha, from tomorrow the land is yours. Can I sell it that way? No. Why? There are other laws in India which says Example, Transfer of Property Act says if you want to sell a land, it should be in writing. It should be writing, it should be registered. You need to go to the registrar office. Both the parties should be present in the presence of the sub-registrar. You both have to sign the government register. Only then one person can transfer land to another. Technically, selling of land is also a contract only, no? Why can't I sell it orally? Now imagine I want to sell this mic to you. I can tell people, okay, Narayan Murthy, take it. Take it, that's all done. Oral. Because people remember, movable goods, only Indian contract will apply. Immovable goods, other laws will also apply. It is your duty to satisfy every law. Understanding, that's the meaning of other formalities also should be complied. If other laws say something, it is your duty to follow that as well. Hello? Understanding? Okay. Next one, people, it should be certain. What do I mean by certain? Certain means, people, I will tell you. For example, the best and easiest example that they always tell us, I will have a contract and I'll ask you, people, can you sell me 10 liters of oil? Is it a valid contract? Is it a valid offer? The answer is no, it is not a valid offer. Why? Because it can be any kind of oil. It can be, or I don't know, groundnut oil, I don't know, any coconut oil. If I tell you, give me 10 liters of oil, which oil are you giving it to me? That means what? If a contract should be valid, the contract has to be certain. Certain means what, people? It should not be vague. Meaning, there should not be multiple interpretations. It has to be to the point. If yes, then we call it as a proper contract. The last one, people, is it should be possible to perform. Impossible acts are not considered as contracts. The best example is black magics or magic, as the case may be. Clear? All these are not considered as a contract. There is a reason also. When the act was made, 1872. If today's date also, some or other place, if you guys still believe in black magic, I know most of you do it as well. Yeah? Hey, don't tell me. We all watch that movie. Take $1, take one, poke it, there someone is died. You will believe it or not? You know? None of you will believe it? Pakka. 100%. Huh? Agate. You see one lemon, 3 chilies in your money, that time you will change. Huh? Yeah? So, it is there. Until it comes and hits us, we'll say, hey, sir, science, sir. So you will say everything. So remember, 1872, people used to take money. People used to enter contracts. Meaning someone used to say, give me, say, 1,000 rupees. I'll make sure this thing works for you. India was run on that system. Beliefs, blind beliefs. That's why someone who saw it from external scenarios, Britishers said, please do not make it as a contract. You should also be aware of something. What is possible, what is not possible. Tomorrow don't come to court and cry. I can't help you. You be aware. And Britishers made that for us and they went. That's the background of this. Understood? Generally, students will ask, sir, why do they put this, sir, possible to perform? One is this. Second thing is, whenever there is a destruction of subject matter and all, that means what? If I tell, sir, Narayan Murthy, I will sell this mic to you. But if the mic falls, if the mic breaks, that means what? Impossible to perform. I said him that I'll give you a good mic. The mic is no longer working. Impossible to perform. The contract automatically comes to an end. Can you tell me what type of contract it will be? For example, I told Narayan Murthy, after this class, I'll give you this mic. But when we went for a break, this mic fell down and it is not working. Can you tell me what type of contract is this? Voidable? Is it a void agreement? Voidable contract? Void contract? Void contract. Why? when we entered, product is working absolutely fine. After some time, the product became impossible. It is gone. So whatever was possible, when you guys entered into an agreement, it was a good contract. But later something happened. This became impossible. That's why I call it as a void contract. Correct. Understood? Yes, sir. Okay. Next one, sir. Essential elements that is given under section 10. What is given under section 10, sir? This is basically, we will not be seeing it here. We will be seeing it throughout unit 1, 2, 3. So when it comes, we will see what is that is given under section 10. I'll just tell you the topics here. One is offer and acceptance, free consent, capacity of parties, consideration, lawful object, not expressly declared, void. So we'll be seeing this until unit 3. Clear? Yes? Okay, done. Next one, sir, types of contracts. Types of contracts, the first one is people based on validity or enforceability. The types of contracts can be classified into, first one is 5 types. That is only called as valid contracts. What do I mean by valid contracts? An agreement which satisfies all the essential elements, we call it as a valid contract. Next one is called as void contract. What do I mean by void contract? A contract which ceases to be enforceable by law is called as a void contract. Generally, students will have doubts in this. One is called as illegal contract. One is illegal. Okay. Next one is void agreement. Next one is void contract. Next one is voidable contract. These are the questions that students will have. Okay, first illegal will come back. What do I mean by void agreement? Simple. An agreement which does not satisfy the essential element is called as a void agreement. Meaning two people are entering into a contract. This fellow's age is 21. This fellow's age is 17. What is the essential element of a valid contract? Both of them, capacity of the parties, competency. This person is a minor. Any essential element not satisfied, we will call it as a void agreement. Example number 1. Is this clear? Simple. Like this, you can give all this as void agreements. Example, sir. Let us imagine if at all 2 parties are entering into an agreement. What is the purpose of the agreement? Let us imagine it's a gamble. Betting, wager. Wagering is void agreements, specifically degrade void. And what else? A lot of things can come, people. Agreement in restraint of trade. Someone telling, A tells B, as long as whenever you leave my company and go, for the next 20 years, you are not supposed to start a similar business. Void agreement. Remember, people, whichever does not satisfy the essential elements, people, we consider such agreements as void. Meaning what, people? If an agreement does not satisfy essential elements, we consider such agreements as void. For example, an agreement to sell 10 liters of oil, what will you consider it as? Vague. It's not certain. Essential element says what? An offer. The contract has to be certain. Here you say 10 liters of oil. Which oil? Not given. And hence it becomes a void agreement. So any essential element not satisfied, it's a void agreement. Clear? Simple? Yes. Next one. Void contract. What do I mean by void contract? Void contract means, people, nothing but when you entered into a contract, it was valid. But later it becomes invalid. So I said, Narayan Murthy, I will sell this mic to you. Mic is working, everything good. We both entered into offer and acceptance. Narayan Murthy said, sir, I'll pay you so and so amount of money. Now, when we entered into an agreement, the mic is working. I said, Narayan Murthy, I'll give you this mic after the class. Now, people, in the break, the mic falls down. What happened? When we entered, the mic was fine. Everything was fine. It was a valid agreement. But later something happened, people. Now the mic is broken, impossible to perform, the mic is not working. So an agreement, a contract which was valid when you guys made, but it is invalid in the later point of time, we call such agreements as people void contracts. Example number 2, A entered into a contract with B to sell some painting. A said, I will sell you my painting, I will paint and I'll give it to you. But after 5 days, A passed away. So when we entered, everything was fair, everything was fine, but later what happened? Later A passed away. Now, can anyone make the similar painting? Answer is no. Now, what do I consider to this contract? This contract, when you made it was valid, later it became invalid. We call such contracts as void contracts. Understood? Now, what do I mean by illegal agreements? Illegal agreements is nothing but people, if you are doing any contracts which is punishable, unlawful or forbidden by law, if you are doing them, we consider such things as illegal. Example people is murder, drug dealing, anything. Illegal only, right? Punishable under the law. So that can be considered as illegal. And the last one is people voidable. What do I mean by voidable? A contract which may be valid or invalid at the option of one party. One person tells, one person decides whether it should be valid or invalid. And such type of agreement, such type of contracts, we call it as voidable. It can be valid or it can be invalid. We consider such type of agreements or contracts as voidable. Example is people, any agreement entered with no free consent. Let us imagine A forced B to sign a contract. A said, if you do not sign, I am going to kill you. I threatened with a gunpoint and I said, if you don't sign, I'll kill you. And B signed. Now, let us imagine for the world, how will they know by looking at the paper that A forced B, that's why B signed. How will people know? By looking at the paper. So for the entire world, it's a valid contract only. Yes or no? But remember, the law has given B a chance. B, if you have courage, come to court, tell the entire scenario. Sir, this happened. The court will come for your rescue. What will the court do? The court will call this particular A and say, what you did is unfair. We will take the papers, we will tear it. So whatever was valid, we will tear it and hence it will become invalid. But for this, B, you should have courage. That's why we call this as voidable. Why? Because if B does not go to court, that invalid will not come. It will remain valid in the eyes of people. If you go to court is when it becomes invalid. If B doesn't go to court, it is always valid. So a contract which is dancing between invalid, valid, invalid, valid at the option of B. Only B can decide, not A. At the option of one party, we call such contracts as voidable. So if B goes to court, we will tear. Contract becomes invalid. If B doesn't go to court, the contract remains valid on the documents. Is called as voidable. Any doubts? Macha? Pakka? Now, another thing I'm going to tell you why students fail. You guys write this in your own language. What do you mean by that? For example, if I ask any student what is voidable, all of you say a contract which can be valid or invalid is called voidable. What you said is right, but what you said is not as per the definition. What are you expected to write? You are expected to write an agreement which is enforceable by law at the option of one of the parties, but not the option of the others. That means what? Both the parties can't decide. Only one party can decide whether it is going to be valid or invalid. This is the biggest reason why students are losing marks in law. You are writing in your own words. Sir, but what we wrote is correct only. No. Remember, if it is defined in another way, for our ease of understanding, we are understanding as a contract which can be valid or invalid is considered as voidable. But the meaning is that, but the intention is not that. No, here they are telling you, it depends upon B. If B goes to court, now that and all you didn't write at all. But that is what is defined. I hope you are understanding. Yes or no? See, the ultimate meaning is same, but the way you are telling is different. So should we copy paste every word? Not needed. But you need to remember the key words, main words. The main words here is agreement, which is enforceable by law at the option of one party. Enforceable underline, option of one party underline, you will get 5 on 5. Who cares what you wrote before or after? Understood? Clear? Yes? Okay. And one more tip. Tip number, I don't know how many. Remember, if at all they are asking you a direct question, make sure to write an example. Meaning, if they are asking you, please write voidable contract, please write voidable contract along with an example. Direct question alone. Hello? Remember. Okay. And one more tip, match the following. Match the following. What is the difference between? When they ask you the difference between void agreement and void contracts, people, remember, if it is for 3 marks, please don't write 3 points. In your book, if there are 7 points, you are expected to write 7 points also. Because when they give you guideline answers, in the guideline answer, they will not write 3, they will write 7. Guideline means what? Someone is telling you how to write. So in guideline, if it is written as 7, you should write 7 points. You don't have a choice. One more, a misinterpretation that students have. What is that? A notion that, okay, 3 marks, 1 line, 1 mark. That's why I wrote this, that means 6 points I have written. Hello? Clear? If you know, please write more. In difference, whatever you know, you are supposed to write. Clear? Irrespective of the marks being allotted. Understanding? Again, one more reason why students get lesser marks and difference between. Okay. We did valid, void, voidable, illegal. What is unenforceable? Any contracts which are not enforceable because of technical mistakes like name mistakes or change stamp papers, there is defects. Because of that, if it is not enforceable, that is called as unenforceable contracts. Next one, people, based on formation, the contract can be classified into express contracts, implied contract. Express means what, people? Whether by words, spoken or written. If at all we have agreed everything, that is called as express. Implied means, people, sir, we have not spoken anything. It is based upon the conduct of the parties, sir. If at all it is, we are entering into an agreement, that is only called as what, people? Implied contract. Implied means what, people? Whichever, when a contract comes into existence, depending upon the conduct of the parties, that is called as implied contract. The best example I can give you is, people, bus stop. When a bus comes and stands in front of you, there is nowhere it is written. They just come and stop. It's an offer that they are making. I am going towards this direction. Are you interested to come? If yes, come. I will drop you in your preferred location. When you get into the bus, it is an implied acceptance that if you go in a bus, you are supposed to pay for it. Whether they ask or not, you are supposed to pay. So it's an implied offer, implied acceptance. Contract came into picture because of conduct. Remember, there is a third type of contract called as, people, tacit contracts. Tacit means what, people? Silent contracts. There will be no even speaking also. Example I can give you is, people, you going and withdrawing money from ATM machine. There is no other party also that side. But is it a contract? Answer is yes. Tacit. Tacit means, people, silent contracts. You withdrawing the money from ATM is a tacit contract. You go to a shopping mall. You order Pepsi can, in that vending machine, there will be a QR code. You just scan, you get your Coke. It's a contract. What type of contract? There are no two parties also there. It comes under tacit contracts. You go to a railway station, you go to a bus stand, you check your weight by dropping a coin. It shows your weight. There is no third party there. What type of contract? That is called as what? Tacit contract. Examples of tacit contracts. I hope it is clear. Next one is quasi. We will do it in your chapter only. E-contracts. What are e-contracts? The contracts which are entered into in the electronic form. It's called as e-contracts. Correct? E-contracts are also called as EDI contracts, also called as cyber contracts, mouse click contracts. Very, very important. Different names. Remember and go. In exam, they can also ask you, what do you mean by mouse click contract? Possible. Don't see left and right. When a contract is entered by two or more parties using a electronic means, such as emails or e-commerce. In electronic commerce, different parties or persons create networks which are linked to other networks through EDI. EDI stands for electronic data interchange. This helps in doing business transactions using electronic mode. Remember and go. Exam point of view, they may ask you. Okay. Next one is based on performance. The contracts can be of two types. One is called as executed, executory. Executed, done and dusted. For example, I take, imagine I would have ordered something on Amazon. They delivered, I paid, done. Next one is called as executory. I order something on Amazon. I have paid online payment, but they are yet to deliver the product. Such type of contracts is called unilateral executory contract. I have paid. Amazon is yet to deliver. That is why unilateral. Let us imagine I enter into a contract with Amazon, cash on delivery. Today we entered into a contract, but even I have not paid. Neither the Amazon has delivered. Both of us are going to do it in future. That's why we call this as bilateral. Both the parties are yet to do something. That's why remember people, bilateral can also be called as people what? These can be also called as future contracts. One more topic that comes in the future, also called as reciprocal promises. Same concept. What is me and Amazon doing today? I am promising Amazon I will pay in the future. What is Amazon promising? I will deliver in the future. Reciprocal promises only, no? I hope it is clear. Remember, reciprocal promises is also an example for bilateral contracts. Clear? Yes, sir. Okay. Next one is people classification of offer. Offer can be classified into express implied, which you have already seen. General offer. What do I mean by general offer? Offer given into public at large. Example, Carlyle versus Carbolic Smoke Ball Company. Remember, for a contract to be valid, always there should be offer, there has to be acceptance. Exception, general offers. General offers will not have acceptance. General offer, if you just follow whatever is the prescription or whatever is the conditions that they have given, if you follow that, that itself is considered as a acceptance. For example, Carlyle versus Carbolic Smoke Ball Company, it was a general offer. Whoever takes the tablet and still get the disease, you will be getting a reward of 100 euros. That was the offer. Now, Carlyle did not call the company and said, I have purchased a tablet today. From today, it is a contract between you and me. She did not tell. She purchased the tablets. She started taking it as per the prescription. That itself will be considered as an acceptance. She need not again call and tell, or she need not call and inform. So in general offer, remember, following the process or procedure prescribed, that itself is considered as a acceptance. You need not have to again call and tell. Very, very important. But whereas in a normal scenario, if there is an offer, you need to give an acceptance. General offer not required. You just follow it. You need not have to give an acceptance. Remember that. Clear? Yes, okay. Next one is called as people specific offer. What do I mean by specific offer? Whenever an offer is made to a specific person, it is called as a specific offer. Group of people, general offer. Specific is called as specific offer. Whenever an offer is made to a specific person, even the acceptance also should be given by the same person, not by anyone else. Remember that. Here there is a case law also. What is that? Specific offer, specific acceptance. What is the case law? Boulton versus Jones. Remember, whenever a specific offer is made, acceptance also should be given by the same person. So if I give an offer to Narayan Murthy, this mic is for you. So another person from the class cannot come and say, sir, yes, we will buy it. When I have given it to you, you should only accept it and no one else. Clear? Next one is people counter offer. What is counter offer? Counter offer is nothing but people. A qualified acceptance can be considered as a counter offer. That means what people? I say Narayan Murthy, this mic is for you for 100 rupees. Offer. Counter offer. Sir, if you give it for me for 80, I will buy. Counter offer. Now when I said Narayan Murthy, do you want to buy this mic for 100 rupees? Narayan Murthy should give an acceptance. He should say yes or no. Yes or no? Now he said, sir, if you are selling it for 80, I will buy. Now I should give an acceptance. Yes or no? That's why counter offer always replaces the initial offer. I repeat, counter offer always replaces the initial offer. Remember. Okay. Last one, sir. Standing or a continuing offer. An offer which is kept open for a certain period of time is called as what, people? Standing offer. That means I can tell Narayan Murthy, I'll give you 10 days time. In 10 days, if you want this mic, you come and tell me. Hello? Now, people, my question, on the 5th day, I got a better deal from someone. Can I take off that particular deal on the 5th day? I told Narayan Murthy the offer will be open for 10 days. But 5th day, I got a better deal. Can I accept that offer? Remember, people, standing offer, Narayan Murthy has still not said yes. Even though I told him I'll keep it open for 10 days, I've said correct. But has Narayan Murthy accepted it? He has accepted it? No. Remember, I can always withdraw my offer. So if I get a better offer on the 5th day, I can accept that and I can inform Narayan Murthy, I'm sorry, that offer is closed. I can always tell. Because remember, in a contract, when does it create a, legal relationship? When it is accepted, it is not yet accepted, I can do anything I want. Exam question, remember. Hello? Understanding? Very, very important. They can test you, they can ask you the question there. Next ones are communication of acceptance can be done by. You can do it by words, conduct, that is express or implied. Next one, even by omission also. So it can be done by any ways. Acceptance can be done by any ways. And let us do of what is that? Rules of offer and acceptance. Takatak will do of that also. Essentials of a valid offer. What and all are the essentials of a valid offer? It must be capable of creating legal relationship. Balfour versus Balfour. It must be certain, definite, and not vague. 10 liters of oil. It must be communicated to the offeree. Lalman Shukla versus Gauri Dutt. What do I mean by that? If at all you need to enjoy the offer, that means I have to first communicate the offer to you. So if someone has to say yes, you should be aware of the offer. If you don't know offer only, how can you give acceptance? So always remember, if the offer or acceptance is to be valid, offer also should be communicated. Acceptance also should be communicated. Very, very important. Remember and go. Lalman Shukla versus Gauri Dutt. It must be made with a view to obtaining the assent of the other party. Meaning, people, I should give you a free will to say yes or a no. I should not say, hey, if you don't reply, it is yes only. If you don't reply within 10 days, it's an yes only. If I don't hear back from you, it's an yes only. Such things are not considered as an offer. You have to give a free will to say yes or a no. You can't say if you remain silent, it is yes only. All these are not considered as valid offers. Hello? Yes or no? Next one, it may be conditional. Offer can be conditional. That means I can say if you want to be eligible for this offer, if you want free delivery, the cart value should be 500. It's a conditional offer. Allowed. If condition is not met, you are disqualified to participate in the offer. Next one, people, offer should not remain a term that non-compliance of which would amount to acceptance. Whatever I told you, you should never say if you don't reply, that means I will consider it as a acceptance. Such things are not considered as a valid offer. Offer is different from what? Mere statement of intention, invitation to offer, a mere communication of information, a prospectus. All four scenarios important. What do you mean by this? A mere statement of intention. Offer is different, a mere intention is different. What do I mean by mere intention? Mere intention is, the best example is given there. What? A father tells his son, I would want to make you the next owner for all the companies or the properties I run. This is just an intention. You should not consider this as an offer. Now, for example, say some employee is working with me. I will tell him, if you continue to work like this, probably someday I will make you the next CEO of the company. It is just my mere intention. You should not consider it as an offer. Intention is someone expressing their thoughts. It is not to be considered as serious. That is what they are trying to tell you. The next one is people, an invitation to offer. Easiest, nothing but people. If for example, you go to a shopping complex, people, everything is glass doors. They would have kept something in the display. They will tell you this particular article is for sale. Looking at that, you will go inside, you will look at more articles. So whatever is the article kept on a display, remember that is considered not as an offer, it is considered as invitation to an offer. Yes, recent scenario I will tell you. I went to Max showroom. Yeah, there was a shirt. The price of this shirt was 1,500, and they have put a tag which is punched to that only. The price has been now put as 999. So I went. We were standing in the queue also. I think the sale is still going on. This was last like 3-4 days back. So I went and I gave it in the counter. My turn came. She scanned. The price in the MRP is coming as 1599 only. Whatever is the original number. It is not showing us 999 in the system. I said, see, the tag is there in the button. It is put in that offer column. It is saying it as 999. And you guys are scanning, your system says 1599. How is it fair? She said, I'm so sorry, sir, I cannot give it to you. I said, no, you have to give it to me. I'm saying real life since this happened 3 days back. Now you tell me, what should I do? Can I fight? Why? I can fight? I can fight or not? For students who know me, you tell me, I would have fought or not? I would have fought or not? Yes or no? I didn't fight, I didn't tell a single word. I remembered this concept, I came back. Remember people, I only know it is invitation to an offer. When I have only told you, because remember, in a shopping people, offer is made by us. When I go and I stand in the queue, I say I want to buy this shirt. I'm saying I want to buy it at 999 because that is what is put here. They say, sir, some technical mistakes. We are so sorry. We cannot give it at 999. It can be a mistake from their end, yes. But do they have an option to say no? Answer is yes. They have an option to say no. They have an option to say no. Is it possible? Yes. Because remember, when they put the 999 tag, what they did is an invitation to an offer. They called me to the shop. I went. I took it. I stood in the queue. I gave it to the cashier. I made an offer. I want to buy this shirt for 999. Acceptance has to be given by them. Remember, they can say no. I can't force. Hello? Understood? Yes, sir. This is as per Indian Contract Act. Remember. Clear? Yes. Next one, sir. A mere communication of information. What is the case law? Bumper hall pen. Which case, sir? Bumper hall pen. Harvey versus Davidson. Harvey versus Pacey. Remember, bumper hall pen case. What is that? I wrote a letter saying that, will you sell me your property? Question number 1. Second one, what is the price at which this property is valued? The person responded 900 pounds. So he said 900. I thought it is an offer only. So remember, people, you should never consider someone quoting the price as an acceptance. Sir, give us easy example. Satyanarayan Murthy asks me, sir, how much is mic, sir? At what price, sir, you will sell this mic for if you are selling? I will say, if I am selling, and I will sell it for 2000 rupees. Satyanarayan Murthy says, sir, then I want this mic. I said, I never agreed. No, sir, you said no, sir, 2000. Yeah, I said if I am selling, I will sell it for 2000. I didn't say I will sell it to you. So, a mere communication of information, a mere quotation of a price should not be considered as an offer or an acceptance. That is what the Harvey versus Pacey teaches us. Understood? Hello? That is only nothing but your bumper hall pen case. Clear? Hello? Understanding it? Okay, last one is people, prospectus. What is prospectus? Anything given, people, when a company is coming for an IPO, whatever you are coming up with a document which explains about the company, that is called as prospectus. Remember, in the prospectus, you are not supposed to keep any information silent. You have to disclose everything. Just for your information, I am telling you, the generic size of prospectus will be 300 to 400 pages minimum. So you imagine how much of information the company is disclosing to the public before they come for a IPO. Like 5 days back, SBI funds IPO came. 5 days back. The prospectus size is what? 430 pages. You have to disclose everything. Everything means everything about the company. If you don't disclose anything, tomorrow someone can come and question you and they can make you liable. Under the ground, sir, the offer was incomplete. They did not disclose everything. Hello? Are you understanding? Sir, now I saw one newspaper advertisement. SBI funds. They said we are coming for an IPO. Please apply. I applied. People like me, everyone applied. The SBI IPO was oversubscribed by 40 times. That means what? I have one share, 40 people want. They gave newspaper advertisement and all. People, please invest. Now I invested. I did not get the share only. Now I want to file a case on them. Hey, you told me newspaper. You gave an offer. I was simply minding my business. You said apply. I applied. You should give me no share. Then why did you not give me? Can I file a case on them? Can I file a case on this SBI company now? Yes or no? Yes or no? Why? Remember, when the newspaper advertisement comes, it is an invitation to an offer. When I apply, that is the offer. SBI has an option to say whether to give, not to give. Absolutely fine. Understood? Yes, sir. That is what is called as prospectus. That is why even this is also coming under invitation to an offer. All four scenarios, exam point of view, important. Remember and go. Clear? A statement of intention, whatever we just saw, everything. Okay. Okay. Last one, sir. Offer may be either specific or general. The offer may be express or implied. Next one, sir. Acceptance. The rules of acceptance is what, people? One is acceptance can be given only by the person to whom the offer is made. I already told you, Bolton versus Jones. What type of acceptance will that be? Acceptance can be given only by the person to whom the offer is made. What type of offer? Specific offer. Next one is acceptance must be absolute and unqualified. That means what? I asked Satyanarayan Murthy, you want to buy this for 1000. He said, sir, I'll buy it for 800. That means it is qualified. Remember, qualified acceptance and counter offer are one and the same. I repeat, qualified acceptance and counter offer are one and the same. When you get an offer, you have to say yes without any terms and conditions attached. If you add any terms and conditions, people, it becomes a counter offer or a qualified acceptance. Understood, all of you? Okay, remember that. Okay, next one. The acceptance must be communicated. I told you, offer must be communicated. Acceptance also must be communicated. Brockton versus Metropolitan Railway Company. Next one is acceptance must be in the prescribed mode. For example, I told a person to accept. Now, say for example, I have told, if you are okay with the offer, please reply to me on an email. But let us imagine you sent me a WhatsApp message. Is it considered as a valid acceptance or not? Remember, I have clearly told you to write it on an email. You have to write it on an email. Okay, you did not write it on an email. You sent it on a WhatsApp. What is my responsibility? My responsibility is to reply you saying, because the acceptance was not in prescribed mode and hence I reject your acceptance. If I do not communicate this to you, it will be considered as a deemed acceptance because you have to tell. If you don't tell, then it is considered as an acceptance. The question can come in the second part. That is what is this deeper understanding. Understood? They can question you here. Clear? I hope you understood the scenario. Yes or no? Okay. Time. Acceptance has to be in the prescribed time. If I tell you within 3 days you have to tell it within 3 days. If not, it becomes lapse of time. Next one, it can also be mere silence is not a acceptance. Maunam sammati lakshanam cannot happen. Acceptance by conduct or implied. I told you offer can be express or implied. Acceptance can also be express or implied. You standing or you getting into a bus is a implied acceptance. Next one, communication of offer and acceptance. The important parts are, when does the offer and communication, when does it come to an end, people? When does offer and acceptance come to an end? When this is very important. Remember, when does the acceptance, when does it come to an end? Let us imagine, people, Mr. A sends an offer to Mr. B. A sends an offer on 10th August. It reaches B on 12th August. B responds to it on 13th August. B responds to it on 13th August and B reads it on 13th August. He sends it on 14th August. It reaches A on 15th August. I hope you are understanding. I wrote an offer on 10th. B read it on 12th. B read it on 13th. B responded on 14th. And A received that acceptance on 15th. Now the question is, sir, if A wants to withdraw the offer, When should he withdraw? What is the time that A has? By when should A withdraw? Is it by 12th? Is it by 13th? Is it by 14th? Is it by 15th? By when should A withdraw his offer? For example, A wants to sell his car for 5 lakh rupees. Yes? Now imagine I wrote a letter. I have a car. Mr. B, do you want to buy it? I want to sell my car for 5 lakhs. Now my question to you, let us imagine C gave a better offer to A. I will pay 7 lakhs to you. Why would A still want to sell it to B for 5 lakhs? Now A would want to take it 7 lakhs. He want to go with C's offer. But the question is, can A withdraw his offer? Is it possible? If yes, by when? What is the date? Is it 12th, 13th or 14th or 15th? Before 14th? Before 14th 5 p.m. What does the law say, people? For this you need to understand when is the acceptance complete for the proposer. So A here is the proposer. When is the acceptance complete? When acceptance is put in the course of transmission. That means what? Put in the course of transmission means, people, remember, I can withdraw my offer. Even after B read the offer, I still have time. I can withdraw it. Hello? B has not yet responded. I can withdraw it. B wrote a letter but still not posted. I can withdraw it. B wrote, yes, I want your car. He puts it in the post dabba. That's all. You can't withdraw the offer. A loses his right to withdraw the offer. That is the meaning of the acceptance is complete for the proposer when the acceptance is put in the course of transmission. That means the moment the particular letter is posted, not reached, posted, A cannot withdraw the offer. Understood? The moment you put it in the post dabba, you cannot withdraw the offer. Now bringing it back to the scenario, sir, B receives it on 12th. Can I respond? Can I take back on 12th? Yes. He reads it on 13th. Can I take back? Yes. On 14th, 5 p.m. I have responded. That means he has put it in the post dabba. Until 4:59 you have time to take back your offer. Meaning send a speed post. Say, I got a better offer. I want to cancel this. If it reaches before 14th 5 p.m. if that reaches, the offer gets cancelled. If that not reaches, then you are fed the macha, you can't do anything. You have to give it to B. Let us imagine A gave the rejection, but B did not read it. Then people, acceptance will be valid. Because B has to read the rejection also. The rejection will come to light only when B reads it. If B does not read it, of course it is not valid. Understood? Yes, sir. But in your exam, they will not complicate all of that. They will tell it reads the first, B read it only, they will give it to you. So what you will choose that only. Understood? Sir, now let us imagine D gives a better offer to B. Hey macha, you are buying A's car for 5 lakh. I have same card. I will give it to you for 4 lakh only. No, people, B has written the letter 14th August. I have posted off. Now B wants to withdraw his acceptance. Can he withdraw? Can B withdraw? What does the law says here? For acceptor, when is acceptance complete? When it comes to the knowledge of proposer. When will it come to your knowledge, people? See, it reaches A on 15th. Correct? That is what the website. It reaches A on 15th. Let us imagine A reads it on 16th. A receives it on 15th. He reads it on 16th. So A is getting to know about the acceptance on 16th. That means, people, if B wishes to withdraw his acceptance, B can do it by 15th, 16th also until you read it. Once you read the acceptance, people, B also loses the right of withdrawing the acceptance. Understood? Hello all of you. So you send a speed post. Now you guys can have a question, sir, what if both of it reaches at the same time? If both of it reaches at the same time, you have to write it, whichever is read first will be considered as valid. So if I read acceptance first, it is valid. If I read rejection first, that is valid. Exam point of view, important, remember and go. Clear? And with regards to special terms and conditions, if there is anything, will it be considered? Let us imagine on the back of the ticket, whenever you buy, there are some special terms and conditions mentioned, which is not specifically discussed. You did not read it also. Is it binding on you? The special terms and conditions? Is it binding on you or not? Remember people, as long as the terms and conditions are reasonable, they are binding on you. So special conditions are always binding on you as long as they are reasonable. If it is unreasonable people, it will not be binding on you. Case law, Lily White versus Manuswamy. Case law, Lily White versus Manuswamy. Remember. So special conditions will be binding on you as long as they are reasonable. Clear? Yes, sir. Sir, what if the contract is happening over a telephone? When will the contract come to an end? Remember, offer and acceptance both has to be properly heard. If there is any disturbance, it is your duty to repeat it, and only after the person understands it, the offer will come to a conclusion. Understood? Hello? Break 1 second. Unit at least will finish. Yarda ni. Now is here. The last one, revocation of offer and acceptance. The modes of revocation of offer and acceptance. How and all we can revoke the offer? The revocation of offer can acceptance can happen in all these ways. What are the ways? First one is by notice of revocation. You clearly tell that you want to withdraw your offer or acceptance by intimating other party, but it has to be done before the person has accepted the offer. Next one is by lapse of time. If at all the offer or acceptance is not done within time, the offer will automatically comes to an end. By non-fulfillment of condition precedent, I told you, for if you want to get a free delivery, you need to have a cart value of 400 rupees. If that 400 rupees is not satisfied, then you will not get the offer. So, by non-fulfillment of condition precedent means whatever you guys have to satisfy to be eligible for the offer. If you do not satisfy that only, offer automatically comes to an end. By death or insanity, I make an offer, the person dies, offer comes to an end. Counter offer, I always tell you, when a counter offer is made, the initial offer came to an end. Next one, non-acceptance in the prescribed mode, I told you, you have to reply in an email, you replied on a WhatsApp, but I have to communicate that to you. You have replied on a WhatsApp, hence it is invalid. Next one is people, subsequent illegality, nothing but void contract. When we entered into a contract, it was valid, but later on it became invalid. We call it as subsequent illegality. For example, until 2017, there was no law between us and North Korea. After 2017, there is change in law. Today, we cannot enter into any contracts with people in North Korea. Pakistan, though you know. Now, before 2017, we were doing contracts with North Korea. Some more other thing. But today, can we? We cannot do. Why? Law changed. Then what about the contracts which were going on? You don't have any other choice. Contract has to come to an end. That is the meaning of subsequent illegality. Understood? All of you. Pakka? That is another way where an offer or acceptance may come to a end. Clear? So that's your unit 1. Okay. Again, the textbook questions of unit 1. Nature of contracts. An agreement enforceable by law is called as contract. A void agreement is one which is valid but not enforceable. Enforceable at the option of both the parties, enforceable at the option of the party, not enforceable in a court of law. Correct? A void agreement, no, they're asking. Hello? An agreement which is enforceable by law at the option of one or more of the parties but not at the option of others is called voidable. When the consent of a party is not free, the contract is, when the consent of the party is not free, the contract is voidable. We saw, no, that shoot a gun now. In case of illegal agreements, the collateral agreements are, in the case of illegal agreements, the collateral agreements are void. What do you mean by collateral agreements? Any agreements connected to the illegal agreements, meaning any agreement connected to the main agreement will be considered as void. What do you mean by that? For example, A and B, they entered into a contract to kidnap C. It's an illegal agreement. Kidnap, how do you want to kidnap? They went and they hired a vehicle with D. Correct? See, one is kidnap. There is one more agreement which is rental of a vehicle. There are two agreements, no, here. I hope you are understanding. So, the renting of a vehicle is connected with the kidnap, illegal. So, what will happen to the renting of a vehicle? Is it valid or is it invalid? It is whether D knows or not is the question. In the first unit, directly they write it is invalid. But in the fourth unit, basically the third unit, they write it as if if D is aware why they are using the car for and still he gives it on rent, then it is considered as invalid. So if D can prove I did not know, I just gave it on rent, if he can prove that I never know why they are using it for, then the agreement will be valid only. I can recover the rental charges, whatever it is. Yes or no? Remember. Okay, an offer may lapse by what and all? An offer may lapse by revocation, counter, or reject, all of the above, correct. A proposal when accepted becomes a promise. If A says to B, I offer to sell my house to you for 40 lakh and B accepts the offer by saying clearly, I accept your offer, it is a express offer, implied offer, general offer, none of the offer. Express offer. Actually, it should be a okay, it should be express contract, but they did not tell us from whose point of view. Okay. A offered a reward of 1 lakh for recovery of some valuable missing articles. B, who did not know of this offer, found the missing articles. Which of the following is correct solution to this problem? B is not entitled. C, as there is no acceptance of an offer due to want of knowledge, B is not entitled to get the reward. What is the case? Lalman Shukla versus Gauri Dutt. You should be aware of the offer. No. If you are not aware, basically offer must be communicated. That's the provision. Remember. Next one. Arun has 2 cars, one of white color and another of red color. He offers to sell one of the cars to Basu thinking that he is selling the car which has white color. Basu agrees to buy the car thinking that Arun is selling the car which has red color. Will this agreement become a valid contract? Of course no. Why? It is consensus ad idem, meeting of the minds. Whatever is there in mind should be same. Our minds have to meet. That is first one. That is also right. Second interpretation is, even if you write the offer is not specific and vague, that is also right. Clear? I told you, I'll tell you eventually how to even pick up the topic. No confusion can be there. Yes?
If a particular question have three, four provision can be applicable, which one?
See, 3-4 is we need to see whether 3-4 is actually applicable. If 3-4 is applicable, you are expected to write 3-4. But if, let us imagine 4, it is like, sir, this also may apply, this also may apply. If that is a scenario, you need to see which scenario suits the most. You need to write as per that. But if you think all 4 applies, you have to write all 4. Yeah? Okay. A dress is displayed in the showroom with a price tag, ababa, $9.99. A buyer interested in the dress and ready to pay. Macha, did they copy or did I copy? I swear I didn't see this. Ready to pay the price mentioned in the tag, approach the shopkeeper for purchasing the dress. The shopkeeper can refuse to sell the dress as display of dress is just an invitation to an offer. Sandanna, easy. Okay. A agrees to pay 1,000 to B if a certain ship returns within a year. However, the ship sinks within a year. For now, let us leave it. We'll do it later. A notice in the newspaper inviting tender is an invitation to an offer only, no? Invitation to a proposal. A telephonic acceptance is complete when the offer is what done? Heard and understood by the offerer, no? Received, heard, understood by some person. Some person, how it will be acceptance? Okay. A and B agree to deal in smuggled goods and share the profits. A refuses to give B share of profit in the case. What is the most apt scenario? B has no remedy as it is an illegal contract, no da? Smuggling da? No. You don't have this one, no? Which one of the following statement is correct? Void agreements are always illegal. Illegal agreements are voidable. Illegal agreement can be ratified by the parties. Illegal agreements are always void. Illegal agreements are always void. All illegal agreements are void. All void agreements are not illegal. All agreements are contracts. All contracts are not agreements. A voidable contract is a one which is A only, no? Who at the option of aggrieved party. Aggrieved means the person who has suffered. When offer is made to a definite person, it is known as specific offer. On the face of a ticket, it is mentioned that to look for the terms and conditions, he looked behind. Mr. A bought the ticket but didn't read the terms. Then he is not bound, may decide to be bound, he is bound. He is bound, no, whether you read it or not. Special terms and conditions. Case law, Lily White versus Manuswamy. It does not affect the free consent of the parties. It does not affect the free consent of the parties. What does not affect? Fraud, coercion, incompetency of parties, undue influence. Nothing but pick the odd man out. Free, oh my God. Okay. 21. Contract is made without intention of, dash contract is made without intention of parties. Which contract? Quasi contracts. A offers to B to supply books at 500 each. B accepts the same with condition of 30% discount. It is considered as counter offer or cross offer ante. Counter qualified acceptance. Remember, both are same. Correct? Hello? Okay, all contracts are agreements, but all agreements are not contracts. We just saw, because for an agreement to become a contract, all essential elements to be satisfied. But if an agreement which does not satisfy all the essential elements, it cannot become a contract. So social agreement is an example. Domestic agreement is an example. Void agreement is an example, which is not a contract. A sends an offer to B to sell his second-hand car for 1,40,000 with a condition that if B does not reply within a week, he shall treat the offer as accepted. Is A correct in his proposition? Remember, an offer cannot be something which non-compliance of which is considered as a acceptance. 1. Silence is considered as an acceptance. Such things cannot be considered as a valid offer. Explain the type of contract in the following agreements under the Indian Contract Act. A coolie in uniform picks up the luggage of A to be carried out to the railway station without being asked by A, and A allows him to do. It is an implied offer, implied acceptance. Obligation of finder of lost goods to return them to the true owner. Quasi contracts. If I lose something, if someone finds it, they have to give it back to me. That is called quasi. We will be seeing it in the unit. A contracts with B, owner of the factory, for supply of 10 tons of sugar. But before the supply is effected, the fire caught in the factory and everything was destroyed. What type of contract? Void contract. When you guys made, it was valid. Later on, it became impossible. Best example, here it was Mike, there it is factory. Same only, no? Hello? Subsequent impossibility. Hello? Okay. Next one. Shambhu Dayal started self-service system in his shop. Srimati Prakash entered the shop, took a basket, and after taking articles of her choice into the basket, reached the cashier for payment. The cashier refused to accept the price. Can Shambhu Dayal be compelled to sell the said articles to Srimati Prakash? Decide as per the provision of Indian Contract Act. Remember, whatever the goods are displayed in the shop is always an invitation to an offer. When Srimati Prakash picks up whatever she wants, she goes to the cashier, she is making an offer. She cannot compel Shambhu Dayal to sell a particular product at any particular price. Because Shambhu Dayal has a free will to make an acceptance. So, in our given case, Srimati Prakash cannot compel Shambhu Dayal, as the display of products in the shop is just a invitation to an offer and not an offer. That should be your answer. How to present it, I'll tell you probably when we come back after the break. I'll tell you, let us write one and we'll see. Next one, state whether there is any contract in the following cases. A engages B to do certain work and remuneration to be paid as fixed by C. Is there a contract? Yes, possible. You see it in Sale of Goods Act also, no? Remuneration can be fixed by a third party. A and B promise to pay for the studies of their maid's son. Social or a domestic agreement, or it can also be intention. A takes a seat in the public bus. Is it a valid contract? Yes. How? Implied contract. A chartered accountant, promises to help his friend to file his return. Social or domestic agreement, one. Or it can also be intention to create legal relationship is absent. Did you guys see? I tell my friend I'll help you. If I don't help, you'll come and file a case on me or what? Then that's what they're telling. Someone had one question, correct? Huh? You have to create intention. You have to show that we were serious. That is what is missing here. Clear? Miss Shakuntala puts an application to be a teacher in the school. She was appointed by the trust of the school. Her friend who works in the same school informs her about her appointment informally. But later, due to some internal reasons, her appointment was cancelled. Can Miss Shakuntala claim for damages? Why? First thing, acceptance should be complete when the acceptance is put in the course of transmission. Here they have not replied at all. Correct? Point one. Second one, acceptance should always be given by the concerned person. It cannot be given by someone else. So in the given case, it was not given by the concerned person. It was given by someone else. So in both the scenarios, you did not get it by a concerned or a designated person. It is an informal acceptance. Only formal acceptance is considered as a valid acceptance. Hence, this is not a valid acceptance. In our case, Shakuntala cannot do anything about it. Clear? Hello? That's your Unit 1 questions. Okay, chalo, if you guys want, go for a break and come. Okay, let's begin. The next unit, people, let's start with consideration. What is consideration? Consideration is three things you need to remember. One is something in written. Next one is same thing in Latin, it is called quid pro quo. That is always an agreement should be supported by some consideration. It can be either in cash, it can be in kind, it can be in service, but there should be something in written. And always remember, there has to be consensus ad idem. What do I mean by consensus ad idem? Consensus ad idem means, people, meeting of the minds. Consensus. Concentrate. Back. Break is done. Side part, yes. Back. Huh? Consensus ad idem means meeting of the minds. Consensus means same thing. We should be able to think same thing in the same sense. For example, you remember that car example? I had white car in mind, you had red car in mind. So it cannot be considered as a valid contract. So remember that and go. Okay. So to understand the definition, let us directly look at the rules of consideration so that you will understand the definition better. What are the rules of consideration say? The first one says the consideration must always move at the desire of the promiser. What do I mean by desire of the promiser? If someone does something voluntarily, you cannot call it as a consideration. You cannot say something I have done voluntarily. Later, you cannot ask the other person to pay for it. That is not allowed. So, one of the example we have it as people is Durga Prasad versus Baldio. What happened in this Durga Prasad versus Baldio? A simple case. Because to understand the rule, I am explaining you the case. There was a person, you can imagine like this. There was a collector in a town called A. The collector told one of the contractor in the town, why don't you build one bazaar? Bazaar means nothing but like a market for your own residents, your own citizens. Why don't you build it? So that your residents need not have to go to the nearby towns to sell any articles. They can stay wherever they are and they can make the trade. So what did B do? B constructed one market. After the construction was done, B started giving this market, all the shops on rent. He charged two rents. One people for using this market, he charged some rent. Next one people, whoever sells any articles, I need to pay certain percentage as commission for selling the items in this particular shop. So I have to pay rent also, I have to pay commission also. Why commission? Because I built this particular shop for you guys, no? I took that effort. So you need to pay me rent as well as you need to pay me commission. So whenever anyone asks, he used to say that. Now what happened? For years together, all the people, all the tenants started paying that. No one questioned. They paid rent as well, they paid commission as well. They paid both. Until a day, one person came called Mr. C, who was a tenant. He came and said, I pay you rent for using the shop, but I will not pay you commission. Why should I pay you commission? I am selling, I will make money. Whatever I have to pay to you, I am paying it to you. Why should I pay you commission in addition to the rent? I will not pay. One tenant cancelled making the payment. He did not pay the commission. Now, 1 month, 2 months, 3 months he didn't pay, and rest of the people also started copying the same thing. Even they stopped paying commission. Finally, what happened? This contractor filed a case on this particular person, saying that there was a clear understanding in a contract. You need to pay me both. One is rent as well as commission. That was a contract. Now, how can you say you will not pay? You have to pay. Matter went to court. Now, the question is whether should the person, according to the contract, I have agreed to pay the both. According to the contract, will I be liable to pay this rent and commission, or I'll only be liable to pay the rent. What will be the scenario? The matter went to court. What do you guys think? Rent only or rent and commission? Because it was there in the contract. Rent only? Rent only? Remember people, in this case it was said, what do you mean by that? The consideration should always move at the desire of the promisor. What do you mean by that? Now, they asked in the court, they asked Mr. B, why do you want rent? He said, they are using my shops, no? For that you need to pay me rent. Okay. The judge asked, why do you need commission? Mr. B replied, don't you think I have taken effort to build shops to all of them? Have I not undergone so much of hardship to build shops for all of them? So they have to pay me extra money for building the shops also because I did it for them. So they need to pay me commission also, said to the judge. This Mr. B, he said it to the judge. The judge replied, B, remember you are collecting rent. That is fine. But this commission, did they come and ask you to construct the market for them? Or you did it because someone else told or you wanted to do? You did it because you wanted to do. They never came and asked you. Yes or no? No, when something they have not asked, you cannot charge them for that. What is the rule? It must always move at the desire of the promisor. Did the tenants, did they ask you to come and build the shops for them? Did they ask you? When they did not ask you, how can you charge commission for that? That is what is a rule. What is that? A rule for consideration. It should always move at the desire of the promisor. Understood what you mean by desire? I should have asked for it. You can't do it by yourself and you cannot come and claim the contract. You cannot say, I have done this for you, no? You also give me something in return. For example, let us imagine, while you are going on the road, you find a purse. Now you go and you return the purse to the concerned person. What happened? What happened? Concentrate. Now, when you find a purse, you will go and return it to the owner. And my question to you, can you demand some money with the owner? Sir, your purse was in Koramangala. You stay somewhere in, say, Jainagar, which is 5-6 kilometers from here. I came in an auto. I've paid my money. Can you please pay me my consideration? Can I ask? Now you tell me, is he required to pay? Should he pay? If he doesn't pay, can I file a case on him? Can I file a case on him? I cannot file a case on him. I cannot file. Remember, we'll come back to that. But when I'm just have to answer this particular topic, I found the purse people, if I go and return it, it's a voluntary act. No one told me to return it. It's a quasi-contract. I'll try to return. But remember, if the other party does not pay for it, people, you cannot file a case on the other party. The maximum you can do, you can keep the purse with you. Until the money is paid, you can keep the purse with you. You need not have to give the purse. But you cannot file a case on the other party asking for the money back. Not at all possible. Why? It's a voluntary act. I hope you are understanding. Yes or no? Something? Hello? Yes. Sir, next one, sir. It must move from promisee or any other person. The simple example of Chinnaya versus Ramaya. What is Chinnaya versus Ramaya? In Chinnaya versus Ramaya, we clearly understand one principle. See, always there should be give and take. Something should be there. Quid pro quo is a mandatory rule that we all know. However, quid pro quo, give and take. There should be give and take, but remember, I should only not give. Someone else on my behalf gives also. It's absolutely fine. So now what do you mean by that? Now let us imagine A and B are entering into a contract. There should be quid pro quo. Give and take should be there. Listen, give and take should be there. However, A only should not give, B only should not be giving. I'm not saying they should only be exchanging. If someone else is coming and telling, I am giving money on behalf of A, this is also considered as valid consideration. That is the meaning of what? It must move from promisee or any other person. Chinnaya versus Ramaya, what happened? There was one old lady, she was about to die. There was one daughter. The daughter asked, you're anyways about to die, can you transfer all your property to me? The old lady said, I will transfer provided I have one condition. What is the condition? I have one of my brothers. If you will take care of him after my death, you have to pay him some pension every month. If yes, I will give you the property. She said yes. She gave an acknowledgement also. She agreed. Now after the lady died, after the old lady died, this daughter did not pay any money to the uncle. That is the maternal uncle. She did not even give 1 rupee. Now this maternal uncle wants to file a case on this daughter. The question is, can this person file a case? He went to the court, filed a case. But in the case, in the court, the daughter is telling, Your Honor, I will give him pension. Quid pro is there. Where is quo? You're telling me there should be give and take. I will give. What is he giving me? Nothing. Then this contract is not valid. The law said, remember, he did not give you anything, but someone else gave something on his behalf. Property was given by the old lady. Yes or no? So whatever the old lady gave on my behalf will become my consideration. So that's the meaning of consideration may move from promisee. The man itself can give, or anyone else on behalf of the man can give. It is absolutely fine, valid. That's the second rule. That is only called as what? It must move on the promisee or any other person. Simple. Third one, people, consideration may be executed or executory. That means what? Consideration can be past, present and future. This we have already seen in types of contract also. It can be past, present as well as future. Next one is, it need not be adequate. Quite a lot of times I have asked the question here. It need not be adequate. What do I mean by it need not be adequate? It need not be same. The value of the mic is 2000. I can sell it even for 200. It's fine. If you ask me, is this contract valid? The answer is yes, the contract is still valid. As long as some consideration is involved, the contract is definitely valid. Clear? Yes, Sham? Okay, next one. Performance of what one is legally bound to perform. What do I mean by this? Let us imagine a police officer. A police officer, now you go and report to a police that you were walking and someone snatched your chain. You go and report. The police finds the thief. They come and recover your chain also. And for recovering your chain, you promise the police to pay 5,000 rupees as reward for helping you. Now the question is, after 3 days, now you are saying, I'm so sorry, I don't mean to pay you any money. Whatever I said that day, please excuse. I did not mean to pay. I simply said, now I want to go back on my word. The police wants to file a case on you now, saying there was a contract, you promised to pay 5,000 and now you are not paying. The question is, can the police enforce the contract in the court of law or not? Why? It is his duty to perform. Whatever is you are legally bound to perform, you cannot claim that as a consideration in the court. Now in the court you will go. You will go and say, Your Honor, she promised me to give me 5,000 rupees for helping her in chain snatching. Now the judge will ask, okay, why did she promise? Because I helped her. Why did you help her? Sir, because it is my duty. So you did your duty. You did not help her specifically. Whatever you did, if it is your duty, you cannot claim that as consideration in the court. Understood? Yes, sir. They can ask this. They can ask firefighter example. Imagine there is a building caught fire. Someone came, someone helped. Because someone helped, the owner promised the firefighter to compensate with 10,000 rupees as a reward. After 2 months, the person does not pay any reward amount. Can the firefighter file a case on the landlord? Answer is no, not possible, because the firefighter's duty is to turn off this particular fire. Next one, it must be real and not illusionary. Whatever we have seen, it should be possible to perform. It should not be unlawful, immoral, or opposed to public policy. This, if you remember, in Unit 3, you will be seeing n number of examples. Consideration opposed to public policy. N number of example is maintenance, champerty, fraudulent, all those things will come there. Correct? We'll be seeing it in the third unit. The next one is called as suit by third party or doctrine of privity of contract. What do you mean by doctrine of privity of contract? If A and B enter into a contract, remember, if anything happens, A should file a case on B, B should file a case on A. The third party cannot interfere in the contract. Meaning what? If a contract is between A and B, C cannot go and file a case on B, or C cannot go and file a case on A. If someone has to file, it should be A or B. A third party, an outsider, does not get any right to the contract. Example was, there was a case called Dunlop Pneumatic Tires versus Selfridge and Company. In this case, what happened? A gave some tires to B with a condition that, imagine, okay, you can imagine like this. There was a manufacturer, there was a wholesaler, there was a retailer. There was a manufacturer of tires. He sold tires to a wholesaler with a condition that you have to further sell the tires for a price more than 1,000. You should never sell less than 1,000. The minimum you have to charge is 1,000. If you charge less than 1,000, you need to pay me compensation. Not only that, if anyone further buys it from you, even they should also agree to this. So I will sell it to you. Tomorrow retailers will come and buy from you. They will further sell it to customers. Even they are not supposed to sell the tires for less than 1,000 rupees. It's a condition. If any one of you sell, then I will collect some compensation from you guys. They agreed in a contract. So M gave it to W. W gave it to R, specifying the same thing. When a retailer came and purchased from wholesaler, I said, see, there is a condition, you are not supposed to sell it for less than 1,000 rupees. Retailer purchased also. But because of some financial stringency, what did retailer do? Retailer wanted quick money. Hence, he offered a sale. And he started selling all the tires at 900 rupees per pair, which is less than 1,000 rupees. The manufacturer got to know, manufacturer wants to file a case on the retailer. The question was whether the manufacturer will be able to file a case on the retailer. Will he be able to do? Can he file? Answer is no. That is what I told you. What? Remember people, can he file? There's a condition. So manufacturer, can he file a case on retailer or not? Can he file or not? Can a manufacturer file a case on the retailer? Covenant running only with the land. You cannot put that scenario to a different place, because what does the condition say? Covenant running with the land. Why did they say only land? They could have said covenant running with any condition, right? So you have to apply that only in the case of the land. Clear? Now, in this case, what is the scenario? People, privity of contract. See, in this case, there are two contracts. One contract is between manufacturer and wholesaler. They both entered one. One more is between wholesaler and retailer. This is two. Now, if retailer is not satisfying the condition, whose contract he broke? Manufacturer's contract or wholesaler's contract? Then who should file a case? Then why should manufacturer come in between? So remember, you may have a problem. You may tell the wholesaler, but you as a person cannot go and file a case in the court because you are an outsider. Hello? Hello? Understood? Sir, but in Chinnaya versus Ramaya, you said this old lady, daughter, uncle gave, uncle did not give, old lady gave, that is my. Then, how did uncle go and file a case on the daughter? The contract was between the old lady and the daughter, no? Then how did uncle go and file a case? What? Exception. Remember people, in the case of Chinnaya versus Ramaya, I don't know where did Chinnaya Ramaya go. This is Chinnaya Ramaya. How did you identify? Okay. Now remember people, in this there is one main arrow. That arrow is, let me do it in blue. Can you see this arrow? What is this arrow? That arrow said people, this is only called as acknowledgement. What do you mean by acknowledgement? The daughter agreed with the uncle. Uncle, I will give you pension. She agreed. I told you the word called acknowledgement. That is what gave the uncle the right directly go and file a case. If the acknowledgement was not there, even the uncle also will have to go through the the granddaughter, old lady, grandmother. Yeah, they. Understood. I don't have a choice. Now, because you directly gave me an acknowledgement, it created a relationship between us. Hello. That's the difference. Now, look at this. Remember this word. Why? I will tell you. Is this clear, all of you? Pakka? That's the difference between this and doctrine of privity of contract. This is an exception. This one is an exception. Chinnaya versus Ramaya is an exception due to acknowledgement. Because there is an acknowledgement, the uncle can directly go and file a case on the daughter. Clear? Hello? Okay. Sir, so generally what are you saying, sir? Outsiders cannot come and interfere between the parties. Correct? That's the rule. Yes, that's the rule. However, every rule will have an exception. So does this rule also have. There is an exception. What is an exception? All these are the exceptions. In the case of trust, beneficiaries can go and file a case. Example, people, your colleges are, I don't know, who created your colleges? Whichever colleges you guys are coming from, most of it are trusts only. Yes, it was started by someone. It is now taken care by someone. But imagine if you have a problem. Can you go and file a case or not? Sir, my college infrastructure is not good. Sir, my classrooms are not good. Sir, it is in a scenario where it is about to break. Can you guys go and complain it or not? Can you fight? Yes or no? Yes or no? Yes or no? Yes or no? Remember people, you can. Possible. That's the beauty of the trust. The person who creates the trust is called as an author. The person who takes care of the trust is called as a trustee. These two people will enter into a contract. But for what? For the benefit of the people. The people are called as beneficiaries. I cannot write everyone's name. Can I write every student's name? But if the beneficiaries feel something is not properly done, the beneficiaries have a right to question. Whom? I can go and question the trustees. Possible. Trustees. Basically, whoever is taken care of the trust, trust is end of the day a body corporate. The people who are behind it is always trustees. Can I file a case? Answer is yes, I can. Understood? Yes, sir. Pakka? All of you? Yes or no? Yes or no? There should be a confident yes or a confident no. Never be a cat on a wall. Yes or no? Worry. Family settlement. Any member of the family. What is my family settlement? In short, I will tell you. Family settlement. Okay. What is family settlement, people? Generally, people, what happens? Hey, you have ancestral property, anyone? Anyone has? Oh, sir, come, we'll tell off. Okay, you have, no? You have, correct? Some tata property, grandfather's property, you have it, yes? Now, people, in the grandfather's property, if you look at the documents, only grandfather's name will be there, correct? But now, 2-3 generations would have passed. Now, my question, who will share this property? No one. In that original document, if you say, no one's name is there. Who will share? Family? Members? Now my question, who all family members means? Children, mother, father, his grandfather, grandfather passed away. Okay, let us imagine, yes, optimistic class, maybe. And who else? Children, wife, husband, grandchildren. He is doing some neighbors. He is doing something, Talabadi. Neighbors? No? Remember, people, this is what I am telling you. That is only called as family settlement. Macha, in Tata's document, no one's name is there. Then how come all of you are coming for a share? Where is your name in the contract? Hello? Whether your name is there or not, Anna, if you belong to the family, you are part of the family, you are having a share in that particular document. And I am telling it in a very clean note. Assuming grandfather has one grandmother. I will leave it to you. Yeah? India, मित्रों, हम दो, हमारा grandmother, 3-4. Yes or no? No? I'll tell you open challenge in class. Tell me at least one person here. Anyone has in your family circles at least like grandfather married or had 2 grand. Yes? People, I'll tell you people, I'm telling, I would have told this even in regular class also. Not even once. In a class size of this much. Not even once I have heard. So no sir, we have only one. Not even like, at least we will have one person saying, sir, we have 2. At least one. In your class also we got answer, but the person does not want to tell it out. I know, they know. Yes, sir. So now people, that means what? Grandmother and grandmother ka sister. I mean neighbor. Neighbor's family is also your family. Then, now people, I need not even tell you how many, your parents have how many siblings? Yes, I know at least one. There will be a cricket team, including impact player. No one? 10? Yes, there should be. Yes, impact player also will be there. Yeah. Now imagine family settlement agreements. That's why we have civil disputes in our society. It's not easy to easily, very smoothly to divide out of possible. Auntie will come. Like serial. Okay. Third one, marriage contracts. Basically, the marriage contracts will be made by, let it be the elders. But the contract is, if it is made for the people, that is whoever is getting married, but the contract was made by elders. They are telling, even if the elders die, the people who are getting married can go and make the benefit of that particular contract. One example, if I have to give you, A promised B, if your daughter marries my son, I will pay 500 rupees as a dowry. Yes, sir. That's 1920 case. Sir. Yes, sir. So now what happened? B agreed, daughter agreed, yes agreed, A agreed, marriage happened. B died. Now D went and asked father-in-law, please give me that 500 rupees. 1920 I am talking. It's a good number. So the daughter-in-law went and asked father-in-law, please give me 500 rupees which you promised to give my father. The father-in-law said, I promised your father. Who are you? Don't you understand simple concepts called privity of contract? Said father-in-law to daughter-in-law. You're an outsider. Have you not studied Dunlop pneumatic tires? You manufacturer? So you cannot come and interfere between me and your father's contract. Now people, daughter-in-law said, you father-in-law? Don't you know? Don't you know there are exceptions? Yes. So in exceptions, people, when the contract is made between someone, but the beneficiaries are us. They are telling you in marriage contracts, such beneficiaries are allowed to go and take the benefit of the contract. Understood? Okay. Next one, sir. The case law is called Khwaja Muhammad Khan versus Hussaini Begum. It's also called as beetle leaf case. 1920, 500 rupees was a contract. Real life case. Assignment of a contract. What is assignment, people? Negotiable instrument. A and B entered into a contract. A transferred the instrument to C's name. Initially A and B entered. Now can C go and file a case on B? If B does not pay the money, I can, because I have transferred. Assignment means what, people? Transfer. If I transfer my right to someone, the person can go and file a case. Absolutely allowed. Correct? Okay, next one. Acknowledgement. What is this? Acknowledgement. Chinnaya versus Ramaya. Understood? Hello? Covenant running with the land. What is covenant running with the land? People, covenant means, people, condition. Let us imagine, people, A sells his land to B. A has 10 acres. A tells, Macha, in 10 acres, you take entire 10 acres, I don't have a problem. But remember, in that 1 acre, you should always leave it to me and my child. We will do some agriculture there. That's our only dependency. If that is not there, we will die. With this condition attached, I will sell my land to B. B agrees that 9 acres he can do anything. 1 acre, he will give it to us. I will be doing agriculture there. I'll pay rent for it. But you cannot take away that particular land. You cannot construct anything there. You cannot do anything to that 1 acre. Now what happened, people? Okay. ಯಾರ್ದ ಮೆಸೇಜ್ ಅದು ಹೋಗ ಆ ಕಡೆ who dies? Okay. Charan. Hey Charan, turn off the phone. Okay. Yes, people. Peace. People, covenant running with the land. Covenant means, people, condition. Condition running with the land. Condition means what, people? Now, so you'll go with. Okay, 10 acres, sorry. Now I have said in this 1 acre, you are not supposed to do anything, correct? Now, people, A said that A and B entered into an agreement. A died. Now, A's son is there. He started doing agriculture. But B, what did he do? In the 10 acre land, he wants to construct one big cricket stadium. In the entire 10 acres. A's son comes and says, hey, my father has told you, Noda, you have to leave 1 acre. You do anything in 9 acres, but this 1 acre you are not supposed to touch. B said, hey, who are you, da? You, outsider, Dunlop pneumatic tire manufacturer. How many times should I tell that case law in you? Get away. You are an outsider to the contract. Now, what does the son say? There is exception, no? There is an exception, da. What is that? Whenever there is a covenant running with the land, whenever a land is sold with a condition, no matter who buys, no matter who has, that condition will always stay intact. So if you know, if you are aware and you purchased it, even after the death of a person, the condition will still be alive. So you cannot touch the 1 acre of the land. That is what this particular case teaches us. Clear? All of you, son can take the benefit of this contract. Next one, contract by an agent. We will anyways be seeing agent principle and all. Unit 7 will be doing it there. Clear? Done. Next one, sir, validity of an agreement without consideration, exceptions to quid pro quo. Generally, people, the agreement should always have give and take. But even if there is no give and take, sometimes the contract will still be valid. When this is the exception. First one, people, natural love and affection. That is nothing but, people, if there is any contracts between you and your, say, parents and, I don't know, Allah. Siblings. Yes. But I like what and all came in your mind. Yeah. So he's like, sir, I'll tell her name. Now I'll tell. Lucky girl. No? Okay. Now people see, what does the law say? Whenever you're entering into a contract with your loved people, then basically this is nothing but they will be giving it to you. What will you give? What will you be giving it back to them? The law says, see, without quid pro quo, there cannot be a contract. So, to satisfy that, they said natural love and affection can be considered as a quid pro quo. Now, your parents gift you something. In return, you don't give them anything. But to say there is something involved, we are telling you are giving them natural love and affection. That's the meaning of it. But remember, if natural love and affection should be taken as a valid consideration, you need to satisfy certain conditions. What is that? 3 conditions should be satisfied. Condition number 1, the parties should be in near relationship. That means what? You should be related. Parents, siblings, spouse, as the case may be. Second one is people, the contract must be in writing. So oral, you cannot consider it as valid. Third one, people, the document should be mandatorily registered. All 3 conditions satisfied, then the contract will be considered valid. Clear? Simple? Okay. They can build you some case and all here. Remember, all 3 conditions should be there. Yes? Okay. Next one, compensation for past voluntary services. What is this? Compensation for past voluntary services means nothing but, say for example, someone found my purse. Papa came in search of me and they tried to return back my purse. Now, because of the goodwill, I said, thank you so much for taking so much of efforts. I hereby tell you that I am interested to give you a reward of 1,000 rupees for your gesture. Now, once I promised to reward you for whatever a person has done voluntarily, I only promised to reward. It becomes a contract. Now, I will have to pay this 1,000 rupees as a reward. Sir, what if I don't pay? That person can come and file a case on me. He can recover it. Sir, that time you said he cannot file, no sir. Now you are saying he can file. Remember, that time I said, you incurred some expenses voluntarily to go from here to there. You are asking that money back. He can question you. Did I ask you to come? He can question you. Sir, in this scenario, what am I telling? In this scenario, I am telling he has come to you. You felt happy and you are only telling that I will give you a reward. Once you agree to give a reward, it becomes a binding contract. In the first scenario, you did not tell anything. Second scenario, you are promising that you will give reward. Once you give that promise, it becomes a contract. If you do not fulfill it, that other party can always file a case on you and recover that money. Hello? I hope you are understanding. Yes or no? Remember this scenario. From exam point of view, it can be important. Purse case can be of 2 scenarios. One, I incurred some expenses voluntarily. So, voluntary expenses. Now, should the other party pay these expenses I incurred? Should the other party pay? The other party is not liable. The other party is not. Then what can you do? You can withhold the purse with you. Until the money is paid, keep it with you only. Can you file a case to recover this money? No right to sue. Very important this thing, remember. Now, what if reward was announced? Reward was announced. In such case, what will happen? Can file suit to recover the reward. Very, very important. Remember this. This will again come in your quasi contracts and all of that. Bailment, again it will keep coming. This is a summary. Understood? Any doubts? This clear? Done? Okay. Next one, sir. Promise to pay a time bar debt. What is time bar debt, people? Any debt, if you have not paid within 3 years, becomes time bar. That means what? Court will not help you to recover that money. Example, A took money from B. A promised to pay B within 1 year. Now I did not pay. Now let us imagine you should have paid by 2026. I did not pay. B has 3 years time to go to court. I need to go within 2029. If you go to court within 2029, the court will help you to recover the money from A. They will file, they will pass an order, they will tell A to pay. So court will come to your rescue. Sir, what if until 2029 B did not go to court? That's all court will tell, don't come to me. You do whatever you want. So from the court's point of view, you will always have a deadline to come to the court. You can't come or you cannot take your own sweet time. This type of debts are called as time barred debts. Hello? Sir, so now if A does not pay in 2026, if B does not go to court by 2029, that's all, sir. The debt is gone, sir. If A gives, you take, but court won't help. Let us imagine we took 3 years. The time period I had to repay was 3 years. After the 3 years, if he still didn't pay, you will have 3 years time to go to court. So whenever your tenure ends, from that time you will have 3 years. Understood? So now if 2029 he did not give, now what to do? B has to go to court within 2029. You did not go, done. Now people, let us imagine, A is a really good fellow. A comes and says, Macha, I'll give you one more contract. I know that contract is waste now. You can't do anything on me. I will sign fresh contract that I will give you money. If you so good people, that contract will become enforceable. So new contract A is telling, Macha, you remember that old contract, now that you cannot take to court, I will give you one more new check. So if he is so good, if he signs a new check, now A is giving you new check. For that, what is B giving again? Nothing, no. So there is no give and take for the second contract, but still law tells it is valid. Understanding? That's the meaning of any promise to pay a time barred debt. A is only voluntarily and coming and he'll tell that, sir, I have not paid within time. Now I pay you the contract now. After 29, I am voluntarily coming and telling, with a written agreement, I'll sign and give it to you. I can go and file a case again based on this contract. Even if there is no quid pro quo, it's okay. Understanding? Hello? Yes? Okay. Next one. To create agency, we'll be again seeing this also in agency chapter. That time we'll discuss. Completed gift. What is completed gift? Gift people. See, generally what happens in the first case, you have to be a people in near relationship. But of course, friends also will give gifts. Now that will not be coming under near relationship. Then where are we covered? We'll be covered in completed gifts. So anyone who gives you a gift in return, of course, we will not give anything, but this is an exception. Correct? There will be no quid pro quo, but still it is a valid contract. Yes or no?
Check, give it as a gift. That's not.
What did you give?
Check.
Check.
Friend, give a check to as a gift. That is dishonest. Is that valid?
Meaning, do I have any right on it?
It's a valid. We can enforce. That's why.
See, first thing is, check does not come under Indian Contract Act. Why? What happens? There are two laws now. One is Indian Contract Act, one is Negotiable Instrument Act. Directly the court says, please refer Negotiable Instruments Act. In Negotiable Instrument Act, for a check to be considered as dishonored, it should be a legally enforceable debt. A gift is not a legally enforceable debt. So a check bounce in the case of gift is not a punishable offense. You cannot go to court. Which one? No, see, here what I meant to tell you is there is a second agreement entered. That means what? I can enter into a fresh agreement. It need not be only check. I am telling you again that I will repay that old money. So what I am trying to tell you is I am trying to repay the old money. It can be in any form. So that is the instance I told you. But if you are going in detail with the check topic, that's the overall perspective. If it is a gift, in the gift you cannot recover the money. If it is a check bounce in the case of gift, you cannot recover. Why and all I'll tell you when we are doing negotiable instruments. Yes, sir. Okay. Next one, people, is bailment. What is bailment? Again, we'll do it in bailment. Next one is, people, charity. What is charity? Charity, people, is it a legally enforceable debt? I mean, is it quid pro quo? Imagine A promised B that I will transfer you some 1,000 rupees. If A does not transfer this 1,000 rupees, can B file a case on A? A, with goodwill, A is telling I will donate you 1,000 rupees. A did not donate. Can B file a case on A? Can they? The question is, people, one question you need to ask, based on A's promise, has B undertaken any liability? If B has undertaken any liability, then yes, B can recover the 1,000 rupees from A. If B has not undertaken any liability, B cannot recover the 1,000 rupees from A. Example, if I have to give you, let us imagine B is raising funds for someone's medical operation. What is the price of this particular operation? Let us imagine it is coming to 5 crores. Yeah. Now, B is raising money from lot of people. So, constantly day in and day out, lot of people they are calling. So, they called a person called A. A heard everything. A said, oh, I'm so sorry. I will agree to donate. I'll give you 20,000 rupees, but I have not yet received my salary. You please wait for the first of the month. After the first of the month, I'll transfer you as soon as I get my salary. A agreed. Now, people, on the first of the month, the operation started. Now, A wants to cancel the contract. A does not want to send this 20,000 rupees. A is coming and asking your opinion. I gave them a word. Now I do not want to transfer this 20,000 rupees. Now the question is, people, can A be compelled to pay this 20,000? Is A liable to pay this 20,000 or A is not liable to pay this 20,000? A is liable to pay 20,000? The reason is, people, see, this is donation, this is charity. But based on your word, they have undertaken to take up a operation worth 5 crore. Now, based on your word, they have taken up this liability. Once the other party has started to take up a liability, you cannot go back on your promise. Now, you are liable to pay. You should pay. Sir, what if there is no operation, nothing? You agreed to give, later you did not want to give. There was no liability that was taken up by Mr. B. If there is no liability, A can cancel the contract. Because other party has not taken up any liability. Understood? So it all depends on whether the other party has taken up a liability or not. If other party has taken up a liability, you are compelled to pay. If other party has not taken up a liability, you are not compelled to pay. Understood, all of you? Hello? Done? That is your consideration. Easy? Takatak? Let us do off. Okay. Questions? Which of the following statement is false? Consideration must move the desire of the promiser, may move from any person, must be illusionary, must be of some value. Of course, see, consideration must move the desire of promiser, promisee, any of the person or any of these. Promiser. Consideration may be past, present, future or all of the above. All of the above. Consideration in simple terms means what? Anything in return, something in return, everything in return, nothing in return. Something in return. Which of the following is not an exception to the rule? No consideration, no contract. Which of the following is not an exception to the rule? No consideration, no contract. Compensation for involuntary services, love and affection, contract of agency, gift. Which is not an exception now. Compensation for involuntary. It was voluntary only, no? Next one, past consideration means. Past consideration means consideration and promise should move together. Executed consideration. Consideration is provided prior to making of the contract. Invalid consideration. Consideration is provided prior to making of the contract. Contract without consideration under section 25 is void, voidable, valid, illegal. A contract without consideration under section 25. Exceptions, nothing but valid. Exceptions to quid pro quo. Hello? Okay. To form a valid contract, consideration must be. Is it true? Is it true? It need not be adequate. It need not be same. It need not be of the similar value, right? For a consideration, for a contract to be in existence, there has to be quid pro quo. But remember, the consideration need not be the same value of that particular product. That is the meaning of need not be adequate. Mr. Sohan Lal sold 10 acres of his agricultural land to Mr. Mohan Lal on 25th September 2022 for 25 lakhs. The property papers mentioned a condition amongst other details that whosoever purchased the land is free to use 9 acres as per his choice, but the remaining 1 acre has to be allowed to be used by Chote Lal, the son of the seller, for carrying out farming or other activity of his choice. On 12th October 2022, Mr. Sohan Lal died, leaving behind his son and life. On 15th October 2022, purchaser started construction of an auditorium on the whole 10 acres of land and denied any land to the son. Now, Mr. Chotelal wants to file a case against the purchaser and get a suitable redressal. Discuss the above in light of the provision of Indian Contract Act and decide upon Mr. Chotelal's plan of action. What is it, people? Doctrine of privity of contract has certain exception. The exception here is, people, covenant running with the land. Hence, Chotelal will be eligible to claim the 1 acre land. Okay, next one. That's all. Done. That's your textbook questions. Okay, done. Next one, people, is your small break. Okay, see here. Unit 3, other essential elements of a valid contract. What is the other essential elements of a valid contract? If you look at it, people, now, section 10 said something. What? For a valid contract, there has to be section 10 said essential elements has to be satisfied. What are the essential elements? One was offer, one was acceptance, one was consideration. We saw rules of offer, rules of acceptance, we saw rules of consideration as well. Now, what are other parts left? We will see capacity of parties, we will see consent of the parties, we will see agreements opposed to public policy. So, all those things we are going to see in this particular unit. That will complete our section 10 also. The first one is, people, nothing but competency or capacity of contract. The people who are entering into a contract, they have to be 3 things. What? They should be major, they should be sound mind, they should not be disqualified. So with regards to minors, there are some things that we need to keep in mind. What is that? The minor rules. The first one, the minor agreement. If you enter into an agreement with a minor, such agreement is considered as void ab initio. Void, invalid. Ab, from the. Initio, beginning. So from the beginning, such agreements are invalid. So what do you mean by that? If you enter into any agreement with the minor, such agreements will be considered as invalid. So the other party will not get any right over that particular contract. Remember, case law, Mohiri Bibi versus Dharmodas Ghosh. Yes, what happened in this case? A minor borrowed money from a money lender. He was 16 years of age. Now, when the money lender asked the money back, he said, I am a minor. The money lender said, so what? He went and filed a case on him. The law said, people, if you enter into a contract with a minor, we will not help you to recover. The money lender in the given case lost the case and money lender could not recover even 1 rupee back. That is only this case law, Mohiri Bibi versus Dharmodas Ghosh. Second one, no ratification. What do I mean by that? Now, same is loan agreement. The minor borrowed the loan when he was 16. Now, you are saying minor agreements, you cannot take to court. Okay, I'll do one thing, sir. I'll wait for him to become major. Once he becomes 18, I'll enter into one more agreement. And I'll ask him, you have to repay all the money that you took when you were 16 years old. Now you promise, now you enter into an agreement. After you turn 18, I'll make him sign. Now the question is it enforceable in the court of law? Answer is, once a minor agreement, always a minor agreement. You cannot further ratify it. You cannot further make it valid. Invalid, always invalid. It cannot become valid in the future. Clear? Third one, he can be beneficiary. Remember, minor can take benefits of the contract, but minor cannot be losing in the contract. He can plead minority at any given point of time. He can go and tell to the court. He can remind to the court, dear court, I am a minor. They will keep that in mind. So that is a valid excuse. Next one, his estate is liable for necessaries. What do I mean by that? If a minor is taking money, imagine I borrowed money in the previous case. Why did I borrow 20,000? Let us imagine if I borrowed it for the purpose of education or say shelter or say education, shelter or basic necessities, food, clothing. So if at all you are taking the money for that purpose, if you are taking it, the law is telling you people, remember, if the minor has any property, that property will be liable. You need to give it back to the person, whoever gave you the money. For example, in our case, let us imagine minor had some property worth 10 lakh rupees. I borrowed some loan, 50,000 rupees for the purpose of my education. The money lender can recover the money from my property. So what if I never had property? Not even 1 rupee property is there. In such case, minor cannot be held liable. Minor can be held liable only if you have a property. If your property is not there, minor cannot be held liable even for 1 rupee. Sir, can I recover the money from his parents? Can I recover the money from his parents? Parents possible? Possible or not? Minor cannot bind his parents. Not possible. Remember. Understood? Not possible. You cannot say my parents will come and pay money. If anyone enters into a contract on that belief, it will not be binding the minor. Next one, people. Then if I want to enter into a contract, how to do? You can enter into a contract, people, by a guardian. For example, how many of you did admissions by yourself? How many of your parents came and did the admission? If there is any minors, you will understand this. Any minors are there? 17? No? Yes? So your parents only would have come and signed. Yes or no? That's all. That's how you enter into a contract. Next one, no insolvency. A minor can never become insolvent. Why? Logical only. He can never enter into a contract. He can take benefit, but he cannot take liability. How can he become insolvent? Next one, no specific performance. I'll tell you when we are doing remedies. He can be an agent. There is a problem here when we are doing agency chapter. I'll tell you what is that. He cannot bind parent or guardian. You cannot bind parent or guardian. Next one. If at all I enter into a joint contract, who will be liable? Joint contract means what, people? Let us imagine one major and one minor. They both enter into a contract. They take a loan together from C. One is an adult, one is a minor. This is the meaning of joint contract. Remember, people, adult will be liable to pay even the money taken by the minor as well. That means together, if we have borrowed 1 lakh, the adult took 50,000 from this, the minor took 50,000 from this. When we repay the money, the adult will have to repay the entire 1 lakh. Remember, in the case of joint contracts. Next one, sir, surety will be liable. What do I mean by this, sir? Important exam point of view. The minor has borrowed 1 lakh rupees. Can I recover the 1 lakh rupees? Not possible. But remember, sir, this money, this loan was guaranteed by another third party. I gave a surety. If minor does not pay, I will repay. I have given a surety. Remember, people, you cannot hold the minor liable, but surety will be liable. Can a minor be a shareholder? Directly not possible, but you can be a shareholder by natural, you can be through a guardian, possible. Remember, directly not possible. The minor will be liable for torts. Torts is nothing but civil mistakes. Any civil wrongs, you will be held liable. Meaning, if you are scolding someone, abusing someone, trespassing, you're walking into someone's property, all this you will be liable. Remember, clear? Next one, sir, a minor, not minor. Next one is, people, a person should be of sound mind. What do you mean by sound mind? A person should be mentally stable. So technically, whenever he is stable, people, he can enter into a contract. That means what, in short, what they are telling you is possible, Circle. Can we enter into a contract? I'm telling you, intoxicated mind cannot enter into a contract. It will not bind you the contracts. Clear? So if any person is under intoxication or alcohol, such person cannot be considered as a sound mind. Not possible. Clear? Next one is, people, you should not be disqualified. What do I mean by disqualified? These people are specifically disqualified. Foreign sovereigns and ambassadors. What do you mean by foreign sovereigns and ambassadors? Example, you cannot enter into a contract with Trump. You cannot enter into a contract with Trump. Why? Let us imagine, people, I allow you to enter into a contract with Trump and you fail to enforce the contract. There is a breach of contract. It is going to spoil the relationship between countries. So, the law says it comes with a complication. Macha, don't hurt their ego. So, law says keep away from your foreign sovereigns and ambassadors. Basically, representatives of the government. Please don't enter into contracts with them. If you still want to do, you can do it after taking the approval from the central government. Directly not possible. Next one, people, alien enemy. What is alien enemy? A country with whom we have a war going on. That is nothing but Pakistan, you can tell it. Next one is called as insolvent. You cannot enter into a contract with a insolvent. Next one is convict. Who is convict? Convict is, if at all you have filed a case on someone and the case is proven and they are arrested, you call them as convict. As long as they are in the courts, they are in the jail, you cannot do any contract with them. Example, I can give you, lot of people, lot of celebrities, no? We have lot of people as examples. Next one is, people, corporations. Corporations, nothing but ultra wires. Ultra wires transaction does not bind the company. When we are doing Companies Act, we will see. Next one is, people, free consent. So tell me, people, in a contract, whenever parties are entering into a contract, there should be free consent. So the first one is, what do I mean by free consent? There should not be any coercion. What do I mean by coercion? Coercion is nothing but you doing any act which is forbidden under Indian Penal Code, but here you need to read it as BNSS. That is how you need to give a cross reference. Contract shall be voidable, party shall be punishable. That is coercion. Coercion is nothing but people force. You are telling some other person, that is, you are telling the second party to enter into a contract by forcing them. They are not entering into a contract with their free will. Then how did they enter into a contract? Because of force. And what type of force? Something which is punishable. Remember, in one of the scenario it was also held, suicide is also considered as coercion. Hello? Understood? Yes? Okay. Next one is people, undue influence. 1 second. Next one is undue influence. What do I mean by undue influence? What is the difference between undue influence and coercion? Coercion is you are doing something which is forbidden under Indian Penal Code, BNS and BNSS. But what do you mean by undue influence? Undue influence means people, there are parties. There are two parties. These two parties are always related to each other. There is a relationship that they share between each other. What type of relationship? This relationship can be like employer-employee, or it can be debtor-creditor, or it can be doctor-patient. It can be advocate and a client. So there is always a relationship between the parties. They both are always related. In such case, we use the word called as undue influence. When a person in the dominating position, he is using his dominance to enter into a contract with the person in the inferior position, we call such contracts as undue influence. Understood? Yes. The difference between coercion and undue influence is, people, in coercion there is a force and the parties need not be related. In undue influence, people, the parties are always related. Remember, clear? Okay. The next one is, people, fraud. What is fraud, people? Fraud means if you do something intentionally. Examples of undue influence, we saw fiduciary relationships and what else? Mental distress, real and apparent authority, father and son, fiduciary relationship, advocate and client, CA and a client, mental distress, doctor and patient, unconscionable bargain, debtor and creditor. What do you mean by unconscionable bargain? Unconscionable means, people, you are giving loan but at a highly unreasonable rate. That means what? I am giving you, let us imagine A is giving loan to B. What is the rate of interest? Rate of interest is 4% per month. Sir, such things exist? Yes, in villages even today it exists. Such type of, now if B goes to court and says, sir, A has given me loan but at a rate of 4% per annum, what will the courts do? The court can tell, 4% is too much. I can pass an order, I can tell, reduce it to say 1% or reduce it to say 2%. The court can interfere. If B goes and complains it in the court, we call such things as what? Unconscionable bargains. You misused my scenario. I am in need of money. You took advantage of that scenario. You call such scenarios as unconscionable bargains. Yes, Sam? Okay, the third one is called as what, people? The third one is called as fraud. What do I mean by fraud?
Whether in normal circumstances we can be able to file a suit.
Like?
Whether in normal circumstances, lender put 5 to 8% of interest rate. Whether the party can file a suit against him.
Per month you are saying?
Yeah.
Yeah. If you can prove that someone has taken advantage of your scenario. Normal circumstances, then why will you go to court?
If they ask more than normal percent, like normal is around 2 to 3%. If they ask around 8% or 5%,
yes, you can go. You can file a case. 100% yes. Yeah. See, the only thing that the law says is, what is the scenario under which the person gave you loan? Whether was there any financial distress in the society? Money is not, now COVID. Now in COVID, if someone gave you the loan at 6% rate of interest, it is still considered valid only. Because there was financial distress. Who was willing to give loan? So if at that point of time, if someone has given you loan, it is still fine. So all these scenarios will be considered. But yes, you can. Yeah. If that is the case, mental distress. Can a patient file a case on doctor saying you took more money? Yeah. So mental distress. Also, you need to look into it. Was it actually a mental distress? Did you misuse your power? Today, how many people can file a case on the doctors? See, you walk into a doctor. I'm not saying everyone, but here and there you will be seeing, right? If you go to a big hospital, what is the first thing they tell? Blood test. I don't know. We will feel what is there in my blood, huh? Correct? So, first thing they tell is blood test, whether related or not. If you say knee pain, X-ray, direct X-ray. Whether required or not, who cares? Now, can I question? Can I go and file a case? Never know. They will say it is required. It is easy to prove for them also other way around. They will tell you might have this liver damage. That's why we asked. If not, you would have died. So that's why I always say in the court, what wins? Truth Allah. Evidence wins. So today's date, if you can prove, you will win. Truth and all, no one cares. Who can prove, they will win. Again, if you want to take the best example as Jantar Mantar only. That place is, Jantar Mantar is generally magic. In another word also, if we say Jantar Mantar, a synonym of is also called magic. What is happening there is magic only. I don't know if you guys know, 2 days back, there is a new amendment that Indian government has passed. It's called FCRA, Foreign Contribution Regulation Act. In the last few months, around $3.2 billion has been sent from outside India to some trusts in India. $3.2 billion. And on 16th of July only, in one of the press notes, I'll not take the names and all, but in one of the biggest, a Democrat, one of the biggest leader has said, 20th of July, be aware, something is going to happen. How? So people knew that these riots are going to happen. Only me and you, we don't know. That's all. Yeah, everyone knows. Now, what did the other parties do? I'm not supporting any party. I'm not against any party. I'll not support also. I'm not against also. But my only thing is, please don't go and take the merit of someone else's dead body. Someone is already doing the strike. They are fighting for it. Political drama. Every political party is coming and joining them now. Why? Couldn't you do it on your own till now? Credit. They want credit. I'm saying every party. Now even the party in ruling, couldn't you have addressed the NEET issue neatly? Correct? There is a very famous saying, right? A stitch in time saves 9. There's a proverb, right? A stitch in time saves 9. There's a proverb. So if you had done it in the initial days only, would it have come to this scenario? Huh? Everyone is at mistake only. I'm telling you, only people who are losers is us. Who think everything is happening properly, we are the losers. Yes. Okay. Next one, people, is called fraud. What is fraud, people? Something which you do even after being aware of it. So, for example, this mic fell down. How? From my hand. Do I know? Yes. I'll come and tell you, people, the mic is working fine. What I did is called as fraud. But remember, the mic fell down. Do I know? Yes. I'll come and sell. People, the mic is for sale. I will not tell you that the mic fell down and all. I'll just keep quiet. Is it fraud? I'll not tell anything. I'll just keep quiet. Is it fraud? Remember people, mere silence is not considered as fraud. Can't you just come and turn on? As soon as I came in, didn't I check the mics? Like that when you're buying something, don't you do your research? That is only called as what people? Doctrine of, or also called as caveat emptor. That means what? Let the buyer also be aware. You do your duty, da. Why always be dependent on the court? Simple things, if you guys check and buy, in this stage only you can stop the scenario. Why do you want to come to court and waste court's time? Court will not help you. Because court will look at you as a negligent person, irresponsible person. Why should I waste my time on you? That is only called as what people? Caveat emptor. So what is the law saying? If at all someone in the case of fraud, remember fraud means I know it's not working. But in the same scenario, whoever is buying it, it is your duty also to check what you are buying. Hello? Exception, if it is my duty to speak, I have to speak. What do I mean by duty to speak? Imagine you ask me a question, sir, is the mic working fine? Now I keep silent. Now this is the fraud. Because I have a duty to speak. You have questioned me. I have to respond. Now if I keep silent, people, it is considered as fraud. Understood? Yes, sir. What do I mean by misrepresentation? Sir, again mic for sale. I went out for a break. Someone checked this mic. They dropped it and they kept it back on the table as though nothing happened. I came back. I didn't know that the mic is not working. But I came back. I said, people, this mic is for sale. Does anyone want to buy? Hello? Now, do I know that the mic is not working? Answer is no. Now, according to me, before break, it was working fine. So I come and say, people, the best mic, it is working really good. If anyone is interested, please buy. Now, I am coming and telling. Now, if I tell something as true without knowing that it is not true, I think it is true. I don't know that it is false. That is called misrepresentation. But if I tell something is true, knowing it to be false is called fraud. I repeat, I tell something as true without knowing that it is false. That is called misrepresentation. If I tell something as true, knowing it to be false, I know that it is not working, I still say it is working, I call it as fraud. What is the difference in fraud and misrepresentation? People, coercion, undue influence, fraud, misrepresentation, in all people, the contract is voidable. Give me back my mic, take back your money. In fraud, people, remember, along with the money, you will also be entitled for compensation because you cheated. In misrepresentation, you will not be entitled for compensation. Clear? All of you? Pakka? 100%? Okay. Or everything else is voidable. Next one, people, is called as mistake. What do I mean by mistake, people? What is mistake? Mistake is something, but mistake can be of two types, people. One is called as mistake of fact, mistake of law. Now, mistake of fact is what, people? Unilateral mistake, bilateral mistake. What do you mean by unilateral mistake? Only when one party is under a mistake. First of all, what is mistake? Na? Mistake means by mistake, sir. Hey, mistake means what? Huh? What is mistake? Remember, mistake means nothing but, people. Mistake can be of two types, people. What is that? See, one is called as unilateral mistake, one is called as bilateral mistake. But what is this? Try to understand with an example. So let us imagine there is something called as unilateral mistake. We both are entering into a contract. The contract and all is entered. Now I know what is that we are entering. But when it comes to the delivery date, you do a mistake. Example, sir, I order something on Amazon. For example, I order a blue shirt on Amazon. Now on the Amazon records, it clearly says I've ordered for a blue shirt. And I'll say, now say my size says, for example, some L. I'll say this is my size. Now what happens? On the day of delivery, you guys also would have come across such scenario. You would have ordered something, but you will end up getting something else. It can be a wrong color. It can be a wrong size. It can be a wrong product altogether. It has happened. Now people, contract is clear. Blue shirt, L size, correct. Everything is there on the paper. It is between you and Amazon. And you know that you are going to get blue, L only. But Amazon delivers a wrong product. That is only called as what people? Unilateral mistake. One person did the mistake. One person did the problem. That is only called as what people? Unilateral mistake. What will happen to the contract? Contract is still considered as valid. I can give back the product. I can claim back my compensation. I can get back my money. I can tell him to no, you have to give me the blue shirt only. I can ask for it. Next one is called as people bilateral mistake. You are also thinking something. I am also thinking something. Such type of mistakes are called as what people? Bilateral mistakes. Bilateral mistakes can also be considered as people absence of consensus ad idem. I have two cars. Let us imagine one is white, one is black. Yes. So A agrees to sell his car to B. B has only seen his white car. Whereas A is planning to sell his black car. So A is thinking of black car in his mind. B is thinking of buying white car in his mind. They both have not specifically asked which specific car we are speaking about. And we enter into a contract. We call such a scenario as what people? Bilateral mistake. What do you mean by that? Both of us are thinking some other product and we are entering into a contract. Such type of contracts are called as what people? Bilateral mistake. Bilateral mistake is not a valid contract. It is a void contract. Understood? Because you did not agree on the same thing at all. So it is not valid. Is this clear? All of you? The next one, sir, there is something called as mistake of law. Mistake of law can be of two types. One is called as Indian law. One is called as foreign law. Mistake of Indian law, it is not exception. The contract will still be valid. Mistake of foreign law is treated as mistake of fact. That is any example of mistake of law? What is mistake of law? Violating the traffic rules. Okay. Foreign law? What the? Mistake of foreign law, what you treat it as? Mistake of foreign law, you can write, you will treat it as a void agreement only. What is mistake of law? Foreign law, if I have to tell you, there will be so much exports that we will be making from India to foreign country. Agreed? You will be selling so many items. Now, we would not know what exactly is the foreign law, and they would not know what is exactly the Indian law on a particular topic. Now, for example, in the class I would have given you example also. There is one, what is that? Everest masala or MDH masala, something. There is a kitchen masala, garam masala. So, we have exported it to one country called Australia. So, Australians, they did it a lab test of this MDH masala, MDH Everest or something. They found one chemical more than the prescribed limit as per the Australian policy. Let us imagine the maximum allowed is 2%. In that it was 8%. Now what happened? According to MDH, Indian policy, Macha, you have what is there? Indians can digest. But foreigners are little weak. They can't digest. Yes. So we can take. The cancer and all won't come for us. But for them it will come. So there is a limit. Now what happened? We shipped it. Export is done. While they are doing the lab tests, people, they got to know that we have exported it. Now imagine the cost involved. So the order was passed either to take back the complete consignment or to destroy the entire consignment. Of course, what did we do? We took back the entire consignment. Now tell me, who will bear the cost for all this? Consignment to send from here to there itself will be in crores. Who will take the cost? The person who is selling or the person who is buying? Simple people, agreement is void. 1 rupee will not come, 1 rupee will not go. Whoever has spent, that person has to suffer the loss. Now if seller has sent it from here at your risk, at your expenses, Macha, I am so sorry, the cost is on you only. The agreement will be treated as void. Because you did not know foreign law, we will excuse you. But the agreement will come to an end. It is called as mistake of foreign law. Mistake of Indian law is not an exception. You are supposed to know. There is no exceptions for it. Mistake of foreign law, it will be treated as void. Is this clear, all of you? Yes? Okay, remember and go. Mistake. The next one, sir, legality of object and consideration. The next rule, sir, when parties are entering into a contract, it should be lawful object and lawful consideration. Basically what? It should not be forbidden by law. It should not defeat the provision of any law. It should not be for fraudulent, smuggling and all. It should not involve any injury to a person or a property. A telling B to go kill C, or A telling B to go and destroy C's properties. Next one, it should not be immoral. Next one, it should not be consideration opposed to public policy. Immoral, I hope you know. Immoral is not considered as illegal. Immoral is we do not have a law on it, but we consider that as unethical. That is called as what, people? Immoral. Yes. For example, in India, adultery is also considered as immoral. Understanding? Yes. Okay. Consideration opposed to public policy. What is the consideration opposed to public policy? Simple. Trading with alien enemy. What do you mean by consideration opposed to public policy? If at all I allow these agreements to happen, our public will suffer. What are such agreements? The first one is trading with alien enemy. You going and trading with Pakistan. Next one, trafficking of public titles and offices. That means what, people? I will sell Padma Bhushan, Padma Vibhushan, or I will sell the IAS post. I will sell the NEET seat. Can we do all of that? Is our country doing all of that? NEET medical seats and all? No, they are doing that. Okay. Agreements creating monopoly. Can we create monopoly? Not possible. Of course, no, not possible. If Jio and Airtel come together, we will die. Then what else? No competition. Whatever they said, that will be the price. So there cannot be monopoly. You cannot kill competition. Marriage brokerage agreements, not possible. But remember, exception is marriage matrimonial websites. That's an exception. What is marriage brokerage agreement? A, B, there will be a middleman. He will go to A and say, hey, the boy is too good. He'll go to boy and say, Macha, that girl has full properties and all in the village side. You marry, you will get at least 100 acres of land, land. He'll go and say. He'll go to the girl and say, he's pretty well settled, US settled, everything he'll say. Why? End of the day, he's doing all of this because he gets a commission. That was the days, that's what I'm saying. It is Indian Contract Act 1872. Those were the days. That's where they said if someone did it, We will treat it as a opposed to public policy. You cannot take money. Understood? Yes, sir. You can ask. Don't you think today there are these marriage brokers are there or not? You guys go down. When your marriage, first you'll give it to marriage brokers only. All our things will have marriage brokers. So it will first go to marriage broker only. There are there. But exception people, remember matrimonial sites will not come here. Shadi.com or IndianMatrimony.com, all those things will not come here because they are not marriage brokerage agreements. They are just selling data. There is difference. They will charge you say 10,000 rupees for 1 year. In 1 year, you can view any number of profiles. If you like it, you guys take it, you guys connect outside the website. We are just doing the role of providing information. I am not promoting like Flipkart verified. I am not verifying anything. That is how we are telling. Clear? Next one is interest against obligation. What is interest against obligation? For example, government officers, when they call for tender, say imagine one government officer, he has to accept a tender. 4 people will apply for tender. One person says 100 rupees per kg, one person says 50 rupees per kg, one says 200, one says 150. So as a government, from whom should we purchase? 100 or 200, 150 or 50? What if this person purchases from a person who is quoting 150 because he will give me 25 rupees per kg as commission? Can I do it? Will a government officer ever do it? Such people, do they exist in India? Ever? Nowhere, no? Yes or no? Yes. No, no, you should tell. Remember people, this is only called as interest against obligation. That means what? Your obligation is to select 50. But you are selecting 150 because you are creating your own interest out of it. Such things, if you are connecting people, the law is telling you it is opposed to public policy. Next one, consideration unlawful in part. A gave land to B for doing agriculture. In first half, I did wheat. In second half, I did weed. Weed, home. Weed means home only, no? No. Weed is home only, no? So anything lawful in part is legal. Any unlawful, I don't know. If anything unlawful, that is illegal. Understood? So here he did wheat, here he did weed. Anything that is unlawful is unenforceable. So this part I can go to court, I can get rent. This I cannot get rent. If it is unlawful. Unlawful home. Interference with course of justice. What is interference with course of justice? Going and bribing, your judge, going and bribing the opposite witness, going and bribing the opponent lawyer, not allowed. Agreements opposed to public policy. Next one, stifling of prosecution. Stifle means what, people? Stop. Stop means what, people? Remember people, if it's a criminal case, you have to take it to the court. You are not supposed to settle it outside the court. Remember it. That means what? A killed B. A went to B's home and said, anyways, soul is gone. What will you get? So, I'll give you 10 crores. Let us settle. If B's family says okay, is it okay? Is it a valid contract? Why? It's actually logical what he said. It's criminal. Remember people, if I allow this to happen, the killing and the murder, it becomes a business in India. That's why I'm telling opposed to public policy. Correct? It can be practical for you, but we will not allow it as a system. Whether as a family you want it or not, you have to come to court. Okay, next one. Maintenance and champerty. What is maintenance and champerty? Maintenance and champerty is simple, people. If someone, okay, there is A and B. A, okay, let us take our proper movie style only. A is a very powerful man in the village, B is a poor man. What will A do? A will be going on one road, Rolls Royce. He will look at one land, that land only villain will like. What will villain do? Villain will come and tell the poor man, hey, give me the land. Now what will the poor man do? He will give it off and then he will cry, looking at the air, Allah, sky. Okay, he'll look at the sky and cry. And then the short thunder will come, their hero will come. In the bus, one hero entry will come, correct? Yes or no? Now the hero will come and say, what is that, to the old person, don't worry, I will help you to get back your land. How will he help? He can help in two ways. One, I will give you money. You go and file a case in the court. And you fight for it. You will get back your money, no? That time, give me back my money. Yes? Isn't hero good now? He became a hero. Second scenario, same thing happened. Someone came and gave money now to the old man. What did he say? You go and fight the case in the court. Now the old man asked, what do you want in return? When you win the case, whatever you get, in that 50% you should give it to me. 50%. If yes, I will give you money now to help you to fight a case. Now people, what happened here? In the first example, people, the hero's intention is not bad. It is only to help. In the second intention, people, what? You are too greedy. What are you expecting in return is very unreasonable. The first one, people, is valid. That help is valid. The second type of help is invalid. You're taking advantage of a scenario. The law will come and say such agreements are opposed to public policy. Why? The person is taking an unfair advantage of the helpless man. He will tell, if I don't help, your entire property is gone. And you are expecting 50% in return? Ridiculous. Such type of helps is called as what, people? Opposed to public policy. So remember, maintenance and champerty by default does not become bad. They are good only. When will they become bad? If at all you are expecting unreasonable return, or why did you help? Because not to help you. I don't like him. That's why I helped you. Understood? Why did I help you? Not because I want to help you, the poor man. Because I don't like that fellow, I am helping you so that I can take revenge on him. My God, malicious motive? Malicious motive means, people, bad intention. If anyone is helping with a bad intention, again such agreements are considered as opposed to public policy. Simple. Yes, see, law is so simple. The last one, people, is called as wager. What is a wager, people? What is wager? Andar, bahar. Yes, people, wager means what, people? Gamble. Correct? Gamble, people, is considered as wager. Void. Correct? In India, people, wagering is considered as void. You cannot do wagering in India. Remember, people, wagering can be seen in lot of topics. I am only and only telling you from Indian Contract Act. According to Indian Contract Act, wagering is void. Yes. Sir, what are the transactions which are similar to a wager? First one is lottery transactions. Wager only, no. Anyway, you may get the lottery, you may not get the lottery. That's why what happens? Lotteries are illegal in India and hence it is also punishable. Okay, now. Only in Kerala. Yes, there are many states also. It's in Kerala. People, there is one state running with lottery. All gambling only when state is running. In fact, you can license also to do gamble. Casinos. Sir, dream destination now. Correct? Then, so that's why I said, before I started the topic only, I am only and only explaining from Indian Contract Act point of view. You remember, people, I told you state list, center list, union list? Lottery is a state list. Gambling is a state list. Every state can make their own law. Kerala said it is legal in Kerala. So, in Kerala, private people also conduct lottery, government also will conduct lottery. Huh? Private lottery is also there, government lottery is also there. Sir, so will it become valid or invalid? Whether private conducts or government conducts, it is wager only. Just that private person I can punish, government person I cannot punish. That's all. That's the difference. According to Indian Contract Act. But we are not seeing about reality. Reality is a very in-depth topic. Very, very in-depth topic. Clear? Lot of debates are there. Dream 11. How are they doing? My 11 circle. How are they doing then? Gamble only, no? And then? And what is that? A123, Rummy circle. How are you doing? Yeah? I am seeing one day, other day, some other student also is playing some game. Huh? Something like that. Betting. My God. What and all you guys are doing? Some aeroplane. Aeroplane will, you know that game? What is that? What is that game now? Someone knows. Someone said. Tell her what is the game now? Tell her. Huh? Siddharth. Huh? Hey, name of the game da. Holy Buddha. Airplane will be going. There will be 10 levels. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Which one da? Aviator. Aviator? That's a game. Hey, I'm promoting or what? Don't download. You'll lose. Full money gone. Yeah. So the aeroplane will be going. It will have 10 levels. You have to bet with money, 100 rupees. Where the aeroplane will crash. You have to say it will crash in level 2. Meaning it will go till here and it will crash. Level 3. Level 4. People are losing money in this. It's a betting app. So you have to bet 500 rupees on level 8. If it goes beyond level 8, money gone. Yes? See? He's playing. I know. Huh? They don't do all that. Bacha, first game you will pakka win. And that's the only game you will win. Trust me, after that you will never win in life. Okay. Crossword puzzle. What is crossword puzzle? Sudoku and all of that. So remember, if the prize of the competition, if it is decided based upon skill, then people, it is considered as not a wager. It is valid. If the winner is decided based on luck, what do you mean by luck? Let us put all the things, all the solutions in one dabba. Now how did you win? Because of your head or because of luck? Luck. If it is luck, people wager. So no sir, fastest fingers first. Whoever did first, then they will win. Then you won because of your skill. Valid. Understood? In their language, their. For him, I'll tell like this, he'll understand. Okay. 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 Wait there. What? Skill. Remember people. Okay, sir. You said fastest. Okay. I solved the puzzle faster. What is the prize money? If the prize money, people, if it is exceeding 1,000, wager. Less than up to 1,000 people, it is valid. Remember this. If the prize money does not exceed 1,000, valid. If the prize money exceeds 1,000, even if it is because of your skill, it is considered as wager. Same thing, people, with horse race. If the prize money is less than 500 people, it is wager. If it is 500 or more, it is considered as valid. There is a logic for this also. 1872, horse race was not for everyone. This, if I have to outright to tell on the face on a simple English people, they said poor people don't enter. This is for people who can afford. Yes, sir. That's the direct thing that they said on those days. That's why I came back. Yes, sir. So, or else in Bangalore and all we have it. Vijay Mallya was the king of this race course. I don't know if you guys know, there is a road called as Race Course Road. Anna had a track, one full heart of Bangalore. And I'll tell you one thing, he has taken one whole property for this horse breeding and horse, what do you say, like looking out for like a staple. 300 acres in Mysore. 300 acres. You should see that villa. Swimming pool will be in the shape of horseshoe. Horseshoe will be there, no? That U. It will be like that. Complete in that home, in the villa, the bar counter and all will be that horse saddles. Like when you're riding the horse, that saddle will be there, no? That is the shape of the bar counter. Anna, I'm telling 2002. This 26 Allah. Macha, he is the king da. Whatever you tell da. Anna was king only. Whatever he did, Anna went, Anna did something he did. But he lived king size. Yeah? Kingfisher, king size. What and all Anna did. Okay, next one people, speculative transaction. What is this? Share transactions, people. You do it in stock market, valid. Outside the stock market, it is considered as wager. Next one, sir, transactions resembling wager but are not void. Chit fund, not considered as void. Share market transaction, do it in share market, not void. Game of skill and athletic, up to 1,000, not void. Contract of insurance, again like gamble only, no? Like if you take insurance policy this year, will you pakka meet with an accident? Huh? You, sir, insurance is about to expire. I'll go and hit a tree. That's how you think? No. So you may meet with an accident. Yes or no? That's what they're telling you. Contract of insurance is also a gamble only. Contingent only, no? Yes or no? So that's your okay. It's called people. Okay, let's start with next unit. Unit 4, performance of contract. One is called actual performance, one is called as attempted performance. So whenever you enter into a contract, it is your duty to make sure you complete the contract. When you complete the contract, we call it as an actual performance. Sir, what if I tried to complete, but the other party was not willing to accept it? We call such things as attempted performance. Example, you have ordered something online, the delivery guy came to your home, he tried delivering, you didn't pick the call, you were not available. In such case, what will happen? They will go back. Correct? That is only called as what? Attempted performance. What will be the effect of that? Okay. Peace? All good? Tell them da. All peace? Tell them another 20 minutes, I'll finish it. Okay. Okay, now people, attempted performance means what, people? Once I try, Flipkart tried delivering you. Flipkart's obligation is done. If anything happens, people, it will not be Flipkart's responsibility. I tried. It is your responsibility going forward. That is the effect of it. Let us imagine if the product damages, it's not Flipkart's responsibility. I tried, you were not there. From that day onwards, anything happens to the product, the responsibility will be on the consumer itself, not on the Flipkart. That is the power of attempted performance. Clear? Understood? Okay. Now, sir, in a contract, who can perform the contract? The first thing is, people, always the promisor himself will have to perform the contract. A and B, whoever are the parties, they should only perform the contract. Who else will perform? However, there is a scenario where what if A dies? In such case, the next question we need to ask is, what type of contract is it? Does it have any special skill or talent involved? Like, is it painting? Is it acting? Is it singing? If there is any special skill or talent is involved, if the person dies, if it was singing, even the contract dies, the contract will become void. It will become a void contract. With the person, the contract will also die. Subsequent impossibility. Hello? Sir, no sir, the contract was, there was this TV, I should give this TV to the person. A had agreed to sell his TV to B. A died. The legal representative should sell this TV to B. The contract will not come to an end because does selling a TV need any special skill or talent? Nothing. So contract will not come to an end. So any special skill, contract comes to an end. No special skill, contract will continue. Legal representatives will have to go for it. Sir, what if any loan was taken? Legal representatives will be liable to repay, but only to the extent of assets they inherited. That means what? If I got a, imagine, loan of 3 lakh, if I got an asset of 5 lakh, the legal representative should pay 3 lakh loan, can take 5 lakh assets. But let us imagine, I got 3 lakh assets, 5 lakh loan as an inheritance. Law says you cannot compel him to pay the rest of the 2 lakh from his pocket. Whatever is the extent of your asset, that will be the extent of the liability also, not beyond your assets. Remember that. Clear? Okay, next one, sir. Agent can do, agency will do. Third person, a consideration may move from promisee or third person, Chinnaya versus Ramaya only, no? Yes or no? Last one, sir, joint promisers. What do I mean by joint promisers? When together people are taking loan, A and B together are taking loan from C. How much did we take? We took 2 lakh rupees. Yes? Now, sir, what does the law say? Let us imagine 3 people only are there. We have taken 3 lakh, 1 lakh each. Remember, we need to repay the entire 3 lakh. Sir, what if any person dies? Now A, B, C, who will repay? If any person dies along with B and C, A's legal representative, D, B, C will have to repay the loan. Sir, what if B also dies, C also dies, A also dies? Everyone's legal representative will have to pay. Sir, what if C becomes insolvent? C has a child. C becomes insolvent. Now, C's child, A, B will have to pay. No. C's child will not be liable. Only A and B will pay. Why will C's child pay? You forgot the logic. Assets, he became insolvent. Not even 1 rupee he will give it to the child. Why will child come and pay the loan? Not even 1 rupee loan will carry forward to the child. So A and B will only have to pay. Correct. Now that is correct. How much will A and B have to pay? 2 lakh or 3 lakh? 2 lakh or 3 lakh? Remember, you need to repay the entire 3 lakh. That 1 lakh should be shared between these 2 people. Understood? Of course, if an insolvent has any assets, use that assets. Anything beyond that, people, it is your duty to share. Clear? People, can this person compel money to be paid from any one person? Can I ask only C to pay? Yes. Later, can C recover from A and B? Yes, possible. Clear? Simple? Hello? Yes or no? Yes, sir. Okay. Now you'll say yes, no? Planning. Okay, joint promises. What is joint promise here? One person, king of good size, that is the next one, this person takes loan from a lot of people. Possible? One person taking loan from lot of people? Possible. Kingfisher only. From one bank he took. Everyone. Not even one person he left. Right to equality. All banks. You should not feel unfair, no, tomorrow. All banks. Always welcomes you. He welcomed and he went. Yes, so remember, in case of joint promises, what will happen, people? In case of joint promise, same thing. If at all any person dies, their legal representative will get the share. Sir, what if everyone dies? Whoever is a surviving person, he will get the entire money. Clear? Okay, time and place of performance, people. Generally, where will be the time and place of performance? Time on the agreed time. Place at the agreed place. If nothing is agreed, if it is my duty, I will check. If it is not my duty to check, then I should specifically ask, sir, where do you want me to deliver? At what time you want me to deliver? Understood?
Yes.
Okay. Next one, sir. Reciprocal promise, people. What is reciprocal promise? We already saw. What is reciprocal promise? When there are two promises, that is, I am also promising, you are also promising. That is called as reciprocal promises. Example, Amazon says I will deliver on 10th of August. I will say I will also pay on 10th of August. That is called reciprocal. We both have entered into a contract today, but the consideration both of us have not given. That is why it is called as bilateral executory contract. Remember. Sir, what are the rules? Promiser is not bound to perform unless reciprocal promise is ready and willing to perform. Amazon will not deliver you the product until you are ready and willing to pay the price. When one fails to perform, he cannot compel the other party to perform. Let us imagine, sir, Amazon came, you are not willing to pay it. You are not paying the money, but can you compel hey, give and Goda? I will not pay. So if you are not willing to pay, he will not deliver. Common sense. Order of performance. Macha, you do whatever you want. First, follow the contract. If contract is silent, follow that particular industry. Whatever they follow, you also follow that only. First, follow your contract. If contract is silent, follow the industry. For example, construction contracts. It is paid for every 25% completion. I'll give you 20 lakhs, he will construct one floor. Again, I give you 20 lakhs, he will construct one floor. That's how construction industry works. Hotel, pay and eat and pay. Both are there. Follow whatever is that particular industry. Understanding now? Next one. Reciprocal promises which are legal in part. If severable, then valid. Part is enforceable. Illegal part is void. What is that? One part is wheat. Second part is weed. Weed. Idu, home. Liability of party preventing the event. If any party prevents the person from carrying, hey macha, weed is done, concentrate. They're now feeling, what is that weed? Forget, aviator. Liability of party preventing the event. Contract becomes voidable plus entitled for compensation. What do I mean by this, people? Let us imagine if any party is preventing the other party from carrying on the contract. I am only stopping you. In such case, what will happen, people? The contract will be considered as void. Meaning, I need not have to perform. The contract will come to an end. And not only that, I can also ask you to pay compensation. I'll explain you this when we are doing a topic called as negligence. Remember. Next one is called as impossible act. Can we have impossible? Initial impossible, void agreement. Later on impossible, void contract. Initial impossibility, void agreement. Subsequent impossibility, void contract. Effect of failure to perform. If time is essential, you have to do it within time. If you do not do it within time, then what will happen? The contract becomes voidable. You will also be eligible for compensation. If time is not essential, then the contract is not voidable, but you are eligible for compensation. For example, I take money, like for example, there are so many coaching institutes, right? One of the coaching institutes, they have filed a case on this particular ground. They have taken money. Your attempt is January. What if the coaching gets completed on January? If your attempt is on Jan 7th, Jan 7th morning, they complete syllabus. Time is essential. You can cancel the contract, ask them to pay the entire money back, plus compensation. I can help you also. If you ask me what is, I can help you what is compensation. When similar cases happened in the past, one student, I'm coming directly to the summary. Yes, summary is, because of such thing, her or she becoming a CA got postponed by 8 months. Correct? You did not write in Jan. Because of that, you are writing in May. Yeah? Hello? You did not write in Jan, you are writing in May. Now what happened? I mean, that time it was only 2 attempts. So, she did not write it in the month of November, she had to write in the next cycle. So, because the classes did not happen on time, her result got delayed by 8 months. That means what? She was not eligible to write. I didn't know anything to write. I gave up the attempt. I wrote the next attempt. Now she filed a case. Now in the case what she filed, she said, me becoming a CA, the dreams were postponed by 8 months. And you know the compensation that was paid by the court? The court paid a compensation of 8 months CA fresher salary as compensation. Because she becoming a CA was delayed and pushed by 8 months. Compensation. Hello? Hello? Understood? Yes, sir. Huh? Time is essential, time is not essential. Cancel the contract, ask the complete money. If time is not essential, sir, you teach, sir, I'll write whenever the right time is at Muhurta and all, we should see. If you write whenever you want, time is not essential. You cannot cancel the contract, money will not be given back, but you can claim compensation. Hello? Clear? All of you? Hello? Yes, people. So, appropriation of payment. In appropriation of payment, what is appropriation of payment? Whenever one person has taken too many loans from the same person. Now, when I am repaying these loans, what happens? At what appropriation means what, people? Which loan am I repaying first? How would I know that? Now, say for example, we have taken 3 loans. Let us imagine one is in the year 2024, one in the year 25, one in the year 26. We have taken 3 different loans. Let us imagine the first loan is say 51,500. Second loan is say 1 lakh. The third loan is say 38,600. That's the loans we have taken. Now A has taken these loans from B. Agreed? Now A is repaying these loans back one by one. First A repaid, people, let us imagine 38,600. But he gave the money back to B in the year 2027 and he just left. Now the question is, how should we understand towards which loan did Mr. A repay the loan? Is it towards the first, second, third? How do we understand? Towards which did we repay first? 1 or 2 or 3? Which one? Did he mention? No, he didn't mention. Then, towards the first transaction? Hello? Remember people, the first option is always given to the debtor to choose. A can tell, I am repaying my loan towards 51,500 or I am repaying towards 1 lakh or I am repaying towards the third transaction. I can tell it. Who? A can decide it. That's the option number 1. Debtor expressly states to be taken as said by the debtor. That means what? A can decide I am repaying the loan towards which transaction. Is it first, second, third? It is always first on the debtor's choice. Sir, what if in our scenario, debtor did not communicate anything? He was just silent. In this case, what do I have to do? When debtor did not communicate anything, people, then remember, we need to see, does the circumstance, does it tell you something? Does a circumstance communicate something? What do I mean by circumstance? Circumstance here means, people, see, he has 3 loans, 51,500, 1 lakh, 38,600. If he is exactly repaying 38,600, the circumstances can tell me that probably he is repaying the third loan. Correct? Sir, no sir, he didn't repay 38,600. He repaid 50,000. Now what to do? That means circumstances are not telling us anything. So whenever the person is exactly repaying the same amount back, that means we will take it as people, circumstances are trying to communicate something. Now what is that they are trying to communicate? They are telling that I am trying to repay the third loan, that is 38,600, when I exactly repay 38,600. Understood? Option 1, debtor's choice. Option 2, circumstances. That's the word you need to remember, circumstances. Option 3, debtor is silent, circumstances are silent, it will be chosen by the creditor. Now creditor will tell towards which transaction I want to take the repayment towards. If the creditor is also silent, let us imagine he also did not say anything. If creditor is also silent, people, then I will take the loan towards the FIFO method, that is first in, first out. In this order, people, it is irrelevant whether that particular debt is time barred, not time barred, it doesn't make any difference. Even if it's a time barred debt, you can still take the repayment, allowed. Understood? Yes, sir? Yes, that is what is called as people appropriation of payment. So you need to remember 4 here. First one is in the order of debtor, whatever debtor chooses. Second one is whatever circumstances chooses. Third one is if both are silent, then we will go to the creditor. If creditor is also silent, we will go in the FIFO method. All these transactions, including the time bar debts, can be repaid. Remember and go. Exam point of view, appropriation of payment important. Clear? Okay. Next one, sir. Contracts which need not be performed. Contracts which need not be performed. What do I mean by contracts which need not be performed? That means, people, nothing but we have entered into a contract, but after some time the law is telling it's okay, you can discharge it, you can stop this contract, you need not have to go ahead. What are those contracts where we need not have to proceed, we need not have to go ahead? What do we call those contracts? Why does it become like that? It becomes like that because of, people, 3 scenarios. The first scenario is called as mutual agreement. Section 62, try to remember. The second scenario is called as remission. The third scenario is called as, people, negligence. 3 scenarios. In these 3 scenarios, people, the contract you entered will come to a temporary halt. It comes to an end. When the first one is called as mutual agreement. Under mutual agreement, people, 3 further scenarios can come. One is called as novation, rescission, alteration. What do I mean by rescission? What do you mean by novation? What do I mean by alteration? Novation means, people, when there is already a contract, that contract gets replaced by a new contract. I repeat, when there is already a contract, you have entered into one term and conditions. You have already entered into one document. Now this existing document gets replaced completely by a new contract. Old contract goes out of the picture. It gets replaced by a new contract. We call such process as novation. Hello? Sir, we didn't understand. Let us imagine, people, there is a person called as Mr. X. They came and took admission with ArivuPro. We issued invoice, everything is done. In attendance registers, in every place, they have written the name of Mr. X. Now let us imagine X says, no, I have a change of plan. Now I do not want to pursue. Let us imagine Arivu says, we are so sorry, sir, we do not have a refund policy. But if you want, you can transfer your seat to someone else. What does Mr. X do? Mr. X will transfer his seat to Mr. Y. Macha, you pay me, I have already paid. Can you please give me that money and can you go to the classes on behalf of me? Can you do it? Now what happens? Mr. Y agrees. Now Mr. Y comes and joins to ArivuPro. Now what will ArivuPro do? The same agreement, whatever we agreed with X, in all the places we will remove X's name, we will write Y's name. The agreement rest all will remain the same. I would have given you an invoice. I will strike off X there. I will write Y there. I'll give it back to you. Attendance register, X I will strike, I'll keep Y. Hello? Rest all is the same. The name of the party changed. It is called as novation. Hello? Understood? Apart from that, if anything else change, we will call it as what people? Alteration. What do I mean by alteration? Let us imagine people, when we both entered into a contract. Yeah? Let us imagine the fees was around 20,000. Now, because of some revision in, something, some changes happened. Because of that, people, we are revising the fees. The 20,000 is becoming 16,000 now. Because of some revisions. Now, we have agreed for a contract of 20,000, but because there are revisions now, what will I say? People, because there is a revision, please bring back your agreement. We will refund you the 4,000. We have to change the invoice value. We have given you 20,000. We will strike it off. We will make it as 16,000. In the existing agreement, there are some terms getting changed. Hello? Are you understanding? If in the existing agreement, if some terms are getting changed, we call it as alteration. Now you should ask me a doubt, sir, name changed. You call it as novation. An amount changed. Why are you calling it as alteration? Why? Remember people, the book and the law specifically writes, whenever a party itself is changing, that's not a small change. It's a very big change. So don't call it as an alteration. You have to consider it. You have to assume it as a novation. Who said? I didn't say. Law only said. That's why we are taking only the change of name directly as a novation and not as alteration. Except that anything in the existing agreement changes, you have to consider it as alteration. Example, sir, there was a loan agreement between me and the bank. I have taken loan from a bank. How much? I have borrowed 5 lakh rupees. Hello? I have borrowed 5 lakh rupees. The interest rate was people 8% per annum. Now after 3 years, my CIBIL score increased. So the bank wants to reduce the rate of interest from 8% to 7% because I'm doing good. My credit rating is good. Now in the same existing agreement, people, if the rate of interest alone is coming down, people, I will call it as what? I will call it as alteration. So in the existing agreement, the terms can change anytime. If it is changing, we call it as alteration. Hello? Understood all of you? Yes, that is called as alteration. The third one is called as people rescission. Rescission means what, people? Rescission means nothing but cancellation. What do I mean by cancellation? Yesterday I told you an example, right? You join to an academy, they do not finish the syllabus on time. What do I call it as? I call it as, now who cares when do you finish? I will call it as people rescission. They can tell, oh, we completed, no, you have to pay the fees. I will say time is essential. If you complete on the day of the exam, what is the use? And hence the student can go and tell, I want to cancel the contract that happened between you and me. Hello? Hello? Cancel. If I cancel, I am eligible to get back my money. Rescission. Hello? Sure? Okay, that is the 3 terms. So mutually you guys can agree and you guys can enter into novation, alteration as well as rescission. What is the next one, sir? Next one is called as remission. Remission means what, people? Remission in short, in simple words, I can call it as people to give up. Remission means what, people? To give up. What do I mean by give up? Give up means nothing but, people, at times we enter into compromises, right? What do I mean by compromise? Let us imagine I have taken loan from a bank, 10 lakh rupees. Now I am not able to repay this loan. What do? I go and tell to the bank, Sida macha, I don't have money. Yeah. So I either will become an insolvent, I will not pay you 1 rupee, or I have 6 lakh rupees. Let us settle it as full and final settlement. I have to repay you 10 lakh rupees, no? Instead, I will repay you 6 lakh rupees. You have to leave me forever. You should not come back and haunt me. Let us imagine if bank agrees. Instead of 10 lakh, if bank agrees to settle the matter for 6 lakh, take 6 lakh, leave it. Bank in the future, even if I earn money, even if I become a crorepati, bank cannot recover the rest of the 4 lakh from me because you have agreed in writing today to settle the matter for 6 lakh rupees. In the class, I give you the example of Kingfisher. Kingfisher, the total debt that Vijay Mallya had to repay was around 9,000 crores. Vijay Mallya, before he went to UK, Vijay Mallya did a final offer of people 5,500 crores. He said, I will pay. And that's the maximum I can pay. That's what I can afford today. Vijay Mallya did an offer, but the banks did not agree. The bank said, you have to pay me 9,000 crore. How can I agree this 5,500 crore in the place of 9,000 crore? Are you understanding? So, if at all, let us imagine the bank had agreed. If it has agreed. Now, even after Vijay Mallya earning back, if Vijay Mallya became a billionaire after that, bank cannot recover that, whatever is the rest of the amount. 9,000 crore, I have taken 5,500 and I have settled. Bank cannot come in the future and say, hey, our contract was 9,000 crore. That day you paid only 5,500. Now pay me the rest of the amount. You cannot come and demand it in the future. Why? Today you have agreed. Who? Bank. What have they agreed? I have given up my right. I will not recover whatever is the rest of the 3,500 crore. I have agreed in writing, right? That is called as remission. The bank has given up its right. And hence, I need not perform that 3,500 crore in the future. Understanding? Yes, sir. So remember, remission means people compromise. Once you compromise people, you will lose a right to recover the money in the future. Understood? Done. The last one, sir, negligence. What is negligence? Carelessness. People, please revise and come. People, please do writing practice. People, please take up mock tests. People, please revise along with the teacher. I tell everything. What do you do home? After going home, what do you do? Book ka aisa pakad ke, aisa maar ke, or someone will be there on the road. The person who will be doing either groundnuts or belpuri will say, Anna, paper venuma. Paper. Inkitta full book irku. Ange book kotputtu, ange going home. Correct? That's what we do, no? So remember, there is a contract between me and you. What? Let us clear CA foundation. I am there. I am here. Whether if you are there in the contract or not decides the contract is enforceable or not. Machas, if you neglect, the contract is discharged from my end. ICO, pass guaranteed batch. Hello? Correct? Yes, sir? Pass guaranteed, provided negligence shouldn't be there. Make sense? Hello? Yes? That is what is called as people. Promiser need not perform when promisee neglects performance. So in a contract, when one party is serious, the other party is not so serious, the first party is discharged. Your fate, they say. I mean, in the contract, whenever a person is negligent in the contract, the first party is automatically discharged, right? Yes or no? That's what the law says. Whenever one person is negligent, the other party is always discharged. Understood? It's not applicable for all of us. We will all clear for sure. Yes or no? Someone else I said this example. Correct or not? You should have confidence. Yes or no? See, then next one, sir. Discharge of a contract. When is a contract discharged? The contract is discharged by performance. Done. Next one, mutual agreement, waiver, negligence. Whatever we saw on the top, contract is discharged. Next one, impossibility of performance. It is also called as subsequent impossibility, also called as supervening impossibility. All are same. Words can be asked anyway. Remember and go. Next one, discharged by lapse of time. Impossibility of performance is nothing but example what? Destruction of subject matter. I entered into a contract to give you phone, microphone, mic. This drops, breaks. Can I give it to you now? No. Impossibility of performance. Understood? A person said, I'll paint it and give it to you. He passed away. Impossibility of performance. Void contract. Subsequent impossibility. Hello? Hello? Okay. Discharge by lapse of time. Discharge by lapse of time. What do I mean by discharge by lapse of time? Discharge by lapse of time means people nothing but time barred it. Agreed? Yes, sir? I will tell them 100 times. Okay. Discharge by lapse of time. What do you mean by lapse of time? Time bar debt. If at all debt you cannot recover within time, 3 years you have to go to court. What if I don't go to court within 3 years? Never go. Never go, that's all. There is no use. Clear? There is an act, people, just for our information. It's called as Limitation Act. You generally complain, no, in court, sir, there are cases pending for years. Why will it be pending? Because you go to court late. Where will you guys submit evidences? After 5-6 years, will evidence be there? There's a movie called Talash in Hindi. Watch it. In that, you will see the police people will go to the investigation spot. There will be a murder, real life story. Yeah, very unfortunate story. One daughter will be killed. So they have to take fingerprints. Whoever did the murder, that person's fingerprints will be there on the wall. The murder would have happened on terrace. So there will be complete fingerprint of the murderer. The police people will not take the fingerprints on that day. They will say, let us take it the next day. Because it was a little late. They will leave. The night, people, there will be heavy rain. Complete evidences are gone. And because of that, that case even today is an unsolved mystery. Sir, so what? Casual only? No, that's not casual. And the end of the day, who got arrested? The parents were arrested. There is a blame that the parents only did the murder. The parents say that no, the worker in the home, whoever works, they did the murder. But who went to the jail? The parents went to the jail. If I'm not wrong, I think around 3 to 4 years, the father was in the jail. Talash, that's a case. Evidence, lack of evidence. Now you tell me, one day if it can change so much, what if the case is filed after 3 years? What will you prove? Where will your evidences be? Understood? That's the seriousness of the evidences. That's the meaning of Limitation Act. You need to come to the court within right time. If you do not come to the court within right time, the courts will not help you. Next one, people, by operation of law. The contract is discharged. What do I mean by operation of law? Change in law. India, Pakistan were bye-bye. It became again bye-bye. Correct? We were brothers, sisters for a long time, and then we fought alien enemies, right? Next one, North Korea also I told you, effective 2017, April 2017 onwards, Indian government gave us 180 days time to cancel all the contracts with North Korea. After 180 days, no contract will be done with North Korea. 180 days time was given in April 2017. Understood? Yes, that is only called as operation of law. Next one, people, breach of contract, nothing but next chapter, merger of rights. What is merger of rights? When a person becomes, okay, for example, people, let us imagine I have entered into a contract with this landowner saying that we want this particular floor on rent. We have taken it, or let us imagine, we have taken it on lease for 5 years. Now, 2 years past, people, we love the locality, the business is going good. Now, what did we decide? We thought, why don't we, instead of renting it, why don't we buy it? So, after 2 years, we decide to buy the land. So, with the same landlord, we go, the first one was for rent, we go and say, after 2 years, we want to buy this land. He also agrees, we also agree, we will arrive at one price. and we will enter into a new contract. This was a rental agreement. This will become a sale deed. Now, if you look at it, people, between A and B, there are two agreements for the same time period. Okay? One, we have rental agreement, which we had agreed for 5 years. Lease, we had given them some money. Now we are going and entering into a contract with the same person for buying this particular property. That means what? There are two agreements at the current point of time. One is rental, one is sale. This type of scenario is called as what, people? Merger of rights. That means two contracts will coincide. In that case, what will prevail? The law said whichever is superior will always prevail. What is superior in rent and sale? Remember, it's always sale. So the rental agreement will come to an end. The sale agreement will always proceed. It's a kind of novation. You can consider. It can be novation also. Yes, possible. Because there will be a replacement of an agreement. But remember, what is the difference between novation and this scenario? Scenario can be similar to novation, but in novation, there will be an agreement between two parties. The terms and conditions will change little. The party's name will change a little. Here, the whole purpose of the agreement itself is changing. So, one agreement is getting replaced by a new agreement. But what type of agreement it is? Is it the same rental agreement or is it completely a different one? Completely a different one. We cannot directly call it as a novation. But yes, scenario can be similar. Now, someone asks, sir, in exam, which one to write? Should we write both? Should we write novation as well as merger of rights? As I always tell you, when there is a specific point which relates more, it is your duty to write that more relatable point. Yesterday I told you, right, one scenario can be similar to two topics. That scenario you will come across in law. And that too I am telling you off late in your question paper. When we are taking up the question paper, I will tell you. I am telling you, people, you should be thankful to the the person setting up the question paper. I will tell you why also. If you guys read the question paper properly, and any person who has revised the book at least two to three times, you cannot fail. Why? The answer is already there in the question only. He would have given you all the possible hints in the question only. This is what it is. This is what it is. Today's date, the question is so safely framed. Earlier, it was like they used to frame it on the top and they used to tell you to discover. Now, I'll show you. When I'm showing it to you, you will understand better what I'm trying to tell you. Yeah. So now you can come across novation. You can come across this also. You will write whichever topic suits the most. In the given case, we have novation, we have merger of rights also. The scenario is similar to merger of rights. I will choose to write merger of rights and not novation. Understood, all of you? Yes. That is called as merger of rights. Clear? Yes, sir. That's your unit 4. Yes, people. Let us do unit 3 questions. Okay, start. Ordinarily, a minor's agreement is void ab initio. Consent is not said to be free when it is caused by all of this. When the consent of a party is obtained by fraud, the contract is voidable. The threat to commit suicide amounts to coercion. Moral pressure is involved in the case of undue influence. Yes, people. Next one. A wrong representation when made without any intention to deceive the other party amounts to misrepresentation. See, a wrong representation without intention to deceive the other party. If I say with, this becomes fraud. Which of the following statement is true? A threat to commit suicide does not amount to coercion. Undue influence involves use of physical pressure. Ignorance of law is no excuse. Silence always amounts to fraud. Silence always amounts to fraud. Ignorance of law is no excuse. Which one we are talking about? Mistake of Indian law. That is the pointer. 7C. In case of illegal agreement, the collateral agreements are void. An agreement, the object or consideration of which is unlawful is an agreement, the object or consideration of which is unlawful is void. An agreement is void if it is opposed to public policy. Which of the following is not covered by the heads of public policy? Which one now? Trading with an enemy, trafficking in public offices, marriage, brokerage, contracts, contracts to do impossible acts. Trading with an enemy, trafficking in public offices, marriage, brokerage, contracts, contracts to do impossible acts. Which of it is considered not as opposed to public policy? Marriage, brokerage, contracts, yes or no? Yesterday only I explained you. The answer is what? Contracts to do impossible acts. Why is impossibility opposed to public policy? That's just a void agreement. Hello. Next one. A paid 5,000 to a government servant to get him a contract for the canteen. The government servant could not get the contract. Can A recover 5,000 paid by him to the government servant? Yes, the agreement is opposed to public policy. No. No, the agreements are voidable agreements, can be avoided by A, and or no, the agreement falls under section 23 and hence illegal. Which one da? Yes, the agreements are opposed to public policy. With regard to the contractual capacity of a person of unsound mind, which one of the following statement is most appropriate? With regards to the contractual capacity of a person of unsound mind, which one of the following statements is most appropriate? Which one da? A person of unsound mind can never enter into a contract. A person of unsound mind can enter into a contract. A person who is usually of unsound mind can contract when he is at the time of entering into a contract of sound mind. A person who is occasionally of unsound mind can contract, although at the time of making contract is unsound mind. Which one? See here, a person who is usually of unsound mind can contract when he is at the time of entering into a contract of sound mind. Correct. An agreement made under a mistake of fact by both the parties forming the essential subject matter will be considered as void, voidable, or valid. Bilateral mistake is always void. Consensus ad idem. There will be no meeting of the minds. That red car, white car. A is in the dire need of 1 lakh but was unable to get any loan from banks as he had no security to offer. A approached his friend B, who, knowing the helpless position of A, lent money at a very high rate of interest, saying that he had himself borrowed money from C. The contract is vitiated by undue influence that B had exercised over A due to his close friendship. Void as the rate of interest being very high was unconscionable, not valid as B had wrongly misled A that he had borrowed money from C. D, valid as a friend, could not be supposed to have wielded undue influence only because money lent carried higher rate of interest. What is the answer, da? If you ask me this now, people, this is in your exam point of view, I wouldn't say these are the questions which will give you grace marks. Yeah? How do you understand the complete scenario? All ifs and buts. Yeah, from textbook point of view, they can give, they might have given an answer. From exam point of view, such questions will not be asked, or you will be allowed to write a explanation like an assumption. If it is asked in a theory form, in MCQ, of course, you will have to choose whatever is there. But from a theoretical point of view, such questions cannot exist. Everything they have only put. What? A friend cannot cheat. Oh, what nonsense. Yes, all assumptions only. But in theory, if they ask you, you're free to write with an assumption. See, how can I interpret this? I myself borrowed from CA. Then I will take higher rate of interest from you. That is also right only. How do I assume? it was vitiated by undue influence, or C, not valid as B had wrongly misled A that he had borrowed. How will you know? So if you ask me, a nonsense question only. Yes, sir. Absolutely. I'm telling you on the face only, nonsense question it is. Such questions cannot come because everything is an assumption here. Are you getting the point? If such questions come, what to do, sir? That is when people, I hope you guys know, there is always a chance of moderation. I hope you have heard of moderation, right? You can be allotted grace marks. I hope you know. People get 5 marks, 7 marks, 9 marks and all as grace marks because of this moderation. So remember always, never leave any question. It is your duty to write everything. Please write and come everything. If you have not attended, then you will lose an opportunity to get that moderation marks. So it is your duty to attempt it and come. Hello? Understanding? 14, what have they given? D. Which one? Valid. See, as a friend could not be supposed to have wielded undue influence only because the money lent carried Sida. Assumption, Damacha. Complete assumption. I would say rather, see this. Why this one? According to the book, if I have to tell you, this is called unconscionable bargain. If someone takes use of your your helpless scenario, that is called as unconscionable bargain. So such questions won't come. Don't worry. Clear? Yes, sir. Okay. Next one. Which of the following is not an exception to the rule that agreement in restraint of trade is void? Which of the following is not an exception? Which one, da? A partner can be prevented for carrying on similar business. An outgoing partner can be restrained on carrying similar business. On dissolution of firm, partners may agree not to carry on similar business. The seller of goodwill of business can be prevented for carrying any kind of business at any place. Which one, da? Which of the following is not an exception to the rule of agreement and restraint of trade? Which of the rule is not an exception? B. An outgoing partner can be restrained on carrying similar business. That one. D. D is the answer. I don't think we did yesterday this void agreements, right? Agreement in restraint of trade. That is one topic which we didn't do. Okay. Agreement in restraint of trade. What will happen, people, generally? Whenever you are imagine whenever you are entering into a contract with someone, say for example, if you are partners A, B and C, in that partnership agreement, you are free to add a clause that when you are a partner in my partnership firm, you are not supposed to do the similar business elsewhere. That type of restriction is called as restraint of trade. Agreement in restraint of trade. Such agreements, are it valid? Yes, people, they are valid. Now, for example, ArivuPro, can they impose a condition? As long as Sai Sir is teaching in ArivuPro, Sai Sir cannot teach in any other place. Can they impose such restriction? Answer is yes. Why? Agreement in restraint of trade. Now, can I go and say, no, this restraint is void. How can they stop me from going and doing my job somewhere else? Can I go and file a case? Hello? It is valid as long as someone is working in one place. You are not supposed to work in other place. Such restrictions are valid. Hello? Understood? Now let us imagine, what if the agreement is like this? You work here, you leave. You are not supposed to again teach for the next 10 years. Is this restriction valid? No. Now I can go and say, this is an agreement in restraint of trade, which is tying my hands forever. 10 years is like for a very long period. What if the restriction says you are not supposed to teach in the same locality, say Koramangala, but you can go and teach in any other place. But in Koramangala you cannot teach. Is it restriction valid or invalid? This will be considered as valid. Why? This is a reasonable restriction. Hello? Are you understanding? So anything which is reasonable will be valid. Anything which is unreasonable, that will be considered as void. Understood all of you? Yes? Okay. Remember that and go. Huh.
They are asking for not an exception. The selling of a goodwill is an exception of the case of vesting of credit.
Mm-hmm.
Sir, selling of a goodwill is an exception.
See, which of the following is not an exception? This is an exception. A partner can be prevented. Selling of goodwill can be prevented for carrying on any kind of business at any place. In a particular place, yes, it's an exception, but not at any place. Correct. Yes. So this is unreasonable. An agreement to pay money or money's worth on happening or non-happening of a specified uncertain event is a an agreement to pay money or money's worth on happening or non-happening of a specified uncertain event is considered as a contingent contract, but if it becomes unlawful, it becomes a wagering contract. A wagering agreement in India is declared by the Contract Act as illegal and void but not illegal, voidable at the option of the aggrieved party, immoral. What is the answer? Illegal and void but not illegal, voidable at the option of the aggrieved party, immoral. What is the answer? Immoral. Void but not illegal. Remember, lottery transaction alone is considered as illegal, not all the wagering agreements. Hello? Hello? Remember, na? And here also I told you, this is a state specific law. That and all is only for our information. Don't write off in your exam and all. Yes? Now, next one. An agreement, the object of which is to procure a public post is void, voidable, valid, defective. Void, trafficking of, what is that? Public offices. While obtaining the consent of the promise, keeping silence by the promiser when he has a duty to speak about the material facts is considered as fraud. A enters into an agreement with B, who has robbed A of 10,000 rupees to drop prosecution against him in consideration of B's returning 8,000. Afterwards, B refused to pay. A can get from B 8,000, 100, nothing, 10,000 plus damages. What can A get? 8,000, 100, nothing, 10,000 plus damages. First of all, what type of agreement is this, people? A has robbed B. A enters into an agreement with B, who has robbed A. Okay, B has robbed A. A said, I will go and file a case on you. B said, don't know, please don't file, I will give back 8,000 rupees. Let us settle it here only. Please don't go and file a case. Can they settle the case? Is it allowed? Can I settle it with a robber? Robber agreed to give me back the money, and I also agreed, okay, I will also not go and file a case. Is it possible? What is the provision? Under what you can say that no such agreement cannot happen? What is the provision? Under which topic you will write this? Agreement opposed to public policy. In that there are 9 topics. In that which one this will come under? Stifling of prosecution. You are not supposed to make a trade of felony. Criminal offences cannot be settled. Yesterday I told you, people, A goes and kills B. Can B's family accept 1 crore? Not possible. In a similar way, a theft is a criminal offence. Hello? You cannot go and settle it with a robber. Sir, what if we have entered into an agreement? That agreement is void, opposed to public policy. I will not get 1 rupee also, nothing. Hello? Because that agreement is not enforceable in court of law. That agreement is opposed to public policy. If you have entered into a settlement, how will I enforce it in the law? Hello? Okay. On attaining the age of majority, a minor's agreement cannot be ratified, becomes valid, can be ratified, becomes void. Cannot be ratified by him. A threat to kidnap one's son in consideration of 5 lakh is void because of a threat to kidnap one's son in consideration of 5 lakh is void because of inadequacy incompetency, absence of day, all. It is wrong question. See, absence of free consent. Question is wrong, da. This is unlawful, da. It should come under unlawful. What is the absence of free consent? Hello? One thing that you can say is it can come under coercion. That is also one possible because it is a threat. Yeah, but it can also come under unlawful act also. But yes, you can take it under coercion. C can be the more relevant one. In which of the following case aggrieved party can sue for damages? Fraud, mistake, undue influence, misrepresentation. Yesterday only I told you. Fraud. So fraud, you can cancel the contract, get back your money, also claim for compensation as well. A mere attempt to deceive a party to a contract is fraud even though the party is not deceived. Is not fraud unless the party is actually deceived. Amounts to coercion, amounts to misrepresentation. What is the question now? What is the answer? A mere attempt to deceive a party to a contract is fraud even though the party is not deceived. Is not fraud unless the party is actually deceived. Is not fraud unless the party is actually deceived. If I have not cheated you, why is it called a fraud? Only it will be called as a fraud if I have cheated you, right? Unless if I have not deceived you, why will it be called a fraud? B is the answer. Okay. An agreement, the meaning of which is not certain, is void. Discuss, people. What is that? Nothing but people offer acceptance. We saw no. Everything has to be certain. Technically, they are telling you an agreement will be considered as void if it is vague. So, unless the contracts are certain, specific, and clear, the agreement will be considered as void. That is a particular answer. Though a minor is not competent to a contract, nothing in the Contract Act prevents him from making the other parties bound to the minor. Discuss. So rules of minor, people, we clearly saw one thing. A minor can always be a beneficiary. So anything that gives benefits to the minor, he can do it. Anything that makes the minor liable, such agreements are void. So any contract which gives benefits to the minor or which makes him a beneficiary, such agreements are considered as valid. That's this particular point. Next one. See, direct question. Hello. Example. This is what yesterday I told you. It's a direct question. Please try to write example. Next one. A student was induced by his teacher to sell his brand new car at the rate less than the purchase price to secure more marks in the examination. Accordingly, the car was sold. However, the father of the student persuaded him to sue his teacher. State whether the student can sue the teacher. Yes. Which ground? Absence of free consent under undue influence. Explain the concept of misrepresentation in matters of contract. Sohan induced Suraj to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, Suraj complained that there were many defects in the motorcycle. Sohan proposed to get it repaired and promised to pay 40% cost of the repairs. After a few days, the motorcycle did not work at all. Now Suraj wants to resign the contract. Decide giving the reasons whether Suraj can resign the contract. This is the case of people misrepresentation. Remember, the bike was not working. Now you have an option to give back the bike, take back the money. But what did the fellow do here? The fellow said, I will take repair charges from you. You repair and give it to me. The seller repaired the bike and gave it to him. And then again the bike stopped working. Can I go and cancel the contract now? Answer is no. Remember, in the case of misrepresentation, you will have a chance to cancel the contract, give back the product, get back your money only once. When the first time you went and took the repair charges, you have taken the benefit of the contract already. You will lose the right to resign the contract in the future. because you accepted the repair charges. On those grounds, this particular person, I think Sohan or Suraj, Suraj will lose a right to resign the contract because he has accepted the benefits of the contract. Hello? Understood? Yes? Okay. Next one. Mr. Samant owned a motor car. He approached Mr. Chotu and offered to sell his motor car for 3 lakh rupees. Okay. Mr. Samant told Mr. Chotu that the motor car is running at the rate of 30 kilometers per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Mr. Chotu agreed with the proposal of Mr. Samant and took delivery of the car by paying 3 lakhs to Mr. Samant. After 10 days, Mr. Chotu came back with the car and stated that the claim made by Mr. Samant regarding fuel efficiency was not correct, and therefore there was a case of misrepresentation. Referring to the provision of Indian Contract Act 1872, decide and write whether Mr. Chotu can resign the contract on the above grounds or not. Can Mr. Chotu resign the contract? Possible? Yes or no? Hello? Can Chotu resign the contract? Yes or no? Now people, see the art of looking at the question. I told you, be thankful to the question paper setter because in the question there will be an answer. Every word used in the question will be used for a purpose. The particular provision, the question that they have given, it clearly says both the fuel meter and the speed meter of the car were working perfectly. Remember in the question, people, there will not be words used casually. Simply they will not put some line. There will be a meaning for it. In the exam, what student misses to see is this. Now what is the meaning of this particular sentence? Why did they have to use it? Let the buyer be aware. Whoever wrote caveat emptor, you will get the mark. So when the buyer has all the means to see and buy, and if you buy it with negligence, people, remember we will not consider it as misrepresentation or fraud or whatever is the scenario. When the speedometer, when the digital meters, when everything is working, it is your responsibility to check and then buy. Hello? Caveat emptor. Understood? Hello? This is what I am telling you. In question, there will be every possible word to help you. It is your responsibility to read the complete question. Don't pick up the answer from 1 or 2 words. Hello?
What if while buying everything works perfectly, but after some days it doesn't work? What if we can cancel it or we can claim some damages?
Like
while buying everything is working perfectly, but after some days it doesn't work. While we can claim damages or we can cancel the contract.
See, one thing is we need to check the intention. Whether did the party cheat you that for the first few days you cannot make out. After that you can make out. Did the party cheat you? If yes, it becomes fraud. If no, it becomes misrepresentation. Then you can claim whatever is the, if you want to cancel the contract, you can go and cancel the contract. That is
how we can find that he is cheating us.
See, always remember, fraud and misrepresentation are proven in the court. I might have done fraud, but if I can convince the judge that I did it unintentionally, then I will always prove it to be misrepresentation. So remember, from our book point of view, it is easy to tell. They will tell you it is a case of fraud, it is the case of misrepresentation. That's why in your book, they will clearly give you that it is a case of misrepresentation. They will only tell you. They will not tell you fraud or they will not tell you to figure out. But do not try to combine the book with reality. Reality and books are absolutely different. People, I'll tell you, you would have done a mistake. If I come and ask you, have you done? Don't you think you will try to defend yourself? Anyone, that's the nature, people. So someone who did a fraud, you really think in the court he will go and agree that I did a fraud? He will say, I did it by mistake only, he will say. So when will it become a fraud? If the parties prove, sir, no, he didn't do misrepresentation, it was fraud. I will prove it with evidence, see sir. That is how in reality it happens. Here, okay, next one. Ishan, aged 16 years, was studying in an engineering college. On 1st March 2018, he took a loan of 2 lakhs from Vishal for paying off his college fee and agreed to pay 30th May 2019. Ishan possesses assets worth 15 lakh. On due date, Ishan fails to pay back the loan to Vishal. Vishal now wants to recover the loan from Ishan out of his assets. Decide whether Vishal could succeed referring to the provisions of Indian Contract Act. Yes, people, can I recover? Minor has borrowed loan. Can he recover? Yes. So see, how do I present the answer? First thing, people, your first para will always be provision. So your first, see, try to divide your question into, say, 3 things. Now, let us take this particular thing only. Let us try to take, now say for example, how do we present this particular question? Let us do one practice also. What is that? First one, people. Now, which section? Absence of competency of parties. So, what will I write? As per section 11 of Indian Contract Act 1872. Now, what is it, people? A contract to be valid should be entered by parties competent to the contract. Correct? Competent to the contract, which means they are supposed to be major, sound mind, not disqualified. They am just scribbling the not disqualified. Correct? However, a minor will be bound if the contract is entered for the purpose of necessaries. Yes, if you want to go a little beyond, right, necessaries like education, food, shelter, etc. Hello, this is my provision. Did I use any of the names in the question? They would have given you some name. Ishan. Did I use anything about Ishan? Did I answer yes? Did I answer no? Your first paragraph should not be answering the question. Your first paragraph should just be copy paste of what the book says. Now coming to what people say. Now you tell me, did I use a textbook language? I used my own language, but I made sure I was able to reproduce whatever are the important words. Hello? Now what do I do, people? Competent parties. Now when you are underlining, what you do? You need to make sure you have to underline these words. Whichever are important, underline. Hello? Now what will I write? In the given case, Ishan aged 16 years has borrowed whatever 2 lakh rupees from so and so for his education, and he has assets worth 15 lakh rupees. the question is Ishan liable to repay the loan? This is my facts. Did I use my brain to write this? Absolutely no. Don't you think this entire information was there in the question only? Remember, facts has to be as less as possible. My provision, look at how many lines. Look at how many lines is my facts. Maximum 2, above 3, in maximum is 4, not beyond 4 lines. Because remember people, I know, you know, examiner knows that you guys are not inventing anything there. You are just copy pasting the answer from the book. Every one of us know. This literally, I'll show you the answer scripts. This will not even be allotted 1 mark. No matter how much time you spend. So what am I trying to tell? Don't waste time in writing the facts. In fact, I'll tell you one more thing. Write the facts for the first 5-6 questions. After that, people, even if you don't write, it's okay. Are you understanding? Because remember, provision and conclusion is more important. Even if this is right, they will not give you even 1 mark for this. So then this is waste. You will get mark when imagine your provision is way too good, your conclusion is way too good. You're getting 4 on 5. That time to make it 5 on 5, they'll allot 1 mark for this. As an overall question, they will allot you 5 on 5. But let us imagine provision is gone, conclusion is gone, facts so beautifully I wrote here, nothing they'll give you. Are you understanding? All of you? Getting a point? So this is how you need to present it. Now come to conclusion. What will I write? I'll write referring to the provision and facts. What? Mr. Ishan will be liable to pay rupees 2 lakh from his assets. Clear? Hello? Yes, this is how I have to present my answer. Write down this much, more than sufficient. Clear all of you? So all the questions will always have 3 paragraphs. Some questions where you have case laws are there. No. Now let us imagine if this was not education, it was some casual loan. Now can I recover? No, I cannot recover because it is a minor agreement. Hence I need to write void ab initio. Do we have any case law for a minor borrowing loan? Do we have any case law? We have a case law called Mohari BB versus Dharmodas Ghosh. Write it down as an additional paragraph when you guys have a case law. If case law is not there, it will have only 3 paragraphs. When you have a case law, under the facts, please use the case law name. The facts in the question are similar to a decided case law called Mohari BB versus Dharmodas Ghosh. Again, I repeat the word. The facts in the question are similar to a decided case called Mohari BB versus Dharmodas Ghosh. That will be my 3rd paragraph, and write down the conclusion as your 4th paragraph. That's how you present it. Clear? Now one more most asked question, sir, should we remember the section names and all? It's okay, people, forget. It's okay. For your level and all, people, they will not pick up section numbers and allot you marks. I've seen papers who got 72, 75 with writing hardly 1 or 2 section numbers. Without writing section numbers also, you guys can get exemption. Absolutely. Sir, no sir, I want to make the best impression and all. Maybe, yes, that time you try for it. But sir, if I am not able to remember, absolutely okay, people. You will not be judged because you are not writing the section number. Remember that. If you guys still want, there is this some important section list that I had prepared. I don't know if they have sent this to you. If you want, I can just send it across. Yeah, if you want, you try to remember these things. At least I'm not saying you will get it from this only, but these are the most asked topics. So from that, I've tried to maintain one list. Is this clear? Yes, but I'm saying it's okay. Case laws are more important than section numbers. Remember that. Yes, all of you got some fair idea. Next one, people, Unit 5, breach of contract and its remedies. Now, what is this, sir? Breach of contract and its remedies. Types of breach, people. A breach can be of two types. One is called as actual breach, one is called as anticipatory breach. What do I mean by actual breach? Actual breach means nothing but when the contract is happening on the day of the contract itself, when the parties say, I am not able to perform the contract, we call it as actual breach. For example, people, your marathon was about to start, say for example, today. I come today and say, I will not take this marathon. This is called as what, people? Actual breach. So let us imagine if your marathon is starting on Friday only I come and tell people I will not take the marathon. It is called as actual breach. So on the day of the contract, if the person is communicating, it's called as actual breach. Or even when the contract is going on, in between I leave and go, that is also considered as actual breach. That means what? Friday I came, I did half, but I left. That is also considered as actual breach only. I'm getting the point. What do I mean by anticipatory breach? The marathon starts on Friday. I tell on a Monday that people are not willing to take this particular marathon because of X and Y reasons. Now that will become as called as what, people? Anticipatory breach. I am telling Arivu in advance that I will not be able to take this marathon. Such type of breach is called as what, people? Anticipatory breach. What can Arivu do? Arivu can wait until Friday and then cancel the contract, or Arivu can cancel the contract on Monday and they can engage with someone else on the very same day. Later I cannot come and tell no, I want to continue the contract. That's why if at all I am doing a breach, the other party will always have a right to cancel the contract. That is only called as what? Rescinding of a contract. Hello, you can cancel the contract. Now later if I come and say I will perform, I cannot perform. Clear, all of you? Yes? Okay. Next one, sir. Whenever if there is a breach of contract, what are the remedies I am going to have? For the breach of contract, people, the remedies are suit for damages. The suit for damages can be further seen as these many. What? The first one is called as general or ordinary damages. What do I mean by general or ordinary damages? General or ordinary damages means nothing but in the course of the business, whatever I have failed to deliver, that I can claim as compensation. Example, people, you have a case law there that is only called as Hadley versus Baxendale. What is the case law here? Or forget about the case law, I'll explain this scenario. What do I mean by ordinary damages? For example, A agreed with B to deliver 1000 shirts at the price of 100 rupees per shirt by 10th of August 2026. Now what happened, people? A informed B that on 1st of August only I informed B, I'm so sorry, I'm not able to deliver the shirts. Now what should B do? B cancels the contract. B wants to go and get the same shirts from Mr. C. Now how much is C charging for the shirts? C is charging 120 rupees per shirt. Now people, what do I mean by ordinary damages? If at all A has sold the shirts to B, I could have got the shirts at 100 rupees per shirt. Now if A did not sell the shirts to B at 100, I got it from C for 120 rupees per shirt. So what is the ordinary damages that B suffered? How much did I suffer? 20 rupees per shirt. So ordinary damages means nothing but whatever I suffered, I can recover from the party. So I will file a case. called as ordinary damages, and I will recover 20 rupees per shirt as damages from Mr. A for cancelling the contract. Understood? Yes. The next one is called as people special damages. What do I mean by special damages? Let us imagine, let us add something to the story. A agreed to give shirts to B. Now I have also said B that, remember the B, I have to, why da? Go out and talk. Da? A has agreed to give 1,000 shirts to B. Agreed? A has agreed to deliver 1,000 shirts to B. Now people, because of this contract, B has taken up further contract. B has agreed to supply the shirts to another person called as D. He has his margin also. He said, he is a manufacturer, he is a wholesaler, he is a retailer. Now, B has clearly told A, remember na macha, with the shirts you are giving, I am further going to sell to Mr. D. If you don't get delivered, I will lose this contract. This contract value is around 2 lakh rupees. Da. Remember, please don't miss this particular contract. Now I have communicated this to A. Now even after being aware people, A does not deliver the contract. Now I have clearly told my circumstance to Mr. A. Correct? You are aware of it. Now B can recover from A this entire 2 lakh rupees because I have communicated to you my special circumstance. Understanding? So if I clearly tell you under which scenario I am in, if I tell you that, I can recover that entire money from you, that entire special circumstance cost from you, I can recover. So in the given case, I can recover from Mr. A 2 lakh rupees. Understood? Such type of damages are called as what people? Special damages. Whenever a special circumstance is communicated, I can always recover that particular special circumstance. I think you would have seen one question also, right? That what is that? Bus, it stops in the night. Vehicle stops in the night. I don't know if you guys have seen. It's actually a good question only. See this question. Mr. Chetan was traveling to Manali with his wife by bus of Himalayan Travels Private Limited. Due to some technical default in the bus, the driver has to stop the bus in a midway in cold night. The driver advised the passengers to get to the shelter in the nearest hotel, which was at a distance of only 1 kilometer from that place. The wife of Mr. Chetan caught cold and fell ill due to being asked to get down, and she had to walk in cold night to reach the hotel. Mr. Chetan filed a suit against Himalayan Travels Private Limited for damages for the personal inconvenience, hotel charges, and medical treatment for his wife. Explain whether Mr. Chetan would get compensation for which he filed the suit under Indian Contract Act. Understood the question? Yeah, they were going in a bus. They asked everyone to get down because the bus was under repair. So what happened? In the night, all the passengers got down. They had to, because night the bus is not working. So they were asked to stay in a nearby hotel. So the passengers got down. They walked 1 kilometer. They all stayed in a hotel in the overnight. Now what did the person do? The person has filed a case. Why? You have caused me personal inconvenience. Second one is, in the night you made me walk from here to the hotel in that cold night. And third thing, you asked me to stay in a hotel. Now that hotel charges are also an additional cost for me. So what did this person do, Chetan? He has filed a case on that particular travels. For what and all? For the personal inconvenience, and the wife has suffered some medical charges because she fell ill. The third one is the hotel charges. They're asking you, can Chetan recover this money from the travels? I don't know which travel. Himalayan Travels. Can he recover? What and all he can recover, what and all he cannot recover. He cannot recover the medical. Why? Why? Remember people, your conclusion is right. Your provision is wrong. You will not get marks, not even one. I again repeat, if your conclusion is right, if your provision is wrong, you will not even get 1 mark. Not even one. 0.5 also you will not get. They would have just put an into mark, they will go forward. I think I was showing you also, conclusion is right. That means you clearly wrote, yes, he can recover, what is that? Personal inconvenience, hotel charges, medical treatment, he cannot incur, is what you are saying. So your conclusion is 100% right. Your third part is correct. I am asking the first part. If first part is wrong, remember people, operation successful, patient died. You will not even get formality sake 1 mark also. But the other way around, your provision is right, your conclusion is wrong, you will get marks. So what do you understand by this? Conclusion is waste. Hey, if you look at it, answer is either yes or no, that's all. You need not be Einstein to rhyme that. Answer lies between yes or a no. So don't you think you can be right even by luck, fluke? Then, do you think 3 marks will be given for that? Never. The question is why people? Always remember, always the person will be liable whatever I did inconvenience. For that, whatever is directly related, for that I am liable. That is what is called as general or ordinary damages. See, I am a travel company. I know that the bus did not work. Because of that, you had to walk. Personal inconvenience, directly related. I am liable. Because I did not drop you in your place on time, you had to stay in a hotel. Directly related to what I did. I am liable to pay for your even hotel charges as well. The third one, I asked 40 passengers to go. Not everyone will fall sick. Because you are sensitive, you have some issue. Because they said, wife fell sick, why not Chetan? People, remember, they will come under special damages or remote damages. It is not related to me. Because of me, you did not get ill. Because of me, you did not get sick. That cannot be put on my head because that will not be considered as a direct damage. That will be considered as a remote damage. There is a difference. Hello? Now, because of that, for your medical condition, I will not be held liable because it is a special damage which you did not communicate. That means what? Let us imagine when you boarded the bus itself, you had clearly told my wife has some medical issue, you cannot make her walk in the night and all, she will fall ill. If this was communicated, that will come under special damage. That time you can even take the medical treatment cost as well. Hello? The provision is ordinary or general damages. Whatever is directly related to the contract can be claimed from the parties. Any remote damages cannot be claimed from the parties. That is my provision. And hence, the medical treatment is not related to whatever this person failed. Because the entire bus will not fall sick. Correct me if I am wrong. So if out of 40, even if 5 people are falling sick, that is considered as remote damage. If everyone is falling sick, that means what? You are probably in a place, imagine mountain ranges, Himalayas only, where you cannot actually get down. Then yes, it is considered as remote damage, not on an ordinary day, not in an ordinary place. Hello? Are you understanding? Now same thing, let us imagine the same bus has stopped in Himalayan ranges, where heaters do not work. If you get down, you will freeze yourself. Ordinary, directly related. Hello? Understanding? So that is your answer. Clear? Exam question. Hello? I hope you are understanding. This is why I tell you, more questions you see, the better will be your clarity. You will understand the concepts better. Always remember that. Okay, special and ordinary damage. Done na? Next one people, vindictive or exemplary damage. What do I mean by vindictive or exemplary? Vindictive or exemplary, what do I mean by the word vindictive? Vindictive means people revenge. So remember, vindictive or exemplary can be only done in two cases. When one person promises to marry and goes back, you can file a case of vindictive damage because you have hurt someone's feelings. They want to take revenge on you. That is vindictive. Second one, people, is case of wrongful dishonor of customer's check. What do you mean by wrongful dishonor? I gave a check down. I gave you a check. You went and presented in the bank. The bank said, "Arre, that fellow's account does not have money." But my account had money. They did not check properly. Don't you think my reputation is gone for a toss in society? My CIBIL score will go down. Who will take the hit for that? That's what they're telling you. I can file a case on the bank for informing someone that my account doesn't have money. Wrongfully, they said. I can withdraw. I can file a case on you. I can claim compensation from you. But remember, here there is a little differentiating factor. What kind of person you are? Are you a businessman or are you a non-businessman? If you are a businessman, you need not prove. By default, you will get good compensation. If you are a non-businessman, then this does not have a great impact on you. So if you really want compensation, you need to prove, sir, it has an impact on you. If you are a non-businessman. But if you are a businessman, directly you will get compensation. Clear? Remember that and go. Next one, nominal damages. What do you mean by nominal damages, people? For example, you ordered something on Amazon, people. They had to deliver it today. They delivered it to you tomorrow morning. Because of that, did you suffer any loss? You suffered. If answer is yes, you file. It will come under general ordinary damages. I did not suffer any loss, sir. But still, he broke the contract. He should have delivered today, but he delivered tomorrow. For that, people, they may even give you a 50 rupees coupon. Nominal damages, people, if you actually read Indian Contract Act, it says nominal damages can even be 10 paise. Can also be considered as nominal damages. So nominal damages is not given for you to compensate. Nominal damages is given to satisfy your ego. That's all. Because someone has to come and say, no, you won the case. You will feel good no in heart. Only for that nominal damages are there. Understood? Yes, sir. Next one is called as, people, deterioration caused by delay. What do you mean by deterioration caused by delay? Imagine, people, there is a fruit vendor who supplies fruits to Reliance Mart, Star Market or Food Bazaar, all these places. I have to supply the fruits. Imagine, people, if I supply the apple today, the fruit mart can sell the apple at 320 rupees per kg. But what did you do? There was a delay in delivery of goods. Instead of delivering the apple today, you delivered it after 3 days. So don't you think the apples will deteriorate? The apples cannot be sold at 320 because it does not look the same fresh. It might now be, I can sell it only at 280. That 40 rupees is a loss for me. I can recover it from the carrier. Carrier is who, people? The person delivering me the goods. The last one, sir, is called as prefixed damages. What do I mean by prefixed damages? In the contract itself, people, if we have already agreed, what is the damage that I need to recover from you? That means what, sir? You take the case of the shirt only. A agreed to deliver 1000 shirts at 100 rupees per shirt. In the contract, they have clearly written, if at all A is not able to deliver the shirt on time, you need to pay me a compensation of 10,000 rupees. In the contract only we have agreed. So when you guys agree the damages well in advance, you will consider such damages as prefixed damages. Hello? Understanding? Now when you go to court, how much will the court give you in reality? Let us imagine now, we have agreed 10,000 rupees in our contract. If A is not able to deliver, then I'll have to pay 10,000 rupees. We have agreed it in the contract. Hello? Yes, sir. Now, sir, let us imagine, now A did not deliver the goods. Now B purchased it from C. C sold the goods at 120 rupees per shirt. Now how much more did B pay to C? I paid 20 rupees per shirt into 1000. So I actually paid 20,000 rupees more from my pocket. Now B is filing a case on A for compensation. How much? I'm asking for 20,000 rupees. You tell me how much will the court order. Court will give you 10,000 or 20,000. 10 or 20? 10 or 20? 10,000, remember. Because you guys have agreed in your contract itself that if at all there is going to be any breach of contract, the compensation that you will get is 10,000. You guys have only agreed in the contract. I will pay you what you guys have agreed in the contract. Hello? Let us imagine, sir, instead of 120, I got the shirts at 105 per shirt. So 5 into 1000, in reality, I paid 5,000 extra. That is what I incurred extra. That B had to pay 5,000 more than what he paid to A. Now tell me, B again files a case on A. We had agreed in the contract 10,000 rupees. But actual loss I suffered is 5,000 rupees. How much can B recover from A? 10,000 or 5,000? 10,000 or 5,000? 10,000 or 5,000? 5,000 is what I can recover. Why? Remember people, the court is not a place where they give you profits. What have you said? Court is a place which will compensate you. They will not give you profit. If I give you 10,000, that 5,000 extra, why should I pay? You have suffered 5,000 loss. I have to give you 5,000. Court is not a place to make profit. You guys can say, then sir, in the previous case you said 10,000. No. So remember always, this is the equation. The court will always give you actual loss or whatever is your prefixed loss, or you can take it as agreed loss in the contract. Actual loss or agreed loss, whichever is lower. Don't write this equation in the exam. This is only for our understanding. So always the court will give whatever you have suffered, they will compare it with whatever you have agreed, whichever is less. Are you understanding? Hello? What do I mean by that? So let us imagine we have agreed 10,000 in our contract. Yeah? But the money that I had to pay extra was 20,000 is what I extra paid. The court will say, people, remember, then why did you write 10,000 in your contract? Because you wrote 10,000, my hands are bound. Because you guys have clearly written, if at all something happens and I need to pay you 10,000, the courts cannot go beyond that. Because you guys have only agreed 10. I can't give you more than that. Are you getting it? So the equation is actual loss or agreed loss, whichever is less. That is what will be given to you by the courts. Remember this, very, very important exam point of view. Clear? Yes, sir? Hello? Okay. And next one is a rescission of contract. What do I mean by rescission? The cancellation. Next one is suit for specific performance. What do I mean by suit for specific performance? Generally people, A agreed to give one watch to B. Now A says, no, I don't want to give this to B. Now B is asking for compensation. What can B ask as compensation from A? He can ask two things, people. One, sir, give me money, sir. He has broken the contract, give me money, I'm happy. Or B can claim, I want the watch only. He said he is going to give me the product, I want the product only. When you say you don't want money, you want the product only, that is only called as, I want the party to perform the contract. I want watch only. Hello? Sir, anytime can we demand, sir, that we don't want money, we want the product itself. Can we demand like that? Will we have that freedom? It depends upon what type of product it is. Let us imagine if the product is of some special value, unique feature, antique, or any emotional quotient attached. In such case, people, the court will listen to your request. If not, the court will never give this. The court will always give money because easy to implement. But court will consider your request if at all the watch, mean that the product has any emotional value to you, or it has any antique features, or it is irreplaceable, anything very unique, you will never find it anywhere else, only then the court will order for specific performance. Now, for example, if the contract was for an antique watch, can I find another in the market? No. On that ground, I can demand for the watch only. Are you understanding? Yes, I hope you are understanding. If it is not, then the court will never give you specific performances. Courts will always give you damages. They will not give you specific performance. Remember this and go. Clear? Hello? Okay, next one, people. Suit for injunction. What do you mean by injunction? Stop. Stay order. So if someone is doing an illegal construction, what will I say, sir? Please tell him to stop from whatever he is doing. So if some party is doing something which he is not supposed to do, you can go to a court and ask them to stop from whatever they are doing. That is only called as what, people? Injunction order. Next one, people, is called suit for quantum merit. What do you mean by quantum merit, people? As much as performed. What do I mean by that, people? Let us imagine, sir. Now I was supposed to teach you law for, let us imagine, 4 days. Now I come for 2 days. The rest of the 2 days I don't come. Why? Because there is some difference of opinion between me and the management. I'll not say they are right. I'll not say I am right. There is difference of opinion. So what do? We cancel the contract. Now what does Arivu say? You have cancelled the contract in between, so we will not even make you 1 rupee payment. Now what will I say? See, I know I did not complete the contract, but I did come for 2 days. So if for 4 days, if you were paying me, say for example, 1000 rupees, for 2 days you have to pay me 500 rupees. Quantum merit means, people, I am eligible to get the money for the work at least I have performed. I have not completed, correct? If I have completed, I would have got the entire 1000 rupees. But I have at least done my part. At least that half I have done. That for the half I am eligible for getting the payment. Hello? This principle is called as what, people? Quantum merit. Sir, what if I came all 4 days, but I did not do my role properly? I skipped some topics. I skipped some chapters. But I did come. I did all 4 days. Probably I should teach you 100%. I taught you 90%. In the before case, as much as performed. That means I did half. It was easy for you to come to a conclusion. Sir, 1000, no, okay, we'll pay 500. But in this case, what I'll do? I came for the entire 4 days. I did my complete job. But the quality, I did not teach you 100%. I taught you only 90%. Now what to do? How much will I get? How much will I get in this scenario? The law will tell people, remember, if whatever the contract, if it is completed, but if it is not done in the right way, now what will Arivu do? Arivu will send some teacher, some other teacher to complete your rest of the 10% syllabus. Correct? Huh? For that they need to pay some 200 rupees, 300 rupees, something for them. Yes? The law tells, please deduct that from mine. That means whatever is a sloppy work I did, to recover that, to compensate that, whatever is the money you have to incur, deduct that and pay. That means I am eligible for 1000. This is what Arivu has to pay to, fix my bad part. Yes. So they will deduct this 200. What I will be entitled is 800 rupees. They can ask you such question in the exam. Remember and go. This is only called divisible, indivisible. Divisible is a first scenario. 2 days I come, 2 days I don't come. I will get the days I have come. I have come for the entire day, but I did not do my work properly. In such case, to fix that, whatever is the money incurred, they can deduct that and they can make you the payment. Clear? Hello? Hello? Easy? Okay. Yes, people. Unit 6, contingent and quasi-contracts. What do you mean by contingent contract? Contingent contract means, people, a contract which depends upon an event which may happen, may not happen. That's why we call this as a uncertain event. Examples of contingent contract, remember people, contingent contract, lot of examples are there. If I have to give you 3 examples, one is contract of indemnity. Our next topic, contract of guarantee. Again, our next topic, wagering agreement is also a contingent agreement only because it is a may or may not event. It may happen, it may not happen. However, remember, contingent contracts, not every contingent contract, or sorry, not every contingent contract is a wager, but every wager is a contingent contract only. It is depending upon an uncertain event. Remember that. Is this clear? Yes, but the only difference, yes, what is the purpose? Here, it is legal for the benefit of the society. That's why we are considering indemnity contract and guarantee contract as legal. Whereas wagering agreement, people, it's not for the benefit of the society. People are actually losing money. That's why we consider this as a void agreement. Remember that. So this is legal, this is void. So contingent means uncertain, but there can be lot of examples. Not everything will become valid. Contingent, it also has wagering in it itself. Clear? Yes, sir. So I hope contingent contract is clear. Next one is people, enforceability of contingent contracts. What is the first one? On an event happening. Now what do I mean by on an event happening? For example, people, I'll give you a simple example. A agrees to B. A agrees with B. What is that? I will buy your house. I am entering into a contract. I am promising that I will buy your house, provided I want a bank loan. Because what is the value of the home? The value of the home is, people, let us imagine, is 50 lakh rupees. That is the value of the home. So A agrees to buy the home from B for 50 lakh rupees, provided this 50 lakh rupees I have applied for a bank loan. If the bank gives me this loan, I'll be able to buy this property. What if the bank does not give me the loan? What if the bank does not give me the loan? I'll not be able to buy the property. So this contract becomes valid on happening of an event. What is happening of an event? The bank loan. Bank may give me a loan. Bank may not give me a loan as well. Now, when will I consider the contract as valid? On an happening of an event. What is happening of an event? Bank gives me the loan, I can enforce the contract. If bank does not give me the loan, this particular contract becomes void. That is the first rule of enforcement of contingent contract on an event happening. Understood? Yes, sir. So, what is contingent here? Bank loan, it is not like for sure you will get bank loan, right? I may get, I may not get. So if the contract is depending upon a bank loan, which may or may not happen, I will consider this particular, contract as what, people? A contingent contract. When will I enforce it? When the event happens. So what if the event does not happen? The contract comes to an end, void. Simple? Yes. Sir, what if I say the bank loan, what is the second rule? On an event happening within fixed time. So the seller here, B, will tell, remember, I can't wait for your bank to confirm forever. I'll give you 10 days time. Within 10 days, if you get, I'll give you the home. Within 10 days, if you do not get the loan, then I'll move on. I'll go and sell it to any other buyer because I also need money. Now, people, again, this is a contingent contract, just that there is a time period fixed. So remember, the contract will be enforceable if you get loan within 10 days. If I don't get loan within 10 days, the contract becomes void. That is the second rule, happening of an event within the fixed time. Understood? The third scenario, event not happening. Listen. On an event not happening. What do I mean by not happening? The best example for event not happening is, people, insurance contract. I can give you an example of insurance contract. Example, sir. Now we import so many things from ship route, right? So I'm buying some. Probably I'm a trader. I'm buying so many materials from outside India to India. There'll be so many materials coming through ship route. Remember, ship route is always uncertain. It may reach safely, it may not reach safely. Now, what do we do to keep our goods safe? What do? We always take insurance contract. How does insurance contract work? It works like this. We take an insurance contract saying that, sir, if at all the ship does not reach India, the value of my goods on the ship is around 1 crore rupees. If my goods does not reach safely to India, can you please compensate me for this 1 crore rupees? We will buy one insurance contract. It's also called as marine insurance. Marine insurance is always taken as on your ship. Hello? They will charge some money for that. 1 crore worth, right? They will charge a premium of, say, for example, 2 lakh, 3 lakh will be the premium to buy this insurance. Now, when can I get the money from the insurance company? When will I get? When the ship does not reach. What if the ship reaches? The contract becomes void. Sir, what if the ship breaks? What if the ship sinks? Will I get money? Yes, because for sure ship will not reach, no? What was the contract? If ship does not reach, you have to give me money. Now, when the ship sinks, where will ship reach? Ship will definitely not reach. So, a contract can be enforced when the event does not happen. What does not happen here? Ship does not reach. I can enforce the contract. Again, this also can be infinite or also within fixed time. That is, I can also have a time period. That is, if ship does not reach within 20 days, you please will have to give me money. If ship does not reach within 20 days also, I can enforce the contract. What if ship reaches within 20 days? Contract becomes void. Hello all of you, understood? That is how import-export contracts work. Clear? Now, for example, I'm telling, right, we export some materials. Yeah, we do that business is there. So for every export we do, at least we incur export charges. If the consignment value is 1 crore, the insurance cost itself will come up to 2 to 2.5 lakh rupees. Now, let us imagine everything is time bound. It has to reach by this time. And just for your information, any idea how many days does it take for the goods to go and reach? Depends on the place, of course. Approximately, people, if you're sending it by air route, it will reach in 2 days. Expensive. Double will be the charges. If I'm sending it by ship route, it will take me at least 35 to 45 days, depending upon the location. Now remember, the ship is on the water for 45 days. I cannot have a certain weather for 45 days. How uncertain it should be. And that too, this is monsoon season. Very, very terrific. So these things will always have a lot of impact. Now imagine the buyer will be waiting 45 days. Season itself will change. Now what do I sell? I sell clothing. Yeah, we do this clothing business. So I'll be selling some materials outside. Now if I delay by, let us imagine 90 days. Time is essential. I'll be shipping winter clothes. If I do not deliver within 50 days, it becomes 90 days. 90 days is 3 months. My monsoon is over. Next season comes. The goods are of no use. Then what will the buyer do? Buyer will cancel the contract. Look at the value of the consignment. What do I do? That's why I say, if the ship does not reach within 45 days, I will take insurance. I will get the entire money. Hello? Understanding? That's how these contracts work. Clear? In reality, that is how it is. Okay. Next one, on an impossible event. What is impossible event? Can we have impossible event? Possible? Initial impossibility, void agreement. Subsequent impossibility, void contract. That's the answer. Upon conduct of a living person. Possible? What do you mean by conduct of a living person? A contract can be entered based upon a conduct of a living person. What do you mean by conduct of a living person? For example, one case law itself is there, Frost versus Knight. What happened in this? One boy promised a girl that as long as my father is alive, I can't marry you. What did the boy do? While the father was still alive, he married another girl. So is this case law? Yes. Don't look at me like that. That is only the case law Frost versus Knight. Now what did this person do? What does the girl do? The girl filed a case on the boy asking for compensation. What compensation she will get? What compensation she will get? Vindictive damages. Someone, sorry, Damacha, I didn't hear it. If possible, please excuse me. Yes, see, Knight promised to marry Frost. Frost was the girl. After the death of his father and got engaged while he was alive, and he married another girl. So such type of contracts are called as what? Contingent contracts upon conduct of a living person. Who knows when that father will die? Contingent only, no? Yes or no? That's why it is coming under contingent contract. Yes? See, death is certain. Death is not uncertain event. Death is certain. But I cannot say tomorrow they will die, no? It can be any day. So no, that's why it's called uncertain event. That's your enforcement. Okay. Last one, sir, quasi-contract. What is quasi, people? It's not a contract, but something similar, resembles a contract. That's why we've used the word called as quasi. Okay, quasi-contract, people, can be of different types. What is that? Quasi-contract means what, people? There is no actual contract. Yeah, but still we say you guys have to follow all the terms of the contract, like a contract. How is that, sir? Example, people, cases deemed as quasi. The first one is claim for necessaries. What do you say? That means, people, let us imagine if you help someone who is minor or unsound mind, can you recover the money? Answer is yes, provided if you have supplied for their necessaries. Not only minor or unsound mind. Let us imagine if there are any people dependent on them. That means, let us imagine there was a minor, 15-year-old. Let us imagine their parents are not alive, but this minor had a grandmother. Her age, let us imagine, is 80-year-old. There was a neighbor. The neighbor supplied some money for this minor for his educational purpose. How much he gave? 3 lakh rupees. The grandmother is also dependent on the minor. Now the neighbor also helped the grandmother to take care of her medical treatment. How much I gave? I gave 2 lakh rupees. Now minor had a property worth, say for example, some 20 lakh. After a few days, the neighbor asked the minor to repay the entire money he has spent, that is for education as well as the medical treatment. They'll ask you in your exam, how much can the neighbor recover? They'll ask you this type of questions in the exam. How much he can recover? 3 lakh or 5 lakh? How much? I can recover entire 5 lakh. So I can recover any money spent on the people who are incompetent and also on those people who are dependent on that incompetent people. I can recover the whole charges. 3 lakh also, grandmother is dependent on the incompetent person. This also I can recover. Understood? Hello. Then next one, payment by an interested person. What is interested person? Imagine, people, we took this floor on rent, people, with an agreement that, sir, the electricity bill will be paid by the owner. We will give monthly rent. Electricity bill should be paid by the owner. We paid monthly rent all 6 months. But unfortunately, the owner did not pay the electricity bill to the department. Whichever is the electricity board, he has not paid. We paid to the owner. Now what happened? After 6 months, we got a notice. If at all you do not clear the last 4 months due, we are going to come and remove the fuse and we are going to stop the inflow of current for a few months until the entire thing is settled. Now what did we do? Even if one day the fuse is removed, you know the dependency we have on current. Correct? Everything has to run on current. Hello. Now what did we do? Arivu only paid that rent. Electricity bill. We only paid it. Now the question is, can we recover this electricity bill from the owner? Can we recover? The owner said, did I ask you to pay? Did you forget consideration chapter? The consideration should always move at the desire of the promisor. Did I ask you to pay? Why did you pay? And why are you asking me to recover? Hello? Understood? One answer can fit in two topics. I'm giving you examples. In such case, always I tell you, one topic will be more relatable and more apt. For this scenario only, they have made one section. You have to follow this section. That is generic. This is special. Special provision will always prevail over general provision. Hello? Clear? Sure? Okay. So, what does interested person means? Macha, in this property, we also have some interest. What is that interest? If you do not pay that electricity bill on time, we are going to suffer. If that is the scenario, you are allowed to make the payment and you can recover it from the owner. Whether you guys agreed or not, law gives me a right to recover the money. Who are you to say yes or no? Law only gave me a right. I can recover the money from the owner, whether we agreed or not. Special scenario, I can recover. Hello? Understood? We will be considered as interested person here. Because in this contract, if you do not pay electricity bill, I am also going to suffer. When that is a scenario, the law says people, you can make the payment, you can recover it from the owner. Clear? I hope it is clear. Hello? Machas? Usho? Hey, entu ipetta, life enthusiasm should be there. You guys are like in the verge of retirement. Sir, I'm not done, sir. Yanna, sir. Idalla. Macha, why? You should show excitement. Huh? Excitement andre, sir, tomorrow I'll bring the cheerleaders agondilla. Sir, you should become, you should be enthusiastic. At least what you are doing, you should love what you are doing, right? Okay. Person enjoying the benefits of non-gratuitous act. What is non-gratuitous act, people? For free. Correct? Let us imagine, people, if someone has ordered some food, Zomato guy came. Yeah. Anyone has two names here? Same names? Two Varshinis are there. Varshini ordered dosa. Dosa came. The guy asked Varshini, another Varshini went and ate. Because Varshini was called. Now you tell me, can that Varshini take the benefit of it? Who are the Varshinis here? One more Varshini is there. So she ordered. She thought she has put her hot, what is that? Hose. Where PG. So she thought she has put the PG address. But by mistake she has ordered it here. Varshini is here. He said Varshini. She went and she had. Correct? Possible? Now the question is, people, tell me, is this Varshini liable for something? Now that person will come back and say, hey, give me back dosa. She said, okay, wait, I ate half. You take this half and go. Can she say? No. He will say, give me money. What will she say? Hey, did I ask you to give? Did I order dosa? Why did you give? You gave, I ate. You know, people, in this world, it's a commercial world. No one means to give it to you for free. Correct? That's a fair bit of common sense we have to say. That is what they're telling you. Person enjoying the benefit of. Non-gratuitous means what? No one means to do anything for free in this world. Selfish world, yes or no? Next one, finder of lost goods. In bailment we'll be doing it. We'll do it there. Money paid by mistake or coercion. What is money paid by mistake, people? For example, I overpaid whatever I have to pay in a shop. Imagine my bill was 100. I gave 200 by mistake. I have paid 100 rupees extra. After coming back here, I realized, I gave a wrong note. Can I go and recover the 100 rupees? What if the person says, did I ask you? By mistake, I have a right to recover. Understood? Yes, Ram, that is your quasi-contract. Okay, Unit 4, performance of contract. Let us do the textbook question. On the valid performance of contractual obligation by the parties, the contract is discharged, become enforceable, becomes void, none of the above. What do you think? Recording, Ada. What is it, people? On the valid performance of contractual obligation by the parties, the contract is discharged, becomes enforceable, becomes void, none of this. What is the answer? Discharged. Contracts which need not be performed, right? Once you guys perform the contract comes to an end. Yes or no? Which of the following person can perform the contract? Who? Promiser alone, legal representative, agent, all of the above. Everyone can perform. Contract is discharged by novation, which means cancellation of existing contract, change in one or more terms of the contract, substitution of existing contract for a new one, none of the above. What is the one? Fourth one, a contract is discharged by rescission, which means that change in one or more terms of the contract, acceptance of lesser performance, abandonment of rights by a party, cancellation of an existing contract. What is it? Remember, resigned, rescission, extinguishment, everything means the same. Cancellation only. Clear? If a person accepts the lesser sum of money than what was contracted for in discharge of the whole debt, it is known as it is called as, if you ask me, people, answer is remission, but options given are little deceiving. That means they shouldn't have given waiver. But why did we mark remission? When you have to explain remission, what do you mean by remission in simple language? Means waiver. But what did they do? They have given both the options. You can take this option shouldn't have been given. But the answer is remission. Novation discharges a contract. No, it means no new contract comes to existence. No, it means new contract comes to existence, but old contract is not discharged. Yes, on novation, old contract is discharged and consequently it need not be performed. Yes, but only if parties agree to discharge. What is the option? Novation, old contract is discharged and you need not have to perform the old contract. No. Next one, novation and alteration are same. Is it same? False. Novation discharges old contract, alteration, the obligation remains. A, B, C jointly promise to pay 60,000 to D. Before performance of the contract, C dies. Here the contract becomes void on C's death. Should be performed by A and B along with C's legal representative. That's answer. Ninth one, Vivan lives on rent in a house owned by Swasti. Later he purchases the house from Swasti. The rent agreement is discharged due to the same example we saw. When prior to the due date of performance, the promiser refuses to perform the contract, it is known as, when prior to the due date of performance, the promiser refuses to perform the contract, it is known as anticipatory. See, when prior to the due date, on the due date if he refuses, actual breach. A owes 15,000 to B, A die living his estate of 12,000 rupees to legal representative of A. So legal representative of A are liable to pay 12,000, 15,000, not liable to pay B, liable to pay 3,000. Liable to pay? Always remember, legal representatives are liable to pay only to the extent of assets inherited. 12. Rani contracted to teach dance to Shruti. Shruti paid an advance of 5,000 for the same. Rani met with an accident and will not be able to dance. She has a daughter as her legal representative. Shruti can resign the contract and ask for refund. Basically, what type of contract is this? A contract which has some special skill or talent involved. The legal representative cannot be held liable to perform. So the contract will die with the person. So it becomes a void contract. So will the legal representative will be liable? No. I can just cancel the contract. Resigned and ask for the refund of money. If I have paid anything, I can ask the money back. Okay, X, Y and Z jointly borrowed 50,000 from A. The whole amount was repaid to A by Y. Decide in the light of Indian Contract Act whether Y can recover the contribution from X and Z. Legal representative of X are liable in case of death. Y can recover the contribution from the assets in case Z becomes insolvent. What is people joint promise? X, Y and Z jointly borrowed money. Okay. Can Y recover the contribution from X and Z? Possible? Yes, possible. Legal representative of X are liable in case of death of X. If X dies, what happens? We already seen the legal representative will have to pay along with the other surviving people. Yes, legal representative will be liable. Y can recover the contribution from the assets in case Z becomes insolvent. Yes. When you become insolvent, I can recover whatever I can recover from your assets. Rest of it, X and Y will have to bear. Loss Allah. X and Y will have to take that cost. Okay, next one. Mr. Rich aspired to get a self-portrait made by an artist. He went to the workshop of Mr. C, an artist, and asked whether he could sketch the former's portrait on oil painting canvas. Mr. C agreed to the offer and asked for 50,000 as full advance payment for the above creative work. See, why do they say all of this? It's a help. Yes? Okay. Mr. C clarified that the painting shall be completed in 10 sittings and shall take 3 months. And would not be, on reaching to the workshop for the 6th sitting, Mr. Rich was informed that Mr. C became paralyzed and would not be able to paint for the near future. Mr. C had a son, Mr. K, who was still pursuing his studies and had not taken up his father's profession yet. Discuss in light of Indian Contract Act, can Mr. Rich ask Mr. K to complete the artistic work? No. Why? See, creative work, special skill or talent. That's why I say, question will have answered. We should be so brilliant to miss it, that's all. Next one. Could Mr. Rich ask Mr. K for refund of money paid in advance to his father? Answer is yes. Any money paid in advance can be recovered. Hello? Okay, next one. What type of contract will that become? Void contract, right? Special skill or talent, right? That also. Mr. Jute entered into an agreement with Mr. Such to purchase his motor car for 5 lakh within a period of 3 months. A security amount of 20,000 was also paid by Mr. Jute to Mr. Such in terms of the agreement. After completion of 3 months of entering into the agreement, Mr. Such tried to contract Mr. Jute to purchase the car in terms of the agreement. Even after lapse of another 3 months period, Mr. Jute neither responded to Mr. Such nor to his phone calls. After lapse of another period of 6 months, Mr. Jute contacted Mr. Such and denied to purchase the motor car. He also demanded back the security amount of 20,000 from Mr. Such. Referring to the provision of Indian Contract Act, state whether Mr. Such is required to refund the security amount to Mr. Jute. What happened, people? One person has agreed to sell his car to another person for 50,000, and the other person has also agreed to buy it for a 50,000 rupees and paid advance of 20,000 also. After paying 20,000, that person never came up. It's been 1 month, 2 months, 3 months, 6 months. He never showed up. The seller tried to contact him so many times, still he did not show up. Now after some 6 months or 9 months, the person is coming and saying that I do not want to proceed with the contract. So they had to cancel the contract. Now the question is, can the person recover the 20,000? Is it possible? Not possible. Not possible? Or the contract came to an end. I can recover 20,000. He has given a chance, he didn't use. He refused to perform. Remember people, he refused to perform. And we have one more point also. Whenever the contract becomes void, any benefit taken, you will have to return it. Correct? Huh? Here remember people, the contract did not become void. The contract is still valid. It's a breach of contract. It's not a void contract. And hence, the law has not said. Law says you to refund only when the contract becomes void. Example is our painting case. Contract became void. Hence, I have to refund. Here, contract did not become void. Why should I refund? Contract is still valid only. Are you getting the point? Now, I cancel the contract. Remember people, for 6 to 9 months period, I have not showed the car to anyone. I have still been living on a belief that you are going to come and buy the car one day. The cost that I can put people, which I have waited for 6 to 9 months, because I waited for so long, remember, I do not have any compulsion to refund that 20,000 back to the buyer because you did not perform the contract on the said terms. Hello? Are you understanding? And I will clearly write, because the contract did not become void, the party need not have to refund any benefit taken. When should you refund the benefit taken? You will refund the benefit taken only when the contract becomes void. Here contract is valid only. Hello? That's the main term that you need to mention. That is the provision. Hello? Getting it? Okay. Next one. Mr. Murari owes payment of 3 bills to Mr. Girdhari as on 31st March 2022. One is 12,120 which was due in 2018. 5,650 which was due in August, 9,680 due in 21. Murari made payment on 1st April 2022 as below without any notice of how to appropriate. So debtor is silent. A check of 9,680 was paid, a check of 15,000 was paid. Advice under the provisions of Indian Contract Act 1872. What will be the terms of appropriation? What is terms of appropriation? First is debtor's choice. Debtor is absolutely silent. Second is circumstances. Does it indicate something? So 9,680, because the circumstances say there is an existing debt with the same amount, the circumstances indicate that 9,680 should be taken towards that debt which is going to be due for repayment in 2021. 15,000, do we have any debt of the same amount? No. Debtor is silent. The second option will always go to the creditor. So my answer will be the creditor will have a choice to decide the order of repayment. Even if the creditor is also silent, in such case people, we will go with FIFO. So the answer should be written in the same format. The first option will be given to creditor. If creditor is also silent, then it will go in FIFO. That is the answer. Clear? Section 59, 60, 61. That is the 3 points. Debtor, creditor, FIFO. Okay. What will be the rights with the promisor in following cases? Explain with reasons. Mr. X promised to bring back Mr. Y to life again. What will be the rights with the promisor? What will happen? The contract is considered as void. It's a void agreement. The main provision is initial impossibility. Impossibility of performance. Void agreement. A agreed to sell 50 kgs of apple to B. The loaded truck left for delivery on 15th March, but due to riots in between, reached A on 19th March. What will happen, people? A agreed to sell. So, it should have reached on 15th March. It reached on 19th March. So, what will happen? Deterioration during delay. I told you the example of Apple only. That is this particular scenario. So what will happen now? The time is essence of the contract because the Apple with every day of delay, the price of the Apple deteriorates, right? So what is the case? The case is where the time is essence. What can I do? I can either I can reject it. I have an option to put an end to the contract. I can cancel the contract and Yes. Basically, what is that? You can even write in detail also here, but for this particular question, this is sufficient. An artist promised to paint on the fixed date for a fixed amount of remuneration, but met with an accident and lost his both the hands. We have seen void contract. Subsequent impossibility, both has to be there. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the countries, the imports from China were banned. What type of contract? Again, subsequent impossibility, void contract only due to change of law. Understood? Okay. Okay, people. Contracts of indemnity and guarantee. What is indemnity and guarantee, people? What is contract of indemnity? In general, what is indemnity? If one person tells the another person, if at all you incur any loss, I will give you money. Don't worry. This contract is called as, people, contract of indemnity. So contract of indemnity is nothing but a contract in which one party tells the other party, if you suffer any loss, I will make sure I will recover the loss to you. Such type of contract is called as contract of indemnity. The best example I can give you of contract of indemnity is, people, insurance contracts. What happens in insurance contracts? One person takes an insurance for his bike. What does the insurance say? If at all you meet with an accident, the bike, there will be some damages. Imagine you will have to put some 15-20,000 for repairing it. The insurance company will come and say, don't worry, we will give you this 20,000 rupees. Whatever is the loss you have suffered, we will give that money to you. This is only called as what, people? Indemnity contract. In indemnity contract, people, there will be two parties. One is called as indemnifier, indemnified, or indemnity holder. Insurance company is called as indemnifier. So the person who promises to make good the loss is called as indemnifier. What do you mean by indemnity holder? Indemnity holder or indemnified means the person to whom a promise is made. So whosoever's property is being, we are recovering, the person to whom we are giving the money, that person will be called as indemnified. Clear? Yes, sir? Okay. Remember again, indemnity contract is also a contract which is a contract where one party promises to save the other from any loss due to the conduct of promisor himself or any other person is called as what, people? Indemnity contract. Is this clear, all of you? Hello? Pakka? But remember, people, there is one thing. If we look at our book, people, they have given some in-depth scenario in this. What does it say? See here, what does it say? Thus, loss occasioned by an accident not caused by any person or act of God or natural event is not covered. What do I mean by that, people? Let us imagine, what does the indemnity contract say, people? If at all damage happen because of me or because of anyone, if any damage happens to the property, I will pay the money. What if the damage happens not because of me or not because of any party? That means the definition says it's a dead end. Best example if I can give you, let us imagine, people, you are going in a bike. Some third party comes and hits you. So someone else has caused the damage. Indemnity contract says any other person causes a damage, indemnity contract covers. Let us imagine, people, you have parked the vehicle outside the building. There is an earthquake, earth splits, your bike goes inside, earth comes back. Now, people, if you look at it, it is the act of God. Did the promiser do the damage? Did any third party do the damage? No. Unfortunately, our Indian definition does not cover the act of God. Because how is the word written? The word is written, whoever has promised to give you the loss, to recover the loss, if he makes a damage or any other person makes a damage, I will give you the money. Now in this case, who made the damage?
In case of marine insurance, the shipper, so marine insurance also insurance, it's also indemnity. If the ship came to the finishing point due to natural circumstances.
See, I'll tell you. Act of God versus, let us imagine the ship breaks. Ship breaking is not an act of God. Now, Titanic, there was an iceberg. It's an accident. It's not an act of God. Yes or no? What is act of God? Tsunami came. Act of God. So, there is a difference. Sea will have tides. High tides, low tides, not act of God. Tsunami, exceptional case, act of God. So, if a ship breaks due to an accident, not act of God. Understanding? Yes. And remember, today marine insurance is a separate set. So what happens is people pay, I'll tell you, I'll complete this complete part. Yeah. Now today, if you guys have seen this movie called as what? Oh my God. In oh my God, this person, I think Ajay Devgan? Allah, sorry. Akshay Kumar? Akshay Kumar only, no? Akshay Kumar has done Oh my God. That's this scenario. Or I think in Telugu, Gopala. Huh? I think that Pawan Kalyan and all has acted, no? He comes as to a person to come and support. I think in Kannada it is Mukunda Murari. What is all this? That entire movie is done on this act of God. A person would have had his entire consignment in a shop. There will be an earthquake actually. His entire consignment will fail. Everything will break. A hero's consignment that is there in the building, everything will break because of act of God. The insurance company will reject the claim on this grounds. It was not conducted due to me or any third person. So it is not covered in insurance contract. From there only the movie starts. Yes? So act of God unfortunately is not covered in many of the scenarios. Hello? For example, we will take life insurance. Life insurance, if anyone dies, you will have to give money, correct? For a very long time in India, suicide was not covered. Suicide also person is dying, no? You have to give insurance, no? They said voluntary or homicide, whatever we call. Suicide, whenever a person is dying willfully, it was not covered in Indian insurance for a very long time. Now what happened? Some insurance companies are giving you the policy. Some companies give you, we cover everything. Now what am I trying to tell? Some companies take extra premium from you and they cover. Now for example, marine insurance in general does not carry or does not cover act of God. Yeah. Let us imagine without act of God 1 lakh premium, with act of God 3 lakh premium. I will think 500 ships will take insurance from me. With everyone I will take 2 lakh rupees more. 2 lakh into 500. One ship will meet with an act of God. That's okay. That's how today's insurance companies are working. But I'm not going into our reality. I'm only answering from Indian Contract Act. From your exam point of view, Indian law does not cover act of God. However, see here, we have something as per English law. See, what does this say? This is an exception. Why I am showing this to you? See here, what does it say? However, in case of Gajanan Moreshwar versus Moreshwar Madan, decision is taken on the basis of English law. Our courts took the decision on the basis of English law. What did it say? Indemnity means promise to save another harmless from the loss. Here it covers every loss, whether due to negligence of the promiser or by natural calamity or by accident. So they covered the act of God in one of the case. Hello? Sir, now today, if anything happens, act of God, what should we do? Is it covered or not covered? Remember, people tell you what are the different types of laws we have. Criminal law. What is common law? What is common law? Common for everyone now. What's common law? Stare decisis. What do you mean by stare decisis? Going forward, this will become a law. Now let us imagine my bike met with an accident. Split, earth went, that happened. Correct? I will go to the court. I will file a case. Imagine my insurance company rejected my insurance. I will file a case on my insurance company. I will quote, Your Honor, in the case of Gajanan Moreshwar versus Moreshwar Madan, it was decided that even the natural calamities can also be considered. See, sir, once the court has decided, please stand by what has already been decided. This will become a case law for me. That is also one of the law. As you guys have read in Indian regulatory framework. Sir, if asked in exam, what should you write? Write the same way. Indian law does not allow. However, there has been a case. This case is there in our syllabus, Gajanan Moreshwar versus Moreshwar Madan, where the court referred English law and they have given a judgment. Hello? Understood? Okay. Okay, next one, sir. Okay, parties I told you, special points, modes of contract can be express or implied. Remember, people, life insurance can never be considered as a indemnity contract. Why? Indemnity means what, people? You suffer any loss, I will recover that for you. You suffer any loss, I will make good the loss. You suffer any loss, I'll make good the loss. I lose money, you will give me money. I lose life. That's why LIC is not a indemnity contract. Understood? Because you cannot make good the loss. Correct? Hello? Yes. Rights of indemnity holder when sued to recover from promisor. That means what, sir? I've taken insurance contract. My bike met with an what is that? Earth and correct? Now what will I do? I'll ask the insurance company, Macha, you said you will pay me the recovery charges. Please pay me 80,000 rupees. You have to pay me. What will the insurance company say? No, we will not pay. It is not covered under insurance. Now what will I do? I will file a case on this insurance company. Sir, we have taken insurance. They are not paying. The matter went to court. What and all I can recover from my insurance company? If you had paid me here, it was 80,000. Now we went to court. No, what and all you need to pay to me? 80,000 for sure you need to pay. If the court tells you to pay, you have to pay. In addition to that, people, now don't you think you wasted my time? Don't you think I have to hire charges of some advocate, lawyer and all? Will he come for free of cost? Court fees? Remember, I can even recover the legal charges that I paid to defend my case. I can recover that entire thing also from this particular person. So that is what they're telling you. The right of the indemnity holder when sued, I can recover from promisor, what and all. The damages compelled to pay in any suit, that is 80,000. My value, I can take that. Next one, any costs in defending the suit, legal charges. Imagine I pay 20,000 to the lawyer. I can recover that also from you. Third one, all sums paid under the terms of compromise. What is compromise? Imagine when the case is going on. At times what happens is few companies will offer you a compromise. Will you please withdraw today? Because the judgment is not given. The court will take another 2 years to pass judgment. Do one thing, you withdraw the case today, I will give you 60,000 rupees. You withdraw, they will give you 60,000 rupees. They have to give. That is the meaning of all sums which you agreed as compromise. Pay that. So these are the things I can recover from the promisor. Understood? They've asked 3 times this question. Important exam point of view. Remember and go. Clear? Next one, people, contract of guarantee. What is guarantee, people? One person, two people are entering into a contract. When the third party comes and gives a surety on behalf of one party, we call such type of contracts as contract of guarantee. In contract of guarantee, how many parties are there? There are 3 parties. One is called as surety, principal debtor, and creditor. Can a principal debtor be a minor? Can a principal debtor be a minor? Why not? Principal debtor is a person who is borrowing the money. He can be a minor. Can a surety be a minor? No, not possible. So if a surety is a minor, the contract of guarantee is invalid. It is void. Hello? Pakkana? Okay. Next one, in the contract of guarantee, how many contracts are there in total? There are in total 3 contracts. One is called as principal contract. The contract between debtor and creditor. The second contract is between creditor and surety. The third contract, also called as implied contract, is between the debtor and surety. What does this implied contract mean? Simple. If debtor is not able to repay the loan to the creditor, the surety will pay the money to the creditor. Done. But I have a right to recover this money in the future from the debtor. Today I will pay on behalf of you. In the future I can recover it from you. Why should I bear the loss? Law has given me a right. That's why we call it as an implied contract. Hello? Clear? Pakka? Done. Sir, essential features of a guarantee. There has to be a principal debtor. I mean, without debt, there cannot be a guarantee. Consideration, guarantee without consideration is void. Quid pro quo, end of the day. But no need of direct consideration. That is, the creditor and surety. Surety is paying money. What did creditor give to the surety? Where is quid pro quo? That's why they're telling you it need not be direct. The creditor did not give anything to the surety, but he gave it something on behalf of you to the principal debtor. No, that is sufficient. Existence of a liability, the debt has to be there. It should not be time barred. Remember, people, there should not be any misrepresentation or concealment. If the creditor has concealed some fact about the debtor, if I do not tell it to the surety, and if I cheat you and if I take your surety, remember the surety is discharged. Need not be in writing, even oral is also valid. Guarantee is not valid until some other person joins. Then it's another industry. Correct? What do you mean by that? Imagine Mr. A has given a surety with a condition. Remember, if I am the only surety, I will not agree the contract. I need at least another 2 people to join me. So remember, until another 2 people joins, the contract will not be considered as valid. If the surety has said that the co-sureties have to join, you have to wait until the co-sureties join. Understood, all of you? Yes? Hello? Types of guarantee, 2 types. One is called special guarantee, specific guarantee. One is called as continuing guarantee. Specific guarantee means a guarantee given to any particular transaction. The transaction is over, guarantee is over. One more is called as continuing guarantee. Continuing guarantee means a guarantee which is given to series of transactions. Can I revoke a continuing guarantee? Yes, possible. Imagine one person says, I am giving you a guarantee for 1 year. That is called as continuing guarantee. Now after 5 months, can I revoke the guarantee? Is it possible? Yes, possible. But remember, you can only revoke the future transactions. Whatever has happened in the 5 months, that you cannot revoke. Hello? Clear? Okay. Nature and extent of surety's liability. The liability of surety is coextensive with the debtor. What do I mean by that, sir? Imagine, people, the debtor is liable for 90,000, surety is also liable for 90,000. Sir, with principal, interest also came 10,000. Even I also have to pay interest. Sir, I have given some collateral. I have given collateral worth 30,000. Even my liability will also reduce by 30,000. So how much ever the debtor is liable, the same liability will be on the surety as well. Liability of surety is secondary in nature. Of course, right, the primary liability is always on the principal debtor. But always remember, let us imagine if the debtor has said, I will repay the loan within 1 year. In 1 year, the debtor did not repay the loan. Say, for example, on 1st Jan 2027, I did not repay. When the term is done, 1 year is done, the creditor has a choice. If he wants, he can directly file a case on the debtor. He can also directly file a case on the surety also. There is no rule that I have to first go and file a case on the debtor and then I have to file a case on the surety. I can directly recover the money completely without even going to the principal debtor. I can directly go to the surety as well. Allowed. Agreed? Yes, sir. That is what they are telling you here. See, the creditor can sue surety directly without proceeding against the principal debtor. Remember, any defect in the document, it discharges debtor also, discharges the surety as well. Liability arises immediately on default of the principal debtor. I will become liable as a surety. Discharge of surety, when all the surety is discharged, people, one is by revocation. When, if at all future transactions, continuing guarantee, can I revoke? Yes, only future but not the past. What about the past transactions? That you will be liable. Imagine I gave a surety for 1 year. After 5 months, the person dies. After 5 months, the person dies. The surety dies. What will happen? The surety's estate will be liable for the 5 months transaction. But after death, the surety is revoked automatically. But until 5 months, whatever has happened, my assets will be liable. Hello? Death of surety, whatever I told you. Novation, old contract replaced by new contract, old contract is discharged. By conduct of the creditor, what is this conduct of the creditor? Variance in contract without surety's consent. That means what, people? Between debtor and creditor and surety, you guys all agreed on one contract. Without asking the surety, they both are changing the terms. That discharges the surety. Next one, by release or discharge of principal debtor, enters into a fresh contract with principal debtor or does any act or omission. What do you mean by that, people? The creditor specifically tells the debtor, you go down, I will not file a case on you. I am releasing you. I will directly go and file a case on the creditor. Wantedly I am releasing the debtor. If you do any such contracts, people, like a private arrangements, they're telling you even the surety is also discharged. Next one, people, the creditor compounds or gives time. What do you mean by compounds? Compromises. If you enter into any compromise, or let us imagine, I have to repay the loan within 1 year. The creditor gives you 2 years to repay the loan. I'm giving you more time. If any such thing is done by the creditor, even the surety is also discharged. Next one, creditor's act or omission impairs surety's eventual remedy. What do you mean by this, people? Let us imagine the principal debtor had given some gold as security. The value of the gold was 30,000. The creditor lost that gold. Whatever gold was given by the debtor, the creditor lost that gold. Remember, when you are filing a case on the surety to recover the money, if the value of the debt is 1 lakh, whatever is the security you lost, my liability will be reduced by that amount. So my liability will become, understood?
If creditor compounds give time to principal debtor, it is an advantage to the surety. If principal debtor omits or he didn't pay the issue part only, surety going to pay. If give time, principal debtor, he paid in that time. The surety, it's advantage for surety. How discharge?
Okay, his doubt is, sir, if I am giving more time, it is advantage only, no, sir, to surety. Why is it discharging me? Remember, I know your value today and I gave you the surety for today. I know how you are going to be for the next 1 year. As a surety, can I predict how your life is going to be after 2 years, 3 years, 4 years? A lot of things can change, right? You might have a property, you might sell it off, you might have some securities with you, you might sell it off. I am fit to give money today. After 3 years, my scenario might not be good. So don't you think when we agreed, I would have calculated all of this? Now you guys are saying after 3 years. Now my scenario might change in 3 years. Your scenario might change in 3 years. I might not be able to recover even 1 rupee from you after 3 years. The law says you are discharged. Yes, it is seen positively, but there are negative impacts as well. Understood? Huh? Good question. Next one, sir. By invalidation of contract of guarantee. When is contract of guarantee invalidated, people? We have already seen all 3 scenarios. When the contract of guarantee is given by misstatement, concealment of a fact, or surety has clearly said, until co-surety is joined, I will not be, bound by this. I am not bound by this. In all these 3 cases, the contract of guarantee becomes invalidated. Misstatement, concealment of a fact, until co-surety joins, I will not be bound. I am not bound. Clear? Okay. Last one, sir. Rights of a surety. The rights of a surety are against 3 people. One is principal debtor. I have already said. If I pay loan on behalf of you, I have a right to recover that money from you. Next one is right against the creditor. What are the rights I have against the creditor? One is people. Whatever is the money you have taken from the debtor as a security, gold, shares, land, my liability will also reduce by that amount. If you have taken any security, my liability should also be reduced by that amount. The gold case I told you, that is what they are telling you. Next one, right to set off. What do I mean by that? Sir, debtor has taken in total 1 lakh loan. He has paid 4 installments of 10,000 rupees each. 40k papa he has paid. When the creditor is recovering the loan, I have a right to claim the set off. Set off means what? If he has paid any money, my liability should be reduced by that amount. You cannot take again 1 lakh only from me. That means whatever he has paid, after that my liability will be 60,000. That's the meaning of it. The third one, right to share reduction. What do you mean by that? A has taken from B 1 lakh. A becomes insolvent. B filed a case. B got some assets of A. What happens when you become insolvent? I will auction your home. I'll auction your gold. Whatever properties you have, a bike, we will sell all of that, right? So I sold all of that. B was able to recover 20,000 from his properties. Hello? The surety has a right to claim whatever is that security or whatever is the properties you recovered from an insolvent. I also have a right to claim the reduction. You recovered 20,000, even my claim also reduces by 20,000. So 1 lakh minus 20, 80,000 will be my loan. That is the third scenario. Understood? First one, security. Second one, third one is set off is if you have paid any installments. Third one is you become insolvent. From your properties, if I have recovered anything, even my liability reduces by that. The last one, sir, right against co-sureties. What is co-sureties? Sir, what if there are 3 people, sir? 3 people together have given surety. Now, what will be our liability? Simple, people. It can happen in 2 ways. One, you guys are equally liable. Equal liable, equal liable. If it is, say, 6 lakh total loan. First scenario, all of you are liable, 2 lakh each. Easiest. Next one, you can even prescribe different proportions. What do I mean by that? You can say A is liable for 3 lakh, B is liable for 2 lakh, C is liable for 1 lakh. You guys can prescribe different proportions. Sir, in this case, what will be our liability? When different proportions are chosen, let us imagine A did a default of 4 lakhs. 2 lakhs he has paid, 4 lakh he didn't pay. Can you guys tell me how do you guys divide the 4 lakh amongst these 3 people? How will you define this 4 lakh amongst these 3 people? Huh? 3 lakh, 1 lakh? 3 lakh, 1 lakh, 1 lakh, 1 lakh? 4 lakh, 4 lakh is the rest. So there are 3 people. How will I distribute 4 lakh people? First you have to share 1 lakh equally with everyone because everyone can take 1 lakh of responsibility. Now C done because he said maximum I can pay is 1 lakh. Now rest try to divide between these 2 people. You should never do in proportion. Don't do 3:1, 2:, that and all don't do. This is how you need to do. So the responsibility will be 1.5 lakh, 1.5 lakh, 1 lakh. Clear? What if the liability is 1 lakh? Imagine I did a default in 1 lakh. How will you share? 33,300 each. What if the liability is 2 lakh? Again 2 lakh divided by 3. What if the liability is 5 lakh? 5 lakh divided by 3? Again same thing you will do. What? 1 lakh, 1 lakh, 1 lakh. I'll add 1 lakh, 1 lakh. What if it is 6 lakh? That's how you divide. Understood? It's an important exam point of view. Remember. Then that's your contract of indemnity and guarantee. When 1 you need to go for a break. Okay, I don't mind. Okay. When prior to the due date, food problem, food problem. Lunch is not ready in the 12:30. They have not yet. It's okay. We'll see. Come. When prior to the due date of performance, the promisor absolutely refuses to perform the contract. It is known as anticipatory. Did we did or not, Then some breach we didn't. Okay. In case of anticipatory breach, the aggrieved party may treat the contract as discharged and bring an immediate action, as operative and wait till the time of performance. Exercise option either A or B. C. In case of breach of contract, which of the following remedies available to the aggrieved party? Suit. Sometimes a party is entitled to claim compensation in proportion to the work done by him. It is possible by a suit for. Generally, the following damages are not recoverable. Which one? Cold, night. Damages which arise naturally in usual course of things from breach itself are called as correct? Ordinarily attached. A contracted to supply 200 bags of rice to B on 30th December 2021. After supplying 20 bags of rice, A informed B that he will not supply remaining bags of rice to B. In this case, there is anticipatory breach, there is actual breach, both of the above, none of the above. Anticipatory, yeah. A contracted to supply 200 bags of rice to B on 30th December. After supplying 20 bags, A informed B, hey, during the performance, the actual breach on there. I told you both scenarios can happen. Where the court orders the defaulting party to carry out the promise according to the terms. It is called as. Where the court orders the defaulting party to carry out the promise according to the terms of the contract. It is called as. Antique. I want antique watch only. I don't want money. Quantum merit means. What is quantum merit? As much as earned. As much as earned. Wrongful dishonor of check by a banker having sufficient funds is called as vindictive or exemplary. Yes, that is also possible. I mean, I saw in this only they have given. Okay. People, an anticipatory breach of contract is a breach of contract occurring before the time fixed for performance has arrived. Discuss stating also the effect of anticipatory breach on contracts. What is breach? Correct now, anticipatory is you try to cancel the contract before the happening of the event. What is the effect of anticipatory breach? You can either cancel the contract immediately, claim for compensation, or keep the contract open until the due date and then cancel and then claim compensation. Both are possible. That is the effects. Next one, people. Liquidated damage is a genuine pre-estimate of compensation of damages for certain anticipated breach of contract, whereas penalty on the other hand is an extravagant amount stipulated and clearly unconscionable and has no loss effort. Explain. What is this, people? Remember, Indian courts do not make any differentiation between penalty and liquidated damages. What do you mean by liquidated damages? It's a calculated amount. Properly you say, prefixed. If a party does not perform the contract, you need to pay me 20,000 rupees. What if the person says, if you do not perform the contract, you need to pay me 5 lakh rupees as compensation. The value of the contract itself is 1 lakh. I say, if you do not perform the contract, you need to pay me the compensation of 5 lakh rupees. Hello? Yes or no? Now, is it called as prefixed damages or is it called as penalty? Contract value is 1 lakh. But if you do not perform the contract, you need to pay me compensation of 5 lakhs. Is it called as liquidated or penalty? It is called as penalty. Why? See, if it's you should not consider it as an agreed amount or not. Both the liquidated damages and penalty both can be agreed in the contract itself. But how did you arrive at the number? Was it calculated? Was it reasonable? See, why did I put 20,000? Because if I buy from someone else, I need to pay extra 20,000. That is why we have put 20,000. But if I ask you, how did you put 5 lakh? Hey, no calculation. Simply I put 5 lakh. It's not a logical expression. That is called penalty. Second one, people, penalty is always, why do we put 5 lakh as a compensation in the contract? Because whenever you see the 5 lakh, no, because of the fear, you should not commit a mistake. It creates terror. That's why the word used in the book will be terrorism. Why do we use the word 5 lakh in your compensation? Because whenever you look at the compensation, you should always feel, if I miss it, I'm gone. So that is always a calculated number. This is always a unrealistic number. It's an extravagant number. It is used for the purpose of creating fear, terrorism in the other person's mind. That is called as penalty. Remember and go. Next one, people. X entered into a contract with Y to supply him 1,000 water bottles at 5 rupees per water bottle to be delivered at a specified time. Thereafter, X contracts with Z for the purchase of 1,000 water bottles at 4.5 per water bottle, and at the same time told Z that he did so for the purpose of performing his contract entered into with Y. Z failed to perform his contract in due course, and market price of each water bottle on that day was 5.25 per water bottle. Consequently, X could not procure any water bottle and Y resigned the contract. Calculate the amount of damages which X could claim from Z in the circumstance. What would be your answer if Z had not informed about the Y's contract? Explain with reference to the provision of Indian Contract Act. If at all you have informed, special damages. If you have not informed, general damages. If I have informed, I can claim that compensation also. If I have not informed, I cannot claim that compensation. Simple. I think we have seen the same example. That's why I'm not again doing it. Pant. Mr. Chetan was traveling. Done. Oh, that's all. Huh? What is this? Okay. We'll do up unit 6 also, instead of starting a unit. Okay, a contract dependent upon happening or non-happening of future uncertain event is called? A contingent contract is? Why double? Hey, A contingent contract depend on happening of future uncertain event can be enforced when the event happens, becomes impossible, does not happen, either of this. A contingent contract dependent on happening of future uncertain event can be enforced when happens. Our case of bank loan, I can enforce a contract only when bank gives loan. What if bank does not give loan? Contract becomes void. Hello? The event happening or not happening? That's the example. A agrees to pay 1 lakh to B if he brings on earth a star from sky. This is contingent contract and illegal. Which of the following is not a contingent contract? A promised to pay B if he repairs his scooter. A promised to pay B 10,000 if B's scooter is stolen. A promised to pay B 10,000 if B's burnt his hands. A promised to pay B 10,000 if it rains on 1st of the next month. Which of it is not a contingent contract? Option? Huh? Option D. C. Macha, you repair, I pay. A contingent. The question is which is not a contingent contract. Hey, machas. Oh, quite a small confusion, sir. We didn't read question. Which of the following statements regarding quasi-contract is incorrect? It resembles Macha, I am only helping you. Incorrect. It resembles a contract. It is imposed by law. It is based on doctrine of unjust enrichment. It is voluntarily created. C, sir, because we don't know that. Answer is D. It is voluntarily created. The quasi contract you guys don't enter, noda. It is created by law. Hello. What is unjust enrichment? Sir, whatever we don't understand is the answer. That's why they have also given. Unjust enrichment means nothing but the case of Varshini, Zomato is unjust enrichment. That means what? Law will never support in a way one person gets an advantage over the other party. Unjust, unfair, enrichment, making advantage. Unfair advantage should never be given. Hello? Whatever we don't know is the answer. Nice. For a contingent contract, the event must be certain, uncertain. Hey? Contingent, uncertain and collateral. Macha, I am becoming you. Which one of the following is not a characteristic of a contingent? Macha, not a characteristic. Same question now. Okay, performance depends upon a future event. The event must be uncertain. The event must be collateral to the contract. There must be reciprocal promises. Wagering contracts are. A contract of insurance is. Finder of goods should take care of goods as. Owner. A Swiggy man wrong, they've used Swiggy. A Swiggy man wrongly delivered the food to Mr. Ishan. Ishan, who took the delivery, ate the food. Ishana Varshinina. The Swiggy boy returned soon once he got information about wrong delivery. Ishan should make the payment as his case is deemed to be quasi-contract under which case? Correct, huh? Explain the term quasi-contract. What is quasi-contract? It is involuntary. Parties do not enter. It is similar to a contract. It is imposed by law. Hello? And it is always a right for money. Of course, right for money, right? Varshini can't say, you come to my home, I'll give you one dosa back. Hello? Very effective point. You should underline that. If not, it is not a quasi-contract. Always the remedy will be money only. Nothing else will be there. Exa minor was studying in MCOM in a college. On 1st July 2021, he took a loan of 1 lakh from B for payment of his college fees and to purchase books and agreed to repay by 31st December. X possesses assets worth 9 lakh. On due date, X fails to pay back the loan to B. B now wants to recover the loan from X out of his assets. Referring to the provision of Indian Contract Act, decides whether B would succeed. Can he? Yes, why? Quasi contract, any money given to a minor, correct? Supply of necessaries. I can recover it from his assets. I believe his assets is 9 lakh or something. Can I recover? Yes, I can recover. P left his carriage on D's premises. Landlord of D seized the carriage against the rent due from D. P paid the rent and got his carriage release. Can P recover the amount from D? Can he recover? Yes. Why? What is the ground? Payment made by a interested person. You need to write that. If that word is not there, you will not even get 1 mark. When students were asking, sir, how do I present? That's all. The examiner will see if that word is there. Rest of it you frame in your own language. It's okay. All that I will look as an value is payment by an interested person written as it is. Rest of it you are free to frame it in your words. Hello. Rahul found a smartwatch in a restaurant. He inquired about all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep it till the true owner is found. After a week, he went back to the restaurant to inquire about the smartwatch. The manager refused to return it to the Rahul, saying that it did not belong to Rahul. In the light of Indian Contract Act, can Rahul recover it from the manager? Remember, whenever the true owner cannot be found, whoever found the goods is deemed to be the next owner until the owner comes. Correct? So here, if at all the manager has spent some money to safeguard the watch for a week, I have to pay those charges and I can recover that particular watch. Clear? Okay. Yes, people. Let us, unit 7 we did done, no? Okay, we'll do up the question and then go. Contract of indemnity guarantee chapter is done, no? Okay. A contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person is called as contract of indemnity. X, a shareholder of a company, lost his share certificate. He applied for duplicate. The company agreed to issue the same on the term that X will compensate the company against the loss where any holder produces the original certificate. This is called as what type of contract? See, the problem is that the background of this is not there in our syllabus. It comes in Companies Act. It is called as contract of indemnity only. It will come in CA Inter. They have taken and they have given. What is there? You know why? The background is this in your old syllabus was in CA Inter. Unit 7, 8, 9. So 1 or 2 questions they have just taken and they have just put it because it was there in CA Inter. So Companies Act was also there. This was also there. In our scenario, it is not relevant for us. So leave. Next one, section 124, 125 of the Contract Act deals with contract of indemnity, contract of guarantee, both A and B, none of the above. Do we know this? Contract of indemnity, because it starts only with contract of indemnity. Next one, people, where A obtains housing loan from LIC housing and if B promises to pay LIC housing in the event of A failing to repay, it is a contract of guarantee. A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C and to be paid for in a month. B delivers 5 sacks to C. C pays for them. Afterwards, B delivers 4 sacks to C, which C does not pay for. Whether A is liable for the price of 4 sacks, A is not liable for the price of 4 sacks, A is liable for the price of 2 sacks only, A is liable for the price of the 1 sack only. What is the answer? Huh? Easy answer, da. What? Huh? Taka taka. A is not liable. Why? It is a contract of specific guarantee. I said you supply 5 sacks, he supplied. Contract came to an end. That's all. Correct? No. It is not a continuing guarantee. If it is a continuing guarantee, it carries on for every transaction. Here it was only for that 5. That 5 was supplied. Contract is done. This was another 4 sacks, which is not dependent for my contract. Hello. Easy, da? X gives a guarantee to extent of 50,000 for the loans given from time to time by A to B. A gave a loan of 10,000 to B. Afterwards, X gives notice of revocation, which is the correct option. X is discharged from all liabilities to A for any loan granted. X is liable to A for 10,000 on default of B. X is liable to A for 50,000 on default of B. X is liable to A for 40,000 on default of B. What is the answer? Huh? 10,000 B. Because people continuing guarantee, whatever has happened, you cannot revoke. Whatever are the future transactions, I can revoke. 10,000 has already happened, hence I cannot revoke. The guarantee is valid even if dash is incompetent to contract. Who? Huh? Principal debtor. Section 143 of Contract Act 1872 deals with guarantee obtained by such type of questions are not required for us, but there is nothing but the case of concealment. The section and all, that time and all, they have just given for MCQ purpose. Keep it for MCQ purpose only. A surety has a right of indemnity and right of subrogation against whom da? Hey, what is subrogation da? What is subrogation da? If I repay your debt, principal debtor's debt I pay, I have a right to recover the money from the debtor tomorrow. Today I pay to the creditor. Tomorrow I can recover it from the debtor. Yes or no? Hello? Huh? Indemnity or same?
Implied 3 stages.
Implied preliminary contract.
Second contract
Between surety and creditor. Third contract is between surety and the principal debtor.
subrogation and implied.
Implied contract, it's a contract between both of us. That's what implied contract says. Subrogation, what do you mean by the word subrogation? Subrogation generally means if I repay the money to your creditor, I repaid, I will become your creditor. So now whatever rights the creditor has on the debtor, the same rights I will have against the debtor. Understood? Debtor is there, borrower is there, bank is there, surety is there. Whatever rights the bank has on the debtor, if the surety repays the loans to the bank, the surety will enjoy the same rights as the bank when recovering the money from the debtor. That means what? I can file a case, I can take you to the court, all of that is possible. That is the meaning of subrogation. If I have to tell you in actual words what the subrogation means putting the surety in the shoes of creditor. That's the exact meaning. Putting the surety in shoes of creditor. Understood? Why did I turn off? I have weakness. Nice breeze. First food and then nice air. Beka. In contract of guarantee, What is the answer? As subrogation against principal debtor. In contract of guarantee for whom guarantee given is called as what? In contract of guarantee for whom guarantee given is called as principal debtor. That is on whose behalf. What are the rights of indemnity holder when sued? 3. What is that? For all the sums promised in the contract, all the sums you might have to pay as per compromise and all legal charges, damages. Correct? 3 things are. Define contract of indemnity and contract of guarantee and state the conditions when guarantee is considered invalid. Contract of guarantee, contract of indemnity, and what is the when is it considered as invalid people? 3 things. One is misrepresentation, concealment of facts, co-surety joints. Hello? Until co-surety joint, I will not be liable. I am not liable. Mr. X is employed as a cashier on a monthly salary of 12,000 by ABC Bank for a period of 3 years. Y gave surety for X's good conduct. After 9 months, the financial position of the bank deteriorates. Then X agrees to accept a lower salary of 10,500 per month from the bank. 2 months later, it was found that X has misappropriated cash since the time of his appointment. What is the liability of Y? What is the liability? I hope you understood the question. A bank hired a person for a salary of 12,000. One person has given a guarantee. If he does any non-compliance, I will come and pay the money for it. After 5 months, they have reduced the salary from 12,000 to 10,500 sims. Mutually, they agreed because the bank is undergoing some tough time, they have reduced the salary. They got to know after all of this that this fellow has been doing some fraud from the date of his appointment. They are asking you what will be the liability of the surety or the guarantee. What will be his liability? He is liable for up to the 9 months. What they are telling you is, people, see, when did the salary change? After 9 months, the salary changed. Up to 9 months, people, the contract went as per the terms and conditions which was agreed by everyone. After 9 months, there was the words you need to write, provision of law, variation in the terms and condition without the surety's consent. If you guys vary in the terms and condition without the surety's consent, the surety is hereby discharged. In the 9th month, there is a variation that salary is being changed. Now, because of that, people, what will happen? From the 9th month onwards, the surety is discharged. But the fraud has been done from 1st to 9th month. That is valid. So, I am liable up to the 9th month. After 9th month, that is after the variation, I will not be held liable. Understood? Hello? Easy? A contracts with B for a fixed price to construct a house for B within a stipulated time. B would supply the necessary material to be used in the construction. C guarantees A's performance of the contract. B does not supply the material as per the agreement. Is C discharged from his liability? A contracts with B for a fixed price to construct a house for B. A is telling, I will construct a house for you. B supplies the necessary material to be used in the construction. I am telling, I will construct the house. But B said, I will give you the material, cement, blocks, that and all I will only give. You just do the construction part. Hello? Okay. C guarantees A's performance. C said, hey B, if A does anything wrong, no, I will pay the money. You don't worry. C guarantees A's performance of the contract. B does not supply the material as per the agreement. That is, I said you need to construct, you did not supply the material only. Now they're asking you, is C discharged from the liability? What will happen to the C's position? What will happen now? Hello? I thought you all went to meditation. No? Huh? Discharged? Why? B did not perform his contract. Can you tell me, first what will happen to the contract between A and B? Is A discharged? People, forget C. Let us imagine C is not there. A and B are there. A said I will construct. B said I will supply raw material. Papa, A came to that place that day. He came. B did not supply the raw material. What will happen to A? What are the A's rights here? Forget C. What can A do? Huh? A can cancel the contract. Can A claim damages? I did not construct anything. But can I claim damages? Can I claim damages? Yes. Time is essential. One day, house. Much. Yeah. What house you are building? Na? One day I will make all changes. Huh? Tell me, tell me, can A claim compensation? Yes or no? No, people remember, you are still answering me yes or no. You still have to tell me on what grounds. I will help you. A can claim compensation. A can even cancel the contract. But you need to tell me the grounds on which A can claim compensation. Provision.
Because of B, A did not contract with others. A contracted with B. If A did contract with A, sorry, in contract with B, A could have contract with others. Because of that, in contract.
Logically, in our real life scenario, what you said is right. But as per law, there will be provision. He said clear, sir, if at all you had not called me, I would have gone somewhere else. I would have earned some money. You called me here, I came here, and hence you have to pay me. People, your ICU batch example, people, negligence. When the promiser is willing to perform, A came. When the promisee neglects the performance, B did not supply the materials. A is discharged from the contract. Negligence. Sir, we will remember ICU example, ICU only. You should ask same. You can't ask something and all. Correct, I'm sorry. My mistake. If possible, I'll try to rectify it. Clear? I hope you understood. Now A is discharged. And our contract of guarantee says that are discharged something went, sir. I don't know inside or outside, but it went. Hey, understood, Ada? Okay, that is why surety is discharged. If they ask you that much, no. Okay. Mr. D was in urgent need of money amounting to 5 lakh. He asked Mr. K for the money. Mr. K lent the money on the sureties of A, B and N without any contract between them in case of default in repayment of money by D to K. D makes default in payment. B refused to contribute. Examine whether B can escape the liability. Can B escape the liability? Hello? Wait, sir, we are reading the answer directly. No. Why? I read it, sir. That's why. Hey, what is the answer? Huh? First of all, what type of co-sureties are there? See, they are telling you they have lent money without any contract between them. That means what? When nothing is agreed, then the liability will be shared equally. Now, can B escape? Answer is no. What if two sureties are paying the money? A and N can recover the money from B. Hello? Hello? Yes, sir. Mr. Chetan was appointed as site manager of ABC Construction Company on a 2 years contract at a monthly salary of 50,000. Mr. Pavan gave a surety in respect of Chetan's conduct. Same thing, bank's case. After 6 months, the company was not in a position to pay 50. Chetan agreed for lower. X agrees to sell goods to B on the guarantee of C for the payment of the price of goods in default of B. Is the agreement of guarantee valid in each of the following alternate cases? What if A is a minor? See, A agrees to sell goods to B. C has given a guarantee. Hello? A is like a creditor, B is like a debtor, C is the surety. So put it like that and say, now if A is a minor, can the creditor be a minor? Remember, minor. Hey, if anything which comes inside is okay, he cannot be liable for any of the losses, not possible. Beneficiary, yes. So creditor, not possible. So contract will be, agreement will be void. You have to correct me. If B is a minor, what if B is a minor? Who is B here? Borrower. Can debtor be a minor? Yes. See, this is how you need to put an answer. Next, if C is a minor, who is C? Surety. Can surety be a minor? Illa. What will happen to the contract? Will correct me. Agreement. Agreement becomes void. Don't use the words interchangeably. And void ab initio. S asks R to beat T and promises to indemnify R against the consequences. R beats T and is fined 50,000. Can R claim 50,000 from S? I told you to beat him. Anything happens to you, I'll look after. He went and actually he did it. Now I am going and asking for the compensation. Can I recover the money? Unlawful. Unlawful contracts, how can it become valid? In the court of law, what will I say? So it is not justified in the court of law, not enforceable, unlawful. Manoj guarantees for Ranjan, a retail textile merchant, for an amount of 1 lakh, for which Sharma, the supplier, may from time to time supply the goods on credit basis to Ranjan during the next 3 months. After 1 month, Manoj revokes the guarantee when Sharma had supplied goods on the credit for 40,000. That's all. There only we can answer. Referring to the provisions, whether Manoj is discharged from all the liabilities, what would be your answer in case Ranjan makes default in paying back Sharma for the goods already supplied on credit of 40,000? Tell me people, can I recover everything? Can I revoke everything? Future transactions, yes. That 1 month, no. If at all is 40,000, if I make a default, it was before revocation and hence the surety will be liable. Hello? Hello? How will I put it in my answer? Provision. Provision says what? First I will establish. Now let us imagine we don't know section. What will we write? We will write as per the relevant section of Indian Contract Act. What does it say? A surety can revoke all the future transactions in a continuing guarantee, but he cannot revoke a past transaction. So in the given case, the 1 month's transactions which has already happened cannot be revoked and the future transactions can be revoked. So in the given case, 40,000, if there is a default, the surety will be liable. That's how you guys have to present it as a conclusion. And remember, whenever they are using the numbers in the question, you are supposed to use the numbers back. If they are giving you in the question 40,000, please write, Mr. Ranjan will be liable for 40,000 rupees. Don't just write that he is liable. Are you getting the point? And if there is any deduction that has to be done, show it. Like 1,20,000, you please show 1 lakh minus 20, like that only you have to do. So writing these things will increase the marks, chances of you getting that 4 on 5, 5 on 5, the chances will be high. So you have to be very specific, not on the top of it. Clear? Okay. C advances to be 2 lakh on the guarantee of A. C has also taken a further security for the same borrowing by mortgage of B's furniture worth 2 lakh without knowledge of A. C cancels the mortgage. After 6 months, B becomes insolvent and C sues A, his guarantee. Decide liability of A if the market value of furniture is worth 80,000 under Indian Contract Act 1872. What happened, people? The creditor has given 2 lakh loan and he has taken a security also worth 2 lakh. Now after 2 years, people, this surety does not know that I have taken a security. After 2 years, people, the market value of the security is 80,000 rupees. They are asking you how much can the creditor recover from the surety if the debtor does a default. Now debtor did not pay 2 lakh. How much I can recover? 1 lakh 20, or can I recover 2 lakh? Because on the date I took the loan, the market, the value of the security that day was 2 lakh. How much will I be liable? How much? Hello? Remember people, if you have taken 5 years loan, you have given your gold. Today your gold value is, say for example, 6,000 rupees. 5 years back. Don't even take 5 years. 3 years back the gold price was 6,500 or 5,600. 3 years back. Today what? 13 and a half, 14 and a half, 15,000 rupees per gram. Now imagine you took 3 years loan, you have given gold, Muthoot, Manappuram. When giving back, what will be the value of the gold? If you don't repay the loan, at what price will they take the gold? At the price you gave or today's price? So remember, always you need to take the today's market value. Always. Hello? That was a question here. What will be my liability? My liability will be 2 lakh minus 80,000. And remember, what is the word I need to write? The surety's liability is coextensive with the debtor. That is 1 lakh 20. I will be also liable for 1 lakh 20. What is the main question that they are trying to test here? When the surety does not know about the security, can I claim it? Yes, you have a right. Understood? Huh? We clearly saw, no? Whatever gold you have given, for that even I have a right. Hello? Yes or no? Okay, that is your... What do you mean by next chapter, people? Bailment and pledge. The most easiest chapter, huh? Yes, sir. Hello? Okay. Sir, you tell, sir, everything is easy for us. Bailment means what, people? Bailment means transfer of, voluntary transfer of possession of the goods, but not the ownership. Voluntary transfer of possession of the goods is called as, people, bailment. And once the purpose is served, the goods will be transferred back. Such type of contracts are called as contracts of bailment. In the contracts of bailment, there are 2 types of parties. One is called as bailer, bailee. The person giving is called as bailer, person taking is called as bailee, jailer. Okay. Now, people, what is the next one, sir? Essential elements of a bailment, people. Contract. It can be express or implied. Delivery of goods. It should be an actual delivery. You have to transfer the physical possession of the goods. Next one, people. The main important thing is, remember, the mere custody will not be considered as possession. You know that the goods have 2 types of right. One is possession, one is custody. Transfer of custody is not considered as bailment. Transfer of possession is considered as bailment. Sir, give us an example. You go, you park your car in a parking lot. You lock it, you take the keys with you. Now you tell me, where is your car? Parking lot. That is basically with that mall or any other person, wherever you have parked it. Now tell me, your car is with them. Is this contract considered as bailment? Is it considered as bailment? Joshua, is it bailment? Is it bailment or not? What are Nitin? Nitin, bailment, huh? No, sir. No, sir, focus, sir. Now you ask me, next question is mine only. People tell me, is it bailment? No, why? The key is with you. Remember, people, there is a difference between custody and possession. What is the difference? Possession means, people, the product's little control is also given to the other party. If you give custody, the control is not given to the other party. Control is with you. You have just given it to them. There is a difference. Sir, we didn't understand. Now say, for example, I give Narayan Murthy this mic. He says, sir, I have some orchestra happening in near my home. in evening, we have some concert. You know concert? Sorry, Gen Z. Orchestra. We are not orchestra people. Yes, orchestra means they used to come, one singer used to come, they used to sing near our home Ganesha festival and all. They are called orchestra people. You Gen Z concerts. Huh? Yes, sir. Now, Narayana Murthy, I will give him this mic. For what? For orchestra. Yes, sir. Orchestra. We give it for orchestra. You should call it as orchestra. See that? Emotion, da. Now, people, I give it to him. He says, sir, after 2 days, I will give back this mic to you. What type of, transfer of possession, or is it transfer of custody? He will take the mic, he will use it for 2 days, he will turn off, turn on. First day, so he will pack up, play in the home only. Simply, he will go around in the home and keep talking like this. Now, is the product in my control or in his control? It is in his control. Whenever I am transferring even the control of the goods to the other party, we call this as possession. In the case of parking lot, keys is with you. Can the person move your car 1 inch?
No.
Don't tell he can push. Can he turn a wheel? Possible? Illa no. Hey, who fell? Someone fell? Bottle fell so hard? Okay. Now people, second one, another example for custody, you will get clarity. Imagine people, you guys go and you deposit your gold in a bank's locker. You will rent a locker, you go keep all your gold in the locker, you will lock it. Now you tell me, can the guy take the gold out? Can you see, oh wow, and can he keep it inside? Is it possible? No. But do you think the gold is with him? Yes. Is it a contract of bailment? Answer is no. Because remember, this is custody, this is not possession. Possession means you should have some control over the goods. Hello? Understanding? Pakka? Yes. So that is what they are telling you. It should always be transfer of possession. Just giving custody is not considered as bailment. Clear? Any doubts? Out of topic? Relative, tell me. Tell me. Police custody. Does it come under bailment or not? Wait, Police custody means police has no rights. On whom?
Custody means possession means they have some rights. Custody means full rights are thing in the his place, but all control over the other person. So police custody means
Police custody I understood. Doubt is police custody bailment or not, correct? That's the doubt? Correct? Allah, if that is the thing I'm telling you, let us imagine police custody. You tell me, if you want, can you get back the goods? In police custody, police can beat you. So you are saying when you are arrested, are you coming under bailment?
Not a good sense.
Sir, I can also move, don't tell. It's only goods. So for us, it does not apply to us. Okay, because you asked, no, there is one question, you guys only tell. People, examine whether the following constitutes a contract of bailment or not. V parks his car at a parking lot, locks it and keeps the keys with himself. Is it a bailment? Seizure of goods by custom authorities. Can we take it like your police authorities? Imagine something is coming in port, customs, you did not pay the duty, so they have seized it. Is it considered as bailment? Try to think on the same grounds. Do you have control over it? You don't have control over it. You don't. Who you means? Customs are, hey, Narayan Murthy, you should not answer diplomatically. Da. He says, sir, you don't have control. Do they have control? Custom authorities have control. Huh?
Custom authority have control, but your control is
Why again come to my control? Da?
the person, the port, the owner of the goods.
Seer. See, understood? Now tell me, custom authorities, when they seize your goods, if you do not pay the money, can they auction it? They will auction it. They will decide where your goods has to be. Is it under their control or not? Exactly. So your police thing can come here. It is not under your control. It will be under their control only. If it is any goods. Clear? Yes. So any goods seized by authorities can be considered as bailment. It is not just custody. Hello? Understanding? Okay. Okay. Next one. Contract bailment can be classified into two things. People, one is gratuitous bailment, one is non-gratuitous. What do you mean by gratuitous? Free. Non-gratuitous people, not for free. Some money is involved. That means you are paying some higher charges. Examples of bailment people. Imagine I take a bike on rent. That is called as non-gratuitous bailment. Imagine people, if you borrow any of your friends' notes, you will tell you will return it in 2 days. That is called as gratuitous bailment. Will you pay for it? For taking your notes? No. But after 2 days, you will give it back. Such type of things are called as gratuitous. Non-gratuitous is not for free. You are paying some money. Clear? Yes? Done. Next one, sir. Rights of bailer. What are the rights of bailer? You have a right to terminate the contract. Do I have a right to terminate the contract? Remember, there are two types of contracts. One is free, one is for rent. If the bailment is for rent, you cannot terminate the contract unless the other party is misusing the goods. If it is for rent, you cannot terminate unless the other party is misusing the goods. That means what? You took a bike for rent. I've paid. I've taken the bike for rent for 1 month. You cannot come and cancel the contract in between. Not possible. You have to give it, you have to wait for 30 days. But you have a right to cancel when? Imagine I'm doing drink and drive, or I'm going above the speed limits prescribed. In such case, you have a right to terminate the goods. But if it is free of cost, I have a right to terminate whenever I want. That means what? B takes his friend's car, maybe probably van. So A is having a van which he is not using at all. B says, can I use it? He says, okay, take it. I don't have a problem. Now, is B paying any money for it? Nothing. B is not paying any money for it. What type of bailment we call it as? Gratuitous. Now, how many days you asked me for? I asked for 6 months. He said, okay, take the take the van for 6 months. After 1 month only, A is coming back and asking for the goods. Can A come and ask back the goods? Can he ask? Yes. Yes, he can. But B has suffered some loss. Can B recover that money from A? B has suffered some loss. Can B recover that money from A? So define as the loss. I have serviced the vehicle, have washed the vehicle, I have incurred some 10,000 rupees. Can I recover it from A or not? I can recover. Whenever you are terminating a contract, even if it is free, if you are terminating a contract, you agreed for 6 months and you gave. Papa, that fellow invested 10,000 rupees believing in that. You have a right to take back whenever we want. We can't stop that. However, if the other party has incurred any cost on it, he has a right to recover.
And petrol charges are very
Petrol is no. Necessary expenses, no. For your cost, whatever you have incurred, that is okay. Anything beyond that, that's why I've used the word loss. If I suffer any loss, I can recover from you. Clear? Premature termination, whatever we saw. Suit against wrongdoer. Imagine if someone hits your vehicle. Bailor can also file a case. Bailee can also file a case. They can ask you, remember in the exam, what are the rights? Right to sue the bailee for. The bailor has a right to sue the bailee for what and all. First one, compensation for loss by negligence. Compensation for unauthorized mixing of the goods. I have my goods, I have your goods. We mix it. I am liable to compensate it for you. Compensate for unauthorized use of the goods. That means what? I've given my bike for service, repairs. The garage fellow says, sir, my God, very complicated problem has happened. 5 days I can't give your bike. I said, okay. What is the complicated problem? Anna is doing Rapido in the city. He's using my bike. Can he use it? Has he told me that he is using it? No. Unauthorized use. You did not ask me, but still you are using it. Muthoot Manappuram, you are giving your gold. You are taking a loan. Hello? Do you know that they are using your gold or not? Hello? Okay, sir, Muthoot Manappuram are big people. They will not do like that. Okay. People remember, this is very common in many places. Yeah, every goldsmith will have this option. You give gold, they will give you some loan. But are you guarantee people that they will not use your gold? Huh? Guarantee, na? They will use. That's what is called unauthorized use. You can hold them liable. Hello? Yes or no? To demand back the goods once the purpose is done. My bike is repaired. I have a right to take back the goods. Right to accretion to the goods bailed. What do you mean by that? Any increase in value of the goods I gave you, I have a right to take back even the increase in value as well. Understood? Hello? Next one, duties of bailee. Take reasonable care of the goods. Who is the bailee? The person who takes the possession of the goods. Not to set up the adverse title. I will take your goods. I will go and sell it to someone. Can I do? No. Not to make inconsistent use of the goods. Correct? Return and accretion from goods. Correct? All his rights will become his duties. All his duties will become that fellow's right. Correct? Next one. Return the goods. Correct? Once the purpose is done, I have a duty to return the goods. Not to mix the goods. We already saw. What if, sir, we mixed it? Imagine I had some sugar. Your sugar also we mixed. What to do? If you can separate it, people, separate it. You are very talented, multi-talented. I don't know. You may be talented. So if you are so talented, people, separate it and give it. No, sir, you cannot separate it, people. You have to pay compensation. That's all. Done. Finder of lost goods. Who is the finder of lost goods? What are the rights of finder? Who is the finder of rights of bailee? We'll finish it off. Okay, we'll finish off this also. What are the rights of bailee people to deliver the goods to any one of the joint bailors? So if two owners are there, I can give it to any person. Right to indemnity. If bailor has no title and bailee delivers them back to the bailor, what do you mean by this, people? If I suffer any loss as a bailee, I can recover that money from you, bailor. Example, people, there is a thief. He snatches a gold chain. I go and give this gold chain in a gold shop as mine. And what do? I borrow some loan, 1 lakh rupees. Now let us imagine whosoever is the owner went to the same gold shop to purchase a new chain. He asked him to show designs. He saw the same design. He said, where did you get this? He said, it is mine. Hello? Now what will this fellow do? The owner of the gold chain. He will want to file a case on this fellow. Who? The gold shop owner. I'll say he only took my chain. My chain is with you now. If someone files a case on the bailee, what does the law say? The gold shop owner has every right to recover that money from the thief. Whether you can catch him or not, it's your headache, it's your fate. But I will give you a choice to recover the money. That's the scenario. Understood? Hello? Now second scenario, now remember, people. The owner is coming and telling that is my chain. The thief also came. You tell me, the gold shop fellow, to whom should I give this gold back, the chain back? To the thief? That is, he is the person who gave me, or to the actual owner who is showing me bills also, that this is mine. Actual owner, yes. Remember people, if at all as a gold shop owner, if you are not able to decide who the owner is, you can go to the court, you can apply, sir, I am so confused, I don't know who the owner is, can you please tell me to whom should I deliver the goods back? For all this, you can recover the expense from the bailer. Hello? Understood? Right to apply to the court. Understood? Okay. Claim compensation in case of faulty goods. That means what, sir? Sir, I have taken the bike on rent. What type of rent? One is free, one is paid. Free. If you have taken the bike on, from your friend, you have taken it for some days. The brake is not working. You met with an accident. Can you recover any compensation from your friend? That is the bailer. In a free transaction, can a bailee recover any compensation from the bailer for meeting any loss or coming across any accidents? Can I recover any compensation? The answer is, people, they will ask you, does the bailer know about the defect? Does the bailer know that the brakes were not working? If the bailer says, I knew that the brakes were not working, then I can recover the compensation. If the friend says, the bailer says, I did not know that the brakes were not working, you cannot recover any compensation from your friend because this bailment was for free, gratuitous. What if the bailment was for rent, hire? Whether you are aware, whether you are not aware, doesn't make any difference. The bailee is entitled for all the compensation from the bailer. Hello. Exam point of view, very important. Okay. Claim any extraordinary expenses incurred. Claim any extraordinary. Ordinary alla. Extraordinary. Ordinary is petrol. Extraordinary is cleaning. Understood? Cleaning charges, any service, things like that. Yes, sir. Right to lien. Let us do lien when we are doing that only. Sale of goods act. Anyways, we have lien there, no? Or you want to do it here? We'll simply mail will do it off. What do you have a particular lien? General lien. Lien means what, people? Until you pay the price, I will keep the goods with me. I will not give it to you. Now this is called as lien. What do you mean by particular lien? I will keep. Now imagine if I have repaid this goods, I have a right to only keep this goods until the money is paid. If I have any other goods of you with me, I cannot keep it. So a right to withhold the specific goods on which any repair or any work is made, just to keep those goods with you. Such type of lien is called as particular lien. General lien means, people, you can keep any goods for any transaction. For example, people, have to explain you one general lien. I'll give you one example. I go and take a loan from a bank. How much? 1 lakh. I have not given anything as a security. Nothing was given. I just took 1 lakh loan. Clear? Hello? Now in the same bank, I have my FD also, which is separate, which is different. But the same bank has my FD. Hello? If I do not repay this loan because you are a banker, the law has given you a right of general lien. That means what? Loan, FD are two different transactions. If I do not repay the loan, the bank has a right to withhold my FD with them until I pay back the loan amount. Technically, if you see, they both are not related transactions. Hello? So particular lien means, people, only that transaction towards which you have worked, only that product can be withheld. General lien means, people, it can be any transaction, any contract, both can be merged. That is the meaning of general lien. Hello? Pakka? Understood? Okay. Next one is called as, people, duties of bailor. What are the duties of bailor? To receive back the goods, of course. To indemnify any loss suffered, I told you. Duty to disclose faults in the goods bailed. Same thing we saw. Hire or non-hire. Pay necessary expenses. Indemnify bailey for any premature termination. I told you this also. Premature termination. I've taken your van. I've invested 10,000 rupees. I am liable to pay the 10,000 rupees. Hello? Hello? Okay. Next one is people. Finder of lost goods. What is finder of lost goods? Whenever I find any lost goods, what will be my duty, people? To return back the goods to the actual owner. But should I return back the goods always? Or can I only keep it? Remember, people, it is my duty to return back the goods to the owner. Sir, what? I have incurred some cost to find the owner. Go tell it to the owner, sir, to search you. I have spent 400 rupees. Can you please pay so that I can give back your goods? Remember, if the owner does not pay, can I file a case? Answer is no. If the owner does not pay your 400 rupees, the law has given you a right. You can keep the goods with you. You can keep it until he pays for it. Until he pays, you can keep it. Sir, how long? You keep it however long you want, you keep it. Sir, what if it is perishable goods? If it is perishable goods, people, I will give you even a right to sell it. Because you can't keep it forever, no. Intimate him once. Macha, I'll give you one more day time. After it is gone, give him 1 day time. If he is not paying even in that 1 day, people, you have a right to sell the perishable goods. Hello? Hello? And when else I can sell the goods? I go and say, sir, you have to pay me 400 rupees. What is the value of the product? So the value of the product is 600 rupees. He has to pay you 400. Value of the product is 600. And he is not paying you 400. The law says when the value of the product itself is amounting to 2/3 of the value of the product. That is what he needs to give you. Then the law says, Macha, don't waste time. Sell it. It's okay. Only these two are the exceptions. In general, people, you do not have a right to sell. You have to wait and you can only retain the goods with you. You cannot sell them. Is this clear? Hello? But sir, remember, whenever the finder of lost goods, I find the owner promises to pay me some reward. In such case, people, until the reward is not paid, I even can file a case to recover that particular reward amount. I can file a suit. Hello? Understood? Whole scenario important, exam point of view, remember and go. Sir, what if finder of lost goods is always the next to owner? Remember that. Example, what is the case law? Finder of lost goods? Case law was there? Hallin versus Howler. Remember. Hallin versus Howler. Okay. Next one, the last one, termination of bailment. When will the bailment come to an end? On expiry of stipulated period. That means if I have done the bailment for 5 days, after 5 days, bailment comes to an end. On fulfillment of the purpose, I gave it for repair. After repair, bailment comes to an end. By notice. Remember, gratuitous bailment, I can withdraw whenever I want. Non-gratuitous, I cannot terminate. Only reason I can terminate? Inconsistent use of the goods. By death of bailee or bailor, in the case of gratuitous, non-gratuitous, it will continue. On destruction of the subject matter, I gave you the mic only destroyed. What will happen to the bailment? Bailment will become void contract. Hello. Next one, people, pledge. What is pledge, people? Pledge is nothing but bailment for a security. So when I give gold for the purpose of taking loan, it becomes a pledge. Correct? Hello. Okay. Here there are two parties. One is spawner, one is spawnee or pledger and pledgee. Meaning bailment of goods as security for repayment. Okay. Essentials, the bailment for security, it has to be movable goods only. Delivery of goods from pledgers to pledgee is important. Similar to bailment only, no? What else is there? What are the pawnee's rights? Same, people. Whatever is the bailee's rights, same will be pawnee's rights also. Same thing here. What are the duties of the pawner? Whatever is the duties of bailor will be same only. Hello? Because pledge is also bailment only, no? Hello? In addition to that, you will have few additional things, that's all. What is it? Okay, we'll see. Right to retain the pledged goods, correct? Until you do not pay me the loan, I have a right to retain the pledged goods. Yes, sir. Next one. Right to retention of subsequent debt. What do you mean by right to retention of subsequent debt? Say for example, bank has given 2 loans to a person. In the first loan, I have given gold. Second loan, I have not given anything. The law is telling, now remember, this person repays the first loan. The bank has a right to keep this gold even towards the second loan. That is only called as what people, right to retention for subsequent debt. Next one, sir, right to extraordinary expenses. If I have incurred anything, I can recover it from you. When pawner makes default, I can file suit and I can retain goods, or I can even sell the goods after giving the notice. What do I mean by that, people? I have taken loan from Muthoot, I have given my gold to them. Now what are the options Muthoot has if I do not pay back the loan? Option 1, they can only keep it. For doing that, they have to first file a case. Directly they can't keep it. Option 2, they can sell it. They can take what belongs to them. Extra, they have to give it back to the bailer, whoever took the loan. Now imagine the value of the gold is say 1,30,000. The loan I have taken is 1 lakh. If I sell the gold, I will get 1,30,000. I can't keep everything. 1 lakh I will take, 30,000 I have to return. Hello? Sir, what if there is any deficit, shortage? I can recover. Imagine the value of the loan is 1 lakh. I was able to recover 90,000 from the selling of the gold. The 10,000, I can recover it from the pledger. Remember that. Hello? Yes, sir. Recover, surplus has to be given. Next one, sir. Duties of pawner, liable to pay all the debt, disclose all the fault. See, same thing. Pay extraordinary expenses, indemnify, pay deficit if pawnee sells the goods. So, if at all I am selling the gold, I got 90, but the value of the loan is 1 lakh. I have to pay you 10,000 rupees. Pledged by non-owners. Let us see this in Sale of Goods Act. We have same topic there. Sale by non-owners. Let us see it there. Cut, copy, paste. Same scenario it will be there. That's all. Hello? Yes, people. Let's do the questions of bailment and pledge. Bailment means what? Temporary delivery of goods, which is not essential element of contract of bailment. Doing contract, purchasing of goods, delivery of goods, return of goods in specific time. Purchase of goods. In the contract of bailment, the person to whom the goods is delivered is called bailee. Bailee should care the goods as per a man of ordinary prudence. What do you mean by that? It is my responsibility to take care of the goods as if a normal man would take care. However he would treat, that is how I need to take care of the goods. Okay, lien means to retain the goods in his possession. In case there are 2 or more joint owners of the goods, the bailee has to deliver them back to a finder of goods is subject to the same responsibility as that of the bailment of goods as security for payment of a debt is called. What is an essential element of a valid pledge? Delivery of goods, delivery of bills, price, none of these. The pledge is a contract of. State the essential elements of a contract of bailment. Director, give difference between bailment and pledge. What is the difference between bailment and pledge? Bailment is always for security. Pledge definition is, pledge is a bailment for security of the goods. I mean, for whatever is a contract, it is always for a better security. And remember, bailment can be free. That is gratuitous, non-gratuitous. But in pledge, that is not the case. It cannot be gratuitous. There is always a money involved, no? Quid pro quo is always there in the case of pledge. That's the biggest difference. Hello? Remember, examine this we saw. Next one, A hires a carriage from B and agrees to pay 500 as hire charges. The carriage is unsafe. Though B is unaware of it, A is injured and claims compensation for injuries suffered by him. B refuses to pay. Discuss the liability of B. Is B liable? Yes. Whenever it is a non-gratuitous bailment, whether I am aware of the defects or not, I am always liable. A bails his jewelry with B on the condition to safeguard it in a bank's safe locker. However, B kept it in safe locker at his residence, where he usually keeps his own jewelry. After a month, all jewelry was lost in a religious riot. A filed a suit against B for recovery. Referring to the provisions of Indian Contract Act 1872, state whether A will succeed. What? A bails his jewelry with B on the condition to safeguard it in a bank's locker. However, B kept it in safe locker at his own residence. What is this? When a bailer gives any instructions to the bailee, it is bailie's duty to follow the instruction. Here I have been clearly told that I have to keep the gold in a bank's locker. But where did the bailee keep it? He kept it in his own locker. If you fail to follow any instructions given by the bailer, the goods will be kept at your risk and I can claim compensation and damages. Yes, possible. Because you did not follow the instructions. Remember. Hello? R gives his umbrella to M during rainy season to be used for 2 days during exams. M keeps the umbrella for a week. While going to R's house to return the umbrella, M accidentally slips and the umbrella is badly damaged. Who bear the loss and why? Who will bear the loss? M. Why? Remember, in a contract of bailment, if you keep the goods beyond the reasonable period or beyond the contract period, here the contract period was 2 days. If you keep the goods beyond the contract period, all the risk, whether you have taken reasonable care or not, is irrelevant. Any damage happened, I can recover the damages from you. Here it was kept for 1 week, that is beyond 2 days. Whether you took reasonable care or not is irrelevant. Hello? Hello? Amar bailed 50 kg of high quality sugar to Srijit, who owned a kirana shop, promising to give 200 at the time of taking back the bailed goods. Srijit's employee, unaware of this, mixed the 50 kgs of sugar belonging to Amar with the sugar in the shop and packaged it for sale when Srijit was away. This came to the light only when Amar came asking for the sugar he had bailed with Srijit, as the price of the specific quality of sugar had tripled. What is the remedy available to Amar? What is the provision? I gave you sugar to keep it safe. You mixed it with your goods. What is the provision? Unauthorized mixing of goods. What will be the what is the remedy? Unauthorized mixing of goods. If it is separable, unseparable. If it is separable, separate it. Cost of separation, you should bear it as a bailee. If it is non-separable, compensation. In this case, what you will write? Sugar is definitely non-separable. Hence, directly write compensation. That is required. Conclusion should be written. Hello? So, in this case, what will be the conclusion? I don't know who it is. Amar bailed. Amar is eligible for compensation because the goods cannot be separated. Miss A delivered her old jewelry to Mr. Y, a goldsmith, for the purpose of making a new silver bowl out of it. Okay. Every evening she used to receive the unfinished goods, that is silver bowl, to put it into a box kept at Mr. Y's shop only. She kept the key of that box with herself. One night the silver bowl was stolen from that box. Was there a contract of bailment? Whether the possession of the goods delivered constitute contract of bailment or not? Is it a contract of bailment or not? I hope you guys understood the question. I gave one gold, silver. I asked that goldsmith to make one bowl. Every day I used to go and I used to take one box. After that day's work, I used to put that bowl in that box and keep it there only, but lock it and keep it there. Again morning I'll go, I'll open and I'll give it. Again he will work, again in the evening I'll close it, I'll keep it in that box. Every day she used to do that. But one day that someone took that, it was lost. The question is, was it a contract of bailment or not? First of all, is it a contract of bailment? What is this called as? Contract of? Is it a contract of bailment? Yes or no? No. Why? Control people. What can I consider this as? This can be considered as custody. After the lock hours, after the, the shop is closed, the goods is not under the control of the goldsmith, no? It is under your control. And when they say box, don't imagine only this much. It can be this much also. Hello? Hello? Yes. There is no contract of bailment. You know what? Your examiners, they got inspired by the bank lockers and they created this case. Bank locker is also custody only, no? The lock will be there. You will take the gold, you will keep it, you lock it and you will come back. But they made some case out of this. Okay. Srishti acquired valuable diamond at a very low price by a voidable contract under the provision of Indian Contract Act 1872. The voidable contract was not rescinded. Shruti pledged the diamond with Mr. VK. Is this a valid pledge under Indian Contract Act? We'll be seeing this people. Basically, this is nothing but pledge by non-owners. Can come again in Sale of Goods Act. Sale of Goods Act also. Sale by non-owners. When I am not a owner, but if you are having the goods under a voidable contract and the contract is not yet rescinded, I have a right to pledge it. This particular pledge will be considered as valid only. Hello? Okay. Yes. What the? Whether he gets good title, yes, he gets good title. Yes. Yes, people. The next unit, people, contract of agency. Okay, people. Contract of agency, it is always between two parties. Who are they? One is called as principal, one is called as agent. In general, what do you mean by contract of agency? What happens in contract of agency? In contract of agency, technically, one person cannot be present in all the places. In such case, what I can do? I can delegate my power to someone else and they will act on my behalf. Such type of contracts are called as contracts of agency. Best example I can give you now, imagine I want to sell a land. I don't know whom to sell. So what do? We give it to a real estate agent, very popular. So the agent will go and talk to 100 people. Whoever fits my criteria, we will enter into a contract. Yes. So agents are who, sir? Agents are those people who represent the principal in a contract. Such people are called as agents. And the contract that exists between the principal and the agent is called as agency. Remember, for the agency to come into picture, you can have consideration. You cannot, without also is possible. Consideration is not mandatory. Hello? Because I can even appoint my own people as agents, right, to represent on behalf of me. I'll not be paying them money to do it. Hello? Yes or no? Okay. So, sir, can a principal be incompetent person? Can a principal be a minor? Can a principal be a minor? Can an agent be a minor? Remember, people, agent can be a minor, but principal cannot be a minor. Because for whatever agent does, the ultimate liability will always be on the principal. Very, very important, remember. But remember people, whenever a principal is appointing an agent, we will always appoint an agent with a scope. That means what? Let us imagine I have a car. I want to sell my car. I will tell the agent, you can sell this car, but please make sure, do not sell it for a price less than 5 lakh rupees. I have clearly told him. Now, if the agent is selling the car, let us imagine for 4,50,000 rupees. I have clearly told, don't sell less than 5 lakh. He has sold it for 4,50,000. The law gives me a right to recover that 50,000 rupees from the agent. Hello? Because he has exceeded his authority. Now, let us imagine I have appointed a minor as an agent and he sold the car for 4,50,000. The law says, people, if at all you have appointed a minor as your agent, if he has sold a car for less than whatever is the price you said, remember, you do not have any right to recover. That 50,000 rupees you cannot recover if that agent is a minor. That's the only risk you take. Clear? Done. Next one. How is an agency created? First one, by words or by conduct. Express, implied. Hello. Next one is people, estoppel. What do you mean by estoppel, people? See, under implied authority, two subcategories are there. One is agency by necessity, agency by estoppel. What do you mean by agency by necessity? Agency by estoppel. What is necessity? Emergency. Now, for example, someone has my goods. To save it, they will act beyond what we said. In that case, people, I cannot question. For example, people, say for example, we have appointed one person to go and deliver the goods from one place to another place. Now, he is taking it from Delhi, he wants to drop it in, say, Bangalore. When he is coming on the road, what happened? There is one place where huge strike is happening. He is not able to go through. Now, what is he carrying? He is carrying a perishable goods. Now, what does this person decides? This person decides, array, if I do not take some action now, my owner will suffer a loss. What will he do? Now, let us imagine he has to deliver the goods from Delhi to Bangalore. What will he do? In between people, he decides to sell the goods in the market there because he knows he cannot reach that point B. Now the question is, does this person has a right to sell the goods? Did we give him that authority? His authority was to go and deliver in Bangalore. Then what gave him authority to sell the goods? First of all, will the will the principal, will he be bound by that? Can I file a case on him? Can I recover that money from him? Can I do it? The law is telling you people, whatever this fellow did, that is only called as agency by necessity. What do I mean by agency by necessity? Remember, whenever the agent is not in a position to talk to you and there is a emergency situation, in such case, the agent can do anything to protect the principal, and for whatever actions the agent has taken, the principal will be liable. You cannot deny. Now, did I tell him to sell it? No, but he still sold it. Such type of agency is called as agency by necessity. That is why it's the example of implied authority. Hello? Understanding? Next one, sir, agency by estoppel. What do you mean by agency by estoppel? Huh? If you want, estoppel means what? He represents himself as a agent and the principal says okay to it. Correct? Yes, sir. Easiest scenario, right? Now, for example, Narayan Murthy, give me your phone. Narayan Murthy. Now, people, this phone is for sale. Who want? This phone is for sale. I'll give it for 2,000 rupees. Who want? 2,000 rupees. Seriously. Who wants? Siddharth want? 10. 2,000 rupees. Who want? Siddharth wants? Now, Siddharth wants to buy it for 2,000 rupees. People. Siddharth, after the class, come and collect it. Yes. Now, Now people after the class, if Siddharth wants to come and take it, now it is with Narayan Murthy. Now can Narayan Murthy deny the contract? Can Narayan Murthy say, no, I will not give? Can Narayan Murthy say it? Can Narayan Murthy say it or not? Remember people, principal, agent, right in front of him, I am making a claim. I want to sell your mobile. Did he say anything? Did he stop me? Did he say at least sell for higher price? Did he say plus please don't sir, please give it? Did he say anything? Did he tell Siddharth it is mine? When he didn't say anything that time, he cannot say anything when Siddharth is coming to collect the phone also. Agency by estoppel. I became an agent by estoppel. Estoppel means what? I told to the world that I am representing this phone. He was also there, right in front of my eyes. And I am doing everything right in front of his eyes. He has the right to say or right to stop. Did he stop me? Did he stop me? Did he stop me? No. Remember people, what happened is called agency by necessity, Allah. Agency by estoppel. Remember, we did not have any express terms between us. That's why this also comes under implied authority. Understood? Hello? Okay, done. Next one, sir. Necessity done. Next one is ratification. What do I mean by agency by ratification, people? Agency by ratification means what, people? Generally what people, let us imagine, say Narayan Murthy has one big home, 3 floors. Yeah. So now what happens? Narayan Murthy's friend is Siddharth. So Narayan Murthy says, Macha, I am going to US. I got a good opportunity. I will not be coming to India for 3 years. What I want you to do is, please take care of this building. Take care means make sure no one enters. Please have an eye on it. That's all. Don't do anything else. Sid said, okay. Now people, Narayan Murthy left to US. Now what did Siddharth do, people? After 10 days, Siddharth thought, hey, 3 floors. Each floor has 2 homes. Instead of keeping it vacant, why can't I just give it on rent? Siddharth thought, anyways, Narayan Murthy won't come in 3 years. Siddharth decided to give this home on rent. Did he ask Narayan Murthy? No, nothing. Siddharth gave this home on rent. Imagine people, each floor was giving around 50,000 rupees. Together, 3 floors gave 1.5 lakh per month. Into 12 people, 18 lakh per annum. Into 3 people, how much? 54 lakh rupees into 3 years. Siddharth after 3 years came back. By then, what did Narayan Murthy do? He said, all of you vacate. Now Siddharth came after 3 years, people. He entered the building. The gate is ungate. The gate is making some noise. It is going, shaking and all. Outside people, there are some cracks and all like this. They have used something and all. Holes are there. Entire walls, they have hit nails. Siddharth became angry. Hey, Narayan Murthy, what you have done? I told you to take care of the goods. Huh? I said, okay, Narayan Murthy tells Siddharth, hey, Siddharth, come here. What you are doing? I told you not to. Why? How do you maintain? Now people, what will Siddharth do? Siddharth will keep money in his hand, people. 54 lakhs are kept in the hand of Narayan Murthy. Now tell me, what will Narayan Murthy do? In his hands, 54 lakh rupees are there. What will Narayan Murthy do? Tell me. First he will hug Siddharth. Macha, vada inga. You are my Nandanda, friend, hey. Huh? This is what friendship means. Yes? Or you think Narayan Murthy will scold or shout at Siddharth? What do you think? Huh? What do you think Narayan Murthy will do? Answer can be anything, people. Of course, subjective. Generally, human tendency, people. What will Narayan Murthy do? Narayan Murthy will take 54 lakhs. Yes? If Narayan Murthy takes 54 lakhs, Narayan Murthy is accepting all the defects in the home. Narayan Murthy is accepting whatever Siddhartha did for the 3 years. In the 3 years, Siddhartha did not have power to give this home on rent. When Narayan Murthy took 54 lakh today, he gave power to Siddhartha today. And he is saying yes to everything Siddhartha did for the last 3 years. Hello? This is only called as what people? Agency by ratification. Ratification means what? Something that happened in the past. In the future, you are going to make it valid. 3 years back it was invalid because Siddhartha did not have the power at all. But today I am making valid everything Siddhartha did. So making the invalid thing valid in the future is called as what people? Ratification. Hello? Understood? Yes? Okay. But ratification, remember, it can be express or implied. Complete knowledge should be there. Siddhartha has to tell everything. He cannot hide anything. Ratify it in entirety. You cannot do it in part. He can't say, Macha, this home is screwed up. This I will not ratify. Rest of 5 homes I will ratify. That you can't do. You have to ratify it as a whole. It has to be done within reasonable time. It should be communicated to the other party. You cannot ratify a void or illegal things. What do I mean by illegal? Let us imagine on the top floor, Siddharth did weed. There was spots. He did weed. Correct? Huh? You cannot ratify illegal acts. Understood? Huh? Hello? Weed, home. People, appointment of sub-agent. People, tell people, can I appoint sub-agent? Huh? People, I gave work to Narayan Murthy. Narayan Murthy is further giving it to Siddhartha. Possible, huh? Remember people, they not possible, da. Delegators non-potest delegate. What do I mean by that? That means a delegatee cannot further delegate. I believe in Narayan Murthy and I have given the work. How can Narayan Murthy further give it to Siddharth? I don't even know Siddharth. So remember, agency always runs on a trust. I believe in Narayan Murthy and I said, whatever you do, I will be liable. You cannot further give that work to someone else. So general scenario, a delegatee cannot further delegate. That is only called as delegators non-potest delegare. That means a delegatee cannot further delegate. But this rule has some exceptions. What is the exception, sir? These 3 are the exceptions. First one, the terms of the appointment allowed. What do you mean by that? Narayan Murthy clearly told me, sir, not possible, I cannot do it, I have to give it to Siddharth. I said, okay. When he has taken my approval, I don't have any problem. Next one, custom of trade provides for such appointment. What do you mean custom of trade provides for such appointment? Remember people, today if you guys want to get married, there are so many things that has to happen. What do you call? Catering? I don't know. And what else you have? Huh? Lawn? Huh? Lawn? Lawn? Why lawn? Okay. Okay, like venue, okay. And what else? Photographer and stage decoration and clothes, good wedding clothes and car key? Car entry. Macha. Car entry. Exit. Barbecue? What are you guys doing? Return gift. Now people, see, how can you do? All these things you can only do, correct? Or what you will do? You will delegate everything to a event manager. Agreed? Technically, you are supposed to do, you are giving all this work to an event manager. Can you please take care of the entire wedding? What he will do? He will go for you. He will search a good person for decoration, catering, and probably, I don't know, some live performances. He is choosing some DJ, songs. He is choosing everything. Correct? Hello? Remember people, this is only an exception. What is it they're telling you? The custom of trade. When you're giving the work to the event manager, let us imagine. Now, Narayan Murthy's wedding only, let us imagine. Okay, okay. Now Narayanamurthi's wedding day, he gave the work to the event manager, who, let us imagine, Siddhartha only. Now imagine people, he said, Siddharth, you have to take care of catering, decoration, live singing, everything you should only take care. On the day of wedding people, Narayanamurthy goes for catering. He's checking in catering. Siddharth is not there. Narayanamurthy called Siddharth. Hey, come down here. He came. I asked you to do catering, Noda. He said, sir, I can't do catering, sir. I will choose the best chef. I will give it to them. They will do it for me. Narayanamurthy like, okay, do whatever you want. Narayanamurthy came to the main stage. On the main stage, there is live performance, but Siddharth is not performing. Narayanamurthy again called, hey, where are you? Come down here. I told you, Noda. Why are you giving someone else? Now people, this is only called what? I might have not given you an approval, people, but don't you think this is something called, this is how this trade works? Correct? Yes or no? That means what? Some agreements, it is understood, if you give it to them, they will further give it to someone else. That is how that industry works. Delegation is allowed. So sub-agents can be appointed. Hello? The last one, unforeseen emergency. When the agent you have appointed, imagine some health scenarios. He is not able to do it. He can further give it to someone else and tell, it's okay, you do it. I'm not able to do it because of some emergency. It is allowed. So in these cases, sub-agent is appointed. In general, people, sub-agent is not allowed, but these are the exceptions. Is this clear? Simple. This is sub-agent. What do you mean by substituted agent?
Delegating my work to.
Delegating your work to someone else. Substituted agent means, people, with the consent of the principal,
Agent will work on.
with the consent of the principal, the agent appoints someone else is called as what, people? Substituted agent. In short, people, if I have to tell you this way, let us imagine, now you guys are, okay, you guys will be doing, you qualify, you become CAs, everything is fine. You will be taking care of a company's books of accounts, you will be doing all audit, IT, everything you will be doing. Now imagine, people, they need a tax audit. A few CAs will do tax audit, few CAs will not do tax audit. What you will say, sir, this is not my competence. I'll tell you one thing, sir. Okay, let us imagine, let us not even take tax audit. Why to complicate? Cost audit. Cost audit CA cannot do. Correct? You have to go to a CMA. Hello? Now your client says, hey, anyways, you are only doing the statutory audit, Noda. You only do a cost audit also. You say, sir, this is not my proficiency. I can't do it. I know a friend of mine who can do the cost audit as well. Now what you will do? You will give your friend's number. The principal will contact him. He will appoint him for cost audit. Hello? Now people, remember, when your principal came to you for a work, you refer someone else and the principal and that person directly gets in touch with each other. Now that is only called as what, people? Substituted agent. Now what if the cost auditor does any problem? If he does not do his job properly, who will be liable? Is principal liable or the person who referred? Now you referred, no, will you be liable? The question asked is, did you refer for commission or you referred because he is good? If you referred for commission, that means you referred for your personal motive, not because he is good. You will be liable for referring the wrong person to your principal. Sir, I referred thinking he is a good person. I don't have any other thing in this particular contract. If you can prove, people, remember the law says the agent whoever referred, his liability will come to an end. Hello? Hello? What is the difference between sub-agent and substituted agent? Sub-agent is generally not valid. Substituted agent is possible. What else is the difference? In sub-agent, people, there is no privity of contract. I gave you work. You gave Siddharth work. There is no relation between me and Siddharth. Hello? Hello? In the case of substituted agent, there is a direct relationship between principal and the cost accountant. So there is a privity of contract. That is very, very important. Remember. Hello? Clear? This is very important point. Remember and go. That is substituted agent. Any doubts? No. Okay, next one, sir. Last we'll see this. Rights of an agent. Right to remuneration. He has a right to remuneration, of course. Right to retain out of the sums received on the principal account advances, expense, remuneration payable. What do you mean by that? I am an agent. On behalf of my principal, I have made some advances. I have paid some expenses. The law says, let us imagine now Narayan Murthy is my agent. I have asked him to sell some goods. Now he might have incurred some expenses. Imagine travel cost. He might have made some advances, security deposits, and end of the month he is also eligible for remuneration. Now when he is selling goods on my behalf, don't you think he will also be receiving money on my behalf? The law is telling the agent is entitled to keep that money with him only towards any advances he has paid, any expenses he has incurred for me, any remuneration he needs to get. So whatever money he is getting on my behalf, he can keep that money for all these things he has incurred. Simple? Hello? Okay, next one. Agents lien on principal's property. What is the lien, people? I have already said. Now let us imagine my goods are there with Satyanarayana Murthy. Now what happened? Until I have to pay him his remuneration, I don't pay his remuneration. What can Narayan Murthy do? He can say, I will keep the goods with me, sir, until you clear my debtor, clear my remuneration, as the case may be. That is only called as what, people? Agent's lien. Hello? Hello? Next one, sir. Right to indemnity. For lawful acts against acts done in good faith, non-liability of employer, compensation for injury caused by principals, neglect. What is, people? For lawful acts, whatever Narayan Murthy does, people, for that I am liable. Because I told you point one only. Anything agent does, that will be the responsibility of the principal only. He is just a mask of the principal. I am liable ultimately. Is this clear? Hello? Next one, people. Agent acts done in good faith. What is agent? Any acts done in good faith. For that, people, again they are telling you that the principal will be liable. What do you mean by right to indemnity? Now, believing in you, people, I go and enter into a contract with an outsider. Hello? Now, for example, if I have to tell you, let us imagine, principal said, agent, I will supply you some goods. Agent went and said the third party, I will give you goods. He has taken advance also. But the principal did not supply the goods as promised to agent. Hello? What will the third party do? Now, agent was not able to supply the goods to the third party. What will third party do? Third party will file a case on the agent. For what? For something that you have not done. Hello? Can the agent, I have to pay compensation. I don't have a choice. The law is telling that compensation you can recover it from the principal. Understanding? Yes. Next one, sir. Non-liability of employer of agent to do criminal act. That means nothing but, people. Let us imagine if someone tells you to kill someone, you go and kill. Later you cannot hold the principal liable. Because in the law, people, it is always unlawful object, hence non-enforceable by law. In the contract, we will not protect you under the court. So even if someone has appointed you to do a criminal act, you do it also. It is not enforceable in the court of law. Criminal itself will be liable. That is, the agent only will be liable. Principal will not be held liable. Hello. Next one, sir. Compensation for injury caused by principal's neglect. What do you mean by this? Compensation for injury caused by principal's neglect. You can take almost a similar example only. What is this? If I neglect performance, if I did not supply the goods to you on time, you will not be able to further supply to the third parties. If you suffer any loss because of me, because of my negligence, I am liable to repay that money to you. And one more thing that you can give you is, in your book, they would have given you an example of something called as scaffolding. What is this? Scaffolding. See here, people, principals neglect means what? Now see here, imagine people, there is a logistic company. Yeah, you're carrying a big tons of cargo. Yes. Now what will the principal do? The principal will appoint a driver. He will tell him to take the vehicle from point A to point B. The mechanic clearly instructed the principal that the brakes are very weak. That particular vehicle is not in a condition to drive. But to fulfill the contract, what will the principal do? The principal will still send the agent to deliver this particular contract in the same vehicle. If the agent suffers any loss because of the negligence of the principal, now it was clear negligence, you know that the vehicle is not in a good condition, you still send the agent in such vehicle. Any loss suffered by that agent in that particular vehicle, the principal's liability is to compensate the agent. That is the meaning of indemnification. Understood? Yes. So in our book, they have given two examples. You can follow this. Clear? Yes, sir. Okay. Duties of agent? Yes. What are the duties of agents, people? One is duty to execute mandate. What do I mean by duty to execute mandate? And duty to execute mandate means what? Whenever a principal is telling something to the agent, Macha, you need to do this. I've clearly given an instruction. It is a duty of the agent to carry on the instruction. Whether he knows it, he does not know it, it is his duty to make sure he has to follow the instruction. That is the meaning of people, duty to execute mandate. One example we had in our book is, people, there was a principal who gave all his goods to his agent and he said, please take care of it. You need to further transfer it to some other person, but make sure, because there is so much of goods here, we need to be safe. So make sure to take an insurance on all the goods, so that something happens also, we will be secured. So the principal has clearly given a mandate. Mandate means what, people? Instruction. Now what is the duty of the agent? The agent's duty is to follow the instruction. In our case, what happened, people? The agent failed to take the insurance as instructed by the principal. And people, unfortunately, there was a loss of goods. It was held that the agent will have to bear the entire loss personally. Because principal has clearly told you to do something, you do not do it. In such case, people, the agent will be personally liable. Understood? Next one, duty of reasonable care and skill. What do you mean by duty of reasonable care and skill, people? Nothing but when you are doing your activity, it is your duty to be diligent, not negligent. That is the meaning of duty of reasonable care and skill. Next one is duty to follow instructions or customs. Now what do I mean by duty to follow instructions or custom? That means, now for example, in the first case we have said, the principal has told you something, it is your duty to follow that. At times what happens, principal might not be able to tell you everything. Now for example, let us imagine I am a principal, I have appointed an agent to look after my business, to take care of my business. Now what happened? I have not given every instruction to my agent, what to do in which scenario. Not every scenario I will be able to tell him. One day what happened? One customer came and he asked for a credit sale. Sir, please give me the goods today. I'll come and pay you the money within a week. Now, as a principal, I have not instructed him anything, whether you can make a credit sale or not. If at all I have said, then the agent's duty, you need to follow whatever the principal has said. Principal has told you, you can do credit sale, you can do credit sale. The principal has told you, you cannot do credit sale, you cannot do credit sale. You have to follow the instruction. Sir, what if the principal has not given me anything? In such case, people, you need to follow the customs. Customs means what? In that industry, just check whether people will do credit sale or not. See in that business, you go and ask others. Check your competitors. Do they do this credit sale or not? If everyone in the business are doing credit sale, then people, even this agent can also do a credit sale. Are you understanding what do you mean by custom? So if the principal is not telling anything, now if the customer came and asked, let us imagine, if you go to a hotel, you want to eat some food. Yeah? You go and tell one hotel guy, sir, is it okay? I'll come and give you the money tomorrow. Will he give you the food? Hello? He will give you? No. Clear. You go to any hotel, you will get the food free? No. There is a clear custom, people. Cash and carry. Give money, eat. Without money, we are clearly telling that we will not be giving you anything. That's the custom. Hello? Now take provisions. Go to grocery shop. Have you seen people saying that, okay, write it down in the next month's bill, I'll clear both the bills. Have you seen people doing it? Credit sale is allowed. Where? In provisions. Understanding? All of you. Now, if I have to club these two and give you one example, now let us imagine the principal has allowed you to give it on credit. Agreed. Or for example, the customs allows you to give it on credit. Okay, well and good. Now, let us imagine a person came, you are seeing him for the first time, he's taken 2,000 worth of provisions and he is saying, I'll give you the money after 1 week. Now, the question is, can the agent give him credit or not? Should he give him credit or not? Now, what did the agent think? Hey, in our sale, we can give credit. So, he gave credit. The question was whether whatever the credit that was given by agent, was it valid? Is it valid? Now, people, that is the meaning of people, reasonable care. What is reasonable care? You are looking at that particular customer for the first time. You do not know anything about him. You do not know whether he is capable of coming back and paying the money tomorrow. When you do not know anything, that means when you gave a credit option, you were negligent. You were not diligent. Are you sure he will come and pay after 1 week? You are seeing him only for the first time. So that means what? Reasonable care here means what? I can give it on credit, but not to every random person. It is only to those people who are worth it. Not every person. Don't you think so? That is the meaning of people, duty of reasonable care and skill. So we can combine these two things and we can read. Hello? Understanding? Yes? Okay. Next one. Avoid conflict of interest. What is avoid conflict of interest, people? Yesterday, you remember I told you, whenever government tender, you should not create interest against obligation. We saw it in unlawful agreements opposed to public policy. Same thing, people. What do you mean by avoid conflict of interest? Not to deal in his own account. Principal wants to sell a car, a beautiful car. What does a principal say? Macha, my minimum price I'm expecting is 4 lakh. Yes. Now, people, agent knows that, Noda. Agent, what he will tell? He will tell his friend only to come and buy the car. He will tell, quote 4 lakh only, Macha. That is the price he'll pakka give it to you. You're taking advantage. That is what the law is telling. You should avoid conflict of interest. That means what? You should not deal in your own account. You should not take the benefit of your situation. They're telling you, people, such a sale if you are making, people, it will be considered as void. The principal can tell you to give any profit you made. He can ask you to give it back. Understood? Simple. That is your duty. Next one, communicate with principal in difficulties. If you are not able to make any decision, you have to first communicate with the principal and then only you are supposed to act. You're not supposed to act on your own wish. Please communicate principal. If principal is also comfortable, if principal tells you to do it something in a particular way, do it in that way. Next one, sir, not to make secret profits. I told you similar to this only. You're not supposed to make secret profits. What do I mean by secret profits? Imagine one principal came and asked, I want to buy a piece of land. He went and told it to a real estate agent. Please show me any good piece of land. The real estate agent itself had one land. He went and showed that land only. What is the price? The principal said, my budget can go up to 1.3 crore. He said, sir, this land is exactly 1.3 crore. What do I mean by secret profits? Secret profit means in a principal and agent relationship, you will be knowing everything. Now, because of that, can you take advantage of it? The law is telling you people disclose and take. Do not secretly take. Secret profit means you have to tell, sir, this is my land. I want to sell this only to you. Is it okay? If you do not disclose people, the contract becomes voidable. Or if any profit the agent has made, I can recover that profit. Any excess money the agent has made, I can recover that profit when the principal gets to know about it. Exam point of view, they can ask you a question here. Remember. Clear? Next one, to render proper accounts, maintain proper accounts, not to delegate, we have already seen. Sub-agent appointment is generally not valid. Delegators, non-potest delegator. Pay sum received for principal. Whatever you have received on behalf of principal, it is your duty to give it to the principal. Not to use confidential information against principal. What do I mean by that? Now you are chartered accountants, sir. You guys will be getting so much of information about the principal, no? Can you go and give it to the authorities, sir? Can you go and give it to the other person and make profit? Not allowed. Don't do it is what they are telling you. Simple? Yes. Next one, sir. Principal or agent's liability to third parties. Generally, people, any contract entered by agent, who is liable generally? Generally, it is who is liable? When an agent goes and enters into a contract on behalf of the principal, who is liable? Principal is always liable. But you tell me, at any scenario, can agent only be held liable? Not principal. Can you hold the agent liable? When will you hold the agent liable? One easy scenario. We saw yesterday only. Whenever you act beyond the scope or whenever you act beyond the authority, that means what? I clearly told you, please don't sell the car for less than 5 lakh. If you sell it for 4.5 lakh, you acted beyond the authority. In such case, people, for the 50,000, the agent will be held personally liable. Hello? Or else, sir, any profit goes to principal only. Any loss goes to principal only. Agreed? Yes. So, principal's liability for acts of the agent. For everything within the scope, principal only is liable. However, there are some exceptions where agent can be held liable. What are the exceptions? First one is called as pretended agent. What do I mean by pretended agent, people? People, I'll come and tell it to you, people. I am the agent of Mukesh Ambani. I am signing the contracts. I am only entering into agreements. You tell me, is Mukesh Ambani liable? No. I'll only be liable. That is the meaning of pretended agent. I am acting as an agent. In reality, I am not. In such case, who will be held liable? Mukesh Ambani or me? I will be held liable. Hello? Yes or no? Okay, next one. Foreign principle. What is foreign principle? Foreign principle? Macha, our Indians only are doing something, we are not able to catch them. Foreigner did something, you will go and catch him, Mada? Huh? Nowadays, our Indians only will go to foreign if something happens. Don't you think so? Yes or no? Why, people? How will that country even allow? Correct, no? And I'll tell you one very common thing. Anything happens, everyone will go to UK only. Vijay Mallya went there, Nirav Modi went there, Lalit Modi went there. There are a lot of more people also. Everyone went to UK only. Everyone are in UK only. And fun part is on everyone there is case, criminal cases. On everyone, and everyone goes to UK only. And even another fun part is, all of them are living peacefully there. Technically, if you come to India, no, you will be imprisoned for life. Meaning entire life you have to sit in prison. And you are roaming freely in the streets of UK. So doesn't the government do anything? Huh? Generally asking. No? Our Singham and all, they do no operation, no? Hey. Can't you go and bring back? No? Movies and all, it is okay, people. Reality not possible. There is a lot of procedural requirements. We have to file something called as an extradition, agreements. We have to ask a petition to their courts. Their court, just like that, will not take him and put him with us. They will conduct court hearings. They will undergo trial. If their court thinks, yes, what we are telling is true and fair, only then their court will send. Now I'll tell you one thing, why their court will also not send. There is a reason. You know why? People, when these people are going, you take Vijay Mallya, Nirav Modi, Lalit Modi, they are all billionaires. Billionaires. As a country, one person is coming in, he is coming into the country with billions of dollars. Hello? I hope you guys know. Well, Vijay Mallya has repaid his debt. He has repaid around 14,000 crores last year. Yeah? Now he has repaid. You think 14,000 crores he has repaid and he still Aram says roaming. He has still assets. That means you tell me how much money he has. Why will that country give him back to you? Da? Then you think the actual worth of Vijay Mallya. Can I say some thousands of crores? That means if I send him back to you, I am sending back even thousands of crores back to your country. Why will I send it? They will not send. When Vijay Mallya is only that Nirav Modi, Lalit Modi and all, don't even ask. They are all born only with diamond spoons. Very, very rich people. Very, very rich people. Will they all come back to India now? Impossible. So when our Indians only we are not able to catch, will you catch foreigners? So let us imagine there is some foreign principal. Agent is in India. Can it happen? Yes. Foreign car dealers. Now imagine you want to buy a Lamborghini. No, I don't know. My knowledge is limited. I don't know what other cars are there. Foreign cars are there. Can you buy Tesla you want? Can you buy in India? But there are agents. There is one Chennai guy who has imported the first Tesla of India. Yeah, there is one Tesla guy. There is a Tesla in India. And the fun part is, he has paid more duty than the car price. If the car price is 2 crore, to import it he has paid around 3 crore. Crazy guys are there in India. That's why we are called, what? India is not for beginners. Yes, all of that is there. Now, you think, there is a principal outside. Tesla is the principal. Agent is in India. They are dealers. They make second-hand sale, something like that. Hello? Now, sir, if anything goes wrong, can I go and catch hold of Elon Musk? Anna will go in SpaceX. So, people, they are telling you, if at all there is an agent in India, if the principal is abroad, I cannot catch the foreign principal, then whom will I catch? The person I am available. Whoever is available to me, I will catch hold of him. So, I will catch hold of Indian agent. The third one, agent does not disclose the name of the principal. Who is this person? A patriotic fellow. Hey, who is your principal? मैं नहीं बताऊंगा. Hey, till we'll hit him. He will not disclose. We will take cutting plier, remove his nails. He is not telling the name of the principal. What do I do? Karma, then you only die. If you tell the name of the principal, we will go and catch the principal. You are not telling. What do? I will catch hold of you only. What do I mean by also called as undisclosed principals? That means you are an agent. But who is the principal, you will never tell. In such case, what do? I'll catch hold of agent only. Simple. The last one, sir, incompetent principal. Not minor, it can be in the case of unsound mind. Yeah, make that correction. Incompetent principal. What do you mean by incompetent principal? When we entered into a contract, everything is fine. Later people, the principal became incompetent. Now if I go and talk to him, he will not understand anything. He became incompetent, unsound mind he became. Hello? Now, but I entered into a contract looking at an agent. I need someone to take care of me, no? Who will I go and question? That fellow does not understand anything because he became incompetent. I hope you understand what you mean by incompetent. He became unsound mind. So I will go and catch hold of a person who is sound mind. I will go and catch hold of a agent. Understood? Simple. So in these cases, I can directly file a case on the agent. Exam point of view, very important. Remember and go. Hello. Next one, sir. Principal's liability. When agent exceeds authority. I already told you people, if an agent is exceeding authority, what will happen? Who will be liable? Up to the authority, principal is liable. Beyond the authority, agent is liable. Sir, what if we are not able to make this differentiation? That means, imagine I told my agent, hey, buy one card for 10 lakh rupees. That's my budget. 10 lakh rupees, buy one car. The agent got a very good car, but the price was 13 lakh rupees. Now you tell me, can I divide the car? 10 lakh I will pay, 3 lakh you pay. Can I divide the car? No. So I will call such contracts as non-separable. When you cannot divide the contract, the entire money, the agent itself will be liable. Hello? Take the other example. Say I told the agent to purchase me raw material worth 10 lakh. He purchased raw material worth 13 lakh. Now can I separate the raw materials worth 10 lakh and 3 lakh? Possible. 10 lakh I will pay. 3 lakh you pay. Separable people, only the, whatever is the power I have told, scope, and up to that people, the principal will be liable. Beyond that people, agent will be liable. If it is non-separable, the entire part, agent itself will be liable. Example understood? Car and the raw material. Hello. Next one. Any notice given to agent is equivalent to giving it to the principal. So if I inform the broker, it is informing to the principal. So in real estate contract, you would never meet the owner itself. Yes or no? Next one, effect of misrepresentation or fraud by agent. If at all you have acted within the course, principal will beyond the agent. Understood? Now, for example, think and tell. I have a car. I ask the agent to sell it. I have a car. I ask the agent to sell it for not less than 7 lakh rupees. Papa is trying. No one came for 7 lakh rupees. Finally, one day what he decided, okay, I'll do one thing. When one customer came, he said, people, actually the car mileage is say 15 kilometers per liter. This fellow said to the customer, sir, you take, sir, it will give you minimum 30 kilometers per liter. Hello? Let us imagine it was a manual car. There is no digital meter and all that. That car. So there is no way he can check. The customer purchased also. After using it for 2 days, he realized that he is not getting 30 kilometers per liter. Now he is asking for, basically it's a fraud. He is asking for compensation. The question is, who is liable? Is agent liable or the principal liable? Think and tell. Agent is liable or principal is liable? Hello? Agent is liable or principal is liable? Agent is liable or principal is liable? Agent, Pakkana? Nakul Pakkana? I'm giving you one more chance, tell me. Pakkana, principal is liable.
He only acted beyond the power.
Remember, he did not act beyond the power. I have given you the power to sell it not less than 7 lakh. He sold the car for 7 lakh. Where did he act beyond the power? He did not tell to. That's why remember, when you are appointing the agent, it is your duty to know whom you are appointing. And remember, agent is always a principal's mask. If I do anything, principal is liable. That fact you should also be aware. He is going to the world and telling he is representing you. You should know to whom you have to give your mask. You should also have a fair bit of responsibility. Hello, Macha? Understood? Huh? When you took all the benefits, liability also will come more. Understood? That is the meaning of this. See, effect of misrepresentation. If acted within the course, meaning within the scope, the principal will be liable. You don't have a choice. If he has acted beyond the scope, that means what? He has sold it for 5 lakh now. I told to sell not less than 7 lakh. He sold it for 5 lakh. Now beyond the scope, for that agent will be liable. But if you have acted within the scope means in the jurisdiction I have given you. If you have acted within that, the law said any word you say, I will be liable. Hello? Pakka? Understood? Exam point of view, important. Remember and go. Next one, sir. Rights of third parties. Contract made by undisclosed agent. If agent doesn't disclose that he is an agent, if principal is disclosed before contract is completed, the third party may refuse to fulfill the contract. What is this example, people? Generally at times what happens, people? Some principles are there. Now imagine, people, one dealer will come and approach a bank. We need some 500 crore loan. Will you give it? See, banks will be very happy because they are calling all of us for taking even 50,000 rupees loan. Sir, please take, sir. I have target, sir. You are getting calls, no? Every day we are getting calls, no? So remember, whenever loan applications go to bank, they are happy. Someone themselves are going and telling we need 500 crore loan. In fact, they will welcome him with roses and all. Sir, please come. Because they are happy. Now, he came in, he said, sir, see, this is the business proposal. They saw everything, they are happy. Hello? He says, sir, I am a representative, but the owners are different. He says, yeah, okay, sir, we don't mind. Now, the bank is willing to give 500 crore loan. Now, tomorrow we have to disperse. The loan should be dispersed. Today, the banks get to know who is the actual principal. They have sent the agent, no, representative they have sent. But who is the actual principal? The actual principal is Vijay Mallya. If the bank gets to know it is Vijay Mallya, will they give him the loan? Huh? No. Huh? That is what they are telling you, people. A contract made by an undisclosed agent. He is going and telling, I am an agent. But he does not tell whose agent I am. But he says I am an agent. If the third party gets to know before the completion of the contract who the principal is, the third parties can cancel the contract. Understood? Hello? Okay. Next one, performance of contract where agent is supposed to be the principal. What do you mean by this, people? Whenever I behave as if I am only the principal, then remember, people, the third party and the agent, they will have a direct contract between them. The principal cannot go and disturb that contract. What do you mean by supposed to be principal? Agent is supposed to be principal means agent is telling I am only the principal. In such case, people, the third party, whatever they have directly agreed, the principal will have to go with the terms. The principal will have no choice. Understanding? The third one, sir, option of third person to sue the agent or principal. So, third parties, if some contract does not go as per our expectation, whom can the third party file a case on? Can I file a case on the agent or can I file a case on the principal? On whom can I file a case? They're telling you, in general, you can file a case only on the principal. However, we have seen 4 scenarios where agent can also be held liable. Can you tell me what the 4 scenarios are? When can you hold agent liable? Foreign principal, incompetent principal, agent acts beyond the authority, pretended agent. Correct? Basically undisclosed principal. In this case, what will happen, sir? In all these cases, people, agent can be held liable. Apart from these 4, who can be held liable? Principal will be held liable. That is what they are telling you. Cases where agent is personally liable. What are these? I am writing for your information. These are the 4 cases. Apart from those 4 cases, generally who will be liable? Principal will be liable. Simple? Hello? Okay. Last one, sir, termination of agency. How to terminate the agency, people? When will the agency come to an end? On completion of business. I tell you to sell a car is sold, business is done. Expiry of time, I have appointed you for 1 year is done, business comes to an end. What if I end it before, people? Imagine I have appointed the agent for 1 year. Now the principal wants to take back or remove him in 6 months only. Can I do? I have appointed him for 1 year, but I want to remove him in the 6th month. Can I do? Yes. Yes or no? Possible or not possible? Yes or no? Yes or no? Answer is you have a choice. You can. That is only called as revocation. Revocation means what? I've given you an authority to act as an agent on behalf of me for 1 year. In between, I can take back. Absolutely fine. But there was a contract for 1 year. If you are withdrawing it in the 6th month only, that means it will be considered as breach of contract. If the agent suffers any loss, I will have to pay compensation for it. Hello? Understanding? Okay. Sir, okay, agent was appointed for 1 year. After 6 months, the agent only wants to quit. Can he resign? Is it possible? In the first scenario, principal took back. In the second scenario, agent wants to resign. Is it possible? Possible or not possible? That's the next scenario. Renunciation by agent. Revocation is with the power of principal. Renunciation is nothing but resign. I give up. Hello? Cut, copy, paste scenario. You said you will be agent for 1 year. You are leaving in the 6th month. Remember, any loss suffered by the principal, it is your duty to pay compensation. Hello? Because it's a breach of contract only, no? Hello? Next one, sir. Death or insanity of principal will put an end to the agency. The last one, sir. Effect of termination. What is that? When will from which date will the termination be effective? Exam point of view, important. See here. The principal has appointed the agent. Yeah. Now the principal wants to withdraw the agency. I want to go back. I want to go back. I want to cancel my agency. So what will principal do? The principal will intimate the agent people on 10th of August 2026 that I want to revoke the agency. Hello? Are you understanding? Let us imagine, sir, the agent still enters into a contract on behalf of the principal with the third party. When do I enter into a contract? I enter into a contract on 12th August 2026. Now the question is, you tell me, when is the revocation effective? Now the agent entered into a contract on behalf of the principal on 12th August 2026 with the third party, correct? Now my question is, people, is the principal liable to this contract? Is he bound by this contract? Yes or no? What do you think? Is he liable? Is he not liable, principal? Until the notice is given to the person, third party or agent. I have intimated agent that 10th of August, my and your relationship is coming to an end. They broke up.
So the third party knows that he is not more an agent.
Okay, very good, people. Remember, for the principal to be free from liabilities, I need to intimate the agent also. I need to intimate the third party also. So when will the agency come to an end? The agency will come to an end the moment I inform the agent. Yes, agency comes to an end. But for the third parties, agency will come to an end only when they get to know or when they are aware of it. Because logically think, hello, people, have you guys seen the founder of ArivuPro? Have you seen all the people of ArivuPro? You have not even seen the principal. Whoever are the people who are representing them is what you guys know. Hello? Now I give some word. Will you take it seriously or not? Because you have seen me. Now it is a duty, if at all. If imagine something happens, if any one person, you were meeting one teacher or one sales executive or anyone you were meeting often, if at all they are not working with us anymore, it is a duty of the ArivuPro to tell you, people, we have removed such person from the job. Please do not act with them. Hello? Are you understanding? Yes or no? So it is the responsibility of the principal to intimate everyone. Sir, is it possible to intimate everyone? You have to. How? Easiest way, put it in a newspaper that person is no longer our agent. Easiest way. This is what you would have seen even in your Indian partnership. A general, what is that, active partner? Upon retirement, he needs to give a public notice. Why? This is the scenario. Understood? How will we give public notice? We'll give it in a easiest newspaper. Whether you read it or not is irrelevant. But you can tell, sir, I have told in newspaper only. If you still do, it is your headache. Understanding? Hello? Yes? Okay. That is your agency. Doubts? Okay. Let's start with the next chapter, people. Sale of Goods Act. Unit 1, Formation of Contract of Sale. Yes, people. The first definition, easy definitions, tell me, what do you mean by goods? Goods means all kinds of movable property other than actionable claim and money in circulation. What do I mean by actionable claim? Nothing but it can be like promissory notes, bill of exchange, as the case may be. So they are telling you goods does not include promissory note and bill of exchange. Why? They go under a different chapter. Which chapter? Negotiable instruments. So goods definition does not include this. Okay. And what else is not included? Money in circulation. But remember, antique coins will be considered as goods. You can buy and sell antique coins as goods, but not money in circulation. What do I mean by money in circulation? Money in circulation means today's currency, whatever is accepted in trade, that cannot be considered as goods. If you give 100 rupees, what will you get back? 50 rupees. 100 only you will get back. So I cannot consider money as goods. But antique currency can be considered as goods. Why? For example, recently I had been to Kerala. While I was going on the highway, one person had put one small like a roadside shop. Yeah. So what is there? All antique things. In Kerala, this is very common. You know, this Kerala antique clocks, yeah, and some things like this. I saw one coin, 1 anna, it was written. That coin was people around this big, easily this big. What is this? This was the currency of India that was prevalent in 18th century, it seems. It is easily this big. 17th to 18th century. How much is it? 1 anna is today, if I go to a shop, 1 anna is not even 1 rupee, technically. How much is it? He was quoting 6,000 rupees. I'm telling you, roadside shop. 6,000 rupees. But what is the value of it? Not even 1 rupee. Now the question is does it come under Sale of Goods Act? This antique coin, this 1 anna, will it come here? Can I consider it as goods? Yes or no? It will come as goods because that 1 anna is not in circulation. Now imagine I go and buy tea. Can I give anna 6,000 rupees anna? You take this anna. Can I give it tada? Who will take? No one will take. Yes? Are you understanding? So that is when I figured out people. There are a few people. Now this is a very big business. There are a few agents. There will be these old homes in villages. Yeah, they go and they get the old items in the home. Like old chair will be there in your home. You sir, take free for this, sir. We don't want it, sir. You take it for free. There will be some table. You'll not,
Space consuming.
you will be thinking simply space is getting wasted. I have one group people, I'll show you probably. You will not believe what and all will come. Yesterday someone had posted one door, old door, easily 200 years old. How will you see it? They old door, everything is worn out. I have to refurbish it. Unnecessary nonsense for me. That door is getting sold in this group for around 1.5 lakh. 1.5 lakh. You should see what and all they sell in this group. Yeah, in Jainagar, I don't know, there is one area here called Jainagar. There is something called as auction house. Auction sale we have no in syllabus. There is something called as auction house. People will bring something and all to come and auction it. Cameras, old cameras. They will simply come and try to sell. They will say 1,200 rupees, 1,800 rupees. People are willing to buy. Why? Because remember, in the next, I'll tell you people, there is one place called as Payana. If you guys go towards Mysore, there is an antique car museum. Antique car museum, yeah. If you go on the way to Mysore, you will get it. If you guys haven't visited, if you are a car enthusiast, go and see. It's good. Very nicely maintained. My dad had a scooter, Chetak, Bajaj Chetak. I was like, I remembered, all the while I said, Dad, we'll go to bike. Because everyone started using bike, I said, we'll also go and take bike. I remember we gave away our scooter for 4,000 rupees. Yeah. Now today people in that Payana museum, they have put the scooter people, the value is more than 1.5 lakh rupees. It is considered as an antique thing. That day I didn't sleep. 4,000 rupees. Somewhere in the home it could have lied. 4,000 rupees we gave away. Now that is when I remember people. Remember something is there in your home which belongs to your, great grand means much as preserve it. I'm even telling grandparents also. It is antique people. You will not believe. Even the utensils that will come. Utensils will come. If you have any other, items in display or, I don't know, something like that. Much of that and all has no value. You take today the clock, antique clock. If it is at least of this size, the minimum price will be 30,000-40,000. If it is a big clock, you remember it used to have this pendulums and all, minimum 70,000-80,000. Minimum. Antique. So preserve it. That is also one good business. Yes or no? Okay. Next one. Goods also include. What and all goods include? Goods include stock and shares, growing crops, grass, things attached to land and agreed to be cut. Severed means cut. Something like I can take vegetables, I can take fruits, trees, timber, all these can be considered as goods. One small information is also, today we have stock market, correct? SEBI and all is there. Before SEBI came into picture, Sale of Goods Act was the only law that was there in India for shares. We used to follow Sale of Goods Act before SEBI came. In 1950s onwards, SEBI rules started coming, like there was a complete law made for stock market. Until then people, for share transaction there was no law. We used to follow Sale of Goods Act only, because that is what is the share scenario here. So anything else is considered as goods, everything people, water, electricity, steam, all of this is considered as goods only. Hello? Understanding? Okay. Classification of goods. Goods can be classified into three things. One is called as existing goods, future goods, contingent goods. Existing goods, what do I mean by existing goods? Existing goods means I can further classify it into three things. But basically what is existing goods? At the time of contract of sale, does the goods are owned by the seller? Meaning if I'm selling you this mic today, am I owning it today or not? If I have it at the time of contract of sale, if I am the owner, this is called as existing goods. Hello? Sir, what do you mean by future goods? Sir, we are entering into the contract today, but today I am not the owner, or the goods are not yet existing. After a few days, the goods will come into picture. Such type of goods are called as what, people? Future goods. Contingent goods. I may or may not become the owner. Is called as what, people? Contingent goods. So there are three types. One is called existing, next one is called future, next one is called as contingent. So existing goods can be further classified into three things. One is called as specific goods, unascertained goods, ascertained goods. What do I mean by specific goods? Specific goods means the goods, if they are identified at the time of contract of sale, we will consider them as, people, specific goods. Now what do I mean by specific goods? Example, let us imagine you clearly say, sir, I want to buy this mic only. Now me and you are entering into a contract now. At this point, you clearly know which mic you are going to get. The goods are identified when the contract is being made. This type of goods are existing specific goods. Hello? Understanding? Pakka? Sir, next one is called as, people, unascertained goods. What do I mean by unascertained goods? Now, for example, I'll tell people, does any of you want this particular book? You say yes. Now I'll tell you, okay, I'll get you one book. When? Now we are entering into a contract now. I'll get you the book. I'll tell people in the break, go and contact the reception. They have printed and kept 100 books. In that they will take one and they will give it to you. Hello? So people, we are entering into a contract now. You want to buy the book, I will give you the book. Contract is made. Done. Now people, there are 100 books. In that, do you know which book you are going to get? You don't know. In that 100, you might get the top one, you might get the bottom one, you might get the damaged one, you might get a semi-printed one, you might get a completely printed one, you might get a black and white, you might get a color. All possibilities are there. So how do you know which one is yours? Until you get. Hello? Now what do you say? The contract is made. When the contract is made, the goods are not yet identified. It is in the bulk. We call such type of goods as unascertained goods. What do I mean by unascertained goods? When, during, at the time of contract of sale, the goods are not yet identified. You do not know which existing one you are going to get, which specific one you are going to get. We call such goods as unascertained goods. Basically, they are in the bulk. They are not yet separated. Sir, now you go to the reception. They will take the top one, they will give it to you. After the contract is made, whatever belongs to you is separated and given to you. Now this becomes what? From the bulk, the one that belongs to you is given to you. We call such type of goods as ascertained goods. Understood? So unascertained is bulk, ascertained is separated from the bulk. Simple. Future goods is what, people? Something which is not yet manufactured, which is not yet owned, not yet produced. At the time of contract of sale is called as what, people? Future goods. Example, sir, you go and give an order to prepare a sofa. You make a sofa. You are giving an order today. The carpenter takes up the order also. Or whoever the person is. He takes up the order. Okay, sir, I'll give you the sofa. You'll tell, I want it in this way. He'll say, okay. Does he have the sofa today? No. But the contract is made today. Does the sofa even exist now? No. So remember, after the contract of sale is made, if the goods are manufactured, such type of goods are called as future goods. Another example, what do you say? Let us imagine a pickle company goes and enters into a contract with a farmer to supply mangoes. Now when a contract is made, is the mangoes there? No. I'll tell, sir, in the next 6 months, whatever mangoes come, you have to sell it to me only. So this is called as what? Future goods. Because when the contract was made, does the mangoes exist today? Hello? Hello? If it is existing, then okay, it becomes existing goods. If it is yet to be produced, then it comes future goods. I hope it is clear. The third one is called contingent goods. What do you mean by contingent? You may or may not get. Best example is people, auction sale is a contingent goods. Now from here I'll go people, I'll pakka show you an antique item. Tomorrow there is an auction, actually it is there Sunday. I will pakka show you an antique item, okay? I'll go and participate, I'll get it in a bid, I'll come and show you. Now people, my budget was, let us imagine 1000. There people are crazily bidding 5k, 10k, 15k. Now what did I do? I did not participate. But I gave you a word, no. People, pakka I will show you. I said or not? Contingent people. How would I know? In an auction, I should be a biggest bidder, highest bidder. Only then I will get the goods. Yes or no? So such type of goods are called as what people? Contingent goods. Understood? Hello? Any doubts? Done. Next one is delivery. Delivery is of three types. One is called as, what is delivery? What is delivery? Transfer of ownership and possession of the goods. Voluntary transfer of ownership and possession of goods is called as, is there a difference? Sir, voluntary, that's all no sir, one word difference. Makes lot of difference in reality because voluntary transfer and only transfer, the difference is theft. Imagine if I give you this mic, it's called voluntary transfer. If you steal this mic, it's called as transfer. Hello? Understood? Okay. So people, voluntary transfer of possession is called as what people? Delivery. Okay sir. Now delivery can be of three types. One is called as actual delivery. Next one is constructive. Third one is symbolic. What is actual? You take a picture, no. Actual delivery. Next one is called as what people? Constructive delivery. What do you mean by constructive delivery, people? Constructive delivery means? Change in ownership but not possession is called as constructive delivery. Generally what happens, people? Let us imagine the goods are all in go down. Yeah? Okay, let us imagine now. I'll tell you. Have you seen Arivu parking? Okay, there is one, one big ground here behind. So there will be one, that's a common parking. Lot of companies take spaces there and we can go and park. Yeah. Now let us imagine, let us enter into a contract. Correct. Nakul is selling geographical location also. Macha, eppadi po, eppadi va. Correct. Yes, that place only. Now imagine people, my car is there. Hello. Now there is a gatekeeper also. He will not allow random people to come in, random people to go out. Highly secured place. More secured, very, very secured because that place is also girls' hostel. So random people will not be allowed. There is a time restrictions and all of that is there. Now let us imagine people, we are sitting here. Now me and Nakul, let us enter into a contract. Nakul wants to buy my car. Hello? Nakul wants to buy my car. I say, okay, Nakul, tell a price. Nakul said, sir, 1 lakh rupees. I said, Nakul, okay, da, anything for you. Now, Nakul people quoted 1 lakh rupees. I said, okay, Nakul, take. Now, the question is, people, but where is the car? Did I actually give Nakul the car? Now, Mike, I gave it in his hand, no. Did I give the car to Nakul now? No. Now, people, what do I tell? I will call that person who is taking care of the car there. Basically, that gatekeeper, I'll call him and tell, there is a person called as Mr. Nakul. I'll give him the identification to identify him. And I'll tell, when he comes and asks, please give the car. Hello? And I will forward him the number that you both coordinate. Now what happens? He will contact Nakul. Sir, that sir told me, I'll give you the car. Okay, I'm holding the car for you. Car did not move an inch. Wherever the car is there, the car is still there only. Correct? Hello? But that fellow contacted and he intimated Nakul and said, sir, I'm holding the car for you. Don't worry. He intimated, people, the delivery is made. In a constructive delivery, how is the delivery made? The delivery is made by acknowledgement. When Nakul and him, they acknowledge with each other, I will take the delivery, he will give the delivery. That's all people, delivery is made. Now anything happens, now the car is there, imagine I have exactly parked under a tree. The tree falls. Who will take the risk? Is it mine or is it on Nakul? From my end, the ownership is also passed, delivery is also made. Anything happens to the car, it is a headache of Nakul. Hello? Understood? This is only called as what people? Constructive delivery. Any doubt? Hello? Machas? Clear? Okay, the third type of delivery is called as symbolic delivery. What is symbolic delivery? Now, can I give Nakul? I said, Nakul, take the car. How will he take the car? I'll give him the keys. The keys is called as people symbolic delivery. When you want to transfer something, on behalf of it, on the token of transfer of something, give something else. So instead of giving car, give him keys. Giving keys is like delivering the car. This is only called as what people? Symbolic delivery. Any doubts? Hello? Clear? Done. Next one, people, is document of title. Document showing title. One more important topic. What is document of title? Document of title means, people, whoever has that, whatever, the document, he is the owner. Document showing title means, people, that is just says who is the owner. Even if I lose it, it's not a big deal. Now, for example, I have my RC card. If I lose it, Nakul found it. Will Nakul become the owner of my car because he found my RC card? No, because this is a document showing title. I have a share certificate. I lose it. Nakul gets it. Nakul will become the owner of the shares? No, it is just a document showing title. What do I mean by document of title? Document of title means, people, if you get this document, you get the ownership. Hello? Example can be movie tickets, or you go in shopping malls, no? You go and deposit your luggage in the baggage counter. He'll give you one token. Macha, you lose it, you are gone. Whoever goes it and he gives it in the luggage, he will verify? So tell me your PAN, show me your IT returns. He'll ask for everything. He'll ask? No. Then, if you lose this token, you lose the ownership. Such type of documents are called as what? Document of title. So if you lose the document, your ownership is gone. Hello? Yes, sir. Another example can be like, not completely relevant, bearer check. Whoever has it, they become the owner. Hello? Okay. Next ones are another two important things. One is called as contract of sale, agreement to sell. What do you mean by, what is the difference between contract of sale and agreement to sell, people? One is immediate transfer of ownership. Next one is future transfer of ownership. Risk transfers immediately in sale. Agreement to sell, risk transfers in the future. Any loss happens to the product in sale, who will take the loss? Whoever purchased it, they will take it. Agreement to sell, seller will take it. In sale, can I further sell it? Resale is possible. In contract of sale, why not? You buy mic from me, you again sell it. Why can't you sell it? In contract of sale, the future sale, resale is possible because it is your goods. Who will stop you? In agreement to sell, you only did not get the goods. How can you further sell it? Hello? Machas? Yes or no? So that is some basic differences of sale and agreement to sell. And what else? Sale and what else is given? Bailment. What is bailment? We have seen. Bailment is just a transfer of possession. Here you are also transferring ownership. There the possession will be given back. Here it will not be given back. It can be for free. This always has to be for. It should always be for. When is it called as a sale? You are giving a product. In return, what are you getting? Is it money or Consideration. Or anything you can get, Anything in kind is okay. I sell you this partly in kind, partly in cash. Something in cash should be there to be called as a sale. If not, it becomes barter. That means what? I give you mic, you give me your phone. It is called as barter, sale Allah. It becomes the exchange, that's all. For something to be called as a sale, money should be mandatorily involved. Hello? Understood? Yes, sir. That is your bailment. And what else is there? Hire purchase. What is hire purchase? Initially you pay installments. Upon paying the last installment, people, the ownership is transferred. Remember, if you do not pay the installment any time in between, the ownership and the possession, the possession can be taken back by the person. Hello? Yes, sir? In hire purchase, the ownership does not get transferred until the last installment. So in hire purchase, can I resell it? No, because you do not have the ownership. You cannot resell the goods. In hire purchase, who bears the risk if anything happens to the product? Let us imagine I took this mic on a hire purchase. Hello? Now I have not yet paid all the installments. Let us imagine 10 installments. I have just paid 8. I kept it here. Dubuk fell. Who will bear the risk? Me or the seller? Me or the seller? Seller? Huh? Oh! Seller? Seller? So I can just keep playing like this. It falls. That's okay? The risk is with the seller only, no? Huh? Remember, people, you cannot forget the concepts, people. He is the owner, correct? The goods are with me, correct? Do I have any responsibility? What responsibility? What do you call this responsibility as? Take care of the goods. Then what will I be called as? I will be called as a bailee. I have to take reasonable care of the goods. Reasonable care, Allah. Hello? Accidental falling. Owner will be liable. Incidental falling. Bailee will be liable. Don't forget it. Sir, what do you mean by accidental falling? Take our example. Earthquake came, earth split, mic went inside, earth came back. Who will be liable? Seller will be liable. What do you want me to stop? Captain America, hold two earths? How do I stop it? Possible? Not possible. So remember, that's the important thing. Clear, Ram? That's your hire purchase. Okay, mercantile agent, people. What is mercantile agent? An agent selling the goods on behalf of his principal. For that agent, whatever agent sells, if I am acting on behalf of the principal, remember the ownership properly, legitimately, validly goes to the buyer. Whatever can be the scenario. If you have purchased it in a good faith, the buyer gets a good ownership when the agent sells the goods on behalf of the seller. Clear, Ram? Yes, sir. Anything else that is there in unit 1? We have covered most of it. Yes. Ascertainment of price. Hey, macha. Hey, pasingale. Yengro. Important topic helala neevu. Ascertainment of a price. In a contract, how is the price ascertained? Section 9, very, very important. How is the price ascertained in a contract? The price can be ascertained, people. The first one, directly. How? By a contract. Agree. A and B clearly agrees. Sir, I will sell my bike for 1 lakh rupees. B agrees in a contract. Oh, okay. In a contract, they agree. That is the first way you can ascertain a price. Second way, people, it may be left to be fixed in the manner thereby agreed may be determined by the course of dealing between the parties. Now, what do I mean by course of dealing between the parties? Bike is a one-time sale. Imagine there is a raw material dealer. Every week I will supply raw materials to you. Now I can't fix the raw material for once, no, because it can vary. Now imagine a farmer who has agreed to sell onions to this supermarkets. One time onion can be 20 rupees, one time onion can be 100 rupees. How can we write in a contract that the price of the onion will be 40 rupees? How can we write it? In such case, what do? We will agree that for the next 1 year you have to supply onions. But what is the price will be decided on that day's market value. That is the meaning of course of dealing. Hello? Understood? Okay. The third one is people. What? It can also be decided by a third party valuer. The best examples can be your chartered accountants only. Say for example, I come and tell people I am interested to acquire one company called as XYZ. Can you tell me at what price I need to acquire? Because if it's a product, it has an MRP. How does a company has an MRP? Now, how do I buy? I will go to a third party, a chartered accountant. I will tell him to do a valuation. Can you tell me what is the value of the company? They will do all the possible methodologies. They'll come and arrive. Sir, the value of this company can be somewhere between 10 lakh to 15 lakh. Hello? So, now can a price of a product or price of anything be decided by a third party? Yes. Now, both of us can agree whatever the value fixed by the third party. According to that, let us do this contract. Can we do it like that? Yes, we can do it that way. Possible. Hello? Understanding? Yes. Sir, let us imagine, sir, imagine, let us take instead of company, A decided to sell his bike to B. He wants to sell his bike to B. Who will fix the price? The price will be fixed by C. Yes, sir. Now, the bike is already given to B. This fellow is yet to figure out the price. He has not told us the price. Imagine people, it so happens that C was unable to tell the price. But A has already given the bike to B. Now what will happen to this contract? Should B give back the bike? In such case, remember, whenever the contract has made, but you have not decided the price, just because you have not decided the price, the contract will not become void. The contract will still be valid. The buyer will have to pay a reasonable price to the seller. Clear? So remember, they can ask you any way of question here. Whenever the goods, whenever you have agreed to sell goods, if price is not decided or determined, only because of that people, the contract will not be cancelled. The buyer will have to pay something called as a reasonable price to the seller. Clear all of you? Yes, that is your ascertainment of a price. And perishable goods, people, remember, before the contract is contract of sale, before the ownership is transferred, anything happens to the goods, people, if it is perished, the risk will be on the seller. After the ownership, anything happens, people, the risk will be on the buyer. This is what you will be seeing even in the unit 3. That is only called as risk prima facie transfers with ownership. Whoever is the owner will bear the risk.
The goods is in transit.
The goods is in transit.
While traveling.
That's okay. You guys would have seen that also, no? Delivery is irrelevant. Who is having the goods is also irrelevant. If the ownership is transferred, then the buyer bears the risk. For example, you take Nakul's scenario only. Delivery, the goods are there. I have not yet given him the car, but I have given him the ownership. Acknowledgement is also done. That's all. The goods are there. Who will bear the risk? Nakul's risk it is. So even when it is in transit, all that you need to check is ownership transferred. If ownership is transferred, when we are doing unit 3, I'll tell you, remember, delivery of goods and ownership are two different things. They are not related. That means, I can have the goods, but still the ownership can be with you. That is possible. Yes, so whoever is the owner will bear the risk. So even in transit, if the ownership is already transferred, then the buyer will only have to bear the risk. Clear? Yes? Okay. Yes, people, unit 1, we covered almost everything. Hello? Yes? See here. Let us do unit 9, agency chapter. A person employed to do any act and represent is called as agent. Both, who can become an agent? Minor and adult. Minor, adult person, dead person. Who? Both minor and adult. Correct? Incompetent person also possible. Oh, third question is somewhere gone. Okay. Dash is a person employed by and acting under the control of original agent in business of agency. Substituted agent, sub-agent, mercantile agent, universal agent. Whoda? Sub-agent or substituted agent? Sub-agent. A person employed by and acting under the control of agent. So it is sub-agent. A substituted agent acts on behalf of principal. Substituted agent. Remember, there is privity of contract. There is a direct relationship. I will refer your name and everything else is between you and the principal. Okay, sixth one. The power given to agent is. The power given to agent is reasonable and unreasonable, express and implied, legal and illegal, all of the above. The legal and illegal, how will you give that? Illegal, how will you give that? Express and implied, unreasonable, how will you give that? On whose insolvency the agency is terminated. Who? Sub-agent, agent, principal, del creditor. Forget del creditor. What is del creditor? Del creditor is nothing but people, a type of agent where generally what happens, any risk is there. Who will bear the risk? Principal will bear the risk. But del creditor agents are such agents who say, sir, if there is any risk, we will only take the risk. You don't worry. So if you are a normal agent, risk is with the principal. If you are a del creditor agent, the risk is with the agent, not with the principal. So such people will also be there. They'll be there. They are there. SBI has one of its wholly owned subsidiary as del creditor agents. What do? Money recovery. Discounting of bills. You would have seen, no? They will do that. Sir, you give me bill of exchange, I will go and recover. What if I am not able to recover? You leave, sir, I will recover. They will do. Sir, why do they want headache and all? Simple. Additional service, additional cost. So general agents, if they are charging say 20,000 rupees as their commission, these people will charge 40,000 rupees as commission or 45,000 rupees as commission. Understood? Such type of agents are called as del creditor agents. Okay, on whose insolvency the agency is terminated? Principal. Because ultimate liability is that fellow, no? If he becomes insolvent, everything comes to an end. Under which circumstances the agent becomes personally responsible? Beyond authority, fraudulent transactions, fraud, all of the above. It is a duty of the agent to protect and preserve the interest on behalf of the principal's representative in case of death of principal, insolvency of principal, both A and B, none of these. Both A and B. Agent should not deal on his own account without first obtaining the consent of the principal. Otherwise, the principal may what? Repudiate the transaction, claim from the agent any benefit which may have resulted to him from the transaction, either A or B, both A and B. Both A and B. Agent should not deal on his own account without first obtaining the consent of the principal. I told you, no, secret profits. You're not supposed to make secret profits. You have to disclose and do it. Okay. A appoints M, a minor, as his agent to sell his watch for cash at a price not less than 700. M sells it to D for 350. Is the sale valid? Question number 1. Again, most common mistake that the students do. See, you will only answer the last line. When you see it, please look at the questions carefully. There can be 2-3 questions in the same paragraph. Most common mistake that the students do. I'm saying at least when you look at the paper, 60 to 80% of the students wouldn't have answered the entire question properly. They would have left one or the other thing. Not because they don't know, because they were not aware. They will forget. They will not give more preference to that part itself. Reading the question is an art. Remember. Okay. Now, is the sale valid? Remember. Okay, tell me. Can a minor make a sale? Possible? Yes or no? Yes or no? Hey, in MCQ guys said agent can be a minor, noda. Why are you saying no now, da? Why do you guys do this? There you will tell one thing, here you will tell one thing. Valid only, noda. A minor can be an agent. So any sale made by an agent, it will be valid. Yes, it is valid. Now, second part. Explain the legal position of M&D, referring to the provisions of Indian Contract Act 1872. That is, can I recover the money from the minor? Can I? I told him to not sell the watch less than 700. He has sold it for 350. Can I recover the loss? Remember, if you are appointing an incompetent person, the risk is borne by the principal. You cannot recover even 1 rupee from the agent. State with reasons whether the following statement is correct or incorrect. Ratification of agency is valid even if knowledge of the principal is materially defective. Answer is no. What is ratification, people? You remember, I don't know whose case, Siddharth and Narayan Murthy's case. Ratification. Ratification is what? When I gave you, I did not give you power. But in the future, you are saying that I'm okay with all the past or previous transactions. You're making the invalid acts as valid in the future. It is called as what? Ratification. For ratification, you saw rules. In that, one of the rules is, remember, the principal should be aware of all the material facts. You cannot cheat and do ratification, impossible. Understood? Hello? So here, if the principal's knowledge is defective, no, ratification is not valid, it will be considered as invalid. Hello? Rahul, a transporter, was entrusted with the duty of transporting tomatoes from a rural farm to a city by Ashwin. Due to heavy rains, Rahul was stranded for more than 2 days. Rahul sold the tomatoes below the market rate in the nearby market where he was stranded, fearing that the tomatoes may perish. Can Ashwin recover the loss from Rahul on the ground that Rahul had acted beyond his authority? No. What is the provision you will write? Agency created by necessity during emergency. Now Rahul has acted in the best interest of principal. So whatever actions done by the agent, the principal will be liable. Just that, remember, when emergency or necessity comes, the agent should have done what the best or ordinary man would do. Whatever the normal man would do, he should have taken that particular alternative. You should have tried calling to the principal. All that is correct. But see why they will not give you. These are all the act given examples. That time phone itself was not there. That's why you will not see that coming. So that's why they say you should try contacting the principal. How will he contact? Letter? So that's I know when students ask me that, that's why I say this is the scenario. So when the examples were written, it was 1872. Clear? Hello? So you should have done whatever is the most commercial alternative available. You should have done that. If all of this is correct, people, then yes, the principal cannot recover any loss from the agent. Okay. Next one, Mr. Ahuja of Delhi engaged Mr. Singh as his agent to buy a house in West Extension area. Mr. Singh bought a house for 20 lakhs in the name of a nominee and then purchased it himself for 24 lakhs. He then sold the same house to Mr. Ahuja for 26 lakhs. Mr. Ahuja later comes to know the mischief of Mr. Singh and tries to recover the excess amount paid to Mr. Singh. Is he entitled to recover any amount from Mr. Singh? If so, how much? Explain. What is this? This is what I tell you people. You are not supposed to make secret profits. How much I can recover? Huh? You understood the scenario? The principal wanted to buy one land. So what did the agent do? The agent asked one of his friend, Macha, you buy the land. He asked him to buy it for 24 lakhs. Allah, where is that? Sorry, 20 lakhs. From his friend, he further purchased it for 24 lakhs. And he further sold it to the principal for 26 lakhs. Hello? They're asking you what is the money that I can recover. Remember, you got it for 20, you are selling it to me for 26. The total difference that you made, people, is this. Correct? This is what I can recover. 6 lakhs I can recover. Hello? Yes or no? Okay. Comment on the statement. Principal is not always bound by the acts of a sub-agent. Comment on the statement. Principal is not always bound by the acts of a sub-agent. Correct? Hello? You will start your answer only with delegatus non potest delegare. Agent cannot further delegate his duties. So whatever a sub-agent does, a principal will not be liable because there is no privity of contract between the principal and a sub-agent. There are 3 exceptions. Nature of trade, or I appointed in contract itself, or emergency. But except those 3, sub-agent is not valid. Yes or no? Hello? I hope you know it. We discussed. Okay. ABC Limited sells its products through some agents, and it is not the custom in their business to sell the products on credit. Mr. Pinto, one of the agents, sold goods of ABC Limited to Messrs. Parul Private Limited on credit, which was insolvent at the time of such a sale. ABC Limited sued Mr. Pinto for compensation towards the loss caused due to sale of products to Messrs. Parul Private Limited. Will ABC Limited succeed in its claim? I hope you guys understood. They have appointed a company has appointed one agent. His name is called as Pinto. Pinto has sold some goods on credit to Parul Private Limited. The company was insolvent, it seems, when they made this sale. And remember, it is not the customs in their sale. You cannot make a credit sale. He still sold it. They are asking you people whether can the company file a case on the agent? Will the agent be liable for this contract? Will the agent be liable? Understood the question? Hey, yes or no? Hey, today only we discussed this. Who? Agent will be liable, principal will be liable. Agent will be liable. Tell me now the provision. Under which provision he will be liable? Acted? Customer's instruction. Remember people, it is your duty to follow the principal instructions or customs. Provision number 1. Second provision people, it is a duty of the agent to act with reasonable care and skill. Here he was negligent. It is your duty to do some background check. They are insolvent. How can you directly give them on credit then? On these two grounds, agent can be held personally liable. Again, I am telling you, yesterday you guys were asking me, what is the art of writing? These two words should be there. You will get 5 on 5. Now, why do people complain, sir, I am not getting marks? Is because of this. Your entire story is correct. But you have not written why. You will not get the marks. Hello? Understanding? Okay. Okay, what is that? R is the wife of P. R is the wife of P. She purchased saris on credit from Nalli. Nalli demanded the amount from P. P refused. Nalli filed a suit against P for the said amount. Decide in the light of provisions of Indian Contract Act whether Nalli would succeed. What is this, people? Is a wife considered as an agent of the principal? Is she considered as an agent of the principal? Is the wife considered as an agent of the principal? Yes or no? Generally, yes. Generally, yes. Exception is people 3. What? If the husband has clearly informed the society, don't give any goods to my wife on my name. So if there is a specific instruction, then the husband will not be held liable. Second one, the husband has already given those goods which the wife has purchased on credit. The husband has already supplied those goods. Again, people, husband will not be held liable. The third thing, people, is necessity. What is the third thing? Is necessity. What did the wife purchase? If the wife purchases something which is not necessity, the husband will not be held liable. So these 3 things you need to remember. What? Generally, husband will be liable. But 3 exceptions are: husband has instructed to the society, husband has already supplied. The third thing is, it is not necessity to the wife. Something luxury. In these 3 cases, husband is not held liable. Here, in this case, anything is given. Hello? You are free to write it with an assumption. You can write sari as necessity because it comes under you. Because see, it sees on how you take it. If you take it as a most luxurious sari, or you take it as a necessity. So that's what I'm saying. You can write it as an assumption. Correct? Huh? Because when we saw minor, there you guys only told me food, clothing, shelter is considered as necessity. You only told. So clothing only know it is. You can write it with an assumption. Assuming that the husband had not instructed any outsiders. Assuming that the husband has not already given the supply. Assuming that this is a necessity. The Nalli can hold the husband liable. This is as per the book, people. In reality, whether this will win or not, today's date it will not be taken in this way. But this is as per the book. Okay, Indian Contract Act alone. Next one, Bhupendra borrowed a sum of 3 lakhs from Atul. Bhupendra appointed Atul as his agent to sell his land and authorized him to appropriate the amount of loan out of the sale proceeds. Afterwards, Bhupendra revoked the agency. Decide under the provision of Indian Contract Act 1872 whether revocation of the said agency by Bhupendra is lawful. We did not see this. This is what people, in whichever contract, the agent has a personal interest. In such cases, people, you cannot revoke the agency. What do I mean by personal interest? Now, in this case, what has happened? There is principal and agent. Agent has given loan to principal long back, it seems. Something on 5 lakh rupees have given. Now, principal has a land. The principal asked agent, can you please sell my land and you will get money? No. In that money, you take your 5 lakh, whatever you had given me as loan. You take that 5 lakh, rest of it, you give it back to me. Are you getting the point? Now, sir, in this contract, it's not only principal, even the agent's money is also now involved because he is going to get back his 5 lakh. Now he becomes personally involved. He has personal interest in the contract. Now, because of this, such agency cannot be revoked. That's the question, that's the answer. Can you revoke? Answer is no, because the agent has the personal interest. That's the provision. If that is there, you will get the mark. If not, you will not get the mark. Clear, huh? Yes, sir. You want a break, huh? Go and come. Yes, people. Next unit, people, unit 2, conditions and warranties. What is conditions and warranties, people? Remember, whenever you go and enter into a trade, a sales guy will make 100 promises to sell a product to you. Some promises may be true, some promises may not be true. Now, for example, Nakul might tell what? This lab, sir, super dog. I tell Nakul I want something that takes care of my home. He'll say, sir, take Pug. Beautiful dog. If anyone comes means it will go and bark. Correct? Now people, now what is the role of Nakul? Nakul will tell 100 things to sell a dog. But in reality, people, is it true or not? Who knows? Papa, people are buying from Thailand and all. Now people, in reality, when the salesman says hundreds of statements, in reality, some of it may be true, some of it may not be true. But a buyer has believed in every word said by a seller. And I always tell you, remember, when you read Indian Contract Act, Sale of Goods Act, Indian Partnership Act, please try to read the law as if you are still in 1930s, 1870s. That time you did not have internet. Like this I can't check. That's why they said there is something called as stipulations. When the seller is telling something, you are bound to live with your words. You can't cheat. So every statement made by a seller, some things are very important to the contract. Some things are okay important to the contract. Something which is very important to the contract, we call them as implied, we call it as condition. Something which is okay important to the contract, we call it as warranties. Remember, if something very important to the contract is not served, then people, as a buyer, you believed in that, but your purpose is not served, you have a right to give back the product, get back your money, or you can even claim compensation, or you can even do both. But sir, imagine I believed in the salesman, but that particular words or the promises he's made, it's okay, it's not that important to the contract. If that is not served, you cannot cancel the contract, but you can just claim damages. So that is the meaning of people, what? Conditions and warranties. Example, if I can give you is people, let us imagine if I go to a store and if I ask for a jacket, I'm going to a Himalayan trek, let's say for example sometime, and I'll ask for a jacket which can take that conditions. Now I have not been to Himalayas, I don't know how exactly the cold will be. Now I ask the sales guy, please give me a jacket suitable for those conditions. What does he do? Now because to sell, he says, sir, try this. This will keep you really warm. You take it and go, sir. Now you tell me, caveat emptor, what maximum I'll do? I'll wear and I'll see. Now can I create the atmosphere here, Himalayan atmosphere? Is it possible? Can I take it, sit in fridge for half an hour and come out? Possible? No. Now people have taken this particular contract on the main condition that people, it should serve my purpose of what? It should serve my purpose of keeping me warm in the cold temperature. Now I've taken, I go to Himalaya, this jacket didn't work. What is the right I have as a buyer? I can come back and tell, sir, there was a main condition. Your main promise was it has to keep me warm. It did not serve my purpose. I can give back the jacket, get back my complete money. Or I can even claim compensation as well. Or Both. I have both the rights. Clear? Now what do I mean by warranty? Warranty is nothing but people, let us imagine this jacket has some cool feature. Imagine some light will come. Hello? Now I took it people. Now it is keeping me warm, but the light is not working people. So it is not important to the contract. It's okay. You can even repair it. Agreed? Yes. Now people, what I will tell, I'll go and tell, sir, this particular light thing is not working. What he will do? He will correct that and he will give it back to you. So remember, the light is not the important element to the contract. Even without that, the jacket is serving its purpose. So something which is not the main element to the contract, if that is not proper, you cannot cancel the contract, but you can claim compensation. Here, what will be the compensation? I will ask the guy to repair it and give it to me for free of cost. That is called as what? Warranties. Clear? Yes? Okay. Sir, remember, at some times when breach of condition happens, you can treat the breach of condition as breach of warranty. When is that? You can treat that in 4 scenarios. The first one, when buyer waives off stipulation, nothing but people give up. This is where most of us belong to. You buy it. It did not serve your purpose, but you will not go and return it back. Hello? We give up. We'll say, right, it's okay. Da. What is there? You give it up. That is only called as what people? Waiver. Hello? Okay, next one. You treat the breach of condition as breach of warranty. I have asked the person to give me first quality of sugar in your shop. So here the condition is what? There are 3 qualities of sugar. I have asked for the first finest quality of sugar. That's the condition. But what did the guy do? The seller has given me the 3rd quality of sugar. Now I took it. I felt both are same. There is no difference between the first quality and the 3rd quality. Now I'm okay with it. Hello? Now what I can do as a buyer? Technically the seller has given me a product. I have asked first quality. He has given me a 3rd quality. My condition is not met. Now what I have right? I have a right. Give back the product. Get back my money. Option 1. Or Macha, the first quality of sugar is 200 rupees per kg. The 3rd quality of sugar is 100 rupees per kg. I am happy. It serves my purpose. So it's okay. I will keep the product. But give me back the extra money I paid. I can go. I can demand back the excess money. I can get that 100 rupees per kg extra I paid. I can get it back. So by doing this, what did you did? Your condition itself is not met, but you did not return the product. You kept it with you. So you treated the breach of condition as breach of warranty. The 3rd one, contract is non-severable and the buyer accepted it as a whole. At times it so happens, right people, now say for example, you buy a product, in that one thing you like, the other thing you don't like. But they are non-separable. In such case, what to do? I don't have a choice. I will decide to either give it back or I will decide to keep it with me. Example, I took the jacket for Himalayas. Hello? The jacket looks really good. I got good appreciation from people. See, this jacket is so good. But did it serve my purpose? No, I have a problem. Jacket is there. People are appreciating. It looks good. But is it serving my purpose? Now, can I separate these 2 conditions? If I want, I have to keep the jacket or I have to return the jacket. When the contract is non-separable, I liked one part of it. I did not like the other part of it. But if you decide to keep it, you can still keep it. You can just go and claim compensation from him. What do I mean? I can say, Macha, see, you gave me this jacket. It is not serving my purpose. However, I'll keep it. But give me some compensation in return. It can be 500 rupees. It can be 1000 rupees. But give me some compensation in return. That is only called as what people, contract is non-severable and buyer accepted it as a whole. The last one, sir, fulfillment is excused by law. Change in subject matter, change in law, alien enemy, destruction of subject matter. Because of that, people, I'm not able to fulfill the contract. It is okay. You will not have to pay damages and all. The contract will be excused. Sir, that is a fourth exception when the condition can be treated as breach of warranty. Clear? Next one, sir. What do they say? The statements made by the seller to the buyer can be of two types. One is called as express, one is called as implied. Express is whatever the parties discuss. Implied is the parties do not discuss, but still it is assumed to be there in the contract. Now, what is that? That implied can be further classified into two. One is called as implied condition, next one is called as implied warranty. Now, what do I mean by implied condition? Implied condition means these are not discussed by the parties, but still it is assumed to be there in the contract. If this is not met, people, then it is still considered as breach of condition. I have a right to give back the product, get back the money. Correct? Sir, examples for implied condition. First one, title. What do you mean by this? For example, people, I'm telling you, I want to sell this mic. Correct? What and all are the questions you will ask? Is it working? And sir, what will be the cost and how many hours you can use? Correct? You'll ask everything, but did you ask, is it mine? Implied condition, when a person is coming and selling you the product, you assume that the product is yours. I'll give you one example. I don't know if any one of you have encountered this. If you guys are moving in some areas of Bangalore, you can see people coming and trying to sell you these Apple products. Has it happened to you? AirPods so popular. Happened? No? Not happened, huh? Okay. You go to Jainagar and all these places. You keep moving. Yeah? Automatically one person will come and approach to you. Sir, AirPods. 5,000 rupees. Take, sir. You just walk away. Sir, 3,000. You walk away. Sir, 1,000. You walk away. Sir, at least give, sir. 500 rupees give, sir. AirPods. Actual price. Base price is 10,000 rupees. Now you will buy. 500 rupees you will buy. You will ask 100 things, original, working, everything. But you will ask, is it yours? Hello? Who knows how did he get it? Who knows how did he get it? Hello? Yes? India is not for beginners. In every state, we have a street, we have an area only called as Chor Bazaar. Chor means what? Theft. Bazaar means what? The things which are theft, stolen, they'll come and sell it. Chor Bazaar. We have it in Bangalore also. We have it in Delhi. Delhi only we have. There only I went and I purchased. Yes. Nike, Adidas and all, it will be on streets. They would have put it on 100 rupees, 200 rupees. Chor Bazaar. Pondicherry also has. Then how? Will you ask us, sir, is it yours? You will ask 100 questions, sir, original, color hogata, sir, shrink, everything you will ask. You will ask, is it yours? It is assumed in a contract, people, that a person selling the product has the title for the goods. Whether you ask it or not, it assumes. Tomorrow, if you are not the owner, what should I do? What should I do? When a real owner comes, if you have purchased it, people, it is your duty to give back the goods to the real owner. You can't keep it. Then, sir, I have suffered loss. No, sir. The law tells whoever is that sales guy who gave you that, he has to compensate you. But you can't say no to the original owner. You have to transfer it to the original owner. Clear? Next one, sir, description. The title will come there also, here also. That's what I try to explain. This warranty as to undisturbed possession. Same only. Correct? Next one, description. What do I mean by description? You've seen, Modi has addressed the paper leak case. He has made one video, 40 seconds video, 303 million views. It's a new world record. Most watched video. What another? Okay. Description, people. What is sale by description, people? Whenever you are selling the goods by description, like fresh sweets, basmati rice, or fresh bread, Darjeeling tea, whenever you are tagging the product with a description, the product has to belong to that description. You tell me, they'll say, sir, Darjeeling tea, sir, take. You know how Darjeeling tea tastes, sir? We are believing it is Darjeeling tea. Assam tea, Ooty. Ooty is not tea? Ooty tea. Yes, sir. Now, how do we know that? How does it taste? They will say, we will buy. Okay. Next one, sample. Correct. Now you go to a sweet shop, people, they will give you taste. I said, no, sir, taste. I said, no, sir, taste. They'll force, they'll put on. I'll say, please don't. Correct. Now, people, you liked it. You say, okay, sir, please give me 1 kg. Law says, sample is fresh, macha. That should not be made 1 week before. Sample should always, the bulk always should correspond to the sample. Sir, how do I know? The buyer has to be given an opportunity to inspect. Hello? Clear? Yes? Okay, next one. Sale by sample and description. If you say it is fresh sweets and I gave you sample also, it has to be fresh as well. It has to meet with the sample as well. Next one, sir, quality or fitness. What is quality or fitness? It should be good quality. Allah. Quality or fitness here means, people, when I tell you my purpose, the product you give should be fit to my purpose. Example is that jacket. When I've made you known my purpose, it has to serve the purpose. Remember, when will this condition come into picture? When the buyer relies upon the judgment of the seller, and if the buyer has made known the purpose to the seller, if seller has recommended you something, this condition will apply. Hello? Clear? Yes, sir? Okay. But if at all you are purchasing the products under trademark or patent, remember this condition will not apply. Why? Because your seller is not influencing you, the brand is influencing you. That's why seller did not make any promises. You have purchased the product believing in the brand. So in such cases, people, the quality or fitness will not apply. Is this clear? Yes. Okay. Next one is, people, merchantability. What is merchantability? When you are purchasing a product, you are purchasing so many products on Amazon. What do you do if it is broken? Merchantability. So because when you shipped it, I was not there to check it. So it is assumed that you have to give me a product which is merchantable, meaning good quality. Next one, people, wholesome. Wholesome means, people, there should not be any defects. So these two, what is the difference? This is for goods, this is for edible items. Non-edible, edible. Clear? Yes, sir? Hello? Okay, next one is implied warranty. So for all of these people, you can cancel and you can get back the money. Here, you cannot cancel the contract, but you can only claim damages. The first one is, people, warranty as to undisturbed possession. That means what, people? It should not be theft. Generally, what happens? Let us imagine, I go to Chor Bazaar and I got this mic. Yeah? And one of the teacher came and said, sir, where did you get this mic? It is mine. I said, how do you know? Sir, see, this is my marks. I know this is my mic only. Now, people, don't you think I have purchased, people, but someone is bothering me from using this mic? Constantly, someone keeps saying, sir, give me back my mic. Give me back my mic. Am I able to enjoy it with peace of mind? No. As a buyer, I have a right to enjoy the product with undisturbed possession. No one should keep coming and telling, sir, please give back our product. I have a right to enjoy it free of mind. Hello? That is what is implied warranty. Next one is non-existence of encumbrances. What do you mean by encumbrance means, people? Imagine people, I have one, okay, let us imagine, I have a gold ring. I've gone and pledged it with a gold shop. Hello? And that gold ring, I'm again coming and selling it to Nakul. Now I've taken the loan, no, I did not repay. What will the gold shop guy do? He'll come and say, Nakul, sir, that gold, on that I've given loan to this person. He did not repay my loan. So give me back that gold ring. Now don't you think Nakul is simply suffering? He purchased this with a good faith. After purchasing, that person is coming and telling, sir, there is a pledge on this. That is what they're telling you people. When you're selling a product, there should not be any encumbrances. Encumbrance means is like this. Pledge, lien, mortgage, such things should not be there. Hello? Okay. What can Nakul do here? Nakul can repay the money to the gold shop. He can recover it from me. Option 1. Option 2. Nakul can tell me, compel me to repay the loan to the gold shop. Both the options Nakul has. Clear? Third one, sir, quality or fitness by usage of trade. Whenever a seller is selling a product, the product has to follow the tradition why the product has been used for over a period of time. What do I mean by that? For example, there will be some products, people. What? Now, one example that I generally show in classes, people, is take this example. What? What is this? Umbrella. Why do we use umbrella for? Rain. Correct? Huh? Now, people, traditionally, umbrellas are used for rain for boys. For girls, of course, tano, everything you guys use. Boys, we don't care. We use it only for the purpose of rain. Girls will use it even in the summer also, because you guys believe in tan and all. Boys has nothing to do with it. Yes or no? Da? You believe? Yes, now people, what is it that telling people? Now Gucci and Adidas people, they came up with this umbrella. Who? Gucci and Adidas. They came up with this umbrella. What is the cost of the umbrella? And what is the beauty of umbrella? Huh? Why? It seems they sold this umbrella, people, as a part of the interior designs of a house. Put it in a display. It looks good, it seems. Now, traditionally, what is that product used for? It is used for people stopping the rain. That is the customer. If a person is deviating from that, it is his duty to inform to the buyer, sir, this is an umbrella, but it does not stop rain. It is your duty to tell. If you go and check the website, people, it tells. Yes? Gucci's China website states that the umbrella is not waterproof and is meant for sun protection. Or why did they tell? Now come back to our example. Implied based on usage of trade. If you are using it, if you are telling it for, if your product is not for that purpose, it is your duty to inform. If you do not inform, this condition will get triggered. Implied warranty. Hello? Clear? The last one, sir, disclose dangerous nature of goods. Whenever you are selling cigarettes, please tell that it causes cancer. When you are buying medicine, it clearly says, please keep it out of the reach of children. When you buy deodorants, it clearly says, highly inflammable. So whenever there is dangerous nature of goods, it is your duty to intimate to the buyer, these goods are it causes harm or they are dangerous in nature. It is your duty to intimate. They have the signs, no? On all the things, correct? The last one, sir, KVA tempter. What is KVA tempter? Remember, whenever the buyer, I said all of this, but remember, it is the duty of the buyer. When you are buying a product, it is your duty to sell. When you are seeing something, it is your duty to see properly and then buy. Check properly and buy. Don't just come to court and cry. Correct? Some things you can only fix it. Why depend on everything on the government? Correct? That is what they're telling you. So KVA tempter means people, if there is a scope for you to know there is a mistake, please first you check. Let the buyer be aware. We will try to protect the interest of the seller. We will protect the seller here. However, KVA tempter also has certain exceptions. That means what? I'm telling buyer, check and buy. Sir, but what if the mistake in this is hidden? So I will check like this. Anything is there, I'll check like this. But what if the mistake is within, inside? Loose connection or microphone inside is broken. How will you check? So remember, KVA tempter also has exceptions. What is that, sir? The first one, fitness as to quality or usage, whatever we saw. Correct? Next one, goods purchased under brand or patent name. Remember, we will not protect the buyer. Whom will we protect? We will protect the... Whom will we protect? We will not protect the buyer. We will protect the... Remember people, very, very wrong. Our book has given this under exceptions to KVA tempter. But in the description they have said, buyer only will be held responsible when you are buying it under patent or a brand name. We have already seen also. It is a wrong grouping or a wrong classification of topic. In our ICAI book also it is given like this only. So when they are asking in the exam, write it. And in the description, write it. That the buyer only is responsible. The seller will not be responsible. If you read it, that is how it is written in the description. Hello? Heading they have put it off. But in the explanation, they have written this only. Getting it? Hello? Okay. Sold by description. When you say Assam tea, what should I go and check it in Assam and come back? So if you are saying with the description, Macha, KVA tempter, exception. We will protect the buyer only. Merchantable quality, when I am purchasing something on Amazon, it is my duty to get a good product. Any defects, buyer will be protected. Sale by sample, description, we already saw. Last one is trade usage, umbrella case. Seller actively conceals a defect, any fraud. Now outside I can make it out. Inside if I cannot make it out. In such case what happens people? KVA tempter, exceptions. That means what? We protect the buyer only. Hello? Clear? So in these cases, what are we telling? We will protect the buyer itself. Only exception is the second one. We will protect the seller only. Hello? Done now? Hello? People? Okay. Transfer of ownership and delivery of goods. People, the entire unit only will start with one simple logic. That is only people. General rule. What is that? Risk always passes with ownership. So as I told you, delivery is irrelevant. Who has the goods is irrelevant. Whoever is the owner will bear the risk. Remember that. Okay. Sir, now when does the property passes? In Sale of Goods Act, property means people, ownership. When does the ownership pass in a Sale of Goods Act, sir? They are telling you, it depends upon the type of goods. If it is a specific or ascertained goods, the ownership passes depending upon in which stage the goods are. Let us imagine if the goods are in deliverable state. Deliverable state means people, sir, the product is ready. Everything is ready. We have packed, we have kept it, it is just to be taken. If the goods are in deliverable state, the ownership transfers people the moment the contract is made. That means what? Offer is made, acceptance is made, the ownership will transfer. Whether you have delivered the product is irrelevant. The moment offer plus acceptance is there, the ownership will transfer. Next one, sir. If the goods are to be put into deliverable state, that means what? So the product is not completely ready. There is something yet to be done. Then when will the ownership transfer? The ownership will transfer only when the product is complete. Until that, the ownership will not pass. For example, people, you go to a shopping complex, you like a really good belt. So the belt will be in that, in that turning thing. So you will take whichever suits you. You will take the belt. You have chosen the belt you want. Hello? Yes, sir. Now the question is the goods in deliverable state or not? You will try to wear it, people. Probably you would need one more buckle or one more hole is to be made to that particular belt. Hello? Now what will you say? You will go and ask the sales guy, sir, can you please put this buckle, can you please put this hole and give it to me? That means what? The goods are still not in deliverable state. It does not fit you. The ownership will not pass until that hole is made. Hello? Are you understanding? You go and buy some goods from the branded store. There should be some alterations made. You will buy it, but the alteration will not be made yet. They will tell you to please come and collect the whatever shirt or pant tomorrow, because some alteration is yet to be made. The ownership does not transfer until the goods are put in deliverable state. That means what? It has to be stitched. Until that time, the goods are not passed. The ownership is not passed. Before that anything happens to the product, the risk will be on whom? The risk will be on the seller only. Once the goods are put into deliverable state, I inform the buyer, sir, your product is ready. The ownership transfers then. Hello? Hello? Third one, sir, goods are in deliverable state. The seller has to do something yet to ascertain the price. What do I mean by that, people? Sir, the goods are ready. Everything is ready, but the seller is yet to do something to ascertain the price. That means, people, I want to buy some rice. What do? I go to a shopping mall. I take a brown bag. There will be this big containers. I take one container. I take one rice. I approximately fill some 1 jug or 2 jugs of rice. Now, people, the question is, rice is there. I have taken how much ever I want. But the question is, do I know how much of rice is there? Do I know how much exactly I need to pay? It can be 1 kg, it can be 1.5 kg, it can even be 2.5 kgs also. Hello? Sir, here the ownership does not pass. If you look at it, I've taken the bag, I've put the rice, everything is there. When does the ownership pass? The ownership will not pass until the price is ascertained. That means what? Go, keep it in the weighing scale, he will check. He'll say 2 kgs is there, he'll take a sticker, he'll fold it, he'll put it and he'll give it back to you. That is when the ownership is passed. Now anything happens to this brown bag, the risk is on the buyer. Before that price is ascertained, anything happens to this, the risk is on the seller. Understanding? Hello? Okay. Next one, sir. If the goods are unascertained or future goods, when does the ownership pass? First thing, people, when will the goods be passed? Unascertained goods first has to be ascertained. If the goods are in the bulk, people, remember the ownership does not pass. When does the ownership pass? Whatever belongs to me in that bulk, it has to be first separated. Once it is separated, now my next question is, who selected it? Who separated it? Did the seller separate or the buyer separate? Sir, whoever separates, what is your problem? My problem is, you should separate it with the approval of the other party. That means, if seller has separated the goods, you need to separate with the approval of the buyer. If buyer has separated the goods or selected the goods, the buyer has to select it with the approval of the seller. Hello? That is only called as what, people? Appropriation. The goods has to be unconditionally appropriated, unconditionally separated by the buyer with the consent of the seller, by the seller with the consent of the buyer. Hello? Okay. Next one, sir. Remember, delivery to the carrier. If you give the goods to the carrier, courier, it is like giving the goods to the buyer only. Hello? Then, okay. Next one, sir. Sale or return basis. In sale or return basis, people, when does the ownership pass? In sale or return basis, the ownership passes, people, on happening of any of the 3 things. First one, the buyer specifically signifies his approval. Second one, people, the buyer does something equivalent to an acceptance. The third one, people, the buyer keeps the goods beyond the returnable period. That means what, people? All your Flipkart, Amazon, Myntra sale and all, you have 10 days to return the product. You keep the goods for 13th day, 14th day. That means what? You have given your approval. Now you can't return, no. Hello? Yes, sir. what do you mean by a buyer does something equivalent to an acceptance? I buy from Amazon, I gift it to my friend. I will gift only that product which belongs to me, no? That means I am telling yes to the Amazon. Hello? Understanding? Yes, sir. Okay. Next, last one, sir. Reservation of right of disposal. What do I mean by reservation of right of disposal? That means nothing but people, remember, in a contract of sale, generally when a person is selling the goods, I can instruct the sales guy that, remember, don't give the goods until they pay for it. Reservation of right of disposal means people, I am reserving the ownership. I have still not yet given you the ownership. The ownership will not be given to you until whatever is a condition I have imposed, until that condition is fulfilled, I will not give you the ownership. The condition can be payment of price, cash on delivery. Until you pay, I will not give you the goods. The second thing can be, imagine you have selected exchange, you have purchased the new phone, you have selected your exchange of old phone. Until you give your old phone, I will not be able to give you the new phone. That is the reservation of right of disposal. Until the condition is met, people, the ownership will not be passed. Clear? Exam point of view, this passing of property, whole topic is very important. Remember and go. Next one, sir, risk transfers with ownership. That is, whoever is the owner will always bear the risk. However, this has two exceptions. What is that? I might not be the owner, but if the goods are with me, my duty as a bailee will always be there. If the goods of someone else is with me, it is my duty to take reasonable care of the goods. If I do not take reasonable care of the goods, I am liable as a bailee. It is my duty. Clear? The second one is, people, if at all anyone does any delay in collecting the goods, that means Amazon has come to deliver the goods today. You did not collect it. So Amazon took back the goods to the warehouse. When the goods was in warehouse, people, there was a short circuit, everything caught fire. So this goods also was burnt in that fire. The question is, who will bear the loss? Amazon or you? Who will bear the loss? Buyer, because they attempted the delivery. You did not accept it. Any delay in collection, people, it was because of the buyer's mistake or seller's mistake. Whoever did the mistake will be liable for any loss caused. Hello, these two exceptions, remember and go. Again, exam point of view, very important. Hello. Okay. Next one, sir. Who can transfer the title? Title means, people, ownership. Who can transfer the title? Generally, whoever is the owner, they can only transfer the title. However, this rule has an exception. The exception is only called as, people, nemo dat quad non habet. Nemo dat quad non habet. What do I mean by nemo dat quad non habet means, people? It means no one can give what they do not have. If I do not have the ownership, I cannot give you the ownership. However, this rule has some exceptions. Even though I am not a owner, I can still give you ownership. What are the exceptions, people? Exception number one, mercantile agent. Don't you think so? Agent is not the owner. No, principal is the owner. But agent, if he is selling the goods, that sale is still valid. Next one, sir, one of the joint owners. So whenever a product has 2-3 owners, if one owner is selling the goods, it is still fine, provided it should be in his possession with the approval of other joint owners. If such a owner is selling you the goods, it will be considered as a valid sale. The third one is sale by person in possession under voidable contract. What do I mean by this? A threatened B. A threatened B to sell his bike. So A took B's bike and he further sold it to C. The question is this sale valid? A threatened B and he took the bike and A sold the bike to C. The question is, did C get a good title? Did he get it or not? Is C aware of it or not? Let us imagine C is not aware of it. Then he will get a good title. Remember people, there is a logic why. Yes, C will get a good title because the papers, how will I know the backstory people? That I threatened you and all of that, how will it reflect on the bike or on the papers? Correct, huh? Hello? So remember, if B does not go to court within time, if B does not cancel the contract within time, and if A further sells it to C, this sale will be considered as valid. Hello? Huh?
Is in my case, it's like a bought from the shore shop.
Which one? Chor Bazaar, huh? Non-owner, huh? Theft.
That time they said the buyer has to return the goods. He mentioned that.
Correct.
Here, it's opposite.
Here, the reason is, on the papers, I am the owner only, no? Now, for example, I forced you to sign this bike transfer document in my name. I forced you. And you signed me the paper and you gave it to me. Now, if I show this paper to the world, I am the owner, no? Legally, legitimately, I am the owner. Until B comes and tells his story. Hey, that signature was taken by force. Until he tells that I am the owner, no? Even in document, I am the owner. But in Chor Bazaar case, I am not the owner at all. Here I am the owner. If you do not go to the court, if you go to the court, then they will ask me to give back the goods. That's why they say anyone who purchases the good under a voidable contract, it will be still considered as a valid sale. Understood? Yes, ma'am. Okay, remember exam point of view important. Next one, sale by person obtaining possession before passing of the property. Sale or return basis is the best example. What do I mean by that? People, I purchase something on Amazon. I have 10 days to return it. Hello. I hope you guys know it, right? There is something called as India Mart. Heard of it? Yeah, 4-5 years back, it used to be a very good platform to sell. Why? India Mart sells you the goods at a wholesale price. That means, let us imagine, now if this mic costs me on Amazon, say for example 3,000 rupees. On India Mart, it will cost me 1,800 rupees. That will be the difference. Amazon 3,000, India Mart 1,800. Why? India Mart is a wholesale. So what will people do? You need to buy in bulk. You need to buy 100 mics. Hello? And they will give you sale or return basis option. That means what? 7 days time will be there. If you want to keep it or you return it. Now what will I do? I will buy everything from India Mart for 1,800. I will further come and I will sell it on Amazon for 2,800. Others are selling for 3,000. I will keep 1,000 rupees margin and I will sell it on Amazon. Will people do it? Or a lot of people will do it. That is also one of the way people sell it. Zero brain. You will easily make 3 to 5% of profit. Hello? Now, if you look at it, people, India Mart has given me sale or return basis. I have 7 days time, correct? Huh? Until this 7 days, who is the owner? India Mart is the owner for this entire 7 days. Sale or return basis, no. Now, on the second day only, I sold all the goods on Amazon. Now, the question is this a valid sale or not? Because for that 7 days, the ownership is with India Mart. That is what they are trying to tell you here. See, what does it say? Sale by a person who got the possession before he got the title. I'll get the title only after the 7th day. Sale or return basis. I'll get the title only after the 7th day. But I sold the goods on 2nd day here. The law is still telling it is valid. Understood? Hello? Yes or no? Sale by person who has already sold the goods but continues in possession. What is this, people? Imagine, people, I want to sell this mic. Hello? I will tell it to you. People, anyone wants to buy this mic. Now someone comes and says, Say Satish comes and says, sir, I want to buy this mic. At what price? Satish says, sir, I'll buy it for 2000 rupees. Hello? I'll tell Satish, okay, I'm fine with 2000 rupees. But I have marathon till tomorrow, no? After the entire marathon is done, then you take this mic. Satish said, okay. Now, people, tomorrow morning, people, I met one more student from another class. Same there also. I made one offer. People, anyone wants to buy this mic. In that class, people, there was one more person. Let us imagine someone called as Nikhil. He said, sir, yes, I want to buy. I'll give you 3000 rupees. I felt, hey, he is giving me 3000. I said, directly, right away, Nikhil, take it, give me money. The question is, did Nikhil get a good title? Same person promised to give the same mic to two people. The question is, who will get the ownership? Is it Satish or is it Nikhil? The law says, sale by a person who has already sold the goods to Satish, but I still have the goods with me only. If I further sell it to Nikhil, Nikhil gets a good title. Why? My goods. Still the papers are with me. When I give it to Nikhil, Nikhil will not know that there was a contract between me and Satish. So who will get the title here? Nikhil will get the title. Sir, then Papa, what about Satish? You have given him a promise, no? Breach of contract. I will be liable for compensation. Understood? Exam point of view, they can ask you who should get the title, Satish or Nikhil? Nikhil should get the title. What will Satish get? Satish will get compensation. Estoppel, people. Yesterday we saw Narayan Murthy's scenario. In front of him I sold. Am I the owner? No. But still I sold it. Estoppel, he should have stopped me. He did not stop. Unpaid seller, next unit we'll see. Other acts. So under other acts, people, a sale can be made by a non-owner. It will still be considered as valid. Best example, Indian Contract Act, people, perishable goods, which is sold by a finder of lost goods. Under Indian Contract Act, it is valid. Under Companies Act, people, whenever a company becomes insolvent, winding up, a liquidator will come and sell all the goods. Whose goods? Company's goods. Liquidator is selling. It is valid. Sir, in Indian Contract Act, if at all you have pledged your gold and if you have taken loan and if you do not repay the loan, you can sell the gold. Sir, sell gold. Can I sell someone else's gold? Yes, valid. Why? It is given, the Indian Contract Act has given you a right. Pledgee can sell the gold and recover the money. It is valid. So, in various other laws, a right has been given to a non-owner to sell. It is considered as valid. Hello? Very less asked question. Somewhere I always feel this is very important from exam point of view. Remember and go. Clear? Hello? Next one, people. Rules regarding delivery of goods. Buyer to apply for delivery. Remember, people, until the buyer asks for delivering the goods, the seller will not deliver the goods. Place of delivery. Where will we deliver the goods, people? Wherever we have agreed as per the contract, the seller will always deliver the goods in such place. What if we have not agreed anything? Then where should the seller deliver the goods? The seller will deliver the goods in such place where? Wherever the goods were manufactured, wherever the goods were produced, or wherever the goods are at the time of contract of sale, the goods will be delivered in the same place. Example, if a farmer enters into a contract with a, say, pickle company that I will sell you some 100 tons of mangoes, where should I deliver this 100 tons of mangoes? If nothing is agreed, people, where is the goods produced? It is produced in the farm. The goods will be delivered in the farm only. Next one, people, time of delivery. Always it is your duty to deliver as per the contract within, if it is not as per the contract, nothing is given, then you need to deliver it within reasonable time. Sir, time for tender of delivery. Can a buyer make a request for delivery? Yes. Is the seller liable to take up the buyer's request? Yes, provided he is making a reasonable request. If he is asking you today to deliver the product tomorrow, day after? Okay, it is valid. What if he calls you in the morning and asks you to deliver the product by afternoon? Such case, seller is not liable to deliver. Next one, sir, effect of part delivery. If part of the delivery is done, meaning I have ordered for 100 kgs of raw material, 50 kgs is delivered. Remember, the rest of the 50 kgs, when we are doing stoppage in transit, I'll explain this, part delivery. Yeah. Next one, sir, goods in possession of third party. Is it delivered? When the goods are in the possession of third party, how is the delivery complete? By people knuckle car case. Until the acknowledgement is made, the goods are not delivered. Installment deliveries, people, by default, installment deliveries are not valid. You're supposed to deliver the product as a whole. You're not supposed to deliver the product in installments. Next one, delivery to carrier is like giving it to the buyer. Deterioration during transit, people, remember, generally if there is the product deteriorates during the transit, the risk will always be on the carrier. However, some goods are having inherent risk. What do I mean by inherent risk, people? By default, the goods will be at risk. If you are ordering such goods, people, if anything happens to such goods, the risk will always be on the buyer. If you order such goods, the risk will always be on the buyer. If I have to give you an example, people, example is, let us imagine if you are ordering ice cream from Zomato. If you are ordering ice cream from Zomato, you tell me, people, you can order dosa also, you can order ice cream also. When you are ordering ice cream, people, you should know that the ice cream will melt. Yes or no? Yes or no? Now, people, do you need Einstein's brain to tell you ice cream will melt during the delivery and you still ordered? Yes or no? Now, people, by the time you receive the ice cream, if at all the ice cream has melted, you cannot hold Zomato liable because the product's nature has risk. When you buy such products, you are buying it at your own risk. I'll give you one more example also. Let us imagine India is a good supplier of iron. So there is someone from Middle East who is buying iron from us. We export some 2 tons of irons through ship route. It takes 60 days to reach. When we sold the iron, people, it was very good, nice, in a good shape. When it reached Middle East, people, when they opened the carriage, people, the iron is completely rusted. Who is liable? The seller or the buyer? Who is liable? Buyer. That is the meaning of inherent risk. When a buyer is buying a product which has risk, or you are from a very far place, you have to understand, people, the product will be deteriorated. And if you still buy it, you are always buying it at your risk. Remember that. Understood both the examples? Huh?
But the seller's responsibility is to take good care of the while delivery.
Correct, correct.
By placing a sheet over the product.
Correct.
In the ice cream example also, the Zomatos or some doing it, their responsibility is to deliver the product in good condition. Right?
Correct.
And how that takes our problem.
So see, I'll tell you how. Whatever is possible, the Zomato guy already does. For example, if I have to tell you, if you guys order from Blinkit, Instamart, they come up with something called as one ice gel will be there. They bring along with that. Now, you should also know when you are driving, ice cream will not always sit on that gel pack. It will keep moving. So, it is not 100% frozen. 5-10% melt will happen. It's the inherent risk. Now, what did the seller try to do here? He tried his effort. He tried to put the gel pack. Now, if you look at it, it comes in a special insulated box, a thermocol box. That is also I tried. Now, you can't expect me to carry a fridge.
So, but ice cream is only small one, right? But if you are buying a bulk one, the amount will be.
No, now you are taking ice cream from the Zomato's point of view. Now, don't you think in reality, there are tons of ice creams which are shipped Shipped from one place to another also? Possible? Now imagine a shop has to get a delivery of ice cream. I try to deliver it in a best product, best shape. But even after that, if at all the ice cream is melting, the responsibility will not be on me. When the buyer buys it, the risk the buyer has to take a little. Now I'll take the iron example and tell you. See, iron's inherent risk, what is that? It will rust. And that too, it is coming through a sea route. A salt is there. That is how the entire sea route is. There will be salt in the air. For 60 days it is exposed. I can reduce the rusting. How? I can paint it. I can put some sheets on it. But still, if something happens, the seller will not be responsible. Now, you can tell, sir, then no one will buy. Correct? Now, the buyer will say, remember, if at all any rust is there, I will not accept the product. You write it in your contract that if rust is there, I will not buy the product. You write it. Remember, always, Indian Contract Act, Sale of Goods Act, Indian Partnership Act, if at all you have agreed something in your contracts will prevail. If your contract is silent, is when Sale of Goods Act, Indian Contract Act, Indian Partnership Act will apply. So if you guys have not discussed anything, that time this law will apply. If you guys have agreed something, this law will not apply. Understood? Yes? Clear? You get the refund, yes. That's what I just told you. Blinkit offers you as a policy of customer retention. If you not, you will start using Instamart. There is a private agreement that, sir, if anything happens, you please let us know. We will give it to you. Correct? I'll tell you one more example also. You order cake on Zomato or Swiggy. I know that the person is getting it on a bike. The cake will shake. The cake will jump. The cake will break. Once you get the cake, let us imagine you open and see if it is broken or if it is, say the cream is touched to the top or if it is any way it is shaken. You click a picture, you upload it on Zomato or Swiggy, you will get a complete refund. Why?
I also faced this situation, but they didn't give me not at all. Within 5 minutes, you
Why I am saying this confidently is I got it on Swiggy. See, logically they can tell that, sir, anyways you cut and eat. Instead you got it cut only. What is there eat? They can say. But unfortunately, cake you guys order it because of an emotion. Cake cut. Now, before I take it, if it is gone, now they have a responsibility. They are doing it out of what? A goodwill to retain you. I don't know if you guys know it or not. The whatever is the solution given by the customer care to the customer varies from customer to customer. Let us imagine you have ordered some 1,000 times in a year on my platform, and once you have raised the refund request, trust me, in seconds it will go through because they have your profile, they know about you. Zero validations will be done. What if this person is doing a refund every week? Scenarios are there. Both will be checked. Now don't you think all of us casually will order one cake? We'll break. At least 2 years back we had to physically break it. Today upload it on ChatGPT, tell it that please break me the cake and upload, give me an image. It will give you. Realistic image it will give you and upload it. Sir, is it a risk for Zomato or Swiggy? I'll tell you, it is a risk. You know who said? Deepinder Goyal himself has said. Now people are uploading. Who is Deepinder Goyal? Your Zomato ka founder. He has said it in one podcast. That people nowadays are even using AI to take such images and uploading it. How can we even make it out? Today you know how AI images are. Who can make it out? People are cheating. That is happening. Yes? Huh? Wait, you did it, huh? They all saw you when I said this story. Seriously. Yes, huh? That's the thing, remember. Buyer's right to examine the goods. Remember, when you are at a distance place, when you have not checked the goods when it was packed, you have a right to check them when you receive it. You have a right to examine the goods. That's all, huh? That's your unit 3. Questions we'll do. Yes, people. Let us do Sale of Goods Act, Unit 1. The textbook questions. Yes. A contract for the sale of goods where property would pass to the buyer on payment of total price would be sale, agreement to sell, hire purchase, sale on approval. A contract of sale of goods where property would pass to the buyer on payment of total price would be sale, agreement to sell, hire purchase, or sale on approval. Which one, da? Huh? This can be, people, sale Allah, it can be agreement to sell. If you ask me, people, this can also be hire purchase also. The ownership passes only on payment of total price.
Like this paid in installments, so it not fair. They having anything specific.
Correct. That's what I'm saying you. Answer is agreement to sell. See, in MCQ, that's why I'm saying we do not have MCQ in our syllabus. But I'm telling you, if it is coming in descriptive, I can also say, no, what type of a contract where the ownership transfers only after repaying the total price. In short, if I have to tell you, it can be hire purchase also. But how do we say hire purchase is? The ownership transfers only after payment of the last installment. That is how we define it. But the meaning can be that also. But yes, agreement to sell. Next one, people. The term goods under Sale of Goods Act does not include goodwill, actionable claims. A contract for sale of future goods is sale. The Sale of Goods Act 1930 deals with under Sale of Goods Act, the term goods means every kind of movable property and it includes stock and shares, growing crops and grass. The Sale of Goods Act deals with sale, mortgage, pledge, all of the above. Which of the following is true? The provision of Sale of Goods Act were originally with Indian Contract Act. Sale of Goods Act 1930 deals with mortgage. Sale of Goods Act restricts the parties to modify the provision of law. None of the above. Which one? I hope you guys know. Yes? Remember, Indian Contract Act, Sale of Goods Act, Indian Partnership Act, they were all part of Indian Contract Act only. In 1930, some sections were deleted from Indian Contract Act and that was only made as a new act called as Sale of Goods Act. In 32, again certain more things were deleted and that is what was formed as Partnership Act. So they all belong to Indian Contract Act only. Okay, next one, people. Goods which are in existence at time of contract of sale is known as? Which of the following is not a form of delivery? Constructive, structured, actual, symbolic. Which one of the following is or are document of title to goods? Railway receipt, wharfing certificate. Which of the following is not true? Document showing title is different from document of title. Bill of lading is a document of title to goods. Specific goods can be identified and agreed upon at the time of contract of sale. None of the above. Which of the following is not true? This is true for sure. Bill of lading is document of title. Specific goods can be identified and agreed at the time of contract of sale. This is also true. So none of the above. Mercantile agent is having an authority to sell or consign goods, raise money, sell or buy goods, any of the above. Contract of sale is executory, executed, both of the above, none of the above. Huh? Contract of sale, executed, executory is agreement to sell, future. In which form of the contract the property in the goods passes to the buyer immediately? In case of hire purchase, the hirer can pass title to a bona fide purchaser. Is it possible? In a contract of sale, the agreement may be express or implied from the conduct of the parties. Is it true? False? Oh, it is only true and false. In a contract of sale, the agreement may be express or implied from the conduct of the parties. True or false? In a contract of sale, subject matter of contract must always be money. Partly also possible, but money should always be there. If not, it becomes barter. Correct? Hello? In a contract of sale, subject matter of contract must always be complete. You can't say completely also because partly is there. No. Hello? They are telling you here must always be money. Partly they have not covered only. So if you ask me, it's false only. 17th one, na? Okay. Next one is, if a seller handed over the keys of a warehouse containing the goods to the buyer, results in symbolic delivery. Next one is, if A agrees to deliver 100 kg of sugar to B in exchange of 50 meters of cloth, then it is barter. See, complete should not be there. Some part of money should be there. In a hire purchase agreement, the hirer has an option to buy the goods, must buy the goods, must return the goods, is not given the possession of the goods. What is the answer? Has an option to buy the goods. Because why, people? Until the last installment is paid, I can cancel the installment at any given point of time. I have that option, right? What if I don't pay any installment? The goods will be taken back by the owner. A agrees to deliver his old car valued at 1,80,000 to B, a car dealer, in exchange for a new car, and agrees to pay the difference in cash. It is legally a contract of sale includes sale, agreement to sale. The sale of goods 1930 came into force on 1st July. The person who buys or agrees to buy goods is known as we have only buyer and seller. Next one. Voluntary transfer of possession by one person to another is popularly known as, if X commissioned Y, an artist, to paint a portrait of A for $200 and Y uses his own canvas and paint, then it is contract of sale, contract of work and materials, contract of sale on approval, hire purchase agreement. What is this called? Contract of. Technically, it does not completely come under Sale of Goods Act. Indian Contract Act is also there. This is considered as contract of work and materials. Logic is nothing but this part is not there in our syllabus. That means what I am telling you, I will give you the goods, but I will use my own materials. Such things are called as contract of works and materials. Not that important from exam, don't worry. The property in the goods means the possession of the goods, custody, ownership of the goods. In Sale of Goods Act alone, property means ownership. The goods are at the risk of a party who has the In case of sale of standing trees, the property passes to the buyer when trees are felled and ascertained, not felled but earmarked, counted and ascertained, both B and C. What is it? Felled and ascertained, not felled and but earmarked, counted and ascertained, both B and C. Huh?
One is
Yes, what is the answer? Remember, directly not related to us. Again, it is a tweak of words. If you go with the words, the answer can be, what does the law say? Agreed to be severed. That means direct answer will be C. Agreed to be cut. That means whenever you have separated, that is when the ownership passes. But remember, not filled but earmarked. Earmarked means also, people, you have selected. You have said, okay, this, I would want to cut. In reality, this is also considered as selected only. Yeah, but if you go with MCQ answers, word to word, C will be the answer. But in reality, B can also be the answer. That's the difference between descriptive and MCQ. Hello? What does your book say? Felled and ascertained. Nonsense. Yeah, but yes, even this can also be, because what happens, people? The moment you say ascertained is there, no? Ascertained is nothing but, if at all I'm counting, if I'm agreeing, it becomes a movable goods. From that time, it will be governed by Sale of Goods Act. Yes, sir. Don't worry, such questions will not come, because in when you are getting it in descriptive, people, you are always allowed to write an assumption. In MCQ, that's the problem. Yes, sir. That's okay. According to me, it will be both B and C, but yes. In case the delivery of goods is delayed, but due to the fault of the party, the goods shall be at the risk of defaulting party, even though the ownership is with the other party. What is the answer? True. If there is a provision to this effect, false, as it is against the general rule. What do you mean by this, people? In case the delivery of goods is delayed due to the fault of the party, the goods shall be at the risk of the defaulting party, even though the ownership is with the other party. True. We generally saw, no, risk prima facie transfers with ownership. Exception was Bailey and delay. Which one of the following modes of delivery of goods is considered effective for a valid contract of sale? All of these. Actual, symbolic, constructive. Correct? Huh? Okay. A agrees to buy a new TV from a shopkeeper for 30,000 payable partly in cash and partly in exchange. Is it a valid contract? Yes. Some part of it should be cash. Some part can be in exchange. That's okay. A agrees to sell. Give reasons. As I be told, some part of it should be in cash. Some part of it can be exchanged. Full should not be exchanged because it becomes a barter. A agrees to sell B 100 bags of sugar arriving on a ship from Australia to India within next 2 months. Unknown to the parties, the ship has already sunk. Does B have any right against A under the Sale of Goods Act? Yes. Remember, people, the goods are destroyed. Impossibility of performance. The contract will be void. Does B has any right? Yes. I can cancel the contract. If I have paid any advance, I can ask for a refund. Same provision is there in Sale of Goods Act also. You guys only ask, no, perishable goods. I mean, goods are perished. So when the goods are destroyed, the same provision is there in Sale of Goods Act as well. If you look at it, this provision is based on the ground of supervening impossibility. Which section says? Section 8. Same thing is there. Yes, sir. Okay. X contracted to sell his car to Y They did not discuss the price of the car at all. X later refused to sell his car to Y on the ground that the agreement was void, being uncertain about the price. Can Y demand the car under the Sale of Goods Act?
Yes.
Yes. Remember people, if the price is not discussed, you cannot cancel the contract. You need to pay reasonable price. Classify the following transactions according to the types of the goods. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. Until it is 100, it is unascertained goods. 50 are selected and kept aside, it becomes ascertained goods. A agrees to sell to B 1 packet of sugar out of the lot of 100 packets lying in his shop. Unascertained goods, because I have still agreed, I have not yet separated. It is unascertain. T agrees to sell to S all the apples which will be produced in his garden this year, which will be produced. So it is future goods. We'll go up for a break and come. Okay. Yes, people. Unpaid seller. Okay, what do I mean by unpaid seller, people? Who is an unpaid seller? Whenever the seller has not received the whole of the price, very important. If the value of the product is, people, let us imagine if the value of the product is say 1 lakh rupees, and if the buyer has paid 99,999 rupees, 1 rupee is not paid, I will still be considered as a unpaid seller. Yes. So whenever there is a whole of consideration which is not paid by the buyer to the seller, I will be called as a unpaid seller. Now what if I am an unpaid seller? As an unpaid seller, I will have 2 rights. The first right is against the goods. The second right is against the person. On goods, what is the right I have? On person, what is the right I have? On goods, I can keep the goods with me until the money is paid, or if the goods are traveling, I can get them back and I can get back the goods and I can resell the goods and I can get my money. That is one. Second one is, it may so happen that I have given up the goods but the money is not paid. Okay, you can imagine like this, people. 2 scenarios can come into picture. With regards to goods, let us imagine ownership is transferred. Ownership is transferred. However, the possession is not transferred yet. Possession is not transferred. The second scenario is, people, ownership is transferred. Ownership is transferred and possession is also transferred. In this case, what do? Ownership is given, but the goods are still with me. I have a right against the goods. I have a right against the goods. Sir, ownership is also gone. Goods are also gone. I have given it off. Now what can I do? If goods are also given, ownership is also given. Now people, I have a right against the buyer. What are the rights I will have? I can file a case on the buyer for the value of the goods. I can claim the money. I can claim compensation. I can pay interest on the advances if any paid, as the case may be. So these are the 2 rights you will be seeing under unpaid seller. What? One is the right against goods. What are the rights I have against the goods? I will have 3 rights. What is that? One is called as right of lien. What do I mean by lien, people? The goods are with me. You said, sir, please keep it. I'll come and take it by end of the day. You please reserve it and you go. Yeah? Now I say, sir, please reserve it. I'll come and take it. Now, sir, until you come and give me the money, people, I will not give you the goods. Such type of right is called as what, people? right to lien. What is right to lien? Right to lien is nothing but right of retaining the goods until the price is paid. Hello? Second scenario, sir, the buyer stays somewhere, the seller stays somewhere. You have ordered the goods on Instagram. Now the goods has to come through a courier. Now in this case, what will happen? The goods is on the courier. It is in the transit. The law says if the money is not paid, you can ask the courier guy to bring it back the goods and give it back to you. That right is called as what people? Right to stoppage in transit. When the goods have left your possession, it is going and about to reach the buyer, you have a right to call that goods back and you have a right to keep it with you. That's why we call it as right to regain the possession and retain it until the price is paid. The third one, sir, in both the cases, we got the goods back. What do I do with the goods? You have a right to resale. I can again sell it. Hello? So these are the three rights that you have against the goods. Any doubts here? No. The next one is people right against the buyer. Right against the buyer, we will see. So this is in general overview of this particular unit. Simple, yes. Okay, let us see now one by one. What does it say? Rights of unpaid seller, right of unpaid seller, right against buyer, right against goods. Okay, let us start with right of lien. What does the law say? When can I exercise right to lien, people? It is a right to retain the possession. Words are very important. Retain. It is a refusal to deliver until the price is paid. Until you give me the money, people, I will not deliver you the goods. That's as simple as that. Sir, right of lien, when can we exercise? Very, very important from exam point of view. When can I exercise right of lien? I can exercise right of lien in three scenarios. The first scenario is what, people? When goods are not sold on credit. I told you have to come and give it to me, only then I'll give you the goods. In such case, if you don't come and give me the money, I will not give you the goods. As simple as that. Second one, people, if the goods are sold on credit, but the credit period is expired, I gave you 10 days time. In 10 days time, if you don't come and give, I will give it to someone else. In 10 days also, if you do not come and give, people, I can exercise right to lien. The third one is, people, when the buyer becomes insolvent. I have given you 10 days time to pay. But in the 5th day only, people, you became an insolvent. Why will I wait for 10 days? I know on the 5th day you have already become an insolvent. So when a buyer becomes insolvent, you can again exercise something called as right to lien. So right to lien, when does it come to an end? Right to lien comes to an end, people, when if I give away the goods to the buyer or any carrier, if I give the goods to them, the right to lien is gone. Remember, lien means, people, the goods should be with you. If the goods go out of your godown, right to lien comes to an end. Hello? Yes? Whether that is express or that is implied, you give up your right, however it is. If the goods go out of your godown, people, right to lien comes to an end. Whether you give it to the buyer, you give it to the agent, you give it to the carrier, however it is, or you give up your right. In all these cases, right to lien will come to an end. Understood? What is the difference between right to lien and right to sit? What is the difference? Right to lien and right to stoppage in transit. What is the difference? First one is right to sit will start when the right to lien ends. So when the goods go out of your custody, it is on the way. That is when sit starts. So lien ends, sit starts. Second one, right to lien can be exercised, people, when in three scenarios. Goods not sold on credit or sold on credit, the credit period is over, buyer becomes insolvent. Right of stoppage in transit can be exercised only and only when the buyer becomes insolvent. Hello? Clear? All of you? Okay. So, sir, right of stoppage in transit. What exactly means the right of stoppage in transit? Right of stoppage in transit means you have sold the goods as a seller, you have sold it. Now the goods are going in a truck. The goods are going in a truck. Yes, Sam. So it is on the way. It is on the way. By the time people it reaches the buyer, you have every right to tell him to take a U-turn and come back to you. The moment the truck reaches the buyer and they intimate the buyer, so the goods are here. The moment it is intimated, people, right to stoppage and transit comes to an end. So what do you mean by right to sit? Right to sit is nothing but right to regain the possession and retain it with you until the price is paid. Such type of right is called as right of stoppage in transit. So transit means what? On the way. Clear? Sir, when does transit come to an end? The transit will come to an end in all these scenarios. When the buyer or bailee takes the delivery. So if you get the goods, transit has come to an end. Whether it can be at the destination or even before also. That means Amazon said they will deliver. You did not wait. You only went to Amazon's godown and you said, please give me my parcel. Anyways, they are telling you transit will come to an end. Second scenario, carrier or bailee acknowledges to the buyer that he holds the goods for him and seller has not reserved the right of disposal. What do I mean by this, people? The courier or the carrier has told the buyer that, sir, your goods has reached. So if the carrier has informed the buyer, people, you lose your right of stoppage in transit. The third one, goods delivered to the carrier hired by the buyer. What do I mean by that? I am telling you, if the goods are on the way, I can exercise right to stoppage and transit is what I told. However, if the truck itself was sent by the buyer, he is my guy. I have sent him. So even if it is on the road, will he listen to the seller or he will listen to the buyer? He will listen to the buyer. So they are telling you, if at all you have given it to the vehicle, which is sent by the buyer, they are telling you right of stoppage and transit has come to an end. Sir, if it is local, we call it as road. What if it's international transactions? We generally use something called as ship or a vessel. So sir, in the same way, if a ship is sent by the buyer, again sir, we tell it the transit has come to an end. If they both belong to the buyer. That is what is given in a different point. What do they say here? Goods delivered to the ship chartered by the buyer. So if I give it to the truck also gone. If I give it to the ship also gone. Next one, sir. Carrier wrongfully refuses to deliver the goods to the buyer. That means what, people? I have come to your destination, but I deny giving the goods to you. I come to the destination. I deny giving the goods to you. They're telling you, if you wrongfully refuse to deliver the goods to the buyer, they're telling people transit comes to an end. Hello? Are you understanding? Has it ever happened to you? The delivery guy would have never called you also. But you will get a message. Delivery attempted. Happened? That itself is called as what, people? Carrier wrongfully refused to deliver. I am there. I was at home. My phone was with me. It didn't even ring. But I'll get a message at 10 o'clock or 10:30 in the night that attempted delivery. The delivery has been postponed. We get a message. Return back to the seller only. Yeah. Now in such case, why do we get this message? Generally, people, what happens is either the delivery guy will have targets. He has to deliver 18 to 20. He would have done it for the day. That time they will have an option. The customer is not available or the buyer is not available. They will click on that tab. Second way, when they have reached the timeline, 10 o'clock is the last time to deliver. After 10 o'clock, they cannot deliver. Now still they have not delivered to you. Automatically the message will be triggered to you from Amazon or any e-commerce that we attempted and we could not deliver. Automatically the delivery has been rescheduled to the next day. The question is, we were available, people, and still they did not deliver. Remember, it is your mistake. You cannot take back the goods. the right to stoppage in transit comes to an end. Hello? The last one, sir. Part delivery. What is part delivery, people? Simple. Let us imagine, sir, I have ordered 100 kgs of raw materials. 50 kgs is already delivered. How much? 50 kgs is already, I told you, no, we'll be doing part delivery in unit 4. So, sir, 50 kgs is already delivered. Another 50 kgs is on the way. The law is telling people, for this 50 kgs, right to stoppage in transit has come to an end. I cannot exercise sit on this. However, this 50 kgs is people on the way. It is still coming to us. The law is telling you people, you can exercise right to stoppage in transit on this. You can ask the truck driver to take a U-turn. Part delivery, sir. When the part of the goods are delivered, whatever is delivered, right to sit is gone. Whatever is on the way, you can still exercise right to stoppage in transit. Hello. Understood. Okay. Next one, sir. How stoppage in transit is affected? How do I do stoppage in transit? Singham style. You only take one jeep and go. You only go stop in front of the truck. Don't wait for the jeep to stop. Like that only should get down. Or people call him and say, Macha, come back. Both the ways you can do. One is go personally take the actual possession of goods. Or people by giving a notice, call. Hello. 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 Next one, sir. Effect of subsale or pledge. What do you mean by subsale, people? What is subsale? Sir, there is a manufacturer. Manufacturer has sold goods to wholesaler. Wholesaler has sold goods to retailer. Manufacturer has sold goods to wholesaler. Wholesaler people has not paid the price. Wholesaler has sold the goods to retailer. Retailer has paid the price. Now the question is, as a manufacturer, I have given you the ownership, but you have not paid me the money. Not ownership. I have sold you the goods. You have not paid me the money yet. So I become what? I become a unpaid seller. Now what did the wholesaler do? He has agreed with the retailers. I will give you the goods to you. He has further sold it. The retailers have paid money also to the wholesaler. Now the question is whether the retailers will get the goods or not. If you look at it, my manufacturer is an unpaid seller, but the retailer has paid the price. What is the scenario? Will the retailer get the goods or not? What do you think? He will get? He will get or not? Yes or no? Da? Kanna, again I'll ask you yes or no. Again I'll ask you yes or no. Fifth time I'm asking you yes or no. He'll get it or not? Da? He'll get it or not? Da? He will not get the goods. Confidence. Give sir, we are there now, we will take care. People remember, this is called as sale. This is called as sub-sale. Remember, sub-sale will not defeat your right to lean, right to sit. End of the day, I am an unpaid seller. Unpaid seller. Until I get money. Who cares what you did with retailer? None of my concern. My money is not, I have not received. Hello? Nakul? I'll tell you. Story inno irukku. Yes, sir. Now people, part 1 is done. Da. Part 2 irukku Pushpa. Idu da. Party leda Pushpa. Now people, listen here. What is the law saying, people? Law is telling that this is a general scenario. Until then, only this much stories there are. This is called as people sub-sale. Remember, manufacturer can exercise right to lean, right to sit. Manufacturer need not give the goods to the wholesaler nor the retailer. Now what will happen? You both fight. Retailer will file a case on wholesaler. They will breach of contract, compensation. They will deal. Manufacturer will not give the goods. Scenario 1. Understood? Scenario 2. Manufacturer sold the goods to wholesaler. Wholesaler. Now what did wholesaler do? Wholesaler said, hey manufacturer, I don't have money da. I will further sell the goods to retailer. Retailer will give me money. I will take the money. I will give you the money. Are you okay with it? You will give me the goods. I will give the goods to the retailer. Retailer give me the money. I will give the money to you. Understood? Again I'll repeat. Now people, manufacturer said people, okay. Manufacturer said, okay. What? I will sell you. He said, people, you take money, you give money. I said, okay na. I said, okay na. Okay na. Now people, retailer gave money. Whether the wholesaler gives it to the manufacturer or not, manufacturer gave the approval of sub-sale because you agreed, I will give you the money. He will give you. Correct? You agreed, no? That means you know there is a retailer, Nakulji. Now people, because you know that I am going to sub-sale, you have agreed to it. Now retailer has given me money, whether I give money to the manufacturer or not, whether I give it or not, irrelevant. Retailer should get the goods. Why? Because you have agreed for sub-sale. In the first scenario, I did not agree for sub-sale. Second scenario, I have agreed. And hence, I cannot use my right to lien, right to stoppage and transit. Even though I did not get the money, I have to give the goods to the retailer. This should happen. Understood? All of you?
Will the retailer know if the sale happened to be a sub-sale?
He may know, he may not know. But generally, what do we say? You should act in a good faith.
Then in the first case, when the wholesaler has given the goods and retailer also paid the goods, retailer has acted in a good faith only. He doesn't have any problem with it. Then how can the wholesaler ask?
Even if retailer acts in a good faith, manufacturer does not know about this transaction, no? Then who will save me? I am also an unpaid seller, first thing.
In that case, wholesaler need to pay manufacturer, sir. What is in the case of retailer? He has already paid it.
Now,
How can the goods be reinvested by the manufacturer again?
understood. You tell me, what does any sound-minded person will do? Someone has not paid me money. What will a sound-minded person do? Goods are still with me. Will I give it and fight in the court? Or the goods are still in front of me. I'll keep the goods until money is paid. What will a sound-minded person do? That's what manufacturer is doing. You give money and take the goods. Where? Goods are not yet passed. Contracts are passing, that's all. If goods are passed, then what else I can say? Where is it? No. See, I said, I am making a sale. You are making a sale. Remember, I did not tell the goods are transferred. If goods are transferred, everything is gone. You can't exercise anything. I'm just talking about contracts. Yes, sir. You will give me the money. Understood? Hello? Okay. Okay, this is clear? Huh? Tilda, it was not working, no. When I call them also, it will be like that only. When I call them, it will not be working. When they come, it will work. Okay, agatte, happens. People, when document or title has been transferred to buyer and he further transferred to parcel, then if it is sale, lien stock, it will be pledged, you can just request. Understood? What happens, people? People imagine the goods are in a weed. Go down. Home da, always that only. It is in a go down. This go down has one watchman. There is a contract between manufacturer, wholesaler. Macha, I have 1 lakh rupees worth goods in the go down. See, this is the cheaty token. If you give this go down certificate to this security guard, he will give you that entire go down ka goods. Understood? Hello? What is the value? 1 lakh. Now what happened? The wholesaler said, okay, I will buy. Now immediately what do I want? They are telling you, the wholesaler agrees to buy people. The manufacturer gave away the cheaty also. What is the cheaty? The certificate. That is nothing but the entry to the go down. I gave it up. Are you paid the money? Did the manufacturer receive the money? Answer is no. Arre. I am an unpaid seller. But people, I gave away the go down certificate. Now, if you have given away the go down certificate, let us imagine if the wholesaler sells that again to retailer, he sells it for 1.2 lakh. Let us imagine retailer paid the money. The wholesaler gave away the cheaty again. He got the go down certificate. Now manufacturer, he has not received even 1 rupee. He is still an unpaid seller. Now in this case, what to do? Law says you can't do anything, da macha. Just to think that you have put in God's undi and you just leave. Law can't protect you. Because remember people, this is document of title. If you lose that go down certificate, that is like you lost that particular goods itself. So if the document of title is transferred and if further the person transfers it to anyone else, they are telling you people, hello, ma'am, I'm in a meeting, I'll call you later. Okay, yes people, what are we doing? Go down certificate. Once go down certificate is given, people, done. Kel katam, dukan banda. Why? I sold to you, you sold to him. You give away the main document, contract done. Right to subsale comes to an end. Hello? Sir, same example. Manufacturer gave the document of title to wholesaler. Manufacturer gave the document of title to wholesaler. Wholesaler wanted money. What did the wholesaler do? Wholesaler went to a creditor. How much money he wanted? I wanted 10 lakh rupees loan. So what did the wholesaler do? He went and gave people this document of title, gave some gold, gave his bike, and left kidney. Yeah, he gave everything. Now people, after giving everything, people, this fellow, creditor, gave him 10 lakh rupees loan. Now the question is, sir, this fellow is still an unpaid seller. Can he go back and get the goods? Is it possible? The law says, I have given it to the wholesaler. Wholesaler has given it to the another person. No, that document. Is that a sale or is it a pledge? Sir, sale. Dukan band done, nothing. You can't do anything, it's gone. Sir, it is a pledge. Oh, pledge. Pledge. Then do one thing. Go to the creditor. Go to the creditor. What is this? Creditor's feet. Feet. Yes, Go and request. Law has said, people, legally you don't have any right. Legally, you can't do anything. Maximum you can do is, people, go and do emotional blackmail. Sir, you have so many things, no sir. You have his gold, you have his bike. Sir, left to right kidney also you take, sir. Please give me the dot back, sir. Please, request, humble request, sir, because I don't have anything else like you. You have his gold, you have his kidney, you have all of this, sir. I don't have anything. Even I also need to get money. All that you can do is go and request. If at all the creditor is a good man, he can recover it from all three and he can give away the document of title to you. However, it is not a legally enforceable rule. It is just a request. Hello. Understood? Clear? Clear. அதுக்கு தான் நான் சொல்ல. என்னடா மச்சான். People, right to resale. What is right to resale? We got back every goods. What do we do with the goods? So I got back the goods, people. How long I'll keep it? I will further sell it. Sir, now whoever buys it from me, will they get a good title? Yes. Now I got back the goods, no, Singham. Took a U-turn. Got back the goods, no. After I get back the goods, sir, I will sell it to any other person. Now, will this fellow get a good title or not? He will get a ownership or not? Yes. This is what you saw under exceptions to Nemodat Quad non-Haber. You saw unpaid seller. Sale made by an unpaid seller will give a good title. Remember. Clear? Sir, now the question is, when I am further selling it, the manufacturer decided, no, hey, wholesaler, go down. I will not wait. I will sell it off to some other fellow now. Because you are not coming. It is simply causing me so much of inconvenience. Now, sir, should I inform the wholesaler and sell it, or I can directly sell it? The law is telling people it is always advisable to inform and sell. Why? If you inform and sell, people, let us imagine the value of the goods was 1 lakh. But when you did a resale, you were able to only sell it at 90,000. If you had informed the wholesaler, if you do not pay it by today, I am going to resell it. If you had informed, you had given a notice, whatever is the deficit, people, you can recover from the wholesaler as a damage. If you have not given a notice, people, you will not be able to recover that shortfall. The loss you will not be able to recover from the wholesaler. Is this clear? Sir, always I have to give this notice, Remember, people, if it's perishable goods, I need not have to give any notice. Perishable goods, no notice. Or in the agreement only I have entered, one clause is there. If at all the wholesaler does not pay the money in 7 days, the manufacturer has a right to resell. I have clearly written in our agreement only. If there is a right to resell written in your agreement, people, then notice is not required to be given. Hello? Done. This is our resale. Remember. Hello. Sir, what if that 1 lakh item I sold it at 1,10,000? What to do with the profit? Should I give that to the wholesaler? Remember, profit I can retain, provided you have given the notice. Sir, what if I have not given the notice of resale? If at all any loss, I cannot recover any profit. I have to give it back to the wholesaler if you have not given the notice. Remember, important. Last topic, sir, right against the buyer. So, if ownership is gone, goods are gone, what else I can do? I can file a case for the price. Macha paid and what else I can do? Pay the money. Next ones are damages. What is damages? Legal charges. We will follow same section 73 of Indian Contract Act. General, special, vindictive, nominal, prefixed, yalla apply. Repudiation of contract means I can cancel the contract, people, so that you cannot ask the contract again in the future. Cancel it. Be done and dusted. Wash off your hands. The last one, suit for interest. What do you mean by that, people? People, he had to pay me the money on people 1st of August 2026. But he paid me the money on 1st of January 2027. Don't you think there is a delay of 4 months? Hello? Then after 4 months also, who will accept the same rupees, same money? If you had given me on 1st August, I would have done more business. That's why when you are giving delay, I will take interest also along with the principal. Logical? Hello? Same thing applies to the buyer also. Imagine buyer has paid money, seller did not supply the goods. Now whatever advance I have received, I have to return back. Now I kept it with me for 1 month, 2 months. If I just return back the money, isn't it a loss for him? The law tells people return back the money with interest. So same thing applies to the buyer also, seller also. Hello? Clear? Okay, what does it say? Rights of the buyer, I can claim for damage for non-delivery. I can also claim for specific performance only if it is of special nature. Correct? Antique items as the case may be. The buyer can also claim for breach of warranty, that is compensation. I can cancel the contract if not delivered within time. I can also file a case for interest. Both of them enjoy the same rights. Hello? The last one, sir, auction sale. What is auction sale, people? Bidding. Whenever the goods are sold by a bid to a highest bidder, we call such sale as a auction sale. The goods can be sold individually or even in lots. The completion of sale is by either the auctioneer says the sale is complete, or I will hit the hammer thrice, or I will ring the bell thrice, as the case may be. The sale is complete only after that. Before that there is any damage, people, that will always be on the seller only. After the sale, any damage, people, it will be on the buyer. Right to bid may be reserved. What do you mean by that? The seller can tell people, I will also participate in the bid. You can reserve your right. Sir, when will this happen? This will happen, people. Let us imagine, I told you, right, there is an auction being conducted tomorrow in Jayanagar. Who will conduct auction? Let us imagine the items, everything belongs to a king. He wants to auction his items. He has given this to a company called as Antique Auctioneers Private Limited. That's the name of the company. They have appointed them to sell all the items of this king. All the antique items they have appointed him to sell this particular item. So what will they do? They will appoint an auctioneer. He will conduct the auction. Now imagine, first they will say a clock is for sale. Whoever comes and bids the highest, we will sell that particular goods for them. Hello? Agreed or not? Yes or no? Now people, this Antique Auctions Private Limited thinks some items in this auction are really valuable, very, very good items. They also want to participate in the auction. Can they do? Because they have another business. What? Museum business. Or they have antique business. Hello? So they have auction business also. They also have their own products. Now, they also want to participate in this auction. Can they participate? But they are only selling it. Law says you have to clearly intimate in the auction that we will also be participating in the auction. And then you can send one representative on your behalf to participate in the auction. Then it is valid. If you do not notify these people, then it will not be valid. Hello? Is this clear, all of you? Pakka? Okay. If not notified, if you don't tell and still participate, it will be considered as a fraudulent bid. Reserve price, that's nothing but people, base price. An auction always starts from the base price. The pretended bidding, what do you mean by pretended bidding, people? Pretended bidding means nothing but namesake. I think they were claiming Rishabh Pant last time they did. Simply they took it to 25-26 crores and they stopped. In IPL they do no. We don't want one player, but they will simply increase the bid They'll make 2 crore, 5 crore, 5 crore, 8 crore, 20 crore, they'll stop. Papa, the fellow who purchased 20 crore rupees, he would have spent. Yes or no? No. No, Laka. So such type of things are called as what people? Pretended bidding. Yes, generally what happens is in class, have you ever seen auction notices and all, government auction notice and all? You've seen? We'll see if I get one notice, I'll quickly show you. Oda? Nakul? Canada? Nakul, you got any deal da? People, see here. Government of India, Ministry of Finance, Income Tax Department. There is a person who has not paid tax. So Income Tax Department has listened. Income Tax Department has seized this fellow's properties. So I am showing you only one part. These are all his cars. All his cars. Yes, sir. Now see here. What cars and all are there? See. BMW, Range Rover, Macha, everything one fellows. One person's 1 lakh. One person's everything. People, Jaguar, Ducati, Innova, Crista. Just for your information, the Innova Crista market price people will come to around 38-40 lakhs. 38, top end is 40. Nissan, people, what is reserve price? Base price. That means auction will start from that. I tell you one very good deal. If you want, you can see this 12th one. Porsche. 5 lakh, that's all, cheap. 5 lakh, the car is 1 crore or something. IT department, these are all, you can, Bangalore only. And all these happen through e-auctions generally. Yes, hello. Who is that person, sir, who did not pay tax, sir? You can see from she, Sukash Chandrasekharan. What is the tax amount he needs to pay? Somewhere around 30 na. If I am not wrong, 308 crore, 48 lakhs, 72,000 as 49 rupees. 308 crore, that's all. For that only will take all these cars. Car only taken, who knows what else he has? Is it the actual value of the asset? Is that you are asking? 308. No. I told you, I'm just showing you one part. Only one part I'm showing it to you. How many assets will be seized? Land will be seized. Properties will be seized. I'm just showing you the cars auction. Ase.
These cars are base price are from zero.
Okay, don't hit him. I have told you guys 100 times. Why do you guys hit him? Okay, our friend only. Base price means that's where the auction starts from. Why will we have reserve price? To save time. See, I'll tell you people. Now let us imagine BMW. You know, I know. 100 rupees, 200 rupees is not worth. What if the auction starts from there? So I will only tell, see, this is where auction real game starts. Here, I have one more option where Hayabusa bike is there, Ducati bike is there. I'll show you in CA Inter. Come. There should be some motivation order to come to CA Inter. Hayabusa is motivation. Okay, na? Okay. Any doubts, da? That's all, na? Okay, that's your Sale of Goods Act. Yes, people. Next one, people. All of your favorite chapter, Indian Partnership Act. What is the definition of Indian Partnership, sir? It's a relationship between persons who have agreed to share profits of the business carried on by all or any of them acting for all. Correct, huh? Sir, majorly the partnership has 5 elements in it. What is that? One is association of 2 or more people. Agreement. That means it is always voluntary. Partnership. Next one is there has to be business. Remember, people, if there is no business, people, a partnership cannot be made. That means what? You cannot make a partnership for not for profit organizations. NPOs you call, no. You cannot have partnership form of business for non-profit organizations. That means orphanages, old age homes, charities. You cannot do it in the way of partnership. Not possible. Next one, sir. It has to be an agreement to share profits. Remember, one partner cannot share all the profits. One partner cannot share all the profits, but one partner can share all the losses. One partner cannot take all the profits, but one partner can take all the losses. And it is end of the day business carried on by all or any of them acting for all. This is only called as what, people? Mutual agency. And that is also called as, people, cardinal principle of partnership. Okay, the true test of partnership. What is the maximum number of partners? The minimum is 2. Maximum is, according to the Companies Act, it says 50 is the maximum number of partners. Remember, true test of partnership, there has to be an agreement, sharing of profits, mutual agency should be there. If these things are there, people, we will consider some organization as a partnership. Remember, at times there will be sharing of profits, but other things will be absent. So in such cases, you are not supposed to consider them as partnership. Example, sir, sharing of rent. Yeah, will it be considered as partnership? We call it as co-ownership. Correct, Tom? Let us imagine there is a land or there is a building. From this building we are getting rent. Two people are dividing this rent equally. Is this considered as partnership? Answer is no. This is considered as co-ownership. Hello? So you should not just see that someone is sharing profits or someone is just sharing money. That alone cannot be a test for partnership. We need to look at lot of other aspects as well. Hello? Some decided things are what? Sharing of returns coming from a property, we will call it as co-ownership because there will be no business. Next one, receipt of money by a lender. Imagine borrower is also giving interest to the creditor, no? So borrower and creditor, will they become partners? No. It is called as interest payment. Receipt of money by a servant or an agent, will they become partners? You pay your agent, no. So is agent and principal considered as partners? No. This will be considered as remuneration. Hello? Receipt of money by a widow or a child. Imagine there was your previous partner. The previous partner passed away. So we are supporting their family by paying every month some money. So we are giving them some money. So the family members, do they become the partners? No. We call it as pension or annuity. That is what we are trying to tell you. Sharing of money alone cannot be a test for partnership. It is one of the tests. Understood? Huh? Hello? Yes? Huh? Okay. Next one, sir, any money paid as a goodwill again is not considered as partnership. That is what was considered in this case law, Santiranjan Das Gupta versus Dasiran Murzamal. What was held in this case? Nothing but whenever you want to check whether there is a partnership between people or not, you need to ask questions like, have they maintained accounts? Have they opened bank account? Was their business conducted? Do they have LLP deed? Is it registered? Do they have partnership deed? Is it registered? All these questions will help you answer whether there is a partnership between the people or not. Next one, sir, kinds of partnership people. There are in total 4 kinds of partnership. One is called as partnership for fixed period. What do I mean by that? In our partnership deed, we clearly write people that the partnership will be valid for a period of 5 years. After 5 years, you have 2 choices. One, end it or continue it. If you continue it, what will it happen? It will become partnership at will. Very good. So if a partnership for fixed period continues even after the fixed period, that becomes a partnership at will. Remember. Next one, what is partnership at will? When you have not decided what type of partnership you are, by default you are considered as partnership at will. That means what? Any one partner, if he gives an intimation to all the other partners telling that let us wind up the partnership, that intimation is called as people partnership at will. So from the date of intimation, the partnership will come to an end. Next one is called as people particular partnership. A partnership which carries on only a single business, we call it as particular partnership. Next one is called as general partnership. A partnership which carries on more than one objective under one name, we call it as people general partnership. For example, let us imagine we do education, finance, probably entertainment, food, everything under one name. We call such partnership as general partnership. Next one, people, is types of partners. One is called as active partner. The partner who involves in day-to-day affairs of the business is considered as active partner. Remember, whenever active partner resigns, you need to give a public notice. Sir, even if our active partner dies, should we give a public notice? Not required. Death, not required. On the date of the death, my liability ends. Sir, what if, who is a sleeping partner? Sleeping partner who is not actively involved in the business, he may retire whenever he wants. Remember, he need not have to give a public notice on his retirement. Nominal partner is a person who just lends his name. Generally, these are the people who have good, I would say, name in the society. They will give their name. Now, for example, for a business, someone gets associated. Like, I don't know if you guys know a person called as Nikhil Kamath. No? Zerodha, you know? Your demat trading account. So, Zerodha is owned by 2 people. One is Nikhil Kamath, one is Nitin Kamath. Nikhil Kamath is a trader. You don't know? His general, what is that? What does he do? He has easily invested into 500, 600 companies. He goes and sees very underperforming companies or not known companies at all. He will invest. He'll turn them. He'll make them extraordinarily good. So when he would have purchased the shares, one share will be 10 rupees, 8 rupees. He will sell it when it becomes 2,000, 3,000 rupees. He makes money. Nikhil Kamath. Okay. You don't know Nikhil Kamath? Don't know. The only interview Modi has given to a private fellow is Nikhil Kamath. Da. Only interview Narendra Modi has done with any person other than himself. Or else where do you see a reporter? He will only talk directly, no? There will be no interviewer. Because when Modi came, he clearly said no interviews. Only interview has done is Nikhil Kamath. Whom and all he has done? Nikhil Kamath. Bill Gates. Kumar Birla. Nikhil Kamath is way too big. Da. We should know all these. Okay. Nominal partner. Okay, na. Nominal partner is now Nikhil Kamath associates with the company. His name has one reputation. I thought till now. Your class proved me other way. Okay. Now people, his name gets associated with the firm's value becomes more. Hello. Understood? Such type of partners are called as nominal partner. You are also liable for all the losses just like any other partners. Partners in profits only. Remember, partners, everyone can be only in profits. Possible. Example can be even minor also. Beneficiary only, no? Hello? Incoming partner? Outgoing partner? Partner by holding out? Phone case, remember? I told I want to sell Narayan Murthy's phone. That is only called as partner by holding out. That means what? Now I'll come and tell in front of Nakul, people, me and Nakul are partners. Tell me which dog you want. Puppy? Husky? Lab? 1,000 rupees. You give me payment, he will later courier the dog. Okay? Okay. Now she will give me 1,000 rupees. Now did Nakul speak anything? No. We became partners. I became a partner by holding out. Hello? Hello? Done. Next one. Let us do of unit 3. We'll do this, then we'll take probably some 10 minutes break. Okay. Registration and dissolution of firm. People, what is this, people? It says, should partnership be mandatorily registered, people? Is it required? Is registration of partnership mandatory? Remember, people, it is optional. But if you want to register, register. How? File all the documents with the registrar of your area, along with all the documents like statement showing the name of the firm, place, partner's name, partner's details, types of partnership, everything you write it and you give it to the registrar. Registrar will enter in his books, he will enter your name as A, B, C and co. Partners are A, he is from Bangalore, B, he is from say Tamil Nadu, C, Kerala, D, Erda, all the place. Yes, so people, that is how I register your name, people, in my register of firms. And going forward, we will use the word A, B, C and co. In the brackets, we write it as registered. Then you become a registered partnership firm. Hello? Clear? Sir, now let us imagine we started our business in the year 1995. But till date we are not registered. Now we want to register. Can we do it? Is it possible? Yes, people. But remember, you need to pay a registration fees. Now you are registered in 95. You are coming for registration now. You need to pay 100 rupees fees as a delay fees for every year of incorporation that you have missed. So from 95 to 2026. Let us imagine is 31, 32 years. For 32 years into 100, 3,200 rupees I have to pay as late fees. I can still register. So what do I mean to say? I mean to say you can register your partnership in the future. Possible. Hello? Clear? Okay. Sir, what if I don't register? Sir, what will happen? Consequences of non-registration, people, is you cannot file a case in the court on the third parties. Can the third parties file a case on you? Yes, that is allowed. Remember, people, you cannot claim set off. That means what? Sir, I have taken a loan of, okay, imagine this way. The partnership firm, they have supplied some goods worth 20,000 rupees to a person called as A. A has also given loan, people, worth 1 lakh rupees. The partnership firm did not repay the loan. Now A filed a case on the partnership firm. What type of partnership? Unregistered partnership. A filed a case on the unregistered partnership, asking for the money back. How much did A ask the money back? A asked people for the entire 1 lakh. Now the partnership firm in the court said, sir, we agree that we have taken loan from A. However, we have also given him a raw material worth 20,000. Please deduct that and please tell us to pay only the remaining amount. That is 80,000. Why should we pay 1 lakh? The court says, what type of firm are you? Are you a registered firm or an unregistered firm? Sir, we are unregistered. If you are unregistered, remember, whatever you have given, we will not count it at all. Not even 1 rupee we will count. So this is only called as people no set off. Now the partnership started crying. Sir, 1 rupee also will not allow, means people, this is injustice, sir. At least consider some, sir. We said, okay, we will consider up to 100 rupees. Not beyond 100. So now how much you need to pay? 1 lakh minus 100. I need to pay 1 lakh only. Why dine 100 rupees? Give that also. 99,900 rupees you need to repay. Who said that, sir? No set off is allowed. However, up to 100 rupees you can do it. More than 100 rupees you will not get any right of set off. Hello?
Yes, sir.
Next one, sir. Aggrieved partner cannot bring legal action against the firm or partners. However, he may go for a dissolution. That means what? I cannot file case on the other partners also. But it will give me a right to dissolve the partnership. If I am not okay to continue, you can go to the court and request for a dissolution. This is allowed. Remember this, it can be important from exam point of view. Next one, as I told you, third party can sue the firm, but we cannot sue the third parties. Okay, next one, sir. Exception for non-registration, third parties can sue. Partners can sue for dissolution or settlement of accounts. Power of assignee of court to release the property of insolvent partner. The liquidator can come and take the insolvent partner's assets, whether you are registered or not. Claim set of 100. Sued by legal representative of deceased partner to realize the property of the firm. That means what? C died. Now it is an unregistered partnership firm. The legal representative of C can come and request for all the share that he needs to get. Whether you are registered or unregistered, you can still file a case for recovery of your share of assets. Next one, sir, effect of change in constitution. In short, I will tell you, remember people, whenever there is any addition of a partner, it is your duty to intimate that also to the registrar. But whenever there is any 1 or 2 partner, they die. Even if you have not intimated that to the registrar, it is still okay. But whenever there is an addition of a partner, you have to intimate that to the registrar. If there is an addition of a partner and if you do not intimate people, it will still be considered as an unregistered partnership firm only. What do I mean by that? Let us imagine 3 partners were there, A, B and C. There are 3 partnership firms. Let us imagine 3 partners people, A, B and C. They are registered partnership firm. After 2 years, a new partner came called D. Now, until this is also intimated to the registrar, you cannot continue the partnership firm. If you continue, you will be considered as an unregistered partnership firm. Whereas A, B and C were there. C died. They have not yet intimated to the registrar, but still they are continuing the business. That's okay. You will still be considered as a registered partnership firm only. But when there is an incoming partner, you have to intimate to the registrar. If not, you will be considered as an unregistered partnership firm. Clear? Okay. Next one, sir. Modes of dissolution. Dissolution, people, is of 2 types. Dissolution of firm, dissolution of partnership. What do I mean by dissolution of firm? What is dissolution of firm? What is dissolution of partnership?
When partners are the firm is dissolved, if any one partner returns or
When any one partner comes in, when any one partner goes, that is called dissolution of partnership. When the entire firm is dissolved, we call it as dissolution of firm. Dissolution of firm will definitely dissolve the partnership also. Dissolution of partnership will not dissolve the firm. May or may not dissolve the firm. Dissolution of the firm, you guys will realize the assets. Dissolution of partnership, you will revalue the assets. Remember. Next ones are modes of dissolution of firm. We can dissolve the firm in two ways. One is voluntary, next one is court. That is mandatory. Dissolution by court method. Voluntarily, how and all we can do? We can do it by agreement. Voluntarily, we all agree and we will wind it up. Next one, people, is compulsory. When all the partners become insolvent, or we have 5 partners, 4 partners become insolvent. That is also one of the ground for dissolution. Next one, any event which makes it unlawful for the business to continue. Meaning, we started as a tobacco company. In India, they brought in a rule. You cannot continue tobacco business. You will be considered as an unlawful business now. Because of that, you have to wind up your business. But if you are a general partnership, you were carrying on many businesses. In such case, you can shut down the tobacco business, you can continue the other business. Next one, happening of contingencies. In your partnership deed, you have clearly written, you are a partnership by fixed period, 5 years. It happened. Now it is your choice. If you want, you can come to an end or you can continue. Next one, completion of specific business. We have achieved it. If you want, you can continue or you can put an end. Death of a partner, remember, it's a choice. If you want, you can continue or you can put an end. Next one, adjudication of partner as an insolvent. Again, one of the reasons for a partnership firm to dissolve. Next one, people, dissolution by partner, notice at will. I told you, whenever partnership is at will, people, if you give your intimation that I want to dissolve my partnership, you can dissolve your partnership. Which will be the effective day? Whatever is the day mentioned by the partner in the notice, if the date is mentioned, it will be effective from that day. If the date is not mentioned, it will be effective from the day he communicated. Next one, sir, dissolution by the order of court, when and all. First one, people, insanity or unsound mind. When any active partner becomes an insane or an unsound mind person, whenever any other partner files a case to the court, sir, that partner has become unsound mind, can we please wind up? The court will look into the scenario and wind up the business. Remember, temporary illness will not be considered as unsound or insane mind. Same thing, permanent incapacity. When an active partner, if at all he meets with an accident, he becomes permanently disabled. Yeah, it's not a temporary accident. It becomes a physical accident. Imagine a loss of leg, loss of limb, loss of hand. I will not be able to work as before. So the other partners can request, sir, we cannot continue the business. The partnership will come to an end. Misconduct, people. Any partner misconducted in his professional life or personal life. Because of that, the partnership firm is receiving a lot of hatred. People have started boycotting this business. It is affecting us. Go and file a case, sir, because of him we are also facing the heat. Please wind up. You can wind up. Next one, breach of agreement relating to embezzlement, erroneous accounts, holding more cash than allowed, or refusal to show accounts. What are those, people? In agreement, we have clearly agreed. You have to show me proper accounts. You are not supposed to hold more than 5,000 rupees in cash. Or when someone is coming and asking you, it is your duty to show accounts. When you do not do all of this, people, the other partners can go and request for resolution. Next one, people, transfer of interest to third party. Remember, sir, there are 3 partners, A, B and C. C transferred his share to D. Now A and B do not like to continue. File to the court, sir, we don't like to do business with the D. Can you please wind up our business? The court may order to wind up the business. Hello? Next one, sir, continuous or perpetual losses. And okay. Yes, people, continuous or perpetual losses is nothing but what, people? From the day we started the business, it is still going on. The losses are still going on. That means what? We have not seen profits at all. Apply to the court. If the court deems fit, the court will pass an order for dissolution. The last one, people, just an equitable grounds. What do I mean by just an equitable grounds? It's like an etc. I can't write every reason, right? Etc. is nothing but tomorrow if something like this happens, people, that can also be one of the ground for dissolution. Example for just an equitable grounds is deadlock of management. What do you mean by deadlock of management? There are 4 partners. 2 people are saying yes, 2 people are saying no. We are not able to convince them, they are not able to convince us, we are not able to go forward itself. Dissolution. Next one, management not in talkative terms. They are hating each other. Fights. They'll apply for dissolution. Next one, people, loss of substratum. Why, whatever is the reason we started our business for, the reason itself we are not able to achieve. We wanted to earn profits, not working out. We wanted to do something that is outdated today. So the loss of purpose, substratum means purpose. The purpose itself is not met. You can wind up. The last one is, people, a partner enters into a stock exchange and he does a gamble. One of the ground for dissolution. So apply to the court may order for dissolution. Like, meaning there are many things, no? Like gamble here in the sense, uncertain activities. Future and options are there, which is not guaranteed that you will make money. So in such case, if any partner is doing, high chances that people will lose money. So you are losing business money. One of the ground for dissolution. Clear? Okay. Relation of partners. Let us do this unit. Let's finish off. Relation of partners to one another. In this, what is the main thing, people? General duties, be just and faithful, be truthful. That is what general duties says. Duty to indemnify. Let us imagine if you do any fraud, it is your duty to indemnify back the partnership firm. Concentrate. Listen. Rights and duties of partners. Always remember, the rights and duties of the partners is always decided by the contract between them. That is nothing but partnership deed. If we want to change anything in the partnership deed, people, it can be changed by the consent of all the partners. So if at all I have to change any rights and duties of the partners, I can change it with the consent of all the partners. Agreement in restraint of trade. Can I stop a partner? If you are a partner in the partnership firm, you cannot do any other business. Can I stop? Is it possible? Answer is yes. As long as it is reasonable, that is, as long as you are a partner, you cannot do any other business. It is reasonable. And hence, such restriction is valid. Next one, sir, conduct of business. The partner has to do his duties diligently, not negligently. Any differences of opinion is always sorted by majority. Whether we need to do it or not, it is always decided by majority. For change in the nature of business, remember, you need to do unanimous approval. What do I mean by that? Till now we are doing educational business. Now if you want to do finance business, I need to take the approval of all the partners before I change the nature of my business. Every partner has a right to inspect and take the copies of the books of accounts, except one person. Who is that? Except transferee. What do I mean by that? Remember this, here only will explain you off. A, B, C. Can C sell his share to an outsider? Is it allowed? Remember, the condition is, it is C's duty first to ask his existing partners, are you interested to buy my share? If A also says no, B also says no, I don't have money, then A and B cannot stop C from selling his share to D. You can sell your share to an outsider. However, remember, the new partner will not enjoy the same rights as of a existing partner. What do I mean by that? The new partner cannot participate in the business of the company, business of the partnership. You will not be allowed to take the You will not be allowed to inspect the books of accounts. You will not be enjoying the same rights as that of the existing partners. Only thing that D will get, every year they will share the profits you need to take. And when we decide to dissolve, you will get your share of capital. We will pay you, you can leave. And not only that, if A and B do not like D coming in, they can also apply for dissolution. We already saw. Remember, transferees rights and liabilities, very, very important from exams point of view. Hello? Understood all of you? Okay. Next ones are mutual rights and liabilities. Right to remuneration. Can I give remuneration, people? By default, you are not entitled for remuneration. But if your agreement allows, you can provide. So what if agreement is also silent? Then remember, people, write down in bracket, if customs allow, you can pay. Meaning if it is a tradition in your partnership firm to pay salary, you can pay salary. Next ones are right to share profits. In absence of any agreement, the P&L will be shared equally. If you guys have it, you can share it as per the ratio. Next ones are interest on capital. I can pay interest on capital only when the agreement provides. If agreement is silent, if there is any customs to pay interest, you can pay, or if any other law allows me to pay, I can pay interest. Interest on advances, we can pay up to 6% per annum. Remember, we have a right to be indemnified as well as to indemnify the firm for any loss suffered. That means what? If I suffer any loss, the partnership firm has to pay me money. If because of me, partnership firm suffers any loss, I will have to pay money to the partnership. That is what is the meaning of indemnify. Remember and go. Next ones are partnerships property. What and all is considered as partnerships property, people? It can be anything that you guys brought in during the time of commencement. Second one, whatever was acquired by the partnership firm during the course of its business. The third one, people, goodwill. All these three things will be considered as a property of the partnership. Remember, partnership's property is different, partner's property is different. Just because the partnership firm is using the partner's property, imagine we are using a partner's car, that does not become the partnership's property. Partner's property is partner's property only. Just because we are using it for the business, it does not become the partnership firm's property. Next one, sir, personal profits earned by a partner. Can a partner earn personal profits? Is it allowed? You can never make secret profits, people. If at all you make any profits using the transaction of the firm's name, using firm's property, for example, let us imagine ArivuPro will be closed after 8 o'clock. We will conduct night shift college, night shift classes. Now they're telling you, people, what does the law say? If at all such things, if I'm using the firm's property and if I'm doing business, people, the law is telling whatever profits I made, I have to return it back to the partnership firm. Clear? Okay, next one, sir. If at all I carry on any competing business, people, whatever money I made as a partner, any competing business, I have to return the entire profit made to the partnership firm. Remember, exam point of view. Next one, liability to third parties, people. Who will be liable? In general, all the partners shall be jointly liable because you have implied authority, mutual agency. One partner signs a contract, all the partners are liable. Liability of the firm for wrongful or negligent acts of a partner. What do you mean by that, sir? What if a partner acts negligently? Remember, people, if it is in the ordinary course of business, whatever a partner does, the partnership firm will be held liable. If it is a responsibility of the partner to be diligent, if at all you do not do the thing properly. For example, to give you an example for this, let us imagine after you guys clear exams, 3 of you start a partnership firm and you guys start practicing CA. You become chartered accountants. Yeah? In 3 of you, 1 of you did a fraud. Yes? 1 of you did a fraud. Now, according to Companies Act, you are liable. The law says, people, your firm has to pay a liability of around, let us imagine, 1 crore rupees. Now, the question is, who needs to pay this? Is it A, B, C, or all of them? Can you say we were not involved? It was that partner who did it? Law is telling that only, people, if you do any wrongful act, negligent act, if it is during the ordinary course, audit only, you did it, who will be held liable? The law says, people, the entire firm will be held liable. Any liability, remember, all of you should pay. You don't have a choice. Only exception is, people, imagine if jail is there. Only the partner who did the fraud will be imprisoned. Not all the partners. But money, all of you should pay. Jail, only the partner who did the fraud. That is the meaning of liability of the firm. Everyone are liable. Hello? Understood? Huh? So, be wise in choosing your partners. Next one, liability of a firm for misappropriation. What do I mean by this? Similar, people. If one partner takes the money and runs away, the partners are liable to repay the debt. Remember, whatever it is, people, firm is liable to repay the debt. What happens? What is this liability of firm for misappropriation? Imagine one partner goes, in the name of the firm, he borrows money from a bank and he runs away with the money. Should the other partners repay the loan? Unfortunately, yes. If you have borrowed the money in the name of the firm, the other partners will be liable. So what if all three of us borrowed money? We have kept the money in the partnership firm's drawer. Once the two partners left it to home, whoever is the partner, he took all the money in the drawer and he escaped. Now also is the firm liable? Yes, people, whoever are the remaining partners, you are liable. You don't have a choice. So misappropriation is a problem amongst you. The outsider will not be affected by it. You guys are liable to repay the loan. Clear? Huh? Okay. Next one, sir. Relation of partners to third parties. What is it? The authority of a partner to bind the firm, done in the ordinary course, acted within the scope. He should have entered in the name of the firm. What do you mean by this, people? If A, B, C, three partners are there. If C has to bind the partnership firm, what should I do? I should act within my scope. And whenever I am entering into a contract, I need to enter like this. Mr. C will sign for A, or you can write like C, the partner, for A, B, C and co. So in a partnership deed, if you sign like this, people, then the partnership firm will be liable. If you just write your name, people, C, and if you sign, this will not be binding the partnership, it will be binding you personally. If you want to bind the partnership, people, you need to write yourself as C, I am a partner of the firm A, B, C and co. If you write it like this, you are binding the partnership. That is what they have given here. Clear? Hello? Yes, it can be specifically restricted by a contract. The third party is liable, or implied authority is restricted when the third party is not about such restriction. The third party does not know that he is dealing with the partner or a firm. What do you mean by this, people? Let us imagine we have clearly written in our partnership deed that no partner can enter into a contract for a value more than 2 lakh rupees. We have written in the contract deed. C enters into a contract with the outsider. He enters into a contract with the D. The value of the contract is, people, 3 lakh rupees. The question was, is the partnership liable for this 3 lakh worth of contract? Or is the partner liable? Is the partnership liable or is the partner liable? The law said, people, they will ask one question to D. Mr. D, did you know that there was a restriction on Mr. C that he cannot act more than 2 lakhs? Did you know? If D says, yes, I knew, then the law says, then the 3 lakh is your headache, the firm will not be liable. Why did you enter into a contract in spite of knowing? If D says, sir, I did not know that there was a restriction on C. If D says, I did not know, then remember, the entire partnership firm will be liable to D. Amongst you guys, you fight. But for outsider, all of you will be liable. So first we will have to give back the 2 lakh rupees to D. Now we can file a case on C to recover the money. But to an outsider, we all are liable. Clear? Hello all of you. Remember and go. Next one, sir. Transfer of partner's interest and transferee's right. Whatever I told you, a transferee will not enjoy the same rights as a partner. He will only get the share of profits and whatever is your share of capital at the time of winding up, you will get that. You will not be allowed to involve in day-to-day management of the partnership firm, and you do not have a right to inspect the books of accounts. These two things you will not get. The day you agree to, you agree to leave the partnership firm and go, that day you will get the books of accounts. The day you agree to leave the firm and go, that day you will get the books of accounts. Exam point of view, very, very important. Remember and go. Yes? Next one, sir. Minor admitted to the benefits of the partnership. What happens with regards to the minor, sir? Minor can never continue as a minor forever in the partnership firm. You can either continue as a minor people and you can only be eligible only for the benefits until you are a minor. Once you become a major people, you will have 6 months time. Within 6 months, people, you need to intimate your decision whether you would like to continue as a partner or you want to leave. You cannot be only a beneficiary forever. You will be having 6 months time to communicate your decision. Within 6 months, you need to tell whether you want to continue as a partner or you want to step out of the partnership firm. Sir, what if the minor does not communicate anything within 6 months? If the minor does not communicate anything within the 6 months, it is deemed to be acceptance. That means what? The minor by default will become a major. That means you will be assumed to be a partner. Sir, remember, until the date of you giving your, consent, until you giving your opinion, until that day, you will still continue be treated as a minor only. So, you will only be eligible for benefits of the company. That is, say imagine you became 18, you took 4 months to communicate your decision. So for the 4 months, you will be still treated as a minor only. You will not be liable for losses. Hello? And as long as you are a minor, what are the rights the minor will enjoy? I have a right to share profits. I have a right to access, inspect, copy of accounts. Hello? Sir, what if they do not give me the books of accounts or they do not give me the copy of accounts? What can I do? I can sue. I can sue the partners for accounts or payment of his share. When? Only when I am cutting his connection with the firm. That means what, people? Imagine I have a right to check the books of accounts. But if the firm does not show me the books of accounts and I am still continuing as a partner there, I cannot sue the firm. I will not get a right to check these books of accounts. When will I get a right? The day I decide to leave, that day if I file a case, I will get a right to inspect the books of accounts. If I am just continuing in the same firm, I will not get a right, people, to check or inspect the books of accounts. Remember, exam point of view, this point is very important. When do I get a right to inspect? In general, I have a right to inspect. But if they don't show me, what is the alternative I have? What is the remedy I have? Remedy is I can file a case, but only when I am agreeing to cut my conditions with the firm. Clear? Hello? This is the minor thing. So, when you have a public notice you have to give, when he becomes a partner, he becomes personally liable to third parties. Very, very important. People, from when will the partner become liable as a partner? From when? From the day when he became a beneficiary. So imagine we took you when you were 15-year-old. From that day only, you will be assumed to be liable as a partner.
Previous doesn't even know he's the partner in the person. That from that day only will be.
So let us imagine you became 18 years, 6 months. You said, I want to be a partner. So from today, you are not eligible only for benefits, you are also liable for losses. So all the benefits of contracts also you will take, all the losses also you will take, correct? Huh? That will start from which day? From the day I gave my approval? From the day you were admitted to the benefits of the partnership firm. Let us imagine you were taken when you were 15-year-old. From that day, whichever contracts are entered, for all the contracts from the day, that is after 15 years. From the 15th year, whenever I was taken, from that day, I am liable for all the profits, all the losses. Very important exam point of view, remember. Hello? This is the only exception, people, for ratification. Generally, you cannot ratify the minor contracts. This is the only exception. Here, huh? Okay. Last one, sir. Legal consequences of partners coming in and going out. Admission of a partner. Remember, whenever a partner comes into a firm, people, he will be liable for the losses only from that day. For the past losses, he will not be liable. That means what, sir? There is, listen. A, B, C are there. Now D is coming in. D is coming on 1st January 2027. From when is D liable for contracts? D is liable from 1st January 2027. But if D wants, D can be liable even from the previous contracts also. That means I can tell my desire. People, I would want to be liable not only for this contract, I would want to be liable from the day the partnership started. I want to be liable from 2021. If I am interested, I can give my approval. Hello? Yes? So remember, for this, D has to agree, A has to agree, B has to agree, C has to agree, and the third parties with whom we did a contract, they should also agree. That means what? Let us imagine there is a loan that we have taken from a person called as Mr. E. Now I am telling, sir, this loan was there even before I came in as a partner, but now even I also want to become liable. Even please add my name also to the loan agreement. If all the people agree, who? A, B, C, D, E, all 5 people agree, even my name can also be added to this particular loan agreement. Earlier 3 people will be liable to repair, now 4 people will be liable to repair. 3 people were liable, now becomes 4 people liable. Existing contract has 3 names, the new contract has 4 names. That's why we can call this type of change as novation. Change of parties, correct? Huh? Hello? Next one, retirement of a partner. Same thing, people. Even after you retire, all the contracts that were entered when you were a partner, you will still continue to be liable. Old contracts, you are liable. From the date of retirement, you are not liable. Sir, from the old contracts, please take away my name. Same thing, people. Again, repeat. A, B, C. C wants to leave. Sir, please leave my name from the contract we entered with D. Okay. C, A has to agree, B has to agree, C has to agree, D has to agree. Novation again, possible to take away a name, allowed. Hello? Understood? Sir, second thing, sir, remember, retirement of a partner, whenever it's an active partner, you will be retired only upon the public notice. Sleeping partner, not required. Next one, people, expulsion of a partner. What do I mean by expulsion, people? Removal of a partner. For a removal of a partner to be valid, people, remember, all these things has to be satisfied. All these things has to be satisfied. What is it, people? The power of expulsion should be there in the agreement. That means in our partnership deed, we should have a power to remove a partner. If the partnership deed is silent, we cannot remove a partner. Point one. Point two, people, majority of the partners should vote. Imagine three partners are there. Only one partner wants to remove. You cannot remove. Two people have to say. Majority should always remove. The third one, people, you should always exercise this power in good faith. That means what? Please don't use it for cheating. What do I mean by good faith? Good faith means nothing but, people, it should be in the interest of the partnership firm. It is not because you hate him. It should be for the purpose of partnership firm. He is not doing something properly. That's why we want to remove him. Okay, you can remove him. And remember, before you remove him, people, there has to be something called as audi altrum partem. What do you mean by that? You have to give an opportunity of being heard. You have to listen to what he says. Fourth law, correct? Huh? If none of these conditions are satisfied, people, then we can consider such removal to be null and void. Exam point of view, important. Next one, insolvency of a partner. From the day you are declared as an insolvent, all your share of assets ceases to be the share of partnership firm. So from the day I am insolvent, from next day, none of my assets are part of partnership firm. From the day of insolvency. Cut, copy, paste even for death. The day of death, all the share of the partner will cease to be a share of partnership firm. They can give you a case-based scenario here. After the death, the partnership firm continue doing business. Whether the partner's share is liable, after death, not liable. Remember, even if you are an active partner, I need not have to give any public notice, not required. Hello? Hello? Fair enough. Okay. There were some two topics that I had to tell in Indian partnership. One was, people, whenever a person, let us imagine there is an outgoing partner. There is an outgoing partner. Let us imagine there is a death. What is the responsibility of the partnership? The responsibility of the partnership is to settle the money whenever there is a death within a reasonable time. Without settling, let us imagine if at all the partnership is continuing its business without settling the share of the outgoing partner. Now, what is this partner entitled to do? So, his family is entitled to what? Whatever is his share of percentage of profits, he should have got, he can claim that, or he can also claim the interest at the rate of 6% on the amount that he has given as capital. This is at the choice of that particular family or the outgoing partner. Whenever the settlement is not made, that is one thing, remember and go. Second thing that I have to tell you is, people, let us imagine if at all a partner is becoming insolvent. In such case, how do we use the assets of the partner? Now let us imagine, let us imagine a partnership firm became insolvent. Partners also became insolvent. Because there was a huge debt we could not pay. So the partnership firm also became insolvent. Partners also became insolvent. Now how do we repay this? They're telling you the partnership firm's properties or assets will be utilized to repay the partnership liability first. If we still have excess, it will be given to the partners. The partners can use to repay their liabilities. In the same way, when the partners have their personal assets and the partnership firm also became insolvent, partner also became insolvent. Now let us imagine I have to give a total outstanding loan of 10 lakh rupees. That's the money I need to give it to the partnership firm. I have my own debts also. So what to do? If a partner is also became an insolvent person and the firm also became insolvent, in such case what do we do? They're telling you whatever are the assets available, in that assets, first you will utilize to repay your own debt. Excess, if any, you will use to repay the partnership firm's debt. So first I will repay my loans. Excess, if any, I will repay the firm's loan. Clear? Remember these two things. Yes, I think rest of it, most of it, I think we did. Okay. Fair enough. Okay. Let's start with people. Company law, the Companies Act. Yes. Okay. Important exam point of view, easy to score as well. Try to concentrate on Companies Act even when you guys are studying. That makes a lot of difference. Yeah. Try to give a good number of time for your Companies Act. Very important from exam point of view. Okay, let's start people. Companies Act. What are the features of a company, people? The characteristics of a company is it has a separate legal entity, or you can also call it as a corporate veil. What do I mean by this, people? Company is different, shareholders are different. So the company's liabilities will not affect the shareholders. The company's assets also, the shareholders will not have any right. Until the company is dissolved, you do not have any right over the assets of the company. In the same way, even if there are liabilities, the liabilities will not affect the shareholders as well. So, when a company is formed, a company is a different entity and the shareholders are a different entity. Remember that. Yes, that's why, right now, whenever there is a loans on company, when a company goes into winding up an insolvency, the best case we can look around is now Byju's. Byju's has got an overwhelming debt, a crazy debt. Now, when there is so much of debt, now the personal assets of the shareholders, that is not at all at stake, no. But the total repayment, how much they need to repay, crazy amount is outstanding. But the shareholders have money. Are they liable to pay that money to the creditors or outsiders? Are we liable? Answer is no. We are not liable. That is what they are telling you. So whenever there is a company formed, the company is different. I am different. The company in the eyes of law will be recognized as a separate person. Clear? Yes. Okay. Next one, people, is perpetual succession. What is perpetual succession? No matter how many shareholders are there, even if they die, the company will continue. But that is not the case in the partnership. Partnership, generally, it is your discretion. But even only if two partners are there, one partner dies, then it will come to dissolution. What if there are 3-4 partners? It is your choice. If you want, you can continue, or it will come to an end. That is not the case with the case of company. It enjoys a perpetual succession. Members may come, members may go, but the company goes on forever. Best example I can give you is Reliance. Started by Dhiru Ambani, carried on to Anil Ambani, Mukesh Ambani. Now there is third generation also, right? So company goes on forever. Next one is limited liability. The liabilities of 3 types, right? What are the 3 types of liability? The first one is called as company liability limited by shares. Limited by shares means, people, I agree on day one to purchase 100 shares. Face value is 10 rupees. Once I pay 100 into 10, I pay 1000 rupees. My liability will come to an end. I am not even liable to pay 1 rupee extra. That is the meaning of what, people? Companies liability limited by shares. At times what will happen? They will call this money in 2 installments. That means what? We have called 5 rupees now. We will call 5 rupees later. That is also okay. You would have seen in your accounts, right? First call, second call and all. So my liability is until I pay all the unpaid calls. Once the entire unpaid calls, everything is paid, people, my liability comes to an end. Second type of company is called as, people, company limited by guarantee. What do I mean by company limited by guarantee? Unlike shares, people, in this type of company, they do not have directly capital. They may or they may not have. Here, what does the shareholders do? Sorry, not shareholders. What does the members do? The members will tell in the MOA, we will tell What is that? We will tell there are, say for example, 3 members, Mr. A, B, C. We will tell, if at all, let the company start its business. On the day of winding up, if the company does not have money, on the last day, on the day of winding up, if the company does not have money, we will come and contribute. How much? A will tell, I will give 2 lakh. B will tell, I will give 1 lakh. C will tell, I will give 1 lakh. We are giving a guarantee today to pay money on the day of winding up. If the company does not have money, that day we will come and give money. We are giving guarantee today. Such type of companies are called as what people? Company limited by guarantee. Remember, company limited by share, company limited by guarantee, they are same only. Even they enjoy limited liability, they also enjoy limited liability. Perpetual succession, all those characteristics are same. Only difference is that people, in the case of company limited by share, they bring the money on day one. The shareholders bring the money on day one. In the case of company limited by guarantee, the members bring the money on the last day. If company's assets are not sufficient, only then the guarantee will come into picture. If not, they will never contribute at all. Such type of companies are called as people, companies limited by guarantee. So who will start, sir, this company limited by guarantee? Who will even start it? Generally people, this company limited by guarantee, you can get that question also. Sir, if they are not bringing money at all, then how are they getting that initial capitals to start the business? The shareholders only are not bringing the money. How are they starting the business then? That's why remember, company limited by guarantee, generally who does it? Section 8 company we call it, no? Non-profit organizations. They carry on people such type of business organizations. That is, they carry on people your company limited by guarantee. The best example I can give you is Reliance Foundation. Reliance Foundation is a Section 8 company as well as it is a company limited by guarantee. Both. Getting the point? Yes. Why? Reliance Foundation, what is the activities it does? It takes care of certain, say for example, medical welfare activities, charitable activities, education. They carry on all these objects under the name called Reliance Foundation. Where will they get the money from? It's a company limited by guarantee. Where will they get the money from? Reliance Industries will give them the money. Or various other people donate the money to this Reliance Foundation. Donations will come. Then why capital? That's why a company limited by guarantee can continue the business even without capital, because you will be getting grants, donations, subsidies, funds from people. It is allowed. You may get. That is why people will follow company limited by guarantee. Who? Non-profit organizations. Understood all of you? Yes. So such type of companies are called as company limited by guarantee. Third type of companies is called as people unlimited company. What do I mean by unlimited company? A company where the shareholders are itself telling people our liabilities will be not limited, it will be unlimited. Just like partnership firm, we will pay from our pocket if something happens. But remember, a creditor cannot directly file a case on the shareholders. Even in the case of unlimited liability, you have to file a case on the company. The company will recover it from the shareholders and settle the dues to the creditors. Remember, clear? Yes, sir. So these are the 3 different types of companies which is limited by liabilities. Next one, sir, artificial person. Once the company is registered, what will happen, people? Once the company is registered, the company will become whatever. It will be considered as a body corporate. From that day, it can enter into contracts. It can hold properties in its name. It can sue and be sued. Common seal. Is it mandatory to have a common seal? Remember, sir, it is optional. In 2015, there was an amendment which said a company need not mandatorily have a common seal. Clear? Sir, if common seal is not there, then how will a company enter into a contract? If a company's common seal is not there, the company will enter into a contract either by two directors signing. If there is a company secretary, one director and one company secretary should mandatorily sign. If common seal is not there. If you have a common seal, people, really good, then common seal alone is sufficient. If common seal is not there, this is the alternative. Remember and go, may be important from exam point of view. Clear? Hello? Okay, next one, sir. We clearly said now, people, one principle called as, sir, there is something called corporate wheel or something called separate legal entity. That is, the company is different from its shareholders. That is what we just saw. Company and its shareholders are different. They both are separated people using one wall, a cloth in between them. So whatever a company does, it does not affect the shareholders. Whatever the shareholders does, it does not affect the company. However, at times what happens, people, in the mask of the company, some shareholders carry on some illegitimate activities, illegal activities, or you are using it for immoral things. In such case, people, the courts have a right to tell you both are not two different entities, you both are same. Whatever is a cloth that is there in between the company and the shareholders, that cloth will be erased by the judiciary. This concept only is called as, people, what? We have a cloth, the judiciary will lift this cloth. This cloth only is called as lifting of corporate wheel. So if I lift the cloth, now it is clear, people, you both are one and the same. Anything done by the company, shareholders are liable. Anything done by the shareholders, company is liable. Sir, when will we generally lift this cloth, sir? Generally, people, it will be done in this 5 scenarios. What is that? The first scenario, to find out if the company is trading with the alien enemy. So generally what happens, okay, I'll tell you this case laws also. There is a company, Daimler company versus Continental Rubber Tires. In short, I'll tell you all this case laws. What happened in this case law, people? There was one company, say for example, a company in UK. Let us imagine company A. Company A was supplying tires to another company in UK. All of this is happening in UK. Yes, sir. Company A was supplying tires to company B. There was a contract for 2 years. But all of a sudden, people, company B said, we will not buy tires from company A. Company A said it will be a breach of contract, we will file a case on you. Company B still did not resume the contract and hence they cancelled the contract. Company A filed a case on company B. That, sir, there was a 2-year contract between us that they will buy the tires from us only. But after 2 years, after 1 year, sir, they have stopped buying the tires from us. Now, while that it was asked in the court, people, that why did you stop buying these tires? Now, what did company B say? Company B said, sir, because company A is our alien enemy. Company A said, sir, how can we become their alien enemy? Because you are also in UK, I am also in UK. How can I become your alien enemy? Company B said, sir, they are not directly our alien enemies, but indirectly they are our alien enemies. How? Because, sir, the shareholders of company A, there are shareholders, no, yes. Who are the shareholders? The shareholders of company A, they are all, sir, German citizens. That is, from Germany, they hold all the majority and they control this company A. Sir, so what? What if they are German citizens? Nothing but, people, when this case was going on, people, there was a war between Germany and UK. And both the countries had declared each other as alien enemies. Now, what did company A say? Sir, it's okay. My shareholders are in Germany, but I am registered in UK only, no? Separate legal entity. I belong to UK, they belong to Germans. Now, in this case, company B proved that, sir, let us imagine we buy tires from them, then we give must the money to them, correct? We give them must the money. Let us imagine we pay them good amount of dollars. Now, sir, when we give them good amount of dollars, sir, now generally what happens, I am giving them good revenue, their profits will increase. When their profits will increase, what will happen, sir? They will declare good dividends. The dividends are going to the German citizens only, no, sir. So indirectly, don't you think we are only giving this money to German citizens? The judge said, yes, this is correct. What you said, the interpretation is correct. and they allowed for lifting of corporate wheel. And they said the German citizens and company A will be treated as one and the same. This contract was put an end. It became a void contract. There was no compensation paid. Done. Lifting of corporate wheel. Case law people, Daimler Company Limited versus Continental Tires and Rubber Company. This was a case law. Second one, sir, to evade tax. If someone starts a company for the purpose of evasion of tax. Example, sir, there was one fellow. This fellow was very smart. He had some 3 crore rupees. He split that into company A, company B, company C. He gave 1 crore each. What did these 3 companies do? These 3 companies further invested into another 5-6 companies. Now indirectly what happened? In whichever companies A, B, C have invested, they all started paying return, interest, dividends as the case may be. Now whenever they are paying interest, dividends and all, then what happened? In all these cases people, the company A's profits started going up. B's went up, C's went up. That means what? All these 3 companies, they were making good profits. Now what did this person do? You are making good profits. He started taking all that money back to his pocket in the form of loans. He borrowed money. Now technically what happened people? It is his company only. The company is making profits. Technically people, you need to pay tax on the profits you are earning. Even if you are a company or an individual, you have to pay tax. But what did this person do? Instead of paying tax on it, people, he diverted all of that into his pocket and he showed that as loans. Now, because of that, what did he do? Try to think. Now, in the company's books, company has earned profits. Now, that profits are given as loan. So, in the company's books, what they're telling you, will that money come back? No. He will start showing them as debtors. Eventually what he will do, he will never repay the loan. That debtors will eventually become people bad debts. So technically what happens, he will write it off. So profits are made people, but that is equally written off in the form of debts. So in that way what happened, he is getting money also. In what way? He is getting it in the name of loan. On loans, will you ever pay tax? Should we pay tax on loans? Sir, neither did he pay loan. Now, because the companies never got the money back, the companies also did not pay the tax. Now, because in this structure, sir, using this structure, this person evaded the tax. It was held that company A, B, C and this fellow are one and the same. The Commissioner of Income Tax said whatever was the profits made by company A, company B, company C, this person has to pay tax on it. And who was this fellow? This fellow was called as people Mr. Dinshaw. That's why the case name is popularly called as people Dinshaw Manekji Petit's case. Yeah, the complete case law is called as Dinshaw Manekji Petit versus Commissioner of Income Tax. It's a complete case law, but in our books it just says Dinshaw Manekji Petit. That's the case law. Clear? The third one, sir, when a subsidiary is appointed to act as an agent. Now, what do you mean by this, sir? What is the case law? In this case, what happened, people? There was one company, company X. They were into logistic companies. They had HTVs, that is your heavy truck vehicles. They had that. You need lorries and all, no? Cargo and all you need for logistic companies. So what did they do? They applied for some registration with their, for India we have RTO office, no? Like that they also have an office called as BTC, British Transport Commission. So they filed an application to BTC for a registration of all their lorries. But unfortunately people, something was not right. The applications or the requirement was not right by this company X. So what does BTD do? BTC rejected their registration application. Now company X felt, array, I have invested a lot. Now they have rejected my application. What do I do? The company X people wanted to somehow get this license. What did they do? They knew now that If they apply again, their application will be rejected. So what did company X do? They formed another company. They formed one subsidiary company. Now they applied again for the same license in the name of company Y. The British Transport Commission felt, recently only similar applications, similar vehicles, we rejected the application. Now how come we getting another application almost of similar background? When the British Transport Commission did a research, people, they got to know that the vehicles or the business was the same. The company X only is trying to get the license now indirectly. Directly, if they file, they will not get the license. What are they trying to do? They are trying to get the license indirectly. The company law, that is British Transport Commission, lifted the corporate wheel and they said, people, company Y, company X are one and the same. They are just using the mask as a subsidiary and they are trying to do the same thing, that which we did not allow them to do directly. They are trying to do it indirectly. Lifting of corporate wheel. Case law, people. Merchandise Transport Limited versus British Transport Commission. Fourth one, sir, to avoid legal obligation. What happened in this case law, sir? Simple language, I'll explain you. There was company X. There was a rule in this country, people. Whenever a company earns good profits, you need to give good bonus to the workers. You need to give good bonus to the workers because the law said very clear. If a company is earning good, the reason is because of its employees. So you have to give a good share of bonus to them. Now, company X had lot of things, people. One of it was they also had made investments in other companies. So they were, now let us imagine, I had also made an investment in company Y. One example I'll give you. Company Y is declaring dividends to company X. Yes? Now company X profits will go up. Now because company's profits went up, should I give more bonus to workers or not? Now people, one of the shareholders in the company X said, why should we give bonus on this investments and all that? Why should we give? What did they do? They formed one dummy company called company A. They transferred all the shares they had in the company Y, whatever was there in their name, they transferred everything to company A's name. Now in company A, there are no workers only. Now what happened? Company Y started giving dividend to company A. All of a sudden, company X's profits started going down because they are not getting that extra income that they used to get. Because of that, the workers saw that their bonus was going down. They saw it for an year or two and then they questioned, why is it so? We have not done anything different. Whatever we are doing the same. How come our commissions are going down? They filed a case. It was held that the company did something like this, a jugaad. They are trying to escape from the legal obligation of paying bonus. It was held that people, whatever you have to do indirectly, if you are trying to stop it, the law does not allow it. You cannot avoid a legal obligation. Case law, people, workmen of Associated Rubber Industry versus Associated Rubber Industry Limited. So the workers filed a case on this company. Clear? Hello? The last one, sir. Company formed for fraud or improper conduct or defeat law. One day what happened, people? A company hired a person. A person was hired as a managing director. There was a company called as Company X. They hired one person as a managing director. This person's name was called as Horn. Now he was hired as a people managing director. In this agreement, it was clearly written what? If at all you leave the company and go at any given point of time, for the next 3 years, you're not supposed to do anything that will take our customers and they will give it to you. You're not supposed to take our customers in any way. There was a clear clause written in the agreement. Now what happened, people? This fellow, after 6 months, because of some misunderstandings, they had to quit this particular agreement. So Horn ended up being resigned from this particular company. He left. Now, as soon as he left, what did he do? He was working for a company called as X. Now, X is called as basically Gifford Motor Company. That's the name of the company. It was a motor company, automobile industry. So what did he do? As soon as he went out, he started a spare parts business. It's an automobile company. So he said, there are all possible spare parts available of Gifford Motor Company with me. If you guys want screws, you want nut, you want whatever the spare parts are, you can come and take everything with us. He started supplying the spare parts of the Gifford Motor Company. Now what happened? According to the agreement, it was clear the Horn was not supposed to do anything which takes away the customers from the company for the 3-year period. But he started doing the spare parts. The customers started going to him. So Gifford Motor Company sent him a sweet warning. Horn, please don't do. There's a clear restriction between us. You should not do anything for the next 3 years. What did Horn do? Horn did not stop it. Horn started doing this indirectly. What did he do, people? Horn went and started a company. In this company, he made his wife and his friend as the shareholders. They were the shareholders, but who, controlled them? The control was still with Horn only. And what did they do? In this new company, they still started continuing the spare parts. Now, Gifford Motor Company saw it enough. Now, Gifford Motor Company sent a notice to this newly formed company. Horn, it is enough. You are trying to still do the same thing which we told you not to do. You are still trying to do it indirectly. Now, Horn tried to challenge it. See, the restriction was between you and me directly. It was not between you and this company. The company is a separate person. I am a separate person. The law said, people, you are not considered a separate person if you are trying to take advantage of the separate legal entity concept. You are trying to do something indirectly which you cannot do directly. The law does not allow it. Lifting of corporate wheel was done. Separate legal entity will come to an end. The company and Horn were considered as one and the same. And the restriction was also applied on that company as well. Case law, people, Gifford Motor Company versus Horn. Remember all 5 case laws. In one way or the other way, they will ask you. Very important from exam point of view. Next one, people, the different types of company. The first one on the basis of liability. We already saw this. Guarantee, shares and unlimited. Second type of company on the basis of control, holding company, subsidiary company. What do I mean by subsidiary company? It is a company in which a holding company or another company controls the composition of the board of directors. Here composition means what, people? Majority of the directors should be under the control of one company. That means what? There are 5 directors in a company called as company S. Out of the 5 directors, people, 3 directors are controlled by company H. I will tell you who the 3 directors should be. I can appoint them. I can remove them whenever I want. If they are completely under my control, people, we call them as people holding subsidiary companies. So even if I do not have even say 10% of the shares, it's still okay. But if the control of appointment and removal is with me, I will still be considered as what? Holding subsidiary relationship. Point 1. Understood? The second way a company can become holding subsidiary. How is that? One is, people, a company holds directly more than 1/2 of the total voting power. 90% of the students will write this and government company wrong. 90%. And I'm sure you are also thinking and would have written the same. And remember, what do I mean by holding and subsidiary company relationship? Whenever one company holds more than 1/2, in your exam, please don't write it as 50, 51 and all. That is somewhere as an example, whoever you guys have gone to, as an example, they would have taught you. You're not supposed to write that in your exam. When a company holds 51%, you are not supposed to write that. You're supposed to write it in words only. When one company holds more than one half. Now, what do I mean by one half? Let us imagine in a company there are 10 lakh shares. When will this company become a subsidiary of another company? It holds 5 lakh one share. It becomes what? A holding subsidiary company relationship. That's the meaning of more than one half. That means even 50.0001, you become a holding company, subsidiary company. It need not be 51%. But when do you become a government company? When you hold at least 51% of the total paid up share capital. That's the difference. There you are supposed to write 51% only. That's the difference. Are you understanding? So in subsidiary, more than one half. 50.001 also is subsidiary. Whereas government, it has to be 51. 51 or more. Clear? Yesterday I was telling you the same thing. Okay. So, sir, when holding company is holding, for our understanding, so that you will remember in the exam I am telling you, let us imagine a holding company is holding 50.5% in another company. What? The total voting power. I am holding it. The law is telling you people, this is considered as holding company. This is considered as subsidiary company. This is first way. Second way, sir, let us imagine there is a holding company. There is a subsidiary company. It holds 51%. There is another company called as company Y. Company S holds in Y people 30%. Company H also directly holds in company Y around 21%. The law is telling people, remember, company Y will become subsidiary of company H. Because you will add these two percentages, because it is still under the direct control of company H only. This is the second type of a subsidiary company. When a company holds the shares on its own along with its subsidiary, you will be considered as holding subsidiary only. The third scenario, you can become a subsidiary company. There is a holding company, there is a subsidiary company, there is another subsidiary company. Imagine one company holds 51%, another company again holds, example, 55%. This becomes holding, this becomes subsidiary, this becomes deemed subsidiary company of company H. Grandfather controls father, father controls son, grandfather controls the grandson indirectly. That's the relationship. Hello? Understood all of you? Remember, so these are the three ways a company can become a subsidiary. Exam point of view, important. The next one, sir, what is the next one? It is called as people associate company. What do I mean by associate company? When one company has a significant influence in another company is called as what people? Associate company. What do I mean by associate company? When I hold people at least 20% of shares or control in any way is called as what people? An associate company. Example, a company A, there is company B. Company A holds 20%. Company B becomes an associate of company A. So at least 20%. If you are holding not less than 20, from 20 up to 50, you will be considered as what people? A holding, associate company, relationship between you and the other company. Remember that. Clear? It includes a joint venture. What do I mean by joint venture? There is Maruti Suzuki. It's a joint venture of Maruti and Suzuki. So Maruti Suzuki will be an associate company of Maruti also. You will be an associate company of Suzuki also. Because you are a joint venture. Hello? Clear? They have never asked on joint venture. Remember and go, exam point of view may be important. Clear? Kia? Hero Honda, yes, everything. All these are the examples. Clear? Yes, sir. Okay. Next one, people. is called associate companies. Okay, next one is called as people based on the number of members. There are three different types of companies. One is called as public company. What is public company? A company people which has minimum 7 members and there is no restrictions in articles. We call such company as a public company. Remember, a subsidiary of a public company will be a deemed public company. Subsidiary company of a public company will be a deemed public company. So even if you are a private company, but if you are a subsidiary of a public company, you will be assumed to be a public company only. Next one, people, private company. What do I mean by private company? A private company means a company which has 3 restrictions in your articles of association. What are restrictions in articles of association? There are 3 things. One is, people, a company which in its articles of association restricts the transferability of share, prohibits the issue of shares to public, limits the number of members to 200. So a company which cannot have more than 200 members, we call such company as, people, a private company. Remember, when you are counting this 200, you are not supposed to add your employees, whether they are present or past employees. Please don't add them. And next one is, whenever there are joint shareholders, that means 2 people, 3 people together, they will be holding 1 share, meaning 1 account. You are not supposed to treat them as 3 shareholders. Please count them as 1 shareholder only. Clear? Yes. In past, people, in your exam they had asked one question. I think even in your textbook question it is there. What is that? One second, if it's there, I'll directly show it to you. According to me, it's a wrong interpretation, but yes, textbook has shown it like that. If given an exam, please take the same interpretation. Hey, don't turn off and all. Put the swing up. Again, for this class to become normal, it will take next day. Put the swing up. If you guys are feeling cold, put the swing up. Okay. Not finding that question. Okay, see here, people. Technically, what is that thing that they have given in the book? So they have given a question. They have given, there is a company which has in total 250 people holding shares in it. And they would have given you a sub-classification. Employees holding, past employees holding, joint shareholders holding, and they would have given people directors and relatives. They would say directors and relatives are holding, say 10 people are holding the shares. What do they do, people? They will not deduct them, directors and relatives. So, according to the interpretation, directors will be considered as employees of the company only. You are not supposed to add them. But in our book, or I think it's in one of the past paper question, they add the directors to the number of 200. Because the words they have used is directors and relatives. We do not know how many is directors, how many will be relatives. So they ended up adding everyone. So they would have given 10 people, the entire 10 is added to the number of members. But what if only directors are given? Please write an assumption saying that the directors are also the employees of the company only, and hence they will be excluded in the limit of 200. That is the right interpretation. But because it is clubbed and given as your directors and relatives, we really don't know how many of them are relatives, how many of them are directors. That's why they have taken an interpretation of, let us add everyone to the list. So they have counted. They have not deducted them, they have counted them in the list of 200. So that is one, in one past exam paper, they have done that. So remember and go. Yeah. Okay. So private company, so they have these three things. One is people, restriction on transferability of share, limits the number of members to 200. In that joint means take them as one. Past and present employees, please don't add them in the limit of 200. And prohibits inviting public for the subscription of shares. Okay, next one, sir. Another type of company is called as OPC, one person company, people. What is the one person company? Who can start one person company? A person who is a natural person, citizen of India, whether you are a resident in India or otherwise. That means what, people? See, until 2023, 2024, there was a rule, people, 2023. That you should be a resident in India. In 2024, what did they do, people? They liberalized the rule because we had NRIs, our own people, but staying abroad. When you say that only resident in India can become an OPC, only they can do OPCs, our own NRIs belonging to the country, but currently temporarily living abroad, maybe 3 years, 5 years, they could not start OPCs in India. That is why what did they do? They liberalized the OPC requirement. That's why they introduced the word, whether you are a resident in India or otherwise, was introduced as an amendment. This is not there since 2013. In 2022, 2023, if I am not wrong, is when this particular amendment was introduced. Before that, it was not there. Are you understanding? Yes. So, sir, if I have to be a resident, then what is the criteria? If you want to be a resident, people, then you should have stayed in India at least for a period of 120 days in the preceding financial year. Hello?
How is it true we stayed in India for 120 days?
If you want to go outside India, you cannot go without passport entry. So in your passport, if you are going outside, it will clearly say when you went outside. It will be stamped. Okay, clear on resident in India, outside India. So remember in a OPC, you should mandatorily have a people nominee. Who can become a nominee? Nominee also people, same rules people. What is that? You should be a natural person, you should be a citizen of India, even if you are resident in India or not, it's absolutely okay. Only you can become a nominee. Sir, can we change the nominee whenever we want? Absolutely fine. Sir, can nominee only resign? Absolutely fine. Sir, can a minor become a nominee? Not possible. Clear? Yes, okay. Next one, sir. Can a OPC be converted into any other form of business? Absolutely fine. Today you can be an OPC. Tomorrow you want to grow big. You can convert yourself into a private company, public company. Absolutely fine. You can do it. Sir, can one person start two OPCs? Not possible. One shareholder cannot be a shareholder in two OPCs. Sir, can one person be a nominee in two OPCs? Not possible. Maximum same person. Now, for example, there is a person called as Mr. A. He can be a member in one OPC. The same person can also be a one nominee in another OPC. Mr. A can be a member also. Mr. A can be a nominee also in another OPC. Same person can be both a member in one and nominee in another OPC. Possible. But sir, wherever I am a nominee, imagine if that shareholder dies, then I will become the next member. No. You said one member cannot be holding two OPCs. It is not possible. Remember, if at all such scenario comes, you will be given 180 days time. You need to choose any one OPC. In another OPC, you need to quit within 180 days. And remember, OPC cannot carry on non-banking investment activities. OPC cannot even invest money into any other body corporates. You cannot make investments. Prohibited. Next one, people. OPC cannot convert itself into a Section 8 company. And OPC should mandatorily have the words OPC in its name. Remember and go. Clear? Okay. Next one, sir. Section 8 company. What is Section 8 company, people? Don't write off. Section 8 company means a company which is not for profit. This is what you're supposed to write. It's a company which is formed for the promotion of charitable objects, commerce, arts, sports, charity, education, etc. Research. It's a company formed for that. Can I declare dividends? No. It's prohibited from declaring of dividends. And not only that, remember, can I earn profits? Yes. You are supposed to reinvest that money back into the business for the purpose of promoting its objects only. So earn it, but put it back into the business. You are not supposed to take it to your pockets. Such type of companies are called as Section 8 companies. They work under a special license by the government. If at all you are not following the rules properly, the special license given to you will be taken back and you will be told to convert from Section 8 to any private public, or I will be telling you to wind up, or I will tell you to merge or amalgamate with any other Section 8 company if at any given point of time you are not following the laws properly. The next one, sir, it need not use the word private limited or limited in its name. That's why I told you example of company limited by guarantee. I gave you an example. Reliance Foundation. Did I tell Reliance Foundation Limited, Reliance Foundation Private Limited? No. It will not have any of the tags. It will just be called Reliance Foundation, Infosys Foundation, Tata Foundation, yes, JRD Tata Foundation. There are a lot. Okay, such type of companies are called as Section 8 company. Next one, people, government company. What do I mean by government company? A company in which minimum not less than 51% of paid up share capital is held by central government, state government, central and state governments. Please do not add any other company's investment into this. Sir, please don't add. Have they written na? Or any government company holding? Add that also. Have they written na? No. So you don't add. They can give you a question like this. There is a company X. In company X, 15% is held by central government. 10% is held by Tamil Nadu government. 10% is held by Karnataka government. Let us imagine. Another 10% is held by, say, Kerala. 30, 45. Sir, another 6% is held by LIC company, which is a government company. They are asking you, is company X considered as a government company? Is it a government company? Is it a government company? Is it a government company? Tell me. Company X is a government company. Yeah? Is it a government company? Is it a government company or not? It is not a government company. Come and see definition. Central government have written, okay, central government. State government have written, okay, state government. Central and state have written, okay, central and state. Where did I write government companies there? Why are you adding this? This is there written in the definition? Then why did you add? You are not supposed to add this. Again tell me. Again tell me. Tell me. There is a government company. To become a subsidiary, how much I should hold? So, law is telling you to only consider if government company is directly holding in your company not less than 50.1%, meaning you should be a subsidiary. Did I tell you to add 6, 10, 13 and all? So directly if you are holding more than 1/2 of the total voting power, then yes you can add. If not, people, you are not supposed to add 5, 6, 8 and all. You are not. Anywhere have they written? Then own interpretations we can't use.
In the case, if LIC is holding like 52%,
Directly you became a government company. Yes. So yes, Nakul's case is, sir, let us imagine LIC is a government company. If they are holding 55% in company X. Now what will become to company X? Company X is a deemed government company. This is given in law. Subsidiary of a government company is a deemed government company. But in law, they have not told you to add 6%, 10%. Hello? Clear? Okay, done. Next one, sir, foreign company. What do you mean by foreign company? A company which is incorporated outside India. It has a place of business in India and carries on business activity in India. We call such company as a foreign company. Remember, you can be present in India directly. Even indirectly is also fine. That is, you can even be present in electronic mode or any ways also okay. Such type of company is called as a foreign company. Example, there is a company called as Alibaba. You have heard of it? Alibaba, they do not have a company in India. Do they have it? You do not have an Alibaba office in India. But can you order from Alibaba? You need to just pay in dollars. But can we order? Yes, just like Amazon. Now people, you guys all shop from Amazon.in. But there is also one more thing called as Amazon.com. Can you buy from Amazon.com? Yes, we can buy. Amazon.com will supply you goods, but you need to pay in dollars. So, company which is having a place of business in India, we will consider it as a foreign company. So, 3 conditions for a foreign company, people. Important from exam point of view. A company which is incorporated outside India, you have a place of business in India. That means whether physically or electronic form, even if your website is accessible in India and you carry on a business activity in India, not only website is there, sales are happening, purchases are happening. If 3 conditions satisfied, you will be called as a foreign company. Clear? Yes. People, you tell me. There's a company called as Google. Google has a subsidiary company in India called as Google India. Google India. It's a subsidiary company of Google. So Google India is registered in India. Yeah. Now my question to you is Google India a foreign company or not? Is Google India considered as foreign company or not? India. Google is registered outside India. It has a subsidiary in India, registered in India. It is a subsidiary of foreign company. Is it a foreign company or a foreign company? Not a foreign company. Or is it a foreign company? It is not a foreign company because remember, you are directly registered in India. If you are directly registered as a company in India, you are an Indian company. Understood? Sir, then everyone will get registered. No. If you are registering in India as a separate company, you will become Indian company. Sir, why sir company and all? I will just have one branch office. Now, for example, Arivu has a office in Chennai, correct? Arivu is there in Coimbatore, correct? Is that a second Arivu or is it just a branch of Arivu? So, do you think we have to take one separate registration from ROC Chennai to start business in Tamil Nadu? Do you think? Nothing is required, people. Zero compliance. Nothing extra because it is a branch office. It's not a second entity. It's just an extension of Arivu. That's all. But if at all Arivu wants to start another company in Chennai separately, ArivuPro Chennai Private Limited. Now that becomes what people? That becomes a separate entity. Hello? Remember the difference. So when a Google has a branch in India, it becomes a foreign company. If Google starts one complete entity or a company itself directly registers in it in India, if you are registering it in India, it becomes an Indian company because you are registering as per Indian laws. Understanding? Hello? Clear? Okay. That's your foreign company. What do I mean by small company? For your attempt, it is applicable. Foreign company means the company who is having a paid up share capital not exceeding 10 crores and turnover not exceeding 100 crores. Remember, for your attempt, the limits are 10 and 100. Very important from exam point of view. Remember and go. Okay. Next, people, what? Incorporation of a company. How do we incorporate, people? The minimum number of shareholders. 1, 2, 7. In the case of OPC private public, they file all the required documents with the ROC, MOA, AOA, SPICE, all this will be given with the ROC. And also we give a declaration that none of us are committed any fraud, we have not arrested, we are not convicted. Whatever is the information we are giving, everything is true. We submit all these declarations to the ROC. If ROC is satisfied, ROC will allot us a certificate of incorporation. Yes, sir. Next one, sir. When a company is incorporated by giving incorrect information, in such case, what will happen? A tribunal will pass an order either to regulate the management of company, or I can even order to change anything in MOA, OA. I can make the liability of the members unlimited. I can even directly remove the name of the company. I can even order for winding up. What are the different types of shares, people? Equity shares, preference shares. Equity shares can be further classified into normal shares, DVR shares. Yes, sir. What do you mean by preference shares, people? They always enjoy a preference over equity share. They have a priority in two scenarios. When is that? One is when you are getting dividends paid. When second one is when you are getting repayment of your capital. First it will be paid to preference, and then if we have extra money, we will pay it to equity shareholders. The next one, people, is company's two main documents. One is called as MOA, one is called as AOA. MOA, people, basically a document which introduces the companies to the outsiders. MOA basically will have people 6 clauses. The first clause is called name clause. Second one is called as registered office clause. Third one is called as object clause. Fourth one is called as liability clause. Fifth one is called as capital clause. Sixth one is called as subscription clause. So first one says name, second one says the state where the company is registered, third one says what are the objects of the company, fourth one says what type of company are you? Are you company limited by share, limited by guarantee, unlimited company will be told in the fourth clause, liability clause. Fifth clause says people authorized capital, nothing but people, the maximum capital of the company will be written in the capital clause. Next one is people subscription clause, also called as association clause. Who your initial shareholders are will be written in the subscription clause. If you are an OPC, one more clause will be there, that is only called as nominee clause. And next document is called as people articles of association of a company. What is articles of association? Generally a document, it is an internal document. Listen, internal document which has the internal rules and regulations of a company. So for the purpose of internal regulation, whatever are the rules that the company wants to set for itself, that is only called as what people AOA. Remember, Companies Act gives you a skeleton. The basic rules is given by the Companies Act. You can go beyond Companies Act, but you cannot go less than Companies Act. That means Companies Act gives you minimum requirements. You can go beyond that, but you cannot go less than that. For example, if I want to make you all pass in your exam, I will say, people, the passing marks here, mock tests, you need to write at least the passing marks will be 50. My intention is, if you get 50 here, you will get 40 there. So the basic is 40. It is given by institute. I can make more stricter. I can't make it lenient. That means, let us imagine I'll keep the passing marks here as 30. Such type of thing, people, is considered as void. You cannot go less than the minimum requirement. You can go more than the minimum requirement. That means what? See, the minimum number of shareholders is how much? 2. In the case of private. In the case of public, 7. I will say the minimum in my company should be 10. That's okay. But you cannot say minimum should be 1. You can go more strict. You can't make it lenient. That is more important. Remember, clear? When you make the articles more strict, this provision is called as entrenchment. Entrenchment means people making the law applicable to the company a little more restrictive or little more stricter. Understood? Yes, sir? Huh?
Liability ceases when members cease from the company. But if the company goes into liquidation within 1 year, not within 1 year, if that ceases the person need to pay the liability.
Yes.
Yes, sir.
Yes, yes. Where you see? It's a little more complicated thing. They are called as contributories. It's a big logic, but yes, it's there. Okay. Understood concept of entrenchment. So to entrench the articles, people, if you're a public company, you need to pass a special resolution. If you're a private company, all the members have to agree for entrenchment of articles. Remember and go. Next one, sir, doctrines. There are 3 doctrines, sir. What are the 3 doctrines, people? One is called as doctrine of ultra-vires. What do I mean by doctrine of ultra-vires, people? When a company goes beyond its powers, we call it as doctrine of ultra-vires. Remember, when a company goes beyond its power, it does not bind the company. The third parties and the company, they will not enter into a valid contract. So company is not bound. Then who needs to bear the loss? Whoever entered into a contract. If it is directors, the directors only will have to bear the loss. The company will not be held liable. And remember, if it is in ultra wires, you have something, right? Ultra wires, the company. So the shareholders also cannot ratify it. But ultra wires, the directors, intra wires, the company, the shareholders can ratify it. Remember that and go. There is a case law, Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Basically, it said people, a company cannot do what is not there in its object clause. For example, today, Arivu's object clause says imparting education to the students. That is what our object clause says. Now, let us imagine now so many students are there. Can we start one small cafe in one of the ground floor? A small hotel or a cafe, can we do it? Short business, no? Our own students will be like 300, 400 students. Pakka business. And if I add all the employees and all, another 100 people. Pakka business. And I'm saying our own people. Can we do? Our object clause does not have any provision on cafe. Now, can we do? If you do, if I just start up, I know it is business, it will give me money. If you do, it is called as ultra vires transaction. Similar thing happened in Ashbury Railway Carriage Company. They did something which their their object clause did not provide them to do. They were into railway and related parts. They did a finance business. It was held as ultra vires. That means we can never do it is not written in object clause. The right way is call all your shareholders. Ask them, people, are you okay? We are doing education. No. Can we add cafe business also? Is it okay? Call everyone and take an approval. If they give an approval, people, in your object clause, in third clause, here add with education one more cafe also. Give it to the registrar. Now you can do cafe business. So we are not saying you can never do it, but the way of doing it, there is a procedure. That's all. Clear? Okay, next one, people. Doctrine of constructive notice. What do I mean by constructive notice, people? Remember, whenever anyone is doing a business with a company, you are assumed to know every information about the company. Whether you know it or not, you are assumed to know. For example, let us imagine we take one floor in this building on rent with this landowner. The directors enter into a rent with him, saying that we want to do a cafe business here. Now, cafe business is not there in our object clause, hence it is ultra vires. So this contract will not bind the company. Now the landowner is coming and telling, hey, how can you do it? You gave me a word. Now you cannot go back. You have entered into a contract. Now you are saying it is ultra vires and all. How will I know? Did you guys give me any documents to check? So we did not give any documents. So Papa, this uncle, the landowner, who will protect him? The law said, people, remember, the moment the company is incorporated, it will be considered as all documents are in the public domain. When you are entering into a contract with a company, you are supposed to check all the documents in the public domain. Only then you are supposed to enter into a contract with the company. Sir, what if I don't know all of this? Remember, in India, ignorance of law is not an excuse. If it is there, you are supposed to know it. Sir, I didn't know. That's your headache. Because in a population of 150 crore, I can't come and tell every one of you people this is one way. If you come, whether you know it and come, you don't know it and come. If there is a signboard there, if you saw it, you didn't see it, it's your headache. If I don't know, you can't run a population of 150 crore. Ignorance of law is not an excuse. That's the first thing that is said in the court. If you say I don't know, the judge will directly tell you, please don't say it. You can't tell it even as a, to defense. You can't tell it. The right way to tell it is, my lord, I accept my mistake. That's the way to tell. What is the difference, sir? Difference in fine will be there. Yes, difference in fine will be there. If you go and accept it. See, first one is arrogance, ignorance. Second one is realization. Yeah, quotes give little respect for what do you say? Realization. Arrogance. People remember, macha. Books always have the word minimum penalty will be 1 lakh, maximum penalty is 10 lakh. So if they put a penalty of 10 lakh on your head, you are supposed to pay. Because law has given them the power to impose 10 lakh on you. It has also given them the power of 1 lakh also. It depends upon your character which one prevails there. If you are arrogant there, it will be that only. Clear, all of you? So remember, constructive notice means if you are a company people, all documents are there in the public domain. That means anyone entering into a contract with the company, you are assumed to know all that information. Whether you know it or not, I don't care. But you are assumed to know. Understood? Hello? So you can't say, sir, the company did not give me MOA. It is there in public domain. Go and take it. Hello? The last one, so always remember, doctrine of constructive notice protects the company from the outsiders. So people cannot come and say, we didn't know that information, we didn't know this information. The last one is called as people, doctrine of indoor management. What do I mean by doctrine of indoor management? Doctrine of indoor management means people, there is an opposite of constructive notice. Not every information, of course, will be available in the public domain. Now, for example, in companies' articles of association, it was written that the directors can borrow such money from the creditors as much as approved by the shareholders in the meeting. It was written in the articles. What was written? It was written as the directors of the company can borrow such money from the creditors as much as approved by shareholders in the meeting. How much and all they didn't write in the articles. So one day what happened? Directors went and borrowed some 10 lakh rupees from a bank with a 1 year maturity period. After 1 year, the bank came for asking for repayment. The company said, why did you guys give 10 lakh rupees? Because the maximum the shareholders had authorized for the directors to borrow was not beyond 5 lakh rupees. Why did you guys give 10 lakh? The bank said, hey, you guys have mentioned in articles of association that the directors can borrow such money as much as approved by shareholders in the meeting. When they come and borrow 10, we assume that you guys have approved 10 lakh only. How will we know? Because we are not allowed to attend your meetings. Are we allowed? No. That's why the third doctrine came into picture. For you to hold the outsiders liable, your public documents has to be perfect. If this is imperfect, in our case, you have not written every information, you can't hold the outsiders liable. Remember, the company itself will be liable on the basis of a principle called as doctrine of indoor management. That means anything happens between the four walls, outsiders will not be liable. The company itself will be liable. So in this case, the company was told to repay this 10 lakh rupees loan. Clear? Yes, sir. Of course, doctrine of indoor management has 3 exceptions. Exception number 1 is any person who has the knowledge of irregularity. That means if you know it and you still did it, people, then we will not help you. We will help the company only. Because why did you do? You knew it, no? Imagine in our case, bank, they knew that there was some intimation given by one person that the maximum the directors can borrow is 5 lakh. In spite of knowing people, they gave 10 lakh loan. We will not protect you. We will protect the company only. Next one, people, suspicion of irregularity. Nothing but people, when you are entering into a contract, you also need to be little careful. You also need to act in good faith. If you are negligent in nothing but people, this is nothing but caveat emptor. You should also do a little research. Suspicion means that if you do little research, you will be able to find. If you don't find, it's your mistake. The third one is called as people forgery. What is forgery, people? Today, people, I can sign like Shah Rukh Khan's signature, I'll do. Easily I'll do. Yes, sir, because in so many public domains, so many places he has given his complete autograph. Is it, you tell me, in today's scenario, is it really difficult to take Shah Rukh Khan's signature and put it in on some check or do a will in his name? Can't we do one will or can't we do one agreement? I'll sell his Mannat to anyone for Nakul. I'll sell Mannats to Nakul. I will sign it on behalf of Shah Rukh Khan. Can't we do it? Is Shah Rukh Khan liable? Remember, forgery will never give you a right. So if someone is signing director's signature, someone is forging it. Remember, it will not bind the company unless the directors only sign. If it's a forgery, it will never bind the company. Understood? Hello? Clear? Yes, sir? That is what I'm telling you. That is forgery.
It's got the bias, not something that is what. If the signature is got actually bias.
If signature is got by coercion, same thing, no? But coercion is also invalid. Forgery is also invalid. Forgery itself will not give you any right. In that coercion also, it will definitely not give you any right. Correct? Yes, sir.
Exception to the
Indoor management. Indoor management means we will protect the outsiders. Exception means we will not protect the outsiders. We will protect the company.
fake sign. How the outsider know this is fake sign?
Correct. Exactly. That's why. Don't you think if I try to protect the outsider, am I not doing injustice to the actual owner? Let us imagine. Now I will sell you Shah Rukh Khan's Mannat. Properly I will put Shah Rukh Khan's signature only. Now you are telling, sir, you are an innocent person. You are buying that from me. You are telling you are very innocent. So you should get the properties what you are saying. If I give it to you, now Shah Rukh Khan, was he involved in this? Don't you think I am doing injustice to him? In comparison to you and him, whom should I protect more? The actual owner or someone who purchased it later? I have to protect the actual owner. I'll tell you why. If not people, I can sell off India only. If I allow forgery, I can sell off India only. I'll go and sign some deal with some foreign government saying that I'm selling arms and ammunition. I'll fake Narendra Modi's signature, can't you? Forgery will never give you a right. If I allow, India is gone. I mean, the country only is gone. So for a greater good, it's okay one person suffering. Yes, what is said is correct. One person will suffer. That's why in India we have something called as litigations in land. Fake documents are created. Over a period of time, what happens? Two different documents gets created. Now original owner also will sell. Let us imagine, Shah Rukh Khan thinks Mannat is his. Now I sold you also one document. You think Mannat is yours. Now Shah Rukh Khan sells to someone. You will also sell to someone. Now see, one document, one ownership, one property is split into two documents now. Both are traveling. One day you will go in registrar office, you go will fight. Yeah, this is how litigations come into picture. Kiera? Yes, sir. That's your Companies Act. Did you believe anything in Companies Act? Any topic? Hello? Okay, see here. Listed company, what do you mean by listed company? Any company which is listing any of its securities on a recognized stock exchange, we call such company as a listed company. If you have not listed on your stock exchanges, you call as unlisted company. Next one is called as dormant company. What do I mean by dormant company? Dormant company is not a separate class of company. Dormant company just means people, it's a inactive company, meaning it's a sleeping company. You have started the company, but there is no business operations. But according to the law, because you are a company, you are supposed to do so many compliances. The law says, okay, I will give you one benefit. You apply to me that you are inactive currently. I will exempt you from following all those particular rules. For example, I'm just telling you, if you're a normal company, you need to conduct at least 4 board meetings in a year. If you're a normal company. If you're a dormant company, people, you just need to conduct 2 board meetings in a year. If you're a normal company, you need to prepare cash flow statement. If you're a dormant company, no need of cash flow statement. Like this, people, you have lot of exemptions if you're a dormant company. Because there is no activity. Why should I do all of that? That's why, people, you will get the benefit provided you should be a inactive company. Sir, what do I mean by dormant or inactive? They say when a company is formed and registered for a future project or to hold an asset or an intellectual property and has no significant accounting transaction. What do I mean by that, sir? We started a company today. Do we have business? No. We are waiting for the business to come. But I've started the company, I've kept it ready. When it comes, let it come. Sir, such type of company, when you have started, now for example, people, I also have one company where we are not doing anything. Yeah, that is there. Just the entity is there. It is going on. Now what do? We apply for dormant status. When someday some business comes, that time what we will do? We will transfer the entity or we will start the entity. We will start the operations on that day. Until then, why should I follow all these rules? I will apply to the ROC. Sir, please give me dormant status. ROC will give me dormant status. So I have started my company not for today, for a future project. Understanding? Sir, remember the main condition you need to satisfy to become a dormant company, you should not have any significant accounting transactions. What do I mean by significant accounting transaction? I have paid some money to the employees. It is significant. If employees are there, means you are making them work. That means work is happening. That means, people, how can you be a dormant company? You are not a dormant company. Sir, we have purchased some plant and machinery. Some investments are happening. It is not a dormant company. Sir, then what is okay? We can spend. Now I have opened the office. I need to pay rent. Rent is okay. Pay the rent. I don't mind. Maintenance of office and expenses. That's fine. Sir, I'm a dormant company, but once in a while, I need to file some information to ROC. For that, there will be some fees involved. It's okay. Pay that fees. It is not considered as significant accounting transaction. Sir, now you are telling me to file some information with ROC. As a person, I don't know what to file. I will come to a chartered accountant. I will come to you for an audit. Now you will ask me fees, yes or no? Sir, should I pay you or not? Now people, anything that is paid to fulfill the requirement under this act, audit, I need to pay. It is not considered as significant accounting transaction. And sir, whenever you are making any share allotment, shares can be allotted. These 4 things are not considered as significant accounting transaction. Anything other than these 4 is considered as a significant accounting transaction. Exam point of view, dormant company important. Remember. So sir, I am a company who is formed for a future project and I am not having any significant accounting transaction, or I am a inactive company. What do you mean by an inactive company? Inactive company means a company which has not been carrying any business or operation, or have not made any significant accounting transaction in the last 2 financial years, or has not filed financial statements and annual returns in the last 2 financial years. I will be called as a inactive company. So who can become dormant company? Those people who have formed the business for future and no significant accounting transaction, or a inactive company. What do you mean by inactive company? No business operation, no significant accounting transaction in the last 2 financial years, or have not filed financial statements and annual returns for 2 financial years. I can be considered as an inactive company. I can apply for dormant status. Clear? Remember, just for our information, a company can remain dormant maximum for 5 years. Beyond that, if you are still saying I'm inactive, the law forcefully strikes off your company. You will be wound up. Yes, sir. Next one, sir. Nidhi company. What is Nidhi company, people? Nidhi company is nothing but it's called as a self-help group or a mutual benefit societies. What do I mean by self-help groups and all? If you go to rural places and all, people, there will be no banks and all. In such case, then where will they get loan, financial help if they need? So what do? Imagine all the villagers will come together. They will form one company. Now, in the village, whoever has excess money, they will give the money to the company as deposits. They will do FD. Whoever needs money, that money will be given to them as loan. So what did the villagers do here? Without depending on the financial system or the banks, they tried to resolve the issue amongst themselves. We call such companies as Nidhi company. That's why the name came called as self-help groups or mutual benefit societies. Such companies are called as Nidhi companies. Understood? The next one is called as public financial institutions. Who are considered as public financial institutions? Remember, people, to be considered as public financial institutions, for now, only 3 people are considered as public financial institutions. Who are they? First one is LIC. Second one is IDFC. Third one is any company which is referred in one act. That act is called as, people, Unit Trust of India Transfer of Undertaking and Repeal Act. In that, whichever company's names are given, they are all considered as PFI. Just that's all. These 3 things remember. What? First one is LIC, IDFC, companies mentioned in UTI, Transfer of Undertaking and Repeal Act 2002. Sir, to this list, can I add anyone? Yes. Whenever central government want, I can add anyone to the list. Not only that, RBI can also tell central government, I can recommend, can you please add that company also as a PFI? Central government will add that companies also as PFI. So technically there are 3 as of now. 2 is CG can add. 5th one is RBI can recommend, CG can add. But sir, we have one doubt. To become a PFI, what is the criteria? To become a PFI, people, the criteria is you need to satisfy any of this condition. The first one is, people, you should be a government company. Meaning what? If you are a government company, that is one of the criteria. That means what? Not less than 51% of the ownership should be with governments. Or, sir, what if I am not satisfying that? You should be a statutory company, meaning you should be registered under any act. Sir, give us an example. All these are what? Statutory companies. Hello? Why? If you and me want to start a company, we have to file an application to the registrar. But ICAI, how did they form it? They passed an act called as Chartered Accountants Act. In that act, they said to take care of the entire act, we want one body, and hence they created one body corporate called as ICAI. We call such companies as statutory companies. So either you should be a statutory company, or, people, 51% of paid up share capital should be held by governments. If any of this condition is satisfied, you can become a PFI. Exam point of view, important. Remember and go. Hello? Pakka? Sure? Then this is your company. Correct now, you have completed. Any doubts in Companies Act? Anything else? That's all? Yes, people, The term partnership, let us continue with the textbook questions. The term partnership has been defined under dash of Partnership Act 1932, Section 4. Not so important for us, it's okay. A partnership for which no period of duration is fixed under the Indian Partnership Act is known as, when nothing is given, what do we call it as? Partnership at will. The most important element in a partnership is business, sharing of profits, agreement, business to be carried on by all or any of them acting for all. See, if you look at it, if they're asked important, everything is important only. Most important they are given. So it's a subjective question. Yeah. Mutual agency, which cardinal, we say no, it's a cardinal principle. Means it's the most important one, mutual agency. Yeah. All this is fit for MCQ only. Descriptive and all this will not come. Okay. Next one, people, is a firm is the name of the partners, minors, business, collective name. Remember, all the partners together are referred as firm. Yeah. A partnership formed for the purpose of carrying on a particular venture or undertaking is known as particular partnership. Next one is, in the absence of agreement to the contrary, all partners are not entitled to share profits, entitled to share in proportion of their ages, entitled to share profits equally. Remember, this and this will be generally confusing for students. Answer is equally. If nothing is given, it is equal. Next one, people, a partnership at will is one which does not have any deed, which does not have any partner, which does not provide for how long the business will continue, which cannot be dissolved. Huh? What among following is not an essential element of partnership? There must be an agreement entered into by all persons concerned. The agreement must be to share the profits of a business. The business must start with 6 months from the date of agreement. The business must be carried on by all or any of them acting for all. What is the question? What among the following is not an essential element? Which one? The partnership is a relationship which arises from operation of law, agreement, status, almighty. Agreement. Any idea which arises from operation of law and status? HUF. Which is not a characteristics of partnership firm? Perpetual succession? What? CZ. Which is not a characteristic of a partnership firm? Perpetual succession, unlimited liability, mutual agency, sharing of profits of business. Which one? Perpetual succession. Select the odd one out of the available options for the entitlement of partners in profits only. Odd one out. He is entitled to share the profits only. He is liable for the losses of the firm. He is not liable for the losses of the firm. He is liable to the third parties for acts of the profits only. What is the odd one out? Select the odd one out of the available options for the entitlement of partners in profits only. So what describes partners in profits? In that, what is the odd one out? Liable for? Mr. Pavan is nominal partner in the correct Noda. He is not liable for losses and only only profits are one and the same, no? So Mr. Pavan is nominal partner in the partnership firm. So he is not entitled to share the profits. He is entitled to share, can take part, entitled. When partnership entered into for a fixed term is continued after the term, it will be treated as partnership at will. Mr. Samarth retires from partnership firm without giving public notice and his name continues to be used on letterheads of the firm. Mr. Samarth is dash in case of repayment of loan to creditors. Liable, not liable. The dormant partner of the firm is not required to give the notice, not liable to third parties, does not share profits and losses. Yesterday only we saw sleeping partner is not required to give a notice of retirement. Mr. XQ and Mr. YU are partners in a partnership firm. Mr. XU introduced MU as his partner to ZU. MU remained silent. ZU, a trader believing MU as partner, supplied 50 laptops to the firm on credit. After expiry of credit period, ZU did not get amount of laptops sold to the partnership firm. ZU filed a suit against XU and MU for recovery of price. Does MU is liable for such purpose? Nothing but people. I need to clearly write section 28 says something called as this is a partnership by holding out or partnership by estoppel. So in the given case, when MU remained silent, when he was introduced as a partner, he created a partnership by holding out. So MU continues to remain liable. Hello. Next one, Miss Lucy, while drafting the partnership deed, taken care of few important points. What are the points? She wants to know the list of information which must be part of partnership deed drafted by her. Also give list of information to be included in the partnership deed. Tell me what and all should be there in the partnership deed. Huh? Name of the partner. See, they're telling you what. While drafting partnership deed, she has to keep certain important points in mind, it seems. What are those important points? For example, partnership deed can be oral as well as writing. You can write, it is advisable to be in writing. Please stamp the partnership deed. Stamp means put it down and stamp it? No, stamp paper. And the partners are advised to sign. All the partners has to sign the partnership deed. And there has to be no, that is on all points. I'm telling you, even before that. So the partnership deed can be oral or in writing. All the partners have to sign. It shall be as per the Partnership Act. Register it, advisable. And then tell all the points. See, it shall include name of the partner, names of the firm, address, details, objects, capital, partnership, sharing ratio, incoming partner, outgoing partner, everything. State giving reasons whether the following are partnerships as per the provision under Indian Partnership Act. XYZ agree to divide the profits equally, but the loss, if any, is to be borne by X alone. Is it possible? One partner can take all losses, but one partner cannot take all the profits. Yes, it is a partnership. X, a publisher, agrees to publish a book at his own expense written by Y and to pay Y half of the net profit. Does this create a relationship of partnership between X and Y? Can paper dealer, that is third party, make Y liable for paper supplied to X? Is it a partnership? No, people, only sharing of profits is there. There is no mutual agency concept, no? I nowhere said you go and act on my behalf, I'll be held liable. All of that is not there. Only profits is being shared. Remember, only sharing of profits is not the only ground to call it as a partnership. Yesterday only we saw this. True test of partnership for section 6. A and B purchase a tea shop and incur additional expense for purchasing utensils, etc. Each contributed half of the total expense. The shop is leased out on daily rent, which is divided between both. Does this arrangement constitute a partnership between A and B? Is it a partnership? Answer is no, people. What did we do? We took one shop which is already there. A tea shop is there. We took it on rent. We added, we purchased it. We added few more utensils. We further gave it to someone else on rent. Are we doing business here? Is there any mine business and all? No. Co-ownership. We are just sharing the rental income. There is no business involved here. It is not considered as partnership. It is just treated as co-ownership. Remember and go, exam point of view. Important. Okay, next one, sir. Unit 2, relations of partners. We'll do it off completely. Hello. Hey, Siraya, Yanadani. Hey, listen down. We'll finish and go. Huh? Hey, questions you can do, no? Yanada. Yesterday only I told you, you have to live your life like this is your last 30 days. In 30 days you will ask break, ada? So that is for yesterday, sir, not for today, sir. Okay. A partner can be expelled if such expulsion is in good faith, the majority of the partners does not agree, the expelled partner is given an opportunity to start a business, compensation is paid. What? Such expulsion is? Which of the following is not the right of the partner? That is, which he cannot claim as a matter of right. Right to take part in business, right to have access to account books, right to share profits, right to receive remuneration. Which one? Which of the following is not the right of the partner? That is, which he cannot claim as a matter of right. Which one? Huh? Remuneration will not come to you by default. Either partnership deed has to provide or custom has to provide. Which of the following acts are not included in the implied authority of a partner? To buy or sell goods on accounts of the partners, to borrow money for the purpose of the firm, to enter into partnership on behalf of the firm, to engage a lawyer to defend actions against the firm. Which will not be considered? Huh? Which are not included. If you remember, I cannot enter into partnership firm on behalf of the firm. This is one topic which we did not do, I believe. What and all is not considered as implied authority. I cannot buy the property on behalf of the firm's name. I cannot sell the property of the firm. I cannot, enter into a compromise in any case. I cannot give up the case against the firm. All these cannot be done. I cannot open a bank account in the name of the partner. These and all they would have given you one big list. In that you can see, I cannot enter into a partnership on behalf of the firm. Not allowed. Okay, next one, people. Fourth one. To reconstitution of the firm takes place in the case of admission, retirement, expulsion, all of the above. A new partner can be admitted in the firm with the consent of a partner may be expelled from the firm on fulfillment of the conditions that the expulsion power is exercised as given by express contract, majority, in absolute good faith, all of the above. What? A minor is a partner representative entitled to carry on the business of the firm, entitled to benefits of the firm. If a partner commits fraud in the conduct of the business of the firm, he shall indemnify the firm for any loss caused to it by his fraud. He is not liable to the firm. He is liable to the partners. He is liable to the third parties. Fraud, you have to indemnify. Yesterday only I told you. Ninth one. Partners are bound to carry on the business of the firm to the greatest common advantage for the welfare of society, earn personal profits. The liability of a minor partner is limited to the extent of his share, his personal assets, his share in the firm as well as his personal assets. He is not liable at all. Sia. Is minor liable, Ada? Is liable or not? What is the option? Remember, people, minor, if at all, let us imagine in a business, imagine we are a general business. We have two businesses. One business made 20 lakh profit, one business made a 10 lakh loss. Everything under one name only, XYZ. How do you distribute the profits? How do you distribute the dividend? There are three shareholders. Let us imagine, three partners, A, B, C. C is a minor. The ratio is 33.33. How do you distribute the profits? Do you do 20 lakh into 33.33 to all the partners? And you do minus 10 lakh into only A and B. C will not share the 10 lakh. How do you guys do? C will not share 10 lakh? C will share 10 lakh or C will not share 10 lakh? Remember, you need to always take the overall balance sheet of the firm. You cannot say that I will give profits of one business, I will not give losses of one business. How am I supposed to do? I need to do 20 lakh minus 10 lakh. Now this is the overall profit of the firm. Now this you need to divide it between all the partners. Now minor will get his share. Now take the other way. Loss is minus 20, profit is 10 lakh. Now what happened? This is, now tell me how will you distribute? So this will be now only divided between A and B, minor will not be liable. So if you see the right option will be what? I will be liable for my share, whatever the 33.3, up to that extent I am liable. After that I will not be liable. Hello, they can ask you in the form of descriptive one. Tell what is the liability of a minor. They can ask you, remember and go. Okay, 11th one, tell me. What is 11th one? Huh? The authority of a partner to bind the firm for his acts as contained in section 19 of the partnership is known as, leave this section based, implied authority. Which are the matters that require unanimous consent of all the partners? Which one da? Admission of a partner, transfer by a partner of his interest in the firm, fundamental changes in the nature of business. Admission also everyone has to approve, no? For all of the above. For admitting a minor into the benefits of the partnership, which of the following is required? Consent of minor's guardian, consent of registrar of firms, consent of all the partners of the firm, all the above. What is that? Consent of all the partners. More relevant one. Registrar of firms is irrelevant. If that was not there, you would have taken up all of the above. Registrar is not, because registration only is not required. Why do you need his approval and all? The implied authority of a partner of the firm does empower him to. Implied authority, what I can do, they are asking you, not about what they cannot do. Huh? See, immovable property I cannot, partnership I cannot, bank account I cannot, this I can. In case of transfer of share in a partnership firm by one partner to any third party, give such third party entitlement to interfere, to require accounts, to receive the share of profits, to receive the share of profits of transferring partner, whether or not agreed by the partners. What are these people? In case of transfer of share in a partnership firm by one partner to any third party, the third party people, can he interfere? Can he require accounts? He can only take the share of profits. Whatever I give you, you can take. Can you come and question me? Can you come and challenge me? Nothing you can do. Correct? Okay. State the modes by which a partner may transfer his interest in the firm in favor of another person under Indian Partnership Act. What are the rights of such transferee? How and all I can transfer? They're telling you, I can sell it. See here. A person can transfer by sale, mortgage, or otherwise cannot enjoy the same rights and privileges as the original partner. That means what? I can sell it, or I need loan. I can go and pledge it and I can take loan. And if I don't repay the loan, what will happen? Then that person will take away the share of partnership. So he will become a partner. So he can become a partner in these two ways. What are the rights? Whatever we saw. You can share the profits. You can be entitled for the capital during winding up. Apart from that, you cannot interfere with the management of the company. You cannot require accounts. You cannot inspect accounts also. But from the day we decide to dissolve, from the day you decide to dissolve, from that day you will be entitled for the books of accounts. Next one. Whether a minor may be admitted in the business of a partnership firm. Explain the rights of a minor in the partnership firm. Yes, he can be admitted for the benefits. The rights people, he can get the share of the profits. Can he inspect the books of accounts? Can he sue the partners? Only at the time of when you are trying to sever your connection. Generally, now people, yesterday I was telling someone, sir, how do we, I always tell, you need to remember the keywords. How do I know what is the keywords? I clearly wrote, now I'm telling you, you have the right to sue, you have the right to books of accounts, you have a right to share profits. If they do not give you, you can file a case. When at the time of severing your contract with the partnership firm, this severing is there, no. Now this is my keyword. If this is not there, you build one entire book, people. It will not even give you 1 mark. So put effort not to mug up this sentence, to mug up this word. So when you see, this minor thing comes into your mind, that word should come into your mind. Getting the point? On attaining majority, 6 months. I can either elect her or I can reject her. Measures XYZ and associates, a partnership firm with XYZ as senior partners were engaged in the business of carpet manufacturing and exporting to foreign countries. On 25th August, they inducted Mr. G, an expert in the field of carpet manufacturing, as their partner. On 10th Jan, Mr. G was blamed for unauthorized activities and thus expelled from the partnership by united approval of rest of the partners. Examine whether action by the partners was justified or not. What should have the factors to be kept in mind prior expulsion of a partner? What all I need to keep in mind? Is expulsion right? Why? 2 things I will say. He has done unauthorized activities. That means I have removed him in the good faith, in the interest of the partnership. Second one, people, it is a united approval. Now I'm telling, for the partnership expulsion to be valid, the power should be there in the partnership deed. All the majority of the partners have to approve. All Allah, majority have to approve. And the third thing is, it should be in the interest of the partnership firm. If not, such expulsion will be considered as void. A, B and C are partners in a firm. As per the terms of partnership deed, A is entitled to 20% of the partnership property and profits. A retires from the firm and dies after 15 days. B and C continue the business of the firm without settling the accounts. Explain the rights of the A's legal representatives against the firm as per the act. What are the rights there? Today only we saw, people. What is that? I can ask the 20%, that's my share of profits. Whatever business they did, I can ask 20% from that profits they will earn. I can ask 20% as a legal representative. Second one, people, I can even ask for, if this is not working out for me, I can ask 6% rate of interest. Nothing is given as whichever is less or whichever is more. It just says as per your share or 6% interest. Master X was introduced to the benefits of partnership firm with the consent of all the partners. After attaining majority, more than 6 months elapsed and he failed to give a public notice. Later on, Mr. L, a supplier of material of measures ABC and Co., filed a suit against ABC for recovery of the debt due. In the light of Indian Partnership Act, explain to what extent X will be liable if he failed to give public notice. Can L recover his debt from X? 6 months he did not give any notice, people. He will be deemed to be a partner, and I will be deemed to be a partner from the day I was admitted for the benefits, and hence, yes, I will be liable for Mr. L. Hello. Mr. A, transfer his shares in a partnership firm to Mr. B. Mr. B is not entitled for few rights and privileges as Mr. A. Discuss in brief the points for which Mr. B is not entitled during the continuance of partnership. We just saw transferee. Transferee is not entitled to all those things, whatever we saw. Yes? We'll do this also and go, or will... Okay, go. Next chapter, people, LLP. Together, let us do all the differences in this chapter. What is the difference between partnership, LLP and Companies Act? First one, people, what is the act? Indian Partnership Act, LLP Act, Companies Act. What is the partnership? What else is there? Partnership, people, no perpetual succession, no limited liability, and no separate legal entity concept. All these three things are there in LLP and Companies Act. Registration is not mandatory, mandatory. The minimum number of members required to start a partnership, people, 2, maximum is 50. LLP people, minimum number of partners, 2, maximum, no limit. Partnership company, private company, public company, 200, 7 and no limit. Next one, people, who carries on the business here? Partners. Who are the owners? Partners. Here, people, who are the owners? Partners. Who are the people who carries on the business? Partners only. Designated partners are nothing but they are people who are nominated only to take care of your legal compliances. The business, every partner is eligible to do, not only designated partners. Designated partners' role is only to make sure the legal compliances are taken care. What do I mean by legal compliances? Legal compliances means nothing but GST is filed, IT returns are filed, ROC is communicated. We are shifting our office. We were in this area. We went to another area. Did we communicate this to the registrar? A new partner is appointed. Did we tell to registrar? One partner left. Did we tell it to the registrar? That's the role of a designated partner and nothing else. In the business, everyone are the same and equal. Hello? Clear? Okay. Now, that is the case of LLP. Company people, owners are shareholders. Management is with directors. Partnership people, what is the document that governs the partnership? Partnership deed. LLP people, LLP deed and LLP Act. Companies Act people, MOA, AOA. And one more thing is, people, here you will have something called as profit sharing. Here also there will be profit sharing. Here, people, dividends. We will have dividends. It is not mandatory, but you may have dividends. Can a minor be a beneficiary? Can a minor be a beneficiary? No. LLP cannot have. In a company, can a minor be a shareholder? Directly not possible, but a minor through a guardian can be a shareholder. But remember, if the share is partly paid, the minor will not be liable. Whoever gave me the shares, they should only pay the rest of the partly paid amount. If 5 rupees is paid, whoever gave me the share, they should only pay the rest of the 5 rupees also. Minor will not be liable. Directly no, through guardian yes. Clear all of you? Okay, so these are basic natures of anything else is there you guys can think of? Is there a concept called as foreign partnership? Can foreigners be a partner in a partnership firm? Have you guys heard of it? No, not possible. Foreigners and all not possible here. In the LLP, possible. In Companies Act, possible. Partnership firm is not considered as a separate legal entity and hence partnership firm cannot invest money in other type of businesses. Only exception, partnership firm can be a shareholder in Section 8 company. That's the only exception. Partnership firm cannot be a partner in LLP. Partnership firm cannot be a shareholder in a company. But partnership firm can be a shareholder in a Section 8 company. That's the only exception. Can a LLP be a partner? Can LLP itself be a partner in another LLP? Can two LLPs come together and form one LLP? Hello? Possible? Possible. Just that, remember, when two LLPs come together and you form one LLP, always remember, you need to have two partners minimum satisfied. You also need to have at least two designated partners. Designated partners should always be individuals. Now here both of them are body corporates. Now what to do? You will nominate one of your partner as an authorized representative. They will also nominate one of their partner as authorized representatives. They will be called as a designated partners and you can start the LLP. Hello? Understood? Can a company be a partner in LLP? Is it possible? Can two companies, company A, company B, can they start one LLP? Is it possible? Hello? Possible? Yes, people, possible. Company A will appoint one person as authorized representative. Company B will appoint one person as authorized representative. They will become designated partners. And yes, you can start a company with two LLPs. Possible. Hello. Then these are some things that you need to keep in mind. Sir, in short, what is LLP, sir? LLP is nothing but people. See, in India, unfortunately, like for example, when I go to hotel, I have this notion. There will be North Indian thali, South Indian thali. Correct? Food. North Indian thali, South Indian thali. You will have, no? I like few items in South Indian thali, few items in North Indian thali. What to do? When I'm taking North Indian, someone comes with South Indian and sits, arre, that was there, I should have taken that. When I'm eating South Indian thali, when someone is eating palak paneer or when they're eating some gulab jamun, arre, I should have taken that. You feel that? Same thing happened, people, for a person who was doing partnership firm. He felt, arre, in Companies Act that is there. A person who was doing company felt in partnership firm, arre, they have so much of flexibility, we don't have. So we always felt the grass is greener on the other side. The first time they introduced North-South Indian thali. How? They put North Indian few items, South Indian few items, mixing, garra, and what came out, people, is called North-South Indian thali. Same way, a partnership was taken, a company was taken. We took all the good features of partnership. We took all the good features of a company. Together we made, people, something called as LLP. That's why we call LLP as a hybrid instrument of company and partnership. That's how the name came. One characteristic of company, limited liability, we took that character, LL. But end of the day, the core nature will be of partnership. We took it from P. That's how the name came, called as LLP. Understood? Limited liability represents the company form of business. Partnership represents the partnership form of business. So you will see all the flexibility of a partnership also, all the advantages of the company form of business also. That means you have perpetual succession, limited liability, separate legal entity, yes, unlimited number of partners. All these are the advantages of company that we took it. But remember, when I give you so much from company, whatever some disadvantages were, even that will also pass. Like, people, no flexibility. As I told you, you need to report everything to the registrar. It is not as flexible as your partnership. Mandatory registration. You cannot become unregistered LLP. Next one, people, remember, whenever any authorities wants, they can come and inspect, investigate on your affairs. Like on a company, however we do, on LLP also we can do the same thing. So such disadvantages will be there. But apart from that, people, all advantages from company was taken. See, all advantages from partnership was also taken and we retained it. See, certain disadvantages from LLP that was deleted. So putting everything together, we formed something called as LLP. Understood? Sir, in LLP, how many minimum partners are there? Minimum is 2. Sir, what if the number of partners go less than minimum 2? What happens? The law says you will be given 6 months time to increase the number of partners to at least 2. What if we do not do it, sir? If you do not increase the number of partners to minimum 2, whoever are the continuing partners, who is aware of it, will be unlimitedly liable. Yes, sir. From that 6th month onwards, you will be unlimitedly liable. Clear? So next one, sir, LLP should mandatorily have a designated partner. How many? There should be 2 designated partners. And remember, in this 2, at least one person should be a resident in India. That means what, sir? it's okay even if you are a foreign citizen, but you need to at least have one person who stays in India at least for a period of 120 days during the financial year. Remember, do not get confused between this and OPC. OPC says to become a resident, you need to stay in India for 120 days in the preceding financial year. In LLP, it is during. That means in the current year, you should be staying in India. That means what? Now, currently we are in the year 26-27, correct? Financial year. So, in this year, if there is an LLP, we need to have one resident in 26-27. This fellow should stay at least 120 days in the financial year. If I take OPC, this 26-27 will become 25-26. So one person should have stayed in India in the previous year. That's the difference. Remember, exam point of view, very important. And second thing, high chances you will get confused between this and OPC. OPC is previous. Designated partner during the financial year. Remember and go. Yeah. Minimum they are authorized to take care of legal compliances. I told you. Yes, sir. Okay, next one. How do we incorporate LLP people? We need to file something called as a form. The form we need to file. The form we file is called as people run LLP. We can reserve a name. The name will be reserved for a period of 3 months. The name will be reserved for a period of 3 months. And we file an application. Once the name is reserved, we need to, within this 3 months, we need to make sure we file all of the rest of the information. Like name of the partners, name of the LLP, address, everything I need to file people within 3 months. We file it in a form called as Philip. And in that, I need to get all the signatures, I need to get all the declarations, at least one professional has to sign. Because what is the guarantee all the information filed is true? So at least one professional has to sign. That is why we are reading all of this. We make money. So minimum you guys can make here for the certificate. At least today's price, if I have to tell you, in Bangalore you can charge is 15,000. That's the minimum charges that is there in Bangalore for this certificate. Yes, sir. So it's a good money. So for that we need to know. That's why we are reading all of this. Clear? Yes, sir. Sir, nice, sir. In a day I'll at least certify 40, 50, sir. I wish. I wish. Yes. Yeah. Remember, opportunities are there. Number of people are also there. So it will get divided. And second thing, when you are new, it is difficult to get a client. But yes, so once I file all of the people, if registrar is satisfied, registrar will give me a certificate of registration. And from that day, I will be considered as a registered LLP. Once I am registered people, I will enjoy the same benefits. What? Artificial person, I'll be considered as a body corporate. I can sue, be sued. I can hold properties in my name. Hello? Correct? Next one, sir. Difference. Body corporate definition, very important. What does the body corporate definition say, people? Is a LLP considered as a, what and all is considered as body corporate, people? Remember, LLP is considered as body corporate. Any LLP which is incorporated outside India, that is also considered as body corporate. A company incorporated in India is considered as body corporate. A company incorporated outside India is also considered as body corporate. So technically, LLP incorporated in India, outside India. Company incorporated in India, outside India. These four things are considered as body corporate. These four things are considered as body corporate. Sir, what about sole proprietorship? What about cooperative society? What about, here it's not there, HUF? What about trust? All of this, is it considered as body corporate? All these things are not considered as body corporate. Exam point of view, body corporate definition, important, remember and go. Next one, sir, financial year. What is the financial year, people? 1st April to 31st March. Sir, what if my company is incorporated on 1st September 2026? What is my financial year? It will start from 1st September 2026. It will end on 31st March 27. Sir, what if my company, my LLP is registered on 30th September 2026? When will my financial year end? 31st March 2020? என்னடா மச்சான், my company is incorporated on 1st October 2026. When will my financial year end? So that's the number. Remember, any LLP incorporated on or before 30th September, your financial year will end usually. If your LLP is incorporated your LLP is incorporated after 30th September of any year, then the financial year will not end usually. It will end in the next year. So instead of 27, you will have 28. The logic is simple. You are a newly formed entity. In 6 months, there will be no much business operations. So they say, combine it with your next year, together file one balance sheet P&L, that is sufficient to reduce your burden. That's all. That's the intention. Then remember, financial year important. What do you mean by small LLP? Again, people, important concept. What is that? Small LLP means an LLP in which the capital, in the LLP we call capital as contribution. The contribution does not exceed 25 lakh rupees and the turnover does not exceed 40 lakh rupees. If both the conditions are satisfied, people, you will be considered as what? Small LLP. Contribution does not exceed 25 lakh rupees and your turnover does not exceed 40 lakh rupees. You will be considered as small LLP. Hello? Okay, partners we saw, minimum number of partners we saw. Hey, who can be a partner? A partner has to be, he should be solvent. Second thing is, he has been found to be unsound mind. That means what? He should be sound mind. He should be solvent. He should have not even applied for the court to become an insolvent. Application should also not be pending. That means what? A person who has applied to the court to become an insolvent and the court has also decided you as an insolvent, you are also disqualified. A person who has applied to the court to become an insolvent, the court has not yet decided, you are also disqualified because tomorrow you will become disqualified. Understood? Exam point of view, remember and go, important. Minimum number of partners I told you, designated partners we discussed. Features of LLP, whatever we saw. Correct? People, one more thing remember, can I do non-profit organization in the form of LLP? Can I have like Section 8 company? Can we have like in the same in an LLP? Not possible. Always remember, LLP should be for profits only. Sir, can I convert one form of business into another? Can I convert a private company into LLP? Is it possible? Can I convert a public company into LLP? Is it possible? Can I convert a listed company into LLP? Is it possible? Yes or no? Remember, everything is yes, so except the last one. Listed company can never be converted into a LLP. Unlisted public company can be converted. Listed company can never be converted into LLP. Remember, hello. Sir, can LLPs have same name people? Is it possible? No. What happens if we have same name? There is a company, LLP, okay, there is a company called as ABC Private Limited. Another LLP called as ABC LLP. Can we have such things? Possible? Now what will the LLP do? Whoever was registered first, they will file an application, people, to the central government saying that, sir, they have copied my name. Whoever copied, they will file an application. Now, whenever you file an application, people, if central government thinks, yes, it is valid, what will central government do? Central government will give, let us imagine LLP only came next. Central government will give LLP people 3 years time to change its name. the central government will give you 3 months time to change your name. So once central government tell you to change your name from ABC to some other thing, if you don't change within 3 months, what will central government do? Central government only will allot you a new name. Hello? Sir, but sir, within how many days I have to go and file an application, sir, to central government? You need to go within 3 years from the day this LLP was registered. If I go beyond 3 years, people, the entire thing will be considered as ineffective. You cannot do anything in this regard.
That's the thing. After 3 years, like ABC Limited is a Karnataka company. ABC is a Tamil Nadu.
Wherever it is.
ABC have goodwill in Karnataka. ABC LLP.
Within 3 years only.
After 3-4 years, ABC LLP had another company. Another branch in Karnataka. ABC Limited from Tamil Nadu to Karnataka in front of ABC PVT. Now, both companies started like over 10 years. They have their names known. If something happened.
See, branch is not considered as a new entity. You need to take it as, now let us imagine ABC Private Limited has 3 years from the day ABC LLP started its business. Now it's been 5 years. We did not take any action. Done. My right is gone. Now ABC LLP, forget about, if let us imagine, your question is, sir, what if ABC Private Limited is in Karnataka, ABC LLP is in say Tamil Nadu. Now after 5 years, they start one branch office in Karnataka only. Forget Karnataka. They want to start a branch office anywhere in India. They can do it. They don't have any problem. Why? Branch office is not considered as a new entity. I need to take it only from the day the registered office was started. So when you started, from that day I will have 3 years. Branch office is irrelevant for me. Clear? Hello? Okay, done. Remember and go. Statement, as I told you, remember, whenever you are filing an incorporation, there has to be a statement filed by both partner and a professional, that we have followed the law properly. Very important. Partner and a professional. Advocate, CA, CS, CMA, anyone can sign. Certificate of incorporation will be given. Okay, done. Registered office of LLP and changes therein. Remember always, every LLP should mandatorily have a registered office. Tomorrow, if anyone wants to give a notice and all, so you need to have one registered office. So to that registered office, we will give all the notices, any information we need to give, we will give it to that address. Sir, what if I change that address at any given point of time? If you are changing that address at any given point of time, people, it is your duty to intimate that to the registrar. So sir, today I am in say this area. I shift my address to any other area. As I told you initially only, people, you have to intimate every information, every detail. So we will open the MCA website, people. Whatever details, address, partners are, we will take all the details accordingly. If at all you are changing anything, it is your duty to intimate and change. Clear? Hello? Pakka? Okay. So if any default is made in complying, well, that means now we are in Koramangala. That's the area in Bangalore. From here we go to some other area called as Jayanagar. Now we did not intimate to the registrar. It is considered as a non-compliance. The penalty will be what, people? They are telling you every partner shall be liable for a penalty of 500 rupees for every day, which can go up to maximum of 50,000 rupees. For the LLP and its every partner. That is going to be the penalty. That means what? 10 days I did not inform. 500 into 10. Every partner has to pay 5,000 rupees plus LLP should also pay 5,000 rupees. Understood? Hello? Effect of registration, once you are registered, as I told you, you will be considered as separate legal entity. You can sue, be sued and all that. Each person. Yes. Now, for example, if I am a partner, each partner will be liable to a maximum amount of 50,000. It's not every partner put together. So imagine if 20 partners are there, 10 days delay happened, it will be 5,000 into 20 partners. So now it is becoming 1 lakh. Yes, it's okay. Yes, sir, we did 200 days of delay. Each partner will be liable for maximum of 500 into 200. How much? 1 lakh. No, maximum is 50,000. So each partner cannot be liable for more than 50,000. Each partner. So let us imagine 500 per day na. We did a 200 days of default. How much is 500 into 200? Now can I ask partner to pay 1 lakh penalty? Maximum is 50,000. So sir, 1 lakh illa, please pay 50,000. Each partner. Now if you have 5 partners, you pay 50 into 5. 2.5 lakh. This is partners. Plus LLP will also pay another 50,000. Separate legal entity, no? You will be also punished. LLP will also be punished. Understood? All of you? Remember and go. Anything in LLP which we left off? Hello? Everything done? Done. Yes. Yes, people. The last unit, people. Negotiable Instruments Act. Okay, concentrate. Now, sir, what do I mean by negotiable instrument? Unfortunately, the negotiable instrument is not defined in the law, but it says what are the different types of negotiable instruments. It is given in section 13, which says there are 3 different types of negotiable instruments. One is called promissory notes, bill of exchange, checks. These are called as basically different types of negotiable instruments. Remember, there can be other types of instruments also, which is not given here. The best example I can give you of is called hundi. What do I mean by hundi? Hundi means, people, nothing but a negotiable instrument in a regional language is called as hundi. Yeah. So if you are entering into a bill of exchange or a promissory note in your regional language, that can also be regulated. If your agreement is silent, that can also be regulated by Negotiable Instruments Act. Remember. Yeah. Okay. Coming to the characteristics of negotiable instrument, more or less similar to both bill of exchange as well as promissory note. What is that? It has to be in writing. So oral is not valid here. Yes. Now, if you remember essential characteristics of a valid contract, which is not given under section 10, you saw other formalities, if any, has to be complied. So, as per Negotiable Instruments Act, for you to enter into a loan agreement, it has to be, if it has to be a bill of exchange or promissory note, it should be in writing. That's the meaning of other formalities to be complied. You have to comply this. Here, next one, it should be signed by the parties. The third one, it should be freely transferable up to the date of satisfaction. That means what, people? If one party is giving one instrument to another party saying that I have to pay you money, I will have to keep it in writing and I can further transfer it to any number of people. Now, for example, if we have to take one instrument, let us take this instrument. Now, this is one of the instrument people called as promissory note. In this case, what is happening? They are entering into one document. The value is 20,000 rupees. Remember, for a bill of exchange or a promissory note to be valid, it should be mandatorily stamped. So you need to take a stamp and you need to affix it. Hello? Remember, every check is a bill of exchange, but every bill of exchange is not a check. What is the difference? For bill of exchange, there should be mandatory stamp duty, but for check, there will be no stamp duties. Have you ever seen stamp affixed in check? This year, of course. Okay. Next one, people. Date: Rangoon, 16 December 1926. This is just to tell you how we were. These documents, these things, it used to exist Even in 18th century also we had. 17th century also we had. Yes, sir. It's not something that you guys are learning today. Clear? Even in kings and queen system also, when Britishers were there, we had negotiable instruments. Yes. If you go to, I don't know if you guys like history, if you go to Mysore and all, or there is one, I forgot the place, it's called as Art of Library of Historical something. It's there in near Kabban Park. You can, where? Alala, here in Bangalore it's there, one library. You can find documents as old as 300 years and all. It's a library, but it will not be given to home. You have to refer it there. You can see big people. You will be seeing all you have in your own languages, right? All people who speak about history and all. You will have this YouTube channels, they and all do. You can find at least one person if you go there. Pakka they will be there. They'll come and sit for hours. In fact, I have seen a few people who come constantly for 5-6 days they will come. Because it will be a 200-page document. You are not supposed to scan it. You are not supposed to take it outside. You have to make a note sitting there. Because these are all original documents. And certain things, so manuscripts and all will be there. Very fragile. Newspapers will be there. Of 18th century, 19th century and all. Yeah. So all those things will exist. Yes. If you want to see, all these are good things. Okay, on demand, we promise to pay at the Imperial Bank of Rangoon. Remember people, when we are seeing the rules of presentation, we'll be seeing rules of presentation, right? Hello? Rules of presentation, you'll be seeing where do we have to present the instrument. We'll be having this, right? Place of presentment. You need to present it at the place specified in the agreement. Is it specified? Now on the date of maturity, I need to go to this place. Sir, what if nothing is mentioned? I will go to the place. What is the next rule? See, if nothing is mentioned, general, that means what? Wherever the person works, I will go to his office to collect the money. Sir, what if I don't know where he works? Go to his home. Sir, what if I don't know the place of residence? So, place is not mentioned. You don't know where he works or where he carries on business. You don't know where he resides. You can present it anywhere you find him, even on road. That's the rule of presentment. Understood? Anyways, it will come. That's why I've done everything here only. Hello? Clear? Okay. Now, sir, okay, so I have to give it. Sir, now see, on demand, these people are agreeing. Who are these people? Somasundaram Chettiar. You don't know? You don't know how to read Tamil? Somasundaram Chettiar. You don't know? Okay. What the nonsense. You don't know how to read Tamil also. Okay. So Somasundaram Chettiar. Somasundaram only, you got it? Somasundaram Chettiar people has promised to pay on demand 20,000 rupees to OAOK CJ Karuppan Chettiar. OAOK CJ Karuppan Chettiar, I have agreed to pay what? On demand 20,000 rupees at Imperial Bank of India, Rangoon. Correct? Hello? Now, sir, so should it be only OAOK CJ Karuppan Chettiar? I also say, or what is order? Sir, Karuppan Chettiar has taken loan from someone. What will Karuppan Chettiar do? Karuppan Chettiar will turn this and he will write, pay to Mr. Nakul and OAOK CJ Karuppan Chettiar G Ano. He will sign. Now what will happen? Mr. Nakul will go to Imperial Bank of Rangoon. He will give this to Somasundaram Chettiar. Somasundaram Chettiar will say, hey, who are you da? He'll say, my name is Nakul. You had to pay money to OA CJ Karupan Chettiar. No, that Chettiar ji has given me this instrument because he had to pay me money. Rather, he said, why should I take and give it to you? You only directly go and collect. Hello, this is only called as freely transferable. Now, let us imagine Nakul has to give money to someone, say, anyone, Satish. Now, Sati, what will he say? Pay to Satish. Nakul will sign. This can go on up to the date of maturity. Any number of times. There is no limit. This is only called as what people freely transferable. This is the basic nature of a negotiable instrument, people. What is that? All the negotiable instruments are freely transferable up to the date of maturity. Understood? Hello? Pakka? Okay. And what does it say? Okay. Next one, sir. It is freely transferable. It should be an unconditional promise. Unconditional means what, people? I cannot say if I earn this much salary, I will give you your money back. So remember, it should be an unconditional promise. Any uncertain events and all, I will not allow. Certain events are okay. Certain means what, people? Which will happen. That means I will pay you money on 1st of August 2026. 1st of August will happen, no? But from July directly will go to 2nd of August. It will come, no? So whichever is certain, such agreements are okay. I cannot tell you I will pay you when you get married. Marriage is again an uncertain event. You never know. I never know. It may happen, it may not happen for you. Now, in such case, such agreements are not valid as per negotiable instruments. Anything certain, valid. Uncertain, not valid. Next one, people, it is to pay money only. And remember, instrument must be delivered. I can't write everything and I only can't keep it. It is considered as instrument is not valid. The first type of instrument is, sir, it's a promissory note. What do you mean by promissory note? It is an unconditional undertaking. Undertaking means, people, nothing but promise. You look at the words he wrote. We undertake to pay. OA, OK, CJ, Karupan, Chettiar. So, I am telling, I am promising to pay that fellow on the date of demand. Hello? To make a certain sum of money only to him or to his order. Correct? Hello? Okay. Sir, my question is, can I prepare a promissory note instead of OA, OK, CJ, Karupan, Chettiar? Can I write here bearer? I'll pay money instead of writing so many times. I will pay money to the bearer of the instrument. Can I say it? That means what? Whoever has the instrument will get the money. Can I write like that, people? Is it possible? Yes or no? Remember, people, you cannot use the word bearer. Only one person can use the word bearer. Who? RBI. There is a logic also behind it, people. Why? Remember, people, if I write it off as bearer, no, it will become a currency, da. Now imagine I had taken money from you. I will give you, instead of 10,000, I will give you this instrument. Till today we used to give money. Now I am giving you instrument. You have taken some money. You will also give instrument. Second currency took birth. That's why, remember, the word bearer cannot be used by anyone except RBI. Go home and see. Take a currency note. You'll be seeing one promise on your currency note. Your governor would have said, I undertake to pay this bearer 1,000 rupees, 2,000 rupees, 20 rupees, 50 rupees, whatever is a currency. The governor will say, we are promising you to pay. RBI's governor will sign it. So only and only RBI can use it, no one else. Any doubts here? No. That is what is the thing they have written here. Exam point of view, very important. Remember, you cannot make an instrument bearer. You cannot write the word bearer. Hello? Sir, okay, I'll write it this way. I undertake to pay rupees 50,000. Can this be considered as a valid instrument? No. When you do not write the name also, it will be considered as bearer instrument. Only RBI can do. Hello? A promissory note cannot be made payable to bearer. Only RBI or CG has the power as per section 31 of RBI Act. Remember, important exam point of view. So, parties in promissory note, one is called as maker, one is called as payee. Generally, what happens, people, in a promissory note, maker draws the instrument, I will give it to the payee. The payee will keep it until the date of maturity. On the date of maturity, I come and present it, I'll get the money. Characteristics are similar to negotiable instruments only. There will be no difference. It should be in writing. It should be stamped, freely transferable. That characteristics will remain the same. Next one, people, is called bill of exchange. Bill of exchange, people, who are the parties involved. What do you mean by bill of exchange, people? Bill of exchange is nothing but generally what happens. Let us imagine there is one seller who has sold some goods to the buyer. The buyer said, sir, I need some time to repay. I can't pay you immediately. I need some 2 months to repay. So you did a credit sale. What will the seller do? The seller will send you the goods. Along with the goods, people, I will also send you one document that is called as bill of exchange. I'll write everything. You, the buyer, has taken the goods worth 10,000 rupees from me, and I hereby order you to pay 10,000 rupees with an interest of 100 rupees after 2 months from today. I write this bill of exchange. I only prepare. I will send it to the buyer. What will buyer do? Buyer will keep the goods. Buyer will look at the bill of exchange because he need to know what amount and all has been written. Buyer will see. He will accept it. He will send back the bill to the seller. Hello? That's why, people, in bill of exchange, there are 3 parties. The person who draws the bill is called as drawer. The person on whom the bill is drawn is called as drawee. The person who is entitled for money is called as payee. It can be drawer only or it can be any other person also. Is this clear? So the bill of exchange will have 3 parties. Remember, if the drawee says, drawer, you prepare the bill, you only keep it, I need not see it, I will pay, you go. If I say that, people, then showing the bill to the drawee is not required. But if drawee says, no, I need to know what amount you have written, what interest you have written, I need to know before I pay. If I say that, people, remember, drawer should show the bill to drawee. Drawee should sign the bill. Hello? This is only called as, people, after sight. When the drawee has said, I need to see the bill will be valid only from the day the drawee accepts it. When the drawee accepts the bill, he becomes the acceptor. Clear? Hello? Done? That's your bill of exchange. Any doubts here? Hello? No? Okay. What are the different types of bills, people? The bills can be of, based on parties, the bills can be classified into one as bearer instrument, one is order instrument. Name is not, meaning if name is not written, name is blank, it becomes a bearer instrument. Whoever has the bill, you can pay to them. Order means name is written, you are supposed to pay only to that particular person. Next one means, people, based on validity, the bills can be classified into 2. One is called as inchoate instrument, one is called as ambiguous instrument. What do I mean by inchoate? Inchoate means, people, incomplete. What do you mean by incomplete, sir? I have written the entire instrument, sir, but remember, I have left the amount blank. This is called as, people, inchoate instrument. Meaning everything is there, but amount is blank. Why do we give that? When we do not know what is going to be the value, we keep the amount blank. Such type of instrument is called as what, people? Inchoate. Do you guys know how do we take the stamp duty? It is always a percentage of the value of your instrument. Generally, let us imagine it will be 0.025 percentage. That means what? Okay, for our information, let us keep it as 0.5 percentage. Now, if the value of the instrument is 20,000, you need to take 0.5 percentage worth stamp duty. And how much is that? 200 rupees. 100 rupees, 200 is 1%. Correct, no? 2000 is 10, 200 is 1, 100 is 0.5%. So I need to take 100 rupees worth the stamp. Hello? Clear? What happened? Yes, so I need to take, here I have taken one anada, but I'm telling you example, that's all. This is 1926. Rules have changed a lot. So I need to take the stamp paper. Hello? Clear? So when parties agree clearly, people, I need to pay whatever is the amount that we have agreed in the contract. I need to pay only that much of amount. But remember, if I am a holder in due course, then how much I can recover? I can recover the money up to the value of the stamp duty. Remember that. Correct? I hope you guys know. Hello? Yes, sir. Yes, sir. Say no or no. Yes, okay. Next one is called as people, what is that? Ambiguous instrument. What do you mean by ambiguous instrument, people? People, a bill which can be treated as promissory note also, bill of exchange also, is called as what, people? Ambiguous bill. Generally what happens in promissory note, there are two parties. In bill of exchange, there are three parties. Clearly one has two, one has three. I can tell what is promissory note, what is bill of exchange. But at times what happens, people, a drawer draws a bill upon himself and he tells, I make the payment to a particular person. So a self-drawn bill. So drawer and drawee becomes the same. And there is another person, payee. Now there are two parties. So a self-drawn bill will have only two parties. So you can get confused with promissory note, because both will have two parties only. Such type of instruments can be called as ambiguous instrument, because it has both the nature of bill of exchange also, nature of promissory note also. In such case, what to do? Remember, the holder can decide. If you want to treat it as promissory note, if you want to treat it as bill of exchange. Once you treat it as promissory note, you cannot go back. Once you treat it as bill of exchange, you cannot again go back. So you take your time, you decide it once, whatever you decided will be final. Clear? Yes, and one more type of ambiguous instrument is, let us imagine, at times the drawers draw the bill on a fictitious person. That means what? For example, I will draw a bill, Mr. A will draw a bill on a person called as Mr. XYZ. Who is XYZ? This fellow does not exist at all. Benami, fictitious. Hello? Now what happens? I will give it, payee is, let us imagine Mr. B. Now on the day of maturity, Mr. B will go and present the bill to Mr. XYZ. Where is XYZ? Who knows? Because that person does not exist at all. Such people are called as fictitious person. Now where will I go asking for the money? This fellow is not there. So where will I go? I'll go to Mr. A only. So technically what happened? There are two parties. This fellow does not exist. That's why I call this as ambiguous instrument. Even though there are three parties, one fellow is not counted. He is not there in the game at all. So this becomes two. Again, this is also called as what, people? Ambiguous instrument. Clear? Yes, this is one type of the instrument. Next type of instrument is called as, people, based on place. Either it can be inland, one more is called as foreign. What do I mean by inland instrument, people? Simple, you need to remember three conditions. If a bill is drawn in India, it is called as an inland instrument, Indian instrument. Sir, what if the bill is not drawn in India? It's drawn outside India. That's all. Don't check any other condition. It becomes a foreign instrument. Next one, sir, if a bill is drawn in India and if it is payable in India, or the person who pays, drawee, should reside in India, any one condition should satisfy. So if a bill is drawn in India and if it is payable in, say, Bangalore, it is called as what, people? Inland instrument. Or a bill is made in India, it is payable in Canada, but the person who pays, drawee, resides in Bangalore. It is called as inland instrument. Sir, a bill is drawn in India, but it is payable in Canada. The person who pays resides in Canada. It is called as a foreign instrument. Sir, a bill is drawn in Canada, but the person who pays resides in India and it is payable in India. Remember, drawn outside, directly it's a foreign instrument only. Understood? Hello? So remember these three, you can answer both. Clear? Is this clear? So these three are very important. Clear all of you? Yes? Top mandatory to satisfy. In this, any one should be satisfied to become an inland. If both are not satisfied, it becomes a foreign. Clear? Yes? Okay. Next one, sir. Foreign instruments, people remember. Sir, what if there are, if it's a foreign instrument, which law will apply? If it's a foreign instrument, people, wherever the bill is drafted, that law only will be applicable. Wherever the instrument is made, that law will be applicable. However, what if the bill is endorsed? If the bill is endorsed, people, wherever the bill is payable, that law will apply. In short, in simple, we'll explain it this way. Let us imagine a bill was drawn in, say for example, US. This is where the bill was drawn. Yeah. Let us imagine the drawer resides in US. Sir, the drawee resides in, let us imagine, I don't know, say Pakistan. Not applicable, but let us take. Drawee resides in Pakistan. Yes, let us imagine the payee resides in New Zealand. Complicated only, let us take. Now it's a foreign instrument. Foreign instrument, let us imagine, in US the rate of interest is 6%. In Pakistan the rate of interest is 10%. In New Zealand, people, the rate of interest is 12%. Now the question is, sir, let us imagine which law will apply to the instruments we prepared. Which law will apply? First thing, people, bare minimum, it's a foreign instrument, correct? Everything is outside India only. So of course it's a foreign instrument. Now which law will prevail? The law is telling you, people, wherever the instrument was drafted, that is where that law will apply. So which law will apply? US law will apply. Now what happened, sir? Let us imagine the payee endorsed the bill to another person, meaning he transferred. To whom did he transfer? He transferred to a person who is in India, where the rate of interest is, say for example, 15%. Till now any doubt? I endorsed it. Clear? On the date of maturity, the Indian went and asked money from the Pakistan person. Sir, you need to make the payment. No, sir, you have not paid. Please give me the money. The Pakistan person became insolvent. He became insolvent. Now the question is, people, you tell me which rate of interest is applicable. Now the bill was endorsed. So the payee from New Zealand, he transferred the bill to India. Hello? Yes or no? The moment the bill is endorsed, whichever is the place where the bill is payable, that rate of interest will apply. So the moment, people, the payee gave it to the person in India, the bill is endorsed. Now people, remember, the law that will apply is, people, wherever the bill is payable, that is Pakistan. So second scenario, when the bill is endorsed, Pakistan's rate of interest will apply, that is 10%. Hello? Wherever bill is made, payable. Now, sir, I went. He became insolvent. He became insolvent. He is not paying. Now, people, if the drawee becomes insolvent, whom will I go and ask the next person? Whom will I go and question? The person who endorsed me, I will go and ask the payee. The person in New Zealand, wherever the bill is made payable will apply. So when the drawee became insolvent, people, I will go and catch hold of payee. The rate of interest is 12%. New Zealand rule will apply. Sir, let us imagine the payee also became insolvent. Ultimately, where will I go? I'll go to US. So he is the person now who is going to make the payment. In his country, how much is the rate of interest? 6%. Now, last scenario, 6% will apply. So you have to put everything in one. What is the rule? Simple. On a normal day, for a foreign instrument, wherever the instrument was made, that law will apply. US, first scenario. Second scenario, if the bill is endorsed, then wherever the bill is payable, that law will apply. So ultimately, see where the bill is being paid. Wherever the bill is paid, in that country, whatever is the rate of interest, that law will apply. Exam point of view, very, very important. Clear? Hello? Done. Next one, sir, based on time, the bill can be classified into demand and time instrument. Not that important for us. Demand is people, whenever I ask for money, you need to give. Whenever I ask for money, you need to give. Time instrument means people, you will pay me after that fixed time. For example, this instrument is the best example of demand instrument. That means you gave me the instrument today. I'll come and ask you the money tomorrow. You have to give. Time instrument means people, I would have mentioned this bill is payable after 3 months. So you need to come after 3 months. Clear all of you? Yes. Okay, that is the types of instruments. Next one, sir, negotiation of instruments. How do we negotiate instrument, people? Depends upon what type of instrument it is. If it is bearer instrument, people, nothing, people, just to transfer the instrument. No endorsement required. Meaning what? If it is bearer, your name itself is not there. So no signing required. If it is order, that means what? In our instrument, people, OA, OK, CJ, Karuppan Chettiar, name is there, no? How will you endorse? Turn the paper, write it, pay to so and so person. You need to endorse it. Endorse means signature is mandatory. Sign it and deliver it. I repeat, sir, two types of instrument. Bearer instrument, how do you endorse it? Just delivery is sufficient. If it is payable to order, delivery plus endorsement is required. Endorsement or endorsement. Endorsement means, people, nothing but signature. Hello, all of you. Sir, there is a scenario. A has signed a bill. He wanted to transfer it to a person called Mr. B. He has kept it in his drawer. But people, before delivery only, A passed away. Before delivery only, A passed away. A's legal representative C saw the bill. Now, can C just hand over the bill to B? Is it considered as valid endorsement? Yes or no? Remember, upon death, a mere delivery cannot happen. When the person has passed away, you cannot deliver the instrument and you cannot call it as an endorsement. This is not a valid transfer. So, if a valid transfer should happen, it should be within the lifespan of a person. If not, you need to wait for the inheritance and you sign a new bill and you do it. This bill cannot be endorsed. Not possible. Is this clear, all of you? Pakka? Hello? Done. Next one, sir. Check. What is a check, people? Check is a check. It is a bill of exchange. See, every bill of exchange cannot become a check, but check is always a bill of exchange. What is the difference between check and a bill of exchange? One I told you. What? It is always, remember one thing, check is always payable on demand. In check, people, drawee is always constant. It is always a bank. Third one, people, for a check, there is no stamp paper. So that's why I can say all checks are bill of exchanges, but all bills of exchange cannot become checks. It's a bill of exchange on a specified banker. So remember, in a check also there will be three parties, right? In check also there are three parties. Who are the three parties in a check? One is drawer, drawee, payee. Whichever is the bank which has to make the payment, that is called as drawee. So drawee in the case of check is always a bank. For whosoever name I have written in the check, this person is called as a payee. The person who gives you the check is called as a drawer. Hello? Clear? People, if date is not written, the check is always payable on demand. If nothing is written, if date is written, the check is payable on that day. Again, I repeat, if nothing is written, the check by default becomes payable on demand. You go and deposit, you will get the money. If date is written, the check has to be redeemed within 3 months. 3 months time will be given to you from the date written here. Hello? If I go to now imagine 3 months I did not deposit the check. After that, sir, that check becomes a stale check. Legally not enforceable. Understood all of you? Hello? Okay. Now, sir, checks are, check includes check in electronic forms. Nowadays, you get e-form checks also, which people use it in systems. They sign it using digital signatures and all. That is also considered as check. Next one is called as truncated check. What do you mean by truncated check? Nothing but people, your checks scanned copy is called as truncated check. Generally, what happens when you give a check to your person, you issue a check to the payee, no? What will a payee do? He will go and deposit with his bank. What will that bank do? That bank will take a image of your check. They will scan it. They will forward it to SBI. Your person has given us one check to take money from you. Can you please transfer? SBI will transfer the money to the payee's bank account. Now there is so many transactions that happen. Physical check, if it keeps moving people, it may be forged, destroyed, risk is there. That's why what do? We stop the physical flow of check and we convert it into electronic form. We call it as a truncated check. Truncated check is also a check only. They can ask you, rarely they have asked, remember. Types of check, open check, cross check. Open check is nothing but which is payable in the counter. Cross check which is payable only in the account. Not important for us. Parties 3. Done. Correct? Sir, dishonor of a check, section 138, very important. Remember and go. What does it say, people? Section 138. Whenever people, a drawer gave you a check, he wrote it, please go and deposit in the bank, my bank will make the payment. He gave you a check. Remember, people, always section 138, nothing but check bounce case can only be used for a legally enforceable debt. That means what, sir? Imagine it's your birthday. A gave you a check to B as a gift. Now B went and deposited in the bank. The bank said A has become insolvent. Now can B go and file a case in the court? Is it possible? No. Remember, gift is not a legally enforceable debt. So if you have earned the money, you will go to the court, you will have all the right. If it's free, you will not get any right. Just like Contract Act, quid pro quo, you will not get any right. Hello. Another example I can give you is gift, inheritance. In inheritance, what happened? There is a check which you got, but for nothing you got. If it becomes insolvent, that means what? You did not earn it. You got it by will. If money is not there, you can't go and file a case and all. Hello? Remember. So see, gift, donation, security is not covered in this section. You know what do you mean by security? Remember, people have taken some loan from you. As a collateral, instead of giving gold, I gave you a security. This check value is 10,000 rupees. I've given it to you as a security. Even that also cannot be considered as what, people? Legally enforceable debt. So 3 things, remember and go. On these 3 things, they can ask you a question. These words itself are important. Hello? Hello? Yes, you're giving some charity to someone. Donation. Same thing, not enforceable. Clear? Okay. So, sir, drawer gave the check to the holder. What will the holder do? Holder will go and deposit the check in the bank. So, I will give it to the bank. I need to do it within 3 months, or any other period mentioned on the check, whichever is earlier. So generally the checks are valid for a period of 3 months from the date written on it. If I go after 3 months, you will not get any right. The check will be stale. Now what will the bank do? If the bank has money, the bank will make the payment. If your account does not have money, people, the bank will return the check saying that people, there are insufficient funds. They will give it to the holder. What will the holder do? The holder will give the notice of dishonor to the drawer. Hey drawer, you have given me the check note. That check came back to us saying there is insufficiency of funds. Now what do we do, drawer? Drawer people, to avoid any further legal cases, within 30 days people, if you want to save yourself, you make the payment at least now. Now sir, let us imagine within 30 days also if I do not make any payment, sir, that is, sorry, within 30 days I have to give him a notice. Once I give him a notice, people, he needs to make the payment to me within 15 days. Within 15 days also if I do not make the payment, people, I have a right to go and file a, remember, check bounce case is a criminal offense as well as civil offense. It's a criminal offense as well. I will go and file a case in the court. All of this is not required for you. You can strike this off, the last part. Yeah, jurisdiction also is not required for you. This is there. Within next 1 month, if within 15 days, if I do not make the payment, within 1 month, I can go and file a case in the court. Not required. Yeah, the court can order for people. This is there for us. Remember this part. Fine is there. Only this part. Fine is there for us. This is not there. Yes, the court can order a, what is that, penalty, people? How much? I can send you even to jail up to 2 years, or I can impose a fine on you up to 2 times of the amount of the check. Remember in exam, if they have given you the value of check as say 1 lakh, please do the calculation and write. The penalty can go up to 2 lakh rupees. Show that. Don't just write off up to 2 times and leave it. Hello. Understanding? And remember, fine is in addition to the check amount. You have to give the 1 lakh also plus fine is 2 lakh. It's not like I give 2 lakh and my duty is done. Hello. Understanding? So that is your check bounce thing. Any doubts here? No. Who is a holder in due course? Not there in our syllabus directly, but I'm generally telling you what do you mean by holder in due course, people? See, generally we have 2 types of people. One who just gets the instrument. He just gets the instrument. Second person, he earns the instrument. There are 2 types of people in negotiable instrument. One who gets the instrument. One who earns the instrument. We will call him as holder. We will call him as holder in due course. In the law, this person will always have more power when compared to this person. Best example only I'll give you. You got a check as a gift. You are a holder. You got a check as a payment for the goods you supplied. You will be earning the check. You will be called as a holder in due course. Law will protect him more than him. Best example is check only. Correct? This is not enforceable at all. People, you tell me a case where A gave a check to B. He told him to go and deposit in the bank. I told him to go and deposit within 2 months. But within 1 month only, A got to know there is no funds. A tells the bank himself, if someone comes and asks you for the payment, please don't accept the money. Please don't accept the check. Don't make any payment. Or A calls B and say, hey macha, money is not there. Please go and don't deposit the check. Please don't go and deposit the check. So I made him a phone call. Now my question to you, this phone call, can I consider it as a dishonor? Now because you told me not to go and deposit, I will not deposit. Now after 3 months, you will say, You did not deposit, that's why you did not get the money. Is this case considered as dishonor of a check? Where a drawer calls you and tells you to, where a drawer calls you and tells, please don't deposit the check. Is this considered as dishonor of a check? Hello? Yes or no? One of the exam question, remember and go. It is in Supreme Court, in one of the case they have said, a drawer intimating the drawee or the payee not to present the check itself can be considered as dishonor. Then why did you give the check? If you tell me not to go and deposit. In Supreme Court judgment it was given as, it is considered as dishonor. So he calls me and tells, no, that day itself I can consider the check is dishonored. So I need not have to follow this entire procedure. I can still directly go to court. Remember, exam point of view, they may ask you. It's there in our syllabus. Clear? Hello? Okay. The next two things that we have, important things is what people, the first one, navigation of presentment, nothing but people, presentment of instruments. Always remember, you present the instrument for two things. One is for acceptance, one is for payment. One is for acceptance, one is for payment. Can you guys tell me which instrument is which instrument is presented for acceptance? Which instrument is presented for payment? There is bill of exchange, there is promissory note. Can you tell me which is presented for acceptance, which is presented for payment? Promissory note is presented for payment, and bill of exchange is presented for acceptance. Remember, promissory note is drafted only by the debtor. I have already seen, I have only drafted, I gave you. That's why I need not accept it. So remember, promissory note is never presented for acceptance. Whereas in bill of exchange is written by, drafted by a drawer. So, drawee needs to know what is drafted. So, only bill of exchange is presented for acceptance. Now, the question is, which is the instrument which is presented for payment? Every instrument. Whether bill of exchange, promissory note or check, end of the day to get the payment, you have to show it, no? So, remember, presentment can come for both. One is for acceptance, one is for payment. I'm just summarizing every rule for you here only. Next one, sir. So, whenever I present it, within how many hours or within how many days should the person accept the bill?
3 days.
3 days, 1 day, 24 hours, 48 hours. Remember, sir, the bill has to be accepted within 48 hours. If you take more time, that means what? Now, drawer has drawn the bill. I've given it to the drawee to accept it. Acceptance, I'm telling. The drawee took 72 hours just to accept the bill. People, bill is already considered as dishonored. So, dishonor can happen in two scenarios also. Non-acceptance is also a dishonor. Non-payment is also a dishonor. Hello? I hope you are understanding. Okay. So, where will I present the bill? Whether for acceptance or payment, where will I present the bill? First is place mentioned in the bill. Not mentioned, business or where the place he works. Nothing, residence. Nothing, you can present it wherever the person is found. Hello? Is this clear? That is what is these things that they say. Sir, and when I should present the bill? You should always present the bill, people, on a business day during business hours. Presentment for site is always only a reasonable time. Failure, it will be liability, whatever I told you. Drawee's time, people, how much? Beyond is considered as dishonor. These two things, leave it here. Next one is time of presentment, people. I have to present it you in the usual business hours. Correct? Huh? At maturity, instruments payable after date or site must be presented exactly at maturity. Sir, what if the promissory note or bill of exchange is payable in installments? Remember people, I hope you guys know the instruments always carry something called as grace period. How many days? 3 days. Some bills, what happen people, some instruments are payable in installments. That means what? Sir, the instrument is 1 lakh. I said I will pay every month 10,000 rupees. When I will pay, I said every first of the month I will pay you 10,000 rupees. So if it's one time payment, I know I get 3 days grace period. In installments, how do you take grace period? Remember, for every installment you will enjoy a grace period. So January, again I get 3 days. February, I'll get 3 days. Any one installment you miss, it is still considered as dishonor. That is what they are telling here. Clear? Hello? Sorry, where? Here. Must be third day. After first date of each installment. Hello? Okay. Next one, sir. Presentment of check people. Same thing, is nothing but people, presentment of check, I need to present it to the bank before the time mentioned, and I need to present it in the bank hours, not after the bank hours. So remember the check part and go. The next one is people, when is the presentment unnecessary? Again important. When is the presentment not required? That means, see, technically I told you, you have to present the bill either for acceptance, you have to present the bill either for payment. But when is this presentment not required at all? These are the scenarios, exam point of view, important. See, no presentment for payment is necessary and the instrument is dishonored at the due date for presentment in any of the following cases. When people, if the maker, drawer or acceptor intentionally prevents the presentment of the instrument. What do I mean by that people? You are trying to reach me. I will not be reachable. You're trying to call me. I'll be not reachable. You'll come to the place. I'll tell my employees to tell I'm not in the office. So when you're intentionally preventing people, I will not present the bill is considered to be dishonored. Second scenario, if the instrument being payable at his place of business, he closes it on a business day using business hours. That means what people, if at all you told me to come to your business day for taking the payment, I came to your business place. It was a Monday. It was around 11 o'clock in the morning. You have shut down your business. I can consider I will not present the bill. The bill is assumed to be dishonored. Next one people, if the instrument being payable at some other place, you said me to come to Imperial Bank of India, Rangoon. I went there, some other place. I came, you did not come. I need not present the bill. The presentment is unnecessary. The bill is considered to be dishonored. Next one, if the instrument not being payable at any specified place, then where will I go? I'll go to his work. I did not find. I'll go to his residence. I did not find. Wherever I did not find. So a person absconded. Absconded means people, I'm not finding him at all. The bill is dishonored. Presentment is unnecessary. Next one, sir. As against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. This is simple case. I have to go and present the bill. The drawee himself has said what? It's okay, Kamda. Whether you come with the bill, you do not come with the bill. I know you that I have to pay money. I'll pay you money, whether you come with the bill or not. So a person has agreed himself to pay the bill without presentment. You need not have to present the bill. Next one. As against any party, if after maturity with knowledge that instrument has not been presented, he makes a part payment or promises to pay or otherwise waive off to take the advantage. What do you mean by this people? Simple. On the due date, I have to pay 50,000 rupees. The due date, let us imagine, was 1st of August 2026. I go. Hello? So 1st of August 2026. What happens, sir? I should have presented the payment. I did not present. I realized it on 5th of August. Grace period, everything is done. I go, I say, I'm so sorry, I did not come on 1st August. That fellow, instead of taking advantage, he made a part payment. Macha, take 20,000 today, you come tomorrow, I'll pay the remaining amount. In such case, presentment is now unnecessary because you made a part payment, you will have to pay the remaining full amount also. Technically, what people, you did not take the advantage of the situation, scenario. Technically, he did not present it on the 1st of August. You're discharged. On the due date, if the person does not present it, you are discharged. You did not take the advantage of it. If the person does not take the advantage of it, he is telling, I will make the payment even without the presentment, or I promise to pay in the future. Give me another 3 days time, I will make the payment. In these 3 scenarios, people, remember, presentment is unnecessary. So I can get the payment whenever I go, if the other party is not taking the advantage of it. Yes, sir. Last scenario, sir, as against the drawer, if the drawer could not suffer damage from the want of such presentment. Simple, sir. Why did I not present the bill? Because I just told you, the drawer himself told me, please don't deposit the check. When you only told me not to present, I did not present. So, sir, drawer does not suffer any damage here because I followed your instruction. In such case, sir, presentment is not necessary. The call itself is sufficient for considering the bill to be dishonored. Understood? Yes, sir. Yes, sir. The last part, sir, is what people. What is the last part? Law. Rules of compensation. For first rule of compensation, people, what am I eligible to get as a payee? If 20,000 rupees is written on the bill, I am eligible to get the entire 20,000. But remember, people, if you did not pay me here, we had to go to court. Now, all that is an extra expense on me. Yes, that here we call it as noting and protesting charges and all. Remember, if I have to get all of that done, if you did not pay me simple, I had to go to court and all. When I am recovering the money, I will recover the money on the instrument 20,000, also the legal charges from you. That is the first scenario. Second scenario, sir, remember A has to get the money from B. Where is B? B has gone to outside India. Where is B currently staying? Let us imagine B is in US. The maturity date was, people, 1st August 2026. Now, unfortunately, what happened? You asked me to come to a place. I have come, but you have not come. Now, you tell me, just to make the payment, will the person come from US to India? He said, Macha, please don't worry. I will send you the payment from US only. Is it okay? A said, it's okay. Who cares whether you come here or not? For me, payment is important. You send it. I don't mind. How much money should B send? B has to take the current today's rate of exchange. Now let us imagine if I have to receive 1 lakh rupees. Please calculate how many dollars will give this person 1 lakh rupees. Because the loan was taken 2 years back. You are sending dollars from US to India. It has to convert. Remember, $1 will give you 96 rupees, 97 rupees, as the case may be. This number will keep on changing. 2 years back, probably this number was 70s to 80s. Which day's rate of exchange I need to take? They are telling you, you need to take the current date rate of exchange. So you need to send so many dollars, whichever will give me 1 lakh rupees. If you have to get it, do 1 lakh divided by 96. You will get some amount. You need to send so many dollars. Understanding? So you need to take that conversion on today's date of exchange. Hello? That is a rule. That is what second one says. Next one, sir. An endorser who being liable has paid the amount due on the specified entitled amount so paid with interest at the rate of 18. What do you mean by this, people? Let us imagine A has drawn a bill given to B. B accepted and gave it. A endorsed it to C. C endorsed it to D. D went and asked the money. B dishonored the bill. Now because B dishonored, where will D go? D went to C. Now C, to avoid any headache people, C made the payment. But technically, don't you think C should also get money from A? Now C will say, A, you had given me the bill noda, I went to B, B dishonored. Can you please make the payment for me? Now people, remember, A may take 1 month, 2 months, 3 months, 4 months, 5 months. For every day of delay, you can charge A 18% rate of interest per annum. For year it is 18%. So you need to take proportionately. They can ask you a question here, remember and go. Hello? Sir, what if we are from two different places? A is in US. Same rule, cut, copy, paste will apply. You can send from US only. You need to take the current rate of exchange between two places. Whatever is the denomination, please take that. Today $1 is equal to 97, you send that much only. Same second rule will apply. So now I have a doubt. A has to pay money to C. What if he doesn't pay in the future? If you want to be safe, you can add one instrument. A has to pay me money to C at the rate of 18% per annum. It will be paid within 9 months. For your safety and security, if you want, you can enter into a new instrument as well. If you feel safe, you can enter into a new instrument as well. Clear? This is rule 3, 4, 5. Rule 3, whoever pays the money, endorser, he can collect the money with interest 18% per annum. If endorser and the whoever is the drawer, if they stay in two different places, I can collect the money at the rate of exchange whatever is prevalent today. Rule 4. Rule 5. If you want to be safe and secure, you can reduce this entire transaction into writing and you can form a new instrument. Rule 5. Clear? Rules of compensation, very, very important from exam point of view. Hello, this is your negotiable instrument. Any doubts, sir? Nope. Okay, go for a break and come. Yes, people, let's do the unit 3. Unit 3 we should do, no? Okay. Unit 3, people. Registration of a firm is compulsory, optional, occasional, none of the above. Optional. An unregistered firm cannot claim set on and set. As per the accepted view, the registration of the firm is considered complete when complete application for registration is filed with registrar. Registrar files a statement and makes entries in the register of the firm. Registrar gives notice of registration to all partners. Court records the statement and certifies the entries in register of firms. A and B. Hey, if complete application is filed, in the registration is complete. Registrar files and make entries. This is when it is complete, no? Application on file matter saka. Yannada macha. Yannada pasingale. Hey boys, then dal chawal eta. Sunday noda full special Hey, Sunday. Hey, I know da. What Nasreen? What was there da?
Sir, even say the menu also.
He simply ate, She didn't eat oil, Nasreen is like, why eat? Did he ask you all that? Okay. Okay. A partnership firm is compulsorily dissolved where all partners have become insolvent. Firm's business has become unlawful. The fixed term has expired in case of A and B only. What? A and B only. On which of the following grounds a partner may apply to the court for dissolution of the firm? Insanity of a partner, misconduct of a partner, perpetual losses, all of the above. All of the above, no. Quote root. Which of the following do not constitute a ground for dissolution by court? Misconduct by partner, transfer of interest by partner, just and equitable grounds, insolvency of a partner. Which of the following do not constitute a ground for dissolution by court? Which one? They transfer of interest, the remaining partners can go and ask, Noda. Yannada macha. Upon dissolution of firm, losses including deficiencies of capital shall be first paid out of what? Out of profits. And then out of capital. And then out of personal assets of the partners. Yeah. Okay. Eighth one. Public notice in case of a firm is not required in case of admission, retirement, expulsion, dissolution. Admission though definitely. Okay. Which of dissolution also you need to give no. When a firm dissolves, you need to tell about that thing to the people. Which of the following do not constitute a ground for dissolution by court? Insanity, business carried on at loss, willful misconduct, expulsion of a partner. This is a different thing. Dissolution of partnership between all the partners of a firm is called as dissolution of partners, partnership, partners, dissolution of firm, reconstitution of the firm. Dissolution of the firm. A partnership firm has to be registered with director, registrar of companies, competent court. In settling the account after dissolution, the firm's assets shall be first applied in losses including deficiencies of capital, payment of partners' loan, payment of partners' goodwill share, distribution to partners in their profit sharing ratio. Settling the accounts after dissolution, the firm's assets shall be first applied in what? First losses. First I have to pay that. After that I need to repay. People, first you will utilize profits to repay. Then you will utilize capital to repay. Then you will ask the partners to bear the loss. That is while repaying. What if we have excess? If we have excess, first you will repay outsiders, creditors. Then you will repay loans and advances by the partners. Then you will repay capital. Then you will repay excess, if any, will be distributed amongst the partners. Remember that. Losses, this is the order. If you have sufficient money, this is the order. Clear? Okay. 13th one, people. XYZ, concentrate on, are partners in a firm. Due to differences amongst the partners, there is a deadlock in the management. X applies to the court for dissolution of the firm. Will he succeed? Yes on just and equitable. No, no, yes. What? Deadlock of a management is just and equitable grounds. Yes, sir. 14th one, they concentrate. A firm is compulsorily dissolved on the death of a partner, adjudication of a partner as an insolvent, expiry of a fixed period for which the firm was constituted, business of the firm became illegal due to happening of an event. D. Even after death you can continue. Hello. Insolvent. If 5 partners are there, one partner becomes insolvent, you can still continue. Expiry of a fixed period, you can still continue. You become partnership at will. Illegal, you cannot continue. The partnership deed does not include the date when the he opened and kept. Mr. A, partner of ABC Associates, give notice in writing to all the other partners, that is Mr. B and Mr. C, of his intention to dissolve the firm on 1st September 2020. Such notice was dated on 30th August 2020. In the given case, the firm stands dissolved with effect from. We saw this also. What is the effective date of dissolution? If the date is written, the effective date will be from the day it is mentioned. If the date is not mentioned, then the effective date of dissolution will be from the date of receipt of notice. Remember, see, such things can be tested. Correct? Huh? Okay. Next one. A firm may be dissolved with the consent of, here what is the scenario? 1st September. Because it is clearly written, no, date is mentioned. A firm may be dissolved with the consent of all the partners or in accordance with the contract between the partners. Such dissolution is known as dissolution by contract, dissolution by agreement, dissolution by will, dissolution of partnership. Dissolution by partnership agreement it is. It is a full name, but they say dissolution by agreement. Okay. The statement for the purpose of registration under section 58 of Indian Partnership Act can be signed by any one partner, legalers, all the partners, agents of partners to the firm. All partners or their agents specially authorized. Okay. What is the procedure of registration of a partnership firm under the Indian Partnership Act? What is the procedure, people? You need to submit a statement along with the name, address, details of the partners, their details, type of partnership, all that, duration, everything. Along with that, if it is delay, along with a delay of 100 rupees per year, have to submit it to the registrar. Registrar, if it is satisfied, will make the entry in the register of firms and issue a certificate of registration. Remember, I hope this is, I don't think I told you this when we are doing. The partnership should not carry these words in its name. What are the words? It cannot have the word emperor, king, royal. All those things should not be there. Common doubts asked by the students is, sir, king, Fisher is there, no. Royal, Enfield is there, no. Yeah, sir, then how is that all possible? Remember, I am telling you, they listened. I am telling you people here, as per Indian Partnership Act, it is not possible. Royal Enfield is not a partnership. Kingfisher is not a partnership. They are all companies. I am telling you, as per partnership, it is not possible. And second thing, King is different, Kingfisher is different. King is not allowed. Kingfisher is a... Thanks, Macha, you said bird. I thought you'll say beer. Nice. Yes, Kingfisher is a bird. Yeah? He's selling bird. Hey. Yes, Sam. So Kingfisher is a bird. King alone is restricted. You don't combine. Getting the point? Yeah. So under Partnership Act, it is not allowed. First of all, Kingfisher is a company. Companies Act will apply. So there are differences. Under partnership, you are not supposed to use these words. Now you can also say, sir, I know partnerships which use these words also. I know. Remember, it is still possible after taking the approval of the government. Take the approval. If you take it, people, then yes. Nakul is like, Yappudra Macha Siddharth, how do you know all this? Siddharth replied, hey, I just saw. See, minute information will know. Yes. When does dissolution of partnership firm takes place under the provision of Indian Partnership Act? When does dissolution take place, people? It can happen, people, voluntary as well as by court. Voluntary is all of those things where you become insolvent or together voluntary, you guys go and accept, everyone becomes insolvent, everyone but one becomes insolvent on happening of certain contingencies. That is voluntary. Mandatory, when you become permanently disabled or a person becomes unsound mind or misconduct, continuous loss, perpetual losses, so just an equitable, write down all that. Indian Partnership Act does not make the registration of firms compulsory, nor does it impose any penalty for non-registration. In the light of the given statement, discuss the consequence of non-registration of partnership. What is the consequence? What is the consequence? We cannot file a case. They can file a case. People, we cannot file a civil case. That means what? Let us imagine someone did a criminal offense to us. We can file a case. Civil suits cannot be filed. Criminal cases, whether you are registered or not, that is not a ground for, restricting you from filing a case. Remember, civil cases cannot be filed. criminal cases can be filed. Allu. Okay, you cannot claim set off. Okay, and I mean 100 rupees. Okay, and outsiders can file a case on you, and you cannot file a case on the firm, but partners can file a case for dissolution, for settlement of assets. All that is allowed. That's all. Okay. Next one, LLP. Takatak will do off. MCA enforce the LLP Act with effect from. When? 31st March 2009. Yes. Whether partnership law applies to the LLP? Whether partnership law applies to the LLP? Of course, no. State which of the statement is correct under LLP Act 2008. All partners have unlimited liability. All partners have limited liability. Which of the following cannot be converted into LLP? Partnership private. The approved name of LLP shall be valid for a period of dash from the date of approval. Name of LLP shall be ended by or LLP. Which one of the following statements about LLP is incorrect? An LLP has a separate legal personality from that of its members. The liability of each partner in LLP is limited. Members of LLP are taxed as partners. A listed company can convert to LLP. For the purpose of LLP, resident in India means what? Allah. Where is it? Yes. Bah, so easy, huh? Okay, examine the concept of LLP. Mixie, put to company and it is only called as what, people? Mocktail. Hey, LLP da. Yes, so people, whenever there are any good advantages, disadvantages, understood? Yes or no? So basically, which enjoys separate legal entity, perpetual succession, limited liability, separate from its members. It enjoys a body corporate. It can hold properties in its name. It can sue. It can be sued. It can have common seal. Write down everything you write down. Enumerate the various characteristics of LLP. Yes, Adida. What? LLP and body corporate, perpetual succession, separately foreign LLP. Understood? See this. They have written something foreign. We don't even know what. Just like your answer. They have written just foreign. You complete. Who cares what? Foreigners can be partners. Foreign LLP can also be there. Remember, a LLP incorporated outside India, if it has a place of business in India and carries on business activity in India, you will call it as a foreign LLP, just like a foreign company. What do you mean by designated partners? Whether it is mandatory to appoint designated partners. What is a designated partner? The people who are appointed for the purpose of taking care of legal compliances as appointed under Section 7 of LLP Act. They are called as what, people? Designated partners. Every LLP should have mandatorily at least 2, one of whom shall be resident in India. 120 days during the financial year. What are the effects of registration of LLP? You will become a body corporate. You can sue. You can be sued. You can hold properties in your name. You will be considered a body corporate. LLP is an alternative corporate business form that gives the benefits of flexibility. No. It is an alternate corporate business form that gives benefits of company and flexibility of partnership. Explain what you will write. Write that only. But benefits are taken, advantages are taken, disadvantages are eliminated. Explain the essential elements to incorporate a LLP. Tell the essential elements, it seems. Hello, what are the essential elements of? 2 parties coming together and entering into day. Minimum should be 2 partners. Performing a active. எப்படி எப்படி எப்படிரா okay. Okay people, what is LLB people? LLB means, as almost what Nakul said, almost 95% being wrong. Two parties, okay, until two parties is correct. Yes people, two parties. What are the main other essential creatures? I mean essential things that you need to do. You need to file a form. The form can be form fill-up. It is all done electronically. You need to reserve a name. The name will be reserved for 3 months. Within 3 months, you need to complete the complete registration process. The LLP should have minimum 2 partners. It should have minimum 2 designated partners. The designated partner should one should stay in India. They should mandatorily have DPIN, designated partner identification number. All this is mandatory. Hello? Hello? Okay. That's all. Children. Okay. Companies Act 2013. Maximum number of members in a private company. 200. The document that regulates the management of internal affairs. Articles of Association. Under the Companies Act, significant influence means at least 20%. Associate company da? Hello. Section 2 clause 6. A private company which is a subsidiary of public company is also treated as public company. A private company which is a subsidiary of a public company will be treated as public company. Which one of the following is not the content of MOA? Name or registered officer, board of directors. An act which is said to be ultra vires of a company when it is beyond the powers of the company directors. Nada questions. Turkan rule is related to doctrine of ultra vires, constructive notice, indoor management. The bank case I explained you. The minimum number of members in a private company and public company are 2 and 7. Only a natural person who is an Indian citizen and who has stayed in India for a period of at least dash days during the immediately preceding shall be considered as either incorporated OPC. XYZ Limited is having 15% of share capital held by X Limited and 50% held by Cent and 10% state. 20%. While what are they? See, why did I study? The doctrine of indoor is a protection that is available to shareholders, outsiders, directors, creditors, students. Outsiders. The doctrine which advocates the fact that the company cannot act beyond the scope of its MOA is called. What is meant by a guarantee company? State the similarities and dissimilarities between a guarantee company and company having share capital. We saw it in detail also, people. What are the similarities? The liability is still limited only. Hello? Whether you are accompanied by a guarantee or this, the liability is still limited only. The basic nature of the company, there will be no change, people. What is dissimilarities? What is the difference between company limited by guarantee and company limited by share? One, when do you bring in the money? If it is company limited by share, you bring in the money on day 1. Because it's a capital, you introduce the money on day 1. When do you bring in the case of company limited by guarantee? When do you bring in the capital? During the time of winding up, when the capital is insufficient. That's the biggest one. Hello? Hello? Okay. Can a non-profit organization be registered as a company under Companies Act? If so, what procedure does it have to adopt? Yes, people, possible. Section 8. Section 8 company, nothing but you should be registered for the purpose of promoting the object of charity, commerce, education, sports, art, culture, etc. Okay. And you need to apply for special license from central government. Central government will allot you a special license, and only then people you can enjoy all the privileges of Section 8 company.
So once the license is revoked, what will happen to that asset, sir?
That's what you can either wind up, you can convert, or you can amalgamate with any other Section 8 company.
Once it is filed,
Sir, let us imagine Section 8 company is winding up. Whatever is the money that is there with Section 8 company, what will happen to that money? That money will be first utilized to pay all the liabilities. Excess, if any, that money will be taken by central government. There is a fund that is created. That fund is called as Insolvency and Bankruptcy Fund. To that fund, you need to transfer all the money. Yes, sir. And what else, sir? A Section 8 company need not use the word limited or private limited in its name. That's all. It does not, it prohibits declaration of dividend to the members. Excess, if any, whatever is the profits earned, you are supposed to use it only for the purpose of promoting its objects.
if they have any other assets or liabilities.
Sell it, transfer the money to insolvency and bankruptcy fund. Let us imagine it makes lot of difference. Instead of selling it, if I'm able to preserve it, you can rather, instead of binding up and selling it, amalgamate with any other Section 8 company. It will be a use of someone else. Both are allowed in law. Amalgamation is also allowed, or transfer to central government fund is also allowed. Briefly explain the doctrine of ultra vires. What are the consequences of ultra vires acts of the company? What is ultra vires, people? Going beyond the object clause of the company, what is the consequence? People concentrate. Ennada Nakolji. This guy, you spoke and he's telling this guy. You tell I will not solve. Now, people, what does it say? Ultra vires people, consequence people, it does not create any contract between the company and the outsiders. Whoever entered into a contract will be personally held liable. And remember, ultra vires transaction of the company, even the majority of the shareholders cannot ratify the contract. But ultra vires the directors, intra vires the company, shareholders can ratify it. Hello? Okay, explain clearly the doctrine of indoor management as applicable in cases of companies registered under Companies Act. Explain the circumstance in which the outsider dealing with the company cannot claim any relief on the ground of indoor management. Basically, they're asking you what is indoor management, exceptions to indoor management. Indoor management is nothing but it tries to protect the outsiders from the company. Whenever anything the company is trying to do, the outsiders will not be aware of the internal decisions of the company because we do not have an access to. So this doctrine tries to protect the outsiders from the company. Exceptions, people, knowledge of irregularity, suspicion of irregularity, forgery, all these are the cases of exceptions. An assessee had large income in the form of dividend and interest. In order to reduce his tax liability, he formed 4 private limited companies and transferred his investments to them in exchange of their shares. The income earned by the companies was taken back by him as a pretended loan. Can A be regarded as a separate from the private limited company he formed? You can write, people, this is nothing but a case of lifting of corporate wheel. So see, how will I write? They concentrate another half an hour, both of us liberation. For you 50%, for me 500%. Another half an hour, please see. Okay, done. Come on, Sai, concentrate. Yes, people. Now, people, what does the law say, people? See, how do I frame this when they are asking me? Now, they are asking me, they have given a scenario. How will I frame my law? My provision goes like this. What? It's the case of doctrine of lifting of corporate wheel. The corporate wheel will be lifted, people, whenever there are scenarios. Now, the question is, if it is asked for 3 marks, 4 marks, do I have to write all 4 scenarios? No. Directly write off. The judiciary enjoys the right to lift the corporate wheel in the case of when the company is used for the purpose of evasion of tax. When you guys tell me what do you mean by keywords, evasion of tax, it's there, you will get 1 mark. Who cares what you wrote before and after? Doctrine of lifting of corporate wheel, underline, you will get 1 mark. Always remember, every law answer will have 2 things, or I will say 3 things. Imagine like this. There is a heading, there is a subheading, there are keywords. You write only heading. Out of 4 marks, you will get 1 mark. If you write heading, subheading, you will get 2 marks. You write heading, subheading, keyword, you will get 4 marks. Most of us, 60% will get blocked here. Maximum will come here. Here though, becoming very, very difficult. So I'll tell you what you mean by keyword in this scenario only. My heading, doctrine of lifting of corporate wheel. My subheading, evasion of tax. My another heading, keyword. This case is similar to Dinsha Manekji Petit. Done. I will get 4 marks. Hello? If you write just the doctrine of corporate wheel, you'll get 1 mark. I hope you are understanding. Yes? Okay. I'll tell that probably after all of this is done, we'll tell it even more detail. So Dinsha Manekji Petit case people, yes, lifting of corporate wheel, him and the company will be treated one and the same. He is liable to pay all the taxes. Sound Syndicate Limited, a public company, its articles empowers the managing agents to borrow both short and long-term loans on behalf of the company. Mr. Little, the director of the company, approached Easy Finance Limited, a NBFC, for a loan of 25 lakh in the name of the company. The lender agreed and provided the above said loan. Later on, Sound Syndicate Limited refused to repay the borrowed money on the pretext that no resolution authorizing such loan have been actually passed by the company, and the lender should have inquired about the same prior providing such loan, hence company not liable to pay such loan. Analyze the above situation. One more thing, I have told you, today's date they are trying to help you. They could have just stopped it here, analyze the above situation and give your answer. Now why do I call it as a help? They will tell you under doctrine of indoor management, it's a help. Hello? Second one, and examine whether the contention of Sound Syndicate is correct or not. Remember, answer to the point. Don't write something and all. They're asking correct or not. You either write correct or incorrect. And they're asking you whether the contention of Sound Syndicate is correct. They will be writing people. It's a doctrine of indoor management people. Turkyan's rule. Royal British Bank versus Turkyan people. Indoor management. If at all it is not having the details in the articles of association, outsiders do not have any information about the things that happen inside the company. So we as outsiders people, we are not liable for the internal matters. Doctrine of indoor management, outsiders will be protected, and hence the contention of Sound Syndicate Limited is incorrect. Are you understanding? Hello? This you will see in lot of questions today. Okay, next one, sir. Examine the following when they are correct or incorrect. A company being an artificial person cannot own property, cannot sue or be sued. Incorrect people, they can sue, they can be sued, they can hold properties in its name. A private limited company must have a minimum of 2 members, while a public limited company must have a minimum of 7 members. The statement is correct as per section 3 of Companies Act. The minimum number of members required to start a private company is 2, OPC is 1, public is 7. Mike Limited is incorporated in India, having liaison office at Singapore. Explain in detail the meaning of foreign company and analyze on whether Mike Limited would be called as foreign company as it established a liaison office at Singapore as per the provision of Companies Act. Is it a foreign company? No. Why? It is directly incorporated in India. It's an Indian company only, and it's not a foreign company. Google India example, whatever we saw. Yeah. So to be called as a foreign company, you should be incorporated outside India. You can have this liaison office in India, branch office in India. then you will become a foreign company. Hello? ABC Limited has allotted equity shares with voting rights to XYZ Limited worth 15 crore during the financial year. After that, the paid up equity share capital of ABC Limited is 100 crore. Define the meaning of associate company and comment whether ABC Limited and XYZ Limited would be called as associate company as per the provision of Companies Act. Associate company is a company in which other company holds significant influence, includes a joint venture. Significant influence means people, company which holds 20% of its total voting power or such control, but up to 50%. Correct? In this case, out of 100 crore, how much I am holding? 15 crore. Please show it in percentage, which amounts to 15%, which is less than 20%, and hence it will be termed as associate company. If you can go that extra step, they will also give you that extra mark. Remember. Hello? How you guys will write? No. Do whatever you want. No only is my answer. Understood? Okay, the last one, people. Negotiable instrument. Yes, people, last one. A negotiable instrument is an instrument which is freely transferable from one person to another person just by way of endorsement and delivery. But of course, depends upon type of instrument also. Yes, if it's a bearer instrument, just a delivery. If it's a order instrument, endorsement and delivery. An instrument which is vague and cannot be clearly identified either as bill or promissory note is called as ambiguous. As per negotiable instruments, negotiable instrument means how many parties are there in bill of exchange? On which of the followings, even not defined in Negotiable Instruments Act 1881, provisions of the Act are applicable? Hundis, I just gave you hundi as an example, all of this. Yes, if you cannot find law anywhere else, Negotiable Instrument Act will apply. Which is not an essential characteristics of bill of exchange. It must be in writing, must contain an express promise to pay, instrument must be signed, it must be stamped. Out of this people, we can say B. But it has to have an express promise to pay. Yes or no? No, this is bill of exchange. Sorry, I thought negotiable instrument. Must have, that it becomes, this is a promissory note, no? Hello, my bad. Which is not an inland instrument. Sixth one, B. Which is not the essential characteristic of bill of exchange. B is the essential characteristic of promissory note, no? Correct? Hello? It is an promissory note is an unconditional undertaking. Bill of exchange is an unconditional order. I am not promising to pay. I am ordering you to pay. This will not come at all. Correct? Which is not an inland instrument. Inland instrument what? Drawn in India and payable in India or drawee should reside in India. Whichever is that right answer. Promise are not made in India. Okay. Payable in India. Drawn upon a person resident in India. Which is not. Then directly go to, okay, everything is made in India only. Hey, Yanada, everything is looking same for me. Made in India, payable in India, drawn upon person resident, okay, outside India. Person made in India, payable outside India. Drawn upon person resident in India. See, this is inland only, correct? Made in India, payable in India. One condition at least satisfied. This is also inland. Promise is not made in India, payable outside India, but drawn upon a person resident in India. Inland only. Made in payable outside, drawn also outside. Hence, foreign. So the answer is this. Negotiable instruments which can be treated either as is known as already done, no? Ambiguous. Order instruments can be negotiated by By delivery only, endorsement. Where any check drawn by a person is dishonored due to insufficiency of funds, such person shall be punished with, we already saw, imprisonment 2 years or fine up to 2 times of the amount of the check or both. Hey, both alada. That is also one of the penalty or both. He's telling both. Ayyo, Bhagwan. Arre. Happens. Dal chawal. What is the answer? Imprisonment 2 years, twice, both. Both. Correct? M drew a check amounting to 2 lakh payable to N and subsequently delivered to him. After receipt of check, N endorsed the same to C but kept it in his safe locker. After some time, N died and P found the check in N's safe locker. Does this amount to endorsement under Negotiable Instruments Act? We saw it today only. Remember, when a person dies, mere delivery cannot be considered as endorsement. M owes money to N, therefore he makes up people whenever there is question from bill of exchange, one more thing, or towards the end I'll put everything and we'll do one something like things to remember. Now then I'll not tell. But remember, you need to remind me, sir, you said something, you will tell in negotiable instrument. Yeah, I will forget then also. Tell me that, sir, you said something like draw. I'll tell you. M, if you forget, your headache. M owes money to N. Therefore, he makes a promissory note for the amount in favor of N. For the safety of transmission, he cuts the note in half and posts one half to N. He then changes his mind and calls upon N to return the half of the note which he had sent. N requires M to send the other half of the promissory note. Decide how rights of the parties are to be adjusted. Simple people, a negotiable instrument for endorsement. How should you endorse people? It should be a full delivery. This part delivery is not considered as a valid delivery. You need to deliver the instrument as a whole. This part and all is not recognized under the law. So for the endorsement to be valid, whoever it is, M or N or N to M, you need to deliver the instrument as a whole. This half and all is not valid. Simple. Hello? Hey, Bholenath drew a check in favor of Surender. After having issued the check, Bholenath requested Surender not to present the check for payment and gave a stop payment request to the bank in respect of the check issued to Surender. Decide under the provision of negotiable instrument whether the said act of Bholenath constitute an offense. Today only we discuss people. Remember, you telling your instruction to the bank, stop the payment, or you calling the payee and telling them, please don't present the bill in the bank. Both are considered as offense only. Under section 138, you can consider the check as dishonored. Hello? Okay. Rama executes a promissory note in the following form. I promise to pay a sum of 10,000 after 3 months. Decide whether the promissory note is a valid promissory note. Remember people, if you do not write any name, it becomes a bearer instrument. Bearer instrument people, only one person enjoys that. And who is that people? RBI. So hence, because of that, such a promissory note will not be considered as valid because it becomes a bearer instrument. I have never written the name only. It becomes equivalent to a currency. Hello? It's not possible. Hey, someone came. Nakul, you're famous, da? Nakul made promissory note in favor of Sahadev of 10,000 and delivered to him. Sahadev endorsed the promissory note in favor of Arjun, but delivered to Arjun's agent. Subsequently, Arjun's agent died and promissory note was found by Arjun in his agent's table drawer. Arjun sued Nakul for recovery of promissory note. Whether Arjun can recover amount under the provision of Negotiable Instruments Act 1881? Can we? The answer is very simple, people. Endorsement can be made to a person or to any agent of the person also. I can give it to you or I can even give it to the agent. In our case, we gave it to the Arjun's agent. Giving it to Arjun's agent is like giving it to the principal only, giving it to Arjun only, and hence Arjun will get a right. Arjun can enforce the contract. He is eligible to recover the amount. Hello? Yes, sir. That's all. Yeah, you also clap, beta. Yes, I did it. Macha, I did it. You also do it still. Now my obligation is not. Hello? People, so wishing you guys all the best. Also, another thing is there. No, will do. Huh? Yes, people. So in this video, what let us try to do is, let us try to focus on your RTP applicable for September 2026 and onwards. So in this, let us try to see the last questions. Let us try how to answer. And I'll try to also tell you how to even read the question. As I always tell, right, there will be hints in the question. We can pick up that and we'll be able to write the answer. So I'll also tell you the art of reading the question also, one of the most essential thing, so that you will not get confused, sir, which provision to apply, this or that. That only is a confusion. Let us try to see that also. And also let us try to sum up what are some common mistakes that the students do. Let us try to avoid doing that. Clear? Yes, all of you? Okay, chalo. So first thing, yes, an amendment is there applicable for your attempt. Small company is not 4 crore and 40 crore. For your attempt, it is paid up capital not exceeding 10 crore, turnover not exceeding 100 crore. And rest of the conditions is as it is. That is other than public company, that is as it is. Clear? Okay. Yes, sir. Let us start with questions. What is that? What do you understand by law? Also elaborate the procedure of making law. What is law, people? Law is something like set of rules and obligations which govern the country. It can be different types of law, social, economic, as the case may be. How is the procedure to make law? Now, what is the tip here, people? Again, if I have to tell everything in one place, okay, tip number 1, always remember, common mistake students do, you should not do. The first question should be your most confident question. Remember, reach early, read the question paper carefully. Not only first, if you ask me, people, please try to maintain at least up to 1 to 3 or 1 to 4 questions. Please try to maintain utmost clarity. Don't write these questions in your own words. Pick up such questions only. And generally, what will students do? Sir, writing a direct question is easy. No. Trust me, you know, I know that we don't know a direct question. If you ask me, for us, direct question is the most difficult one compared to an indirect question. Because direct question is, you know the concept, but you know nothing directly given in the book. 1 or 2 points you will know. It will be for 5 marks. So you know, I know that it is our biodata. You have written something. Or people, you would have done the jalebi of the same one sentence. Yes, I would always suggest, let the first question be a indirect question. Yes, always. Clear? And point number 2, just now I told you, there will always be, people, 3 things in your answer. Provision. So go with the format. We have already discussed what is a format. The format people try to stick to. The first paragraph will be your provision. This should be the maximum part. Let us imagine if it is a 5 marks question, your provision carries 3 marks, your facts carries 0 marks, your conclusion carries 2 marks. So facts is nothing but people, it is the artistic way of presentation. For the answer to look right, you're writing facts. Keep it as less as possible. 2 lines, 3 lines, more than sufficient. Now, when I'm writing the format, I told you this is a format, remember. Now, how to get that 3 on 3, sir? This is very, very important. Just now, whatever we saw people is, our answer will always have 3 main things in it. If you just want 1 mark, just write the heading. Yes. Now, for example, people, there is a transfer of property from a father to a daughter. The father met with an accident. The daughter wants to claim the property. They're asking you, is this a valid contract or not? What will you write? So the father has written everything on a piece of paper. Yeah. So is it a valid contract or not? There will be a question. Now what will I write? For me to get this entire 5 marks, this is how the answer will go. First heading, people, I will write exceptions to quid pro quo. That is my heading. Exceptions to quid pro quo. That is my heading. Now there is a subheading also. What is that? For a contract between father and a daughter to be valid, it has to be, subheading is now important. It should be out of natural love and affection. Now comes people keywords. Now I have just written, it is quid pro quo, natural love and affection. Now under natural love and affection, people, there are keywords. What is that? The document should be mandatorily in writing. They should be in near relationship, and people, it should be mandatorily registered. How long did it take us to write this? Now remember, if this is there, you will get 3. Now any sentences connecting these 3 things, you write in your own language, it's absolutely fine. It will make 0 difference. But please don't change anything in these 3. This is the art. Now from today, when you guys are writing question paper, remember this. Your mind has to first tell you, heading, have you written? Subheading, have you written? Now check for are there any keywords. If you write only heading, you will get 1 mark. If you write heading, subheading, you will get 2 marks. You write heading, subheading, keywords, you will get all 3 marks. Hello, is this clear, all of you? Now, point number 4, you figured out what to write. Please don't write everything in a paragraph. Please try to put it into points. And point number 5, I know what to now underline. Please underline them. Underlining is the key. Please don't give extra effort to the evaluator. Let us respect their job. Hello? Very, very important. All of you, I don't know if I have answered this question in the class or not. Now, most of you will have this doubt. Sir, should I remember the section? Is it important for your level? Forget. I'll be the only faculty telling in this country to tell, forget the section. And I mean it. Don't worry. It's okay. Remember, you are in the first stage of CA. They are not going to expect so much out of you. You are kids. If you are able to write it, it's good. And I'm telling you, and I mean it. People even writing final level, they will struggle to remember sections. Do you really think they will deduct 1 mark for you not writing the section? Answer is no. I am a living witness. I have seen papers who have got 80, 78, 76 without quoting even one section. So stop putting efforts here. If you can remember, of course, you can impress little. I'm not denying the fact. But if you do not know the sections, it's okay. Do not stress your mind. Our opening statement, as per the relevant section or as given under the Indian Contract Act, this topic comes under, write down like that. That will be your opening statement. Is this clear, all of you? Hello? Pakka? Remember that. Seventh one, most important one. Remember, please maintain the time. Your first 1 hour, you should be done with at least 30 marks. Your second hour, you should be at least around 60 marks. God has given you an exceptional talent to cover people 100 marks. It is 40 marks in the last 1 hour. That means what? Constant check on time is very, very important. Do not realize it. Don't look at the time in the last hour. And that time, people, please don't draw bullet trains. We don't want snakes and bullet trains in the answer. You know, I know that we don't know anything that they have written there. And don't come and tell me that time, sir, I attended 80. You know, I know. The last 3 questions is bullet trains. Correct? So maintain decent pace from question 1. Very, very important. Do not overwrite. Do not overwrite. Especially don't waste time on facts. It's okay. And I'm telling you, in the last 1 hour, you'll be writing those questions. No, don't even write facts. It's okay. Leave facts. Because remember, writing one whole question is more important than you filling the facts, which will not even give you 1 mark. Are you getting the point? Yes, that is very, very important. Do not overwrite or underwrite. What do I mean by do not overwrite or underwrite? Remember, people, if at all, the best thing I can tell you is, if there is a difference between, you are expected to write all the points. You're expected to write all the points. You can't just pick up the, what do you say? Sir, 3 marks, no. 3 points I've written, more than sufficient. If 7 points are there, you're expected to write all the 7 points. Sir, next one, in difference between, we'll have one more question, sir. Should we write the basis of difference? If you can remember, very good. If you cannot remember, try to add the basis of difference in the difference only. Now, for example, definition, instead of writing, directly write what agreement defines as. So definition, define is there, underline that. Hello, getting the point? And this is where I told you to remind me, you didn't tell me. Draw. Now what is draw? Illa, not right time. Now people, remember people, whenever they're asking you anything in Indian Contract Act or Sale of Goods Act, especially Negotiable Instruments Act, draw it. Who is seller? Who is buyer? Who is what? Because the characters will be confusing. It will be, remember, you will be seeing 30 different characters. Who is what only you will forget of. Draw means what, sir? I take pen and take pencil. At least for your understanding, when you're seeing, don't touch question paper. In your answer script, draw. If you don't need it, take it off later. It's okay. But when you're doing it, see it. What is happening? You will get better clarity. Hello? Very important, remember. And whenever there is a direct question, again, you know, I know, we don't know enough points to write for 5 marks. Then how do we do? In your jalebi, add one extra kaju barfi, that is example, relevant. Direct questions, the only way to increase the length, people, is by adding example. Please don't write examples for indirect questions, case-based questions. And next one, people, very, very important point is what? Sir, should we remember case laws? If at all same scenarios come, people, yes, we need to write the case laws. Compared to sections and case laws, forget sections, try to remember case law. That is point 1. Another common question you guys will have, should we explain the case laws? Answer is no, not required. Just write the case law and say the facts in the question are similar to a decided case law, Balfour versus Balfour. Again, I repeat, the facts in the question are similar to decided case law, Balfour versus Balfour. Is this clear? All of you? Hello? Remember, most important chapters, very, very important. Do not try to skip these topics before the exam. This is Indian Regulatory Framework, followed by LLP, followed by Companies Act, followed by Indian Partnership, Negotiable Instruments, Sale of Goods Act, Indian Contract Act. Day before the exam, you guys will revise in this order. Hello? Remember? Pakka? So remember, these things are very, very important from your exam point of view. Clear? Any doubts? So put this into use and see, I hope it is going to make difference. Especially now you guys might have another 20 days, 30 days left, whatever it is. This is going to be a game changer for you. Your mind should automatically start thinking from these 3 points. Is heading there in my answer? Is subheading there in my answer? Is keywords are there in my answer? Getting the point? All of you? Yep. Okay. Sure. What is that? Now we have to do this one, no? Okay, taka we'll do up this paper. We'll end up for the day. See, also elaborate the procedure for making a law. So let us continue with people. Okay, let us continue with, what is this? What are we doing there? RTP 2026. Yes, as I told you, yes, the only amendment for your thing is people. Small company, paid up capital is 10 crore. Turnover is 100 crore. Rest of it is same. People, see, now September 2026 RTP. What do you understand by law? Also elaborate the procedure. Law, as I told you, it's a set of rules and obligations. We can have different types of law, economic, social, and other types of laws as well. Elaborate the procedure for making the law, people. Remember, instead of writing paragraph, write it in points. Committee, bill, Lok Sabha, Rajya Sabha, President of India's approval, and then official gazette notification. Okay, R owns an electronics store. P visited the store to buy a water purifier priced at 54,000 rupees. He specifically requested R for a purifier with a copper filter. As P wanted to buy the purifier on credit with the intention of paying in 9 equal monthly installments, R demands a guarantor for the transaction. S came forward and gave the guarantee for payment of water purifier. R sold P a water purifier of a specific brand. P made a payment for 4 monthly installments and after that became insolvent. Explain with reference to Indian Contract Act the liability of S as a guarantor to pay the balance price of water purifier to R. See question number 1. Again to our list, add, what is that? Please read the complete question. There can be 2 questions in the same question. Question number 2. What will be your answer if R sold the water purifier misrepresenting it as having a copper filter, while it actually has a normal filter? Neither P nor S was aware of this fact, and upon discovering the truth, P refused to pay the price. In response to P's refusal, R filed the suit against S, the guarantor. Explain with reference to the Indian Contract Act 1872 whether S is liable to pay the balance price of water purifier to R. Yes, people, now think of our way of answering the question. Whenever you are answering a question, indirect based question, you need to write again same thing. Provision, facts. There are 2 conclusions here. Correct? So now what am I going to write? My provision. Try to think where does it fit. I need to think of 3 things now. What is the main heading? What is the subheading? What are the keywords that I can write? What is the main heading, people? When does the surety gets, when does the guarantee becomes liable? So in the given case, people, whenever on the failure to repayment by the main party, the guarantee will have to be liable. It's a direct provision. So it's nothing but the meaning of guarantee only. So for my first conclusion, they've given me all the details. 54,000 rupees, 9 installments. 54,000 divided by 9. How much will it be? 6,000. So 6,000 per installment. He has paid 4. 4 6 24 he has paid. How much is not yet paid? 30,000 is not yet paid. I will write, yes, guarantor will be liable to pay the balance price. Please don't write balance price. Write it like this. I am liable to pay 6,000 into 5 months. I need to pay 30,000. Now see, you have written it to the point. Everything you have written. Yes, you will get the complete mark. Hello? Next one. Sir, there is a misrepresentation. Now people, will the guarantee be liable? Now try to put our point here. Do we have provision? Yes. When is the guarantee discharged from a liability? So my first point, the guarantee will be discharged. That's my main heading. Subheading, misrepresentation, concealment of a fact, co-sureties and all will come. My main heading is what here? Misrepresentation of a fact. Hello? Misrepresentation of a fact which cannot be. Which cannot be? They have clearly given, right? Which cannot be discovered. That means what? We have not been negligent or something. Misrepresentation of a fact which cannot be, discovered. Sir, in such case, sir, the guarantee will be discharged as the principal itself is discharged. Hello? So in the second case, people, because it is misrepresentation, the contract will become void and the surety will not be held liable. Understood? All of you? And try to use the same words in your conclusion. Is yes liable to pay the balance? Yes. Yes is liable to pay the balance of 30,000. Where is it? Yes is not liable to pay the balance in the case of misrepresentation. That will be going as my conclusion too. Hello? Yes? Okay, next one. Rahul directs Sarthak to sell laptops for him and agrees to give Sarthak 11% commission on the sale price fixed by Rahul for each laptop. As government of India put restriction on import of laptops, Rahul thought that prices of laptops might go up in near future and he revokes Sarthak's authority for any further sale. Sarthak, before receiving the letter at his end, sold 5 laptops at the price fixed by Rahul. Sarthak asked for 11% commission on sale of 5 laptops for 1 lakh each. Explain under the provisions of Indian Contract 1872 whether sale of laptops after revoking Sarthak's authority is binding on Rahul. Question number 1. Whether Sarthak will be able to recover his commission from Rahul. If yes, what will be the amount of such commission? People try to see what is the case. The scenario comes under people revocation of agency. That's my heading. Hello? When will, no, that's my main heading. When will my agency be effective? Now there is no subheading, it is direct. So when will the, agency of, revocation of agency, my main heading, subheading will be people, agency will be effectively revoked when it comes to the knowledge of the agent, when it comes to the knowledge of the third party in the given case. Now are you getting it? Knowledge is my keyword. Revocation is my keyword. Now write conclusion 1. What? Whether the sale of laptops after revoking Sarthak's authority, is it binding? Now I tell you, remember today's date, examiners are trying to help you. Why do they have to use the same words? It's a hint. People, I'm asking from revocation of agency topic. Are you getting it? You will see those words if you actually see it. Now what will I say? The revocation of agency, when did it happen? It happened, people, after the sale happened. So remember, agency will not be effective, people, after the revocation of agency is come to the knowledge of the agent and the third party. In the given case, it happened, people, the sale happened before the revocation of agency, and hence, yes, Sarthak will be liable. Sarthak will be eligible for what is that? The commission. Second one, whether Sarthak will be able to recover his commission? Yes, from Rahul, yes. What will be the amount of commission? 1 lakh is the selling price, huh? Something they have given, no? 1 lakh each into 11% into 5. So 11,000 per laptop into 5, 55,000. That is the commission I can recover. You write this much, macha. Macha, you see this time. You guys put this and see how much you guys are getting in law. Yes, sir. Pakka, I am telling you, you will see difference in your answers. You will see difference in your marks. Yeah. Okay, right. Next one, sir. Preeti, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of MT Laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum by 31st July 2023. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will be able to pay back on her behalf. After 1 year, when Preeti was asked to pay the outstanding amount with interest, she refused to pay on the ground and told the owner that she is a minor and now he can't recover even a single penny from her. She will be a major on 1st Jan 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will be succeeded in the recovering of the authority. By filing a case against Preeti, a minor, by filing a case against father, by filing a case against Preeti, minor, for recovering. People, I'll again show you they are helping you. Yes, I'll show you why did this word come. Why should they have given it to you? They are helping you. Instead, they could have just asked, no, can Preeti be made liable after she becomes a major? Why did the word ratify come into picture? They will help. I'm telling you, every question will have a help. Yes. Now, one more point. Again, I'll answer very important thing in this particular thing. What is that? How much should we write, sir? Now, this is a minor thing. We got to know heading. Incompetent to contract, heading. The agreement is void when the parties are incompetent to contract, heading. Subheading, when the party is a minor, the agreement is void ab initio. Heading is done, subheading is done. What is that? I've made sure I've written my main 2 marks. Now, how do I get a 3rd mark? What and all I am supposed to write? They have given me 3 main, things in the question. What is that? I have taken it when I am a minor. As a minor, I am liable. My first keyword is a minor can always plead minority and minor cannot be made liable for any agreements. Every agreement with the minor, void ab initio. That's my first keyword. Second keyword, they have given me about the father. Now try to think in all the rules, which rule speaks about the parent? Minor cannot bind the parent or guardian. Underline, done. They have clearly given, can I make her liable after she becomes a major? A minor's agreement is void ab initio. It cannot be ratified even after attaining majority. My provision solidly I have established. Forget facts. Why? When there are more than one question, don't write facts. Don't waste time. Now directly come to conclusion. Conclusion 1. Can minor be liable? Referring to the provisions, it can be clearly stated that the minor agreement is void ab initio. Very, very important. Conclusion should write. Who is it? Preeti, a minor cannot be made liable. Please don't write the answers vaguely. Point 2. Can father be made liable? We saw father, that is parent or guardian, cannot be held liable. Third one, by filing a case against Preeti, a minor, for recovery of outstanding amount after she attains majority ratification. 5 on 5 you will get. Pakka. Now you guys test yourself. Where you guys writing so much? Knowledge you all had. Application. Now why I am saying that is, you guys can make a lot of difference in the next 3 days, because so many tests you will be doing. Put it in the right spirit. Mr. L let out his residential house to Mr. M for 50,000 per month for a period of 1 year. According to the rental agreement, electricity bill will be paid by L. Now you guys only should tell me the 3 things here. You need to tell me heading, subheading, keywords. We'll see. According to the rental agreement, electricity bill will be paid by L, but L could not pay electricity dues up to 5 months due to his financial hardships. The electricity board sent notice of disconnection if it is not paid within a week's time. To avoid all this, Mr. M paid the electricity bill of 50,000 rupees with penalty. Later on, L refused to reimburse the 50,000 and argued that he has paid bill voluntarily because of his own interest. Decide with reference to the provision of Indian Contract Act whether Mr. M is entitled to be reimbursed by Mr. L. People, again I will prove that the examiner is helping you. Payment made by a interested party. Heading, people. What is heading? Subheading is payment made by an interested party. Where did you guys see payment made by an interested party? Quasi contract. That's my heading. Quasi is not there. It is going to create a very big impact. So quasi contract heading. Now think of subheading. There are so many. It will be payment made by a interested person in the property. Yes. Now my heading, subheading established, sir. Now try to write the keywords. What is that? The keywords in this case will remain the same. That is, whenever a party is equally having an interest in the property, will be allowed to make the payment even in the absence of a contract and will be free to recover the money from the person under operation of law. Quasi contract, it's not voluntary. Getting the point? Yes. So can I recover? Yes, I can recover. Next one, people. Mr. A offered to sell 25 chairs to B at 1,500 per chair on 15th Feb 24. A promised B that he would keep the offer open till 15th Feb 24. However, on 13th Feb 2024, he sold those chairs to Mr. C at 1,700 per chair without the knowledge of Mr. B. Mr. B communicated the acceptance of the above offer on 14th Feb 2024. Advised with reference to the provision of Indian Contract Act whether Mr. B can claim damages from Mr. A. Yes, people, what happened in this case? The question is, people, what is my heading? The heading is, people, it's a standing offer. Second thing, people, an offer can be revoked before the acceptance. So in the given case, this is just an offer. An offer can be revoked at any given time by notice. Hello? So can I revoke the offer? Even if I have said I will keep the offer open till 15th, can I sell it to someone on 12th? I am free to do. Why? Remember that Sir William Anson, you would have seen my matchstick gunpowder. Until offer meets acceptance, it is no contract between me and you. I can tell 100 things. Whatever I want, I'll tell. Standing offer, my first finger. Second offer, revocation of offer. Possible, valid. Hello? Understanding? Next one. Mr. A was running an orphanage. His friends, Mr. S, a philanthropist, agreed to donate 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now, Mr. S refused to pay. Whether Mr. A can claim 1.5 lakh from Mr. S with reference to the provision of Indian Contract Act. Tell me heading. Heading. Validity of an agreement, nothing but exceptions to quid pro quo. That's my heading. Subheading. Charity. Keywords. Based upon a promise, if a liability has been incurred or undertaken, underline. That's all, you will get the marks. So in the given case, people, it's a charity and the liability has been incurred. I cannot go back. I am liable to pay. 1.5 lakh can be recovered. I hope you are able to understand that. Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26 Feb 2025. The borrower, Mr. Mukesh, asked for a further loan of 1,50,000. Mr. Sohan agreed but provided the loan in parts on different dates. He provided 1 lakh on 28th Feb and remaining 50,000 on 3rd March. On 10th March 2025, Mr. Mukesh, while paying off part rupees 75,000 to Mr. Sohan, insisted that the lender should adjust 50,000 towards the loan taken on 3rd March and balance on 26th Feb 2025. Mr. Sohan objected to his arrangement and asked the borrower to adjust in the order of date of borrowal of funds. Now you decide whether the contention of Mr. Mukesh correct or otherwise as per the provision of Indian Contract Act. What would be the answer in case borrower does not insist on such order of adjustment of repayment? What is this, people? The first one is, what is this? Appropriation of payment. There will be 3 things. The first one will always be in the order as recommended by the debtor. So in the given case, the contention of Mr. Mukesh is correct. He will be the first person to specify the order. Second one, sir, what if Mr. Mukesh is silent? The next option will be, people, first one will be debtor or circumstance. Second one, people, if debtor and circumstance both are silent, people, it will be creditor's choice. Correct? Appropriation of payment, heading. Keywords, in the order as prescribed by debtor, in the absence of which it will be in the order prescribed by the creditor. Underline, that's all. If people, am I writing full 5, 6 sentences, then if this is there, you will get the marks. What would be the mode of adjustment? If both are silent, people, then order of repayment. In light of provision of Indian Contract Act, answer the following. Mr. S and Mr. R made contract wherein Mr. S agreed to deliver paper cup manufacture machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise at the time of delivery. Tell me, what will you write? What is the heading? What is the heading? Mr. S and Mr. R made contract wherein S agreed to deliver the paper cup to Mr. R and to receive payment on the date of delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether S is bound to fulfill his promise at the time of delivery. What is the heading? Heading. Anyone who wrote reciprocal promises will get it. First heading is reciprocal promises. Now under reciprocal promises, you saw all the rules. In that one rule, now you wrote heading. Subheading is, people, what? Promiser need not perform unless the promisee is willing to perform, ready and willing to perform. These are the keywords. I came on that day. You are not willing to pay me. Why will I deliver the product? Reciprocal promises. Hello. Mr. Y has given loan to Mr. G of 30,000 rupees, 30 lakh. Mr. G defaulted the loan on due date and debt became time barred. After the time bar debt, Mr. G agreed to settle the full amount to Mr. Y. Whether acceptance of time bar debt contract is enforceable as per Indian Contract Act? Heading exceptions. Subheading promise to pay the time bar debt. Yes, it is enforceable. Direct, I'm not doing direct. Let us direct, only do the indirect questions. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer. 100 bags of 10 kg each. Okay. On sale or return basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer K. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? What is the main heading? Sale or approval basis. Okay. Under that, people, okay, that's the main heading. There is no subheading here. When does in sale or approval basis, what is the subheading? When is the acceptance complete? When you signify the approval, you do something equivalent to an acceptance, you keep the product beyond the reasonable period. Here, I have not given the acceptance. I have not kept the product beyond the reasonable period. But I have taken it from you. I have further sold it. Out of 100 bags, 5 bags I have sold it. 95 bags, it is still with me. 5 bags, acceptance is done. You lose the right of sale or return basis. 95 bags still with you. You can enforce the sale or return basis. See, you're able to frame it. Yes. Hello. Ritvik sold 500 bags of wheat to Anuj. Each bag contains 50 kgs of wheat. Ritvik sent 450 bags by road and Anuj himself took remaining 50 bags. Before Anuj receives delivery of 450 bags sent by road transport, he became bankrupt. Ritvik, being still unpaid, stops the bag in transit. The official receiver on Anoj's insolvency claims the bags. Decide the case with reference to the provision of Sale of Good Act. People. Rata, help is there. Heading, right of stoppage in transit. Subheading, when does the stoppage transit comes to an end? When the goods are delivered to the buyer or an agent or the carrier on behalf of the buyer. In the given case, people, 450 bags are already delivered and hence the transit has come to an end for the 450 bags. Whereas the rest of the 50 bags are still with Anuj and still in the transit, and hence you can exercise the right to stoppage in transit on those 50 bags. See, try to classify clearly. Mr. Mukesh was running a shop selling good quality washing machines. Mr. Vivan came to his shop and asked for washing machine which is suitable for washing woolen clothes. Mr. Mukesh showed him a particular machine which Mr. Vivan liked and paid for it. Later on, when the machine was delivered to Mr. Vivan's house, it was found that it was the wrong machine and also unfit for washing woolen clothes. He immediately informed Mr. Mukesh about the delivery of the wrong machine. Mr. Mukesh refused to exchange the same, saying that the contract was complete after the delivery of the washing machine and payment of price. With reference to the provision of Sale of Goods Act, discussed whether Mukesh is right in refusing to the exchange of the washing machine. People, one thing I have to tell you people, that unfortunately, our institute is complicating this topic called as implied condition and implied warranty. Unfortunately, they are complicating it. Wantedly, they will show it as one thing and the answer will be written in one way. If you ask me personally though, I am never happy with one topic of questions that is being asked from the exams point of view. That has always been Sale of Goods Act, implied condition, implied warranty. This stands as one best example. According to me, I'll tell you what is my answer, people. Clearly, Vivan came to his shop and asked for washing machine which is suitable for washing the woolen clothes. According to me, quality or fitness becomes applicable here. Second point, Mr. Mukesh showed him a particular machine which Vivan liked. If I showed you something, that means what? There is a washing machine in display. Then I will consider this as a sample. So both are there. Agreed? But unfortunately, people, the answer that institute says that is right. This is what is that? Implied condition as to sale by sample and description. Yeah. So I don't know how the description comes into picture here, because the woolen clothes, people, the buyer has asked for it. Seller is telling that it's a washing machine. Hello? So according to me, that is what it is. But yes, and they nowhere write quality or fitness. According to me, not sure if it is right or wrong, but according to me, it is wrong. Quality or fitness should be there. Hello? Then why should we mention this? Correct? That too, the entire condition is clearly revolving around woolen clothes. That is so clearly quality or fitness. Buyer made known the purpose to the seller and relied upon the seller's decision. Yes? But yes, the answer that they have given is, people, sale by sample and description. According to me is wrong. According to me, it should be quality or fitness should be the first priority. Sample to an extent is okay, but description I'm not sure. Yeah? Okay. Neeraj entered into a contract with Rahul to purchase 1000 liters of mustard oil at the price which would be fixed by Akash. Rahul already delivered 600 liters out of 1000 liters to Neeraj, but when the remaining 400 liters was ready to deliver, Akash denied fixing the price of mustard oil. Rahul asked Neeraj to return the oil already delivered and avoid the delivery of 400 liters. Neeraj sued Rahul for non-delivery of remaining 400 liters. What is this, people? Ascertainment of a price. You can fix the, ascertainment of a price. You can fix the price by the third party. If the third party is unable to arrive at the price, then the contract can be avoided. This is my total points. However, if the product is already delivered, then the buyer needs to pay what is reasonable price. Now, in the given case, people, I have delivered 600 liters. I have not yet delivered 400 liters. For 600 people, you need to pay what is reasonable price. For 400, what is not delivered, the contract can be avoided. Hello? I hope you are understanding. Okay. Indian Partnership Director, Ram and Sarthak are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. Ram introduced Gopal to Sundar, a supplier to the firm, as his newly joined partner. Gopal, knowing that he is not a partner, preferred to keep quiet on such an introduction. This information about Gopal being a partner of the firm was shared by Sundar with another businessman, Madhav. Next day, Sundar supplied the raw material on credit and Madhav lent Rs 5 lakh to the firm for a short period on the understanding that Gopal is a partner of the firm. On due dates, the firm failed to discharge its liability towards both. Advise Gopal whether he is liable to Sundar and Madhav for the aforesaid liability of the firm. Main topic, types of partners, partner by holding out or estoppel. Keywords, the partner will be liable to such outsiders with whom there was a direct, he made known or he did not stop that he is not a partner or he is a partner. So with whomsoever we created that impact, only to them I am liable and not to the people whom they communicate to. So in the given case, people, to Sundar I am liable, to Madhav I am not liable. To whomsoever I directly created an apprehension that I am a partner, only to them I am liable. If they go and tell to someone else further, I am not liable for all of that. If I was there, if I did not stop you, only then I am liable. If you tell to another 100 people, I am not liable. Remember that. That's the answer. Mr. Ram, Mr. Rakesh are working as teachers in Ishwar Chand Vidyasagar, and they are good friends. They jointly purchased the flat which was given on rent to Mr. John. It was decided between the landlords and tenants that the rent would be 10,000 per month inclusive of electricity bill. It means electricity bill will be paid by the landlords. By mistake did not pay the electricity bill. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill of 2,800 and 200 as penalty. Mr. John claimed 3,000 from Mr. Ram, but Mr. Ram replied that he is liable only for 1,500. Mr. John said that Ram and Rakesh are partners, therefore he can claim the full amount from any of the partners. Explain whether under the provision of Indian partnership, Mr. Ram is liable to pay the whole of the amount to John, that is 3,000 rupees. Simple people, if I am a partner, I was liable to pay the entire 3,000. But this is the case of people, they have used the word landlord. I am people, co-owners. In co-owners, I am liable only for my share. So in the given case, I am liable for 1,500 because it's a co-ownership. Mutual agency is not there. And hence people, there is absence of partnership between these two people, Ram and Rakesh. What exists between them is just the contract of co-ownership. And hence, Mr. Ram is right in his opinion. He is liable only for 1,500 and John has to recover the rest of the money from Mr. Rakesh. That's my answer. Hello. A, B and C are partners in unregistered partnership firm named ABC. Is the suit maintainable in the following cases as per the provision of Indian Partnership Act? What is that? A filed a suit against B who had stolen the goods of the firm. It is unregistered partnership firm itself. Can we file a case against the robber? Criminal case, the thefter, you can file. Civil cases, you can't file. Criminal case, you can file. Today only I told you. A filed a suit against measures A, B, C and associates for claiming shares of the assets on its dissolution. Separation, possible people. Correct? Huh? Realization of assets on dissolution, I can file a case. M filed a suit against the firm, measures A, B, C and associates for the recovery of 10,000. M also owed 4,000 to the firm. The firm claimed a set-off of 4,000. Third parties can file a case on the unregistered firm, but an unregistered firm cannot claim a set-off beyond 100 rupees. So you can file, but I cannot claim a set-off more than 100 rupees. Done. Mr. R, a manufacturer of toys, approached MNO Private Limited for supply of raw material worth 1,50,000. Mr. R was offered a credit period of 1 month. Mr. R went to the companies prior to the due and met Mr. C, an employee at the billing counter, who convinced the former that the payment can be made to him as the billing cashier is on leave. R paid the money and was issued a signed and sealed receipt by Mr. C after the lapse of due date. Mr. R received a recovery notice from the company for the payment of 1,50,000. R informed the company that he had already paid the above amount and being an outsider had genuine reasons to trust Mr. C, who claimed to be employee, and issued him a receipt. The company filed a suit against R for non-payment of dues, discussed the fate of the suit and the liability of Mr. R towards company as on the current date in consonance with the provision of Companies Act. Question number 1. Question number 2. Would your answer be different if a receipt under the company seal was not issued by Mr. C after receiving the payment? Heading people, doctrine of indoor management. When the company, the person has issued the seal, people, we will believe that it is a company's authorized document, people. In the given case, company cannot recover the 1,50,000. If seal was also not put, people, in such case, remember, it becomes a case of suspicion of irregularity, exceptions to doctrine of indoor management. Heading is doctrine of indoor management, exception to doctrine of indoor management, that is having suspicion of irregularity. You guys need to have little suspicion. Seal is also not given. You don't know who he is. You cannot act. So in the second case, people, if seal is not given, then you will be liable to pay that 1,50,000 again to the company. Company can reject your claim. Hello. Mr. Vijay sold his business of cotton production to a cotton production company, CPL Private Limited, in which he held all the shares except one, which was held by his wife. He is also the creditor in the company for a certain amount. He also got the insurance of the stock of cotton of CPL Private Limited in his own name and not in the name of the company. After 1 month, all the stocks of the cotton of CPL Private Limited were destroyed by fire. Mr. Vijay filed a claim for such loss with the insurance company. State with reasons that whether the insurance company is liable to pay the claim. The case law, people, Makaura versus Northern Assurance Company, separate legal entity. The insurance contract should always be in the name of the company. You cannot have it in the name of the shareholder. Case law is important. Makaura, Northern Assurance Company. Alpha School is a Section 8 company which started imparting education on 1st/4/2015 with the sole objective of providing education to children of weaker society with a nominal fees depending on another plan. However, on 31st March 2023, it came to the knowledge of the central government that the said school was operating by violating the objects of its object clause, due to which it was granted a Section 8 company. Describe what powers can be exercised by central government. Whenever a Section 8 company does not follow the rules prescribed under the Act, the central government can either wind up the affairs of the company, amalgamate the company with any other company, and they can also convert the status of the company into any other form of business. If the company is winding up people, I can either transfer the assets to any other similar company, or I can transfer the money to insolvency and bankruptcy fund. That will be my provision. Hello. What do you mean by common sale? Okay, direct questions. Last one we will see. Advik purchased a mobile from Bano. He issued a promissory note to Bano which was payable on demand, but no specific place for payment was mentioned on it. On maturity, Bano did not present the promissory note for payment. As the promissory note was not duly presented for payment, whether Advik would be discharged from liability under the provision of Negotiable Instruments Act 1881. We saw today only, people, presentment rules. Whenever there is no specific place mentioned, people, the presentment becomes unnecessary. It's okay. You will be still made liable. Shiva gave a gift of 21,000 to his sister through a check issued in her favor on the occasion of Raksha Bandhan. Afterwards, Shiva informed his sister not to present the check for payment and also informed the bank to stop the payment. Examine the provisions of negotiable instrument. Decide whether Shiva's acts constitute an offence under section 138. What if it was not a gift and legally enforceable debt? Yes, because stopping is considered as to be dishonor of a check only. Yes, people, it is not a legally enforceable debt, and hence it is not an offence under Negotiable Instruments Act. That's all, people. That's the number of questions. So that's your RTP September 2026. Yep. So that's it, people. Wish you guys all the best. Let me know if you guys have any doubts. If you guys need even any more, I don't know, topics or anything more in detail, let me know. I'll try to do topics or videos on those particular things so that let us try to cover it. As I told you, I've already made one video on case law. I think it's around 1.5 hours or something, people. Just search on YouTube, you will get all the cases right from Indian regulatory framework till the negotiable instruments. Everything is covered letter by letter. Please make use of all of that. Sure. So that's it from my end, people. Thank you so much. See you all. Bye-bye.